Ms. Maxwell,
Let us roll.
are we ready?
Are we ready?
Ms. Kelly's ready. I'd like to call this regularly scheduled February meeting of the Tennessee Real Estate Commission meeting into order. And I'd like to remind all of the attendees and everybody in the audience that if you have an electronic device, cell phone, whatever, put it on silent. And we want you to enjoy while you're here. We hope this will be very beneficial, that you will learn something that you can take back to your offices and you can take back into your career as a real estate professional licensee and be more in tune as to what this phase and what this part of the real estate industry in Tennessee does. The Tennessee Real Estate Commission was enacted and set up and established in 1951. Purpose of this commission is to protect the public, protect the citizens of Tennessee. We've got about 5.5 million people in this state. And our duty and what we are charged with, we only have 6 of us here today. 3 of our members are not here, but there's a total of 9 of us. But our job is to make sure that the industry functions and that those who shouldn't be doing things that are going to harm the public, that we discipline them and we make sure that those 5.5 million people in this state are protected. That's what we do. But anyway, I just want to welcome you here and hope that you enjoy the next day and a half and that you will find it beneficial. First thing on our agenda is the roll call by Miss Eve Maxwell, our Executive Director.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, January 30th, 2014. This meeting has been noticed on the 10Gov website since Friday, January 31st, 2014. Now the roll. Alexander, absent. Bloom.
Present.
Collins.
Here.
DeChara.
Here.
Flitcroft, absent. Franks.
Here.
Grease, absent. McMullen.
Here.
Stevenson.
Here. Thank you, Ms. Maxwell. Next on our agenda, I'd like to call on one of our newest commissioners from Memphis, Mr. Gary Bloom, if he would lead us in our invocation this month.
Let's bow our heads. Father, we are really thankful that we're able to live in this great country where freedoms are available to us that we sometimes take for granted. Help us not to do that. We pray that in our deliberations today we'll use wisdom and be mindful of the rights of all who are here, and that our decisions will be reflective of good judgment that will help people be protected in real estate matters in this state. And we pray in Jesus' name. Amen.
Amen. Next on our agenda is to adopt our agenda. Are there any additions or corrections to the agenda that has been prepared? Anybody have anything they'd like to add?
Motion to adopt.
Second.
We're going to have some discussion, Commissioner DeShara. We have a motion by Commissioner.
They're in a big hurry this morning.
We have a motion by Commissioner Collins to adopt our agenda and a second by Commissioner McMullen, and we're going to have some discussion by Commissioner.
Robin discussed with us several months ago that we could give her some authority to maybe negotiate a little bit on consent orders. I'd like to put that on the agenda for discussion today.
Where would you like to put that?
Let's put that with Julie's
She'll
legal
be in this
report, 'cause she'll be
afternoon.
here.
Yeah.
So, right after the legislative update?
Probably before that, because she'll leave as soon as Julie's part's over.
Well, right after the legal report or before the legal report?
Before the legal report.
Okay. Before Julie does the legal report, we will add that we will have a discussion to give the authority to Robin Ryan, one of our general counsels, that she'll have the authority to negotiate some of these issues out. Okay. Any other things about, we have a motion, it's been amended. The motion to adopt the agenda has been amended. All in favor say aye.
Aye.
Opposed, no. Motion carries. Next, approve our minutes.
Second.
Have a motion by Commissioner Collins to approve our minutes from last month, and we have a second by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Minutes are approved. Next thing on our agenda is an informal applicant appearance. We have Roger Sweeney. Is Roger Sweeney and Mickey Stafford here? If you two would, Mr. Sweeney and Mr. Stafford, if you two would come up here and sit in these first two chairs.
In the dark.
It's not so dark. We can see them. We're conserving electricity for the state. Ms. Crop?
Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Roger Sweeney, and I had sent a little synopsis of Mr. Sweeney's information. Mr. Roger Sweeney is applying for an affiliate broker license. He is not yet tested. He was formally licensed in Tennessee as an affiliate broker on 2/27 of 2009, and his license expired on 2/26 of 2011 for failure to pay his renewal fee. When first licensed, Mr. Sweeney got his license through Reciprocity. As he was licensed affiliate broker in Alabama at the time and was affiliated with a firm located in Madison, Alabama during his period of licensure in Tennessee. Mr. Sweeney, who is here today, is the principal broker for Mr. Stafford. Mickey Stafford is here with Mr. Sweeney as a principal broker. Mr. Stafford is the principal broker of Farm and Home Real Estate LLC, which is located in Fayetteville, Tennessee. Mr. Stafford was first licensed as an affiliate on 11/7 of 2003. He got his broker's license on 11/30 of 2012, and he became the PB of Farm, Home, and Real Estate LLC on 12/10 of 2012. That particular firm was first licensed on 9/2 in 2009. The firm has 6 affiliates and 2 brokers and a principal broker, Mr. Stafford. There's been no disciplinary action against Mr. Stafford according to the TREC records. Mr. Sweeney was licensed as a salesperson in Alabama on 4/8 of 2002. Mr. Sweeney had a complaint filed against him with the Alabama Real Estate Commission in 2010, and that complaint ultimately resulted in the revocation of his Alabama license on 4/23 of 2010. The decision of the Alabama Real Estate Commission was remanded back to the commission upon the request of the parties so the commission could hear additional evidence about things that had occurred since their initial hearing to remedy the situation that was presented at that time. On 5/20/2011, after hearing the evidence, the commission confirmed its earlier decision to revoke Mr. Sweeney's license. Mr. Sweeney appealed the decision of the commission to the Circuit Court of Alabama, which held there was a reasonable basis for the decision made by the Alabama Real Estate Commission, and they denied the appeal on 4/10 of 2012. The attorney for ARAC, who I've spoken with, has stated that Mr. Sweeney can reapply for his Alabama salesperson real estate license and come before the Alabama Real Estate Commission to present his case to allow for reissuance of his license. This morning, Mr. Sweeney said he has not yet taken that action. The basic facts of the complaint against Mr. Sweeney before the Alabama Real Estate Commission were that in 2009, Mr. Sweeney, as a member of one LLC, contracted to sell a partially constructed home to some buyers. On the same day, Mr. Sweeney, as a member of a different entity, also contracted to sell the lot adjoining the partially constructed home to the same buyers for $10. At the time of the contract, Mr. Sweeney was a licensed Alabama salesperson affiliated with a licensed Alabama real estate firm. which did not have any affiliation with either of the two companies, the contractor company, the developer company. The home was completed and the sale closed in July of 2009, but the adjoining lot was not conveyed. It was not conveyed because Mr. Sweeney's company did not own the lot at that time and did not own it at the time they entered into the contract. But because of Mr. Sweeney's financial condition at that point, the buyers agreed to not close on the adjoining lot and not have it conveyed until December 31st of 2009. By December 31st of 2009, Mr. Sweeney's financial condition, I guess, had worsened, and he was still unable to convey that adjoining lot. The buyers said that the main reason that they purchased the house that they bought was the inducement of the lot next door for $10 so that they would not have anyone build next door to them. The Alabama Real Estate Commission determined that Mr. Sweeney made false promises to the buyers and should have disclosed that he didn't own the lot, that he had an interest in each of the companies involved, and he did not do that. When Mr. Sweeney went back to present additional evidence to the Alabama Real Estate Commission, he presented evidence that they had in fact purchased the lot now for about $16,000 out of foreclosure and had deeded it to the buyers. And that was in 2011. And that's where it stood. As I say, he appealed it to the Circuit Court of Alabama, and they turned down the appeal. And that's a short synopsis of what happened, and Mr. Sweeney probably has some additional facts he'd like to add, or not.
Mr. Sweeney, none of us that's up here, I mean, we've had a chance to review this, and we've looked over it, and Mrs. Maxwell has read us a short synopsis of what happened. But we would like for you, in your own words, just to tell this commission what happened and why your behavior was such, and the actions as egregious as they were, that the Alabama Real Estate Commission revoked your license. Just tell us in your own words what happened and why you have this desire to get reinstated and get a real estate license to get back in this industry.
Thank you, sir. I appreciate it.
And the one thing I want to caution, I want to ask you, we've got a permanent record, and some people's voices are louder than others. I'm an auctioneer, so.
And I'm a mother of 5, so I don't need a microphone either. Boys,
But-
boys,
Five
yes,
boys,
5
she
boys.
has.
So
But anyway, just lean forward and talk in a more audible voice so we can, not only us can hear, the audience can hear, plus we've got a record of it for this meeting today. So go ahead, in your own words, tell us what happened.
Yes, sir. Thank you for your time. I appreciate that. I'm also a father of 5 kids. So from 2002 to that complaint, I was fortunate enough to sell over 1,000 homes, and mostly working for builders, representing builders. And so that was a good number of chances, if I was not doing good business, for something to crop up. I was also asked to be part of the ethics committee for our board of realtors, and I served on that for about 3.5 years. When I made the decision in 2007 to become a builder myself is where I exposed myself to some exposure. And I began to build houses right as my company started, right as the crash was happening. So we actually had my little company, my little building company, we contracted 52 homes to be built in just 2.5 years. And those 52 homes, we had 13 people back out of contracts. They were not able to close, their financial situation, their job situation. So I was left as the guarantor of their construction loans, which was causing me, I didn't have that kind of money to support 13 spec houses or at different stages of construction. So this particular home was one that a customer had backed out of, and the banks were shutting down funding, and I don't want to rehash all that stuff because it was a nightmare, but one of the banks that had construction loans closed. So we were not able to finish the home. We were just trying to sell it as is, and this one happened to be that particular case. So this customer came and said, we will buy the home and contract you to finish the home. we'll go get our own construction loan to finish it, and we want to move forward with you as the builder. So I explained that because of the crash that was happening, my building company was not that viable. And therefore, we would need them to basically fund the rest of the build, meaning not only get the construction loan, but they would have to pay the bills directly to the vendors and the subs, because we were not able to. Sometimes builders will pay ahead of time and then wait for their draws. That's typically how it went. We weren't able to do that. So they agreed to that. And then after we had wrote a contract for the home, they asked, could we buy the lot next door? And this is in a neighborhood, and it's probably 30 home sites that were not built on yet, and one happened to be right next door to this home that was partially finished. So I explained that I had a building company, and then I had a development company where I would go out and buy the lots as part of the development company, and then we would have the building company build on them. They understood that. They also, when I disclosed to them that the lot had a mortgage loan against it, it had a loan against it, that we were not able to pay that off to give it to them for $10. We would need more time, and if these 13 houses that were under construction at certain aspects, if they all closed, or a good portion of them closed, we would then have proceeds to then go pay off that lot and give it to them for $10. So my attorney that I asked to represent me after I went and appeared before the commission, which I appeared by myself, he is a municipal judge in the city of Madison. After he looked at it, he felt like that I had given proper disclosure, that there was risk involved, that building companies going under, there's a loan against the lot next door, so if we want to include the lot in the deal for $10, there's risk that they may not get it. So that's why he represented me on that case, and we went and appealed it. The district court ruling was that they cannot overturn anything but a procedural. So unless the commission had not followed their own procedures, they could not rule on it. So they didn't have an opinion whether I was in the good or the bad. They just basically had to rule, did the commission follow the procedures? That's what the law reads. After we got together with the bank and began to negotiate with them, and I was in communication with the customer saying, the building company's closed, but I'm still negotiating with the bank that holds the loan on that lot to sell it to me cheaper so that I can convey it to you. Of course, they got impatient, which I understood, and they filed a complaint. It took some time, but I was able to secure the funds to pay off that bank. I also signed over my right of redemption that gave them peace of mind that I wouldn't come back on them to claim that lot, and conveyed that, and they dropped their complaint, and they were happy. The commission felt like that the wrong had already been done. Now, in hindsight, I have looked back on that, and I've learned a lot, and I understand where I could have made a better decision. And that is when we are, as realtors, in a dual representation, it's my opinion that a home builder should not be a licensed realtor. That's just my opinion. And after looking at this, going through this myself, my thoughts are, you never take off your realtor hat. So if you are building homes and you're saying that you're going to represent the buyer, but you own the building company, I just don't feel, in my opinion, that you can represent both parties 100%. Now, since then, Cindy Sang, the owner of National School of Real Estate in Huntsville, she trains probably about 80% of the new real estate agents for North Alabama, has asked me to come and guest speak, which I have on several occasions, about 30. And I share how the situation came about and what we went through and what I've learned from it. And I've tried to give new realtors and existing realtors going through CE credits advice on how to avoid that same situation. And I've gotten very positive feedback from her as the owner of that National School of Real Estate, and also former fellow realtors and new realtors that I've really helped. So my thoughts are, I had 1,000 transactions before I had my first complaint. I enjoy real estate. I understand the seriousness of it and the gravity of selling homes and helping people buy and sell. It's their largest purchase of their life. And I know it's a part of the American dream that the home is our castle. So I have helped in the appeals process. I was able to keep my license for 2 years. I was working with a builder. I sold another 76 homes, did not have a complaint on those 76 sales. And I was dealing with other realtors that knew that my license had been revoked. So, there was potentially cause of concern, but I never had any issues with the local board or the state.
I think you've explained your situation very well. I would like to ask, we've got a diverse group of people sitting up here at this table, and I would assume that there's probably one or two of them have some questions of you, Mr. Sweeney, as we look at this particular matter before us right now. Does any of the commissioners have any questions of Mr. Sweeney?
I do.
I do. Go ahead.
You still live in Alabama?
Yes, sir.
I don't know, if you're a citizen of Alabama, I don't know why we'd have any decision for a Tennessee license.
Ms. Maxwell?
He's applying for a Tennessee affiliate broker license, and with the revocation in Alabama, he would come before the commission for the commission to determine whether or not under 6213-303 he met.
He doesn't live in
qualifications.
Tennessee.
Well,
He doesn't have to.
he doesn't have to live in Tennessee to get a Tennessee license. He lives less than 50 miles from the office of his broker, Mr.
But
Stafford.
the license he had was through reciprocity, and that has been stopped.
Right, so now he wants.
So he's
gonna-
circumventing their rules.
No, he's going to he will sit for the exam. He'll sit for the exam like anyone else who wants to be licensed in Tennessee. Did that answer your question?
Yeah.
Are you wanting to sell property in Tennessee or in
Yes.
Alabama?
In Tennessee. I'm right by the border of Tennessee. And I did a good number of business in Tennessee when I previously had my license.
Would you be allowed to have reciprocity in Alabama then off your Tennessee license?
No. No, their minimum is 2 years, which comes up here in April to reapply.
When a contract was written, did you disclose in writing that you were a realtor?
Yes,
Okay, and was the contract on a real estate contract or on your construction company contract?
real estate contract,
Okay, and you represented both parties.
correct.
Okay, why did you enter in a contract that on a lot you did not own?
Well, when we're saying we did not own it, I was on the title, but the bank, I owed a loan on it. I guess what that information is, I didn't own it outright to be able to give it for $10.
Okay.
I mean, I did have the title. My name was on the,
Why $10 on a $16,000 lot?
well, it was a $35,000 lot. They basically said, would you throw in the lot next door to us as part of the deal? So we worked out the deal on the home, and then they said, could you throw in the lot next door?
To give it an enticement, what year did this? I know the bubble burst in spring of '08,
Yes,
and I fully understand how you got caught along with a whole lot of other folks around this country just like you.
Yes, sir.
Who was in the building business, got their
yes, sir.
fanny handed to them on a platter.
Yes, sir.
But what was the date of this contract that you entered into on that house and said, hey, we'll throw this lot in. If you could get a release from the bank,
Right.
then you'd throw that lot in for $10 as an enticement to get them to buy that house. What year was that?
I believe that was '09.
09?
Yes,
Yeah,
yes. It was after the crash had
Yeah, you-
fully started.
Just doing anything they could to get people in house.
Yeah, you were trying to do some creative things, just liquidate inventory and get that bank off your back.
Mr. Sweeney, can I ask you, you said that your attorney thought you'd given enough notice on the lot. What notice did you give the purchaser regarding your interest in that lot?
Yes, sir. It was in writing that I was a member of the LLC, R&K Development, that owned that lot next door. And the other notice I gave is that the building company was in trouble. So therefore, when we closed on the home, we needed another 6 months to see if income could be generated to pay off the note to give them the lot for $10. That was in writing as well.
If I was that purchaser, would that have been real clear to me?
Well, looking back on it, it was not. The risk was not clear. No, sir.
So they thought you had the power to do that?
They felt like I would, yes.
Did you apply to Tennessee to get your license to read and you're appearing before us?
No, I let it lapse.
No. But why are you appealing to our commission rather than just applying?
Because he has a conviction.
Did even them say you couldn't have them or something?
When an individual applies for a license and they have had a revocation in another state or a revocation here, they are brought, we ask them to come before the commission so the commission can make a determination as to whether they meet the qualifications under 303.
This is just a statement, but we have 38,000 realtors in the state of Tennessee. Most of them can get totally through their real estate careers without ever even having to go before a commission, much less having their license revoked. I just think that is very serious. That is very serious. I just need to make that statement.
Mr. Sweeney, could you reiterate to me the current status of those purchasers? They own that house that you built, and do they now own the lot next door?
Yes, sir. Thank you for asking.
And did you?
we were scrambling to do all we could to meet our obligation of providing that lot for $10. And the truth is, and I just need to state this because I understand what the madam said about the seriousness of it. I drained my kids' college fund. I drained my retirement fund that no bankruptcy can touch. They can't touch your retirement. I drained it, took all the penalties, put that into the company to try to keep it afloat. So I scraped it all the way down to nothing and sold all the property that we owned except for our existing home. And so we were able to come up with the money and negotiate with the bank to pay that lot off and convey it to them for the $10. So they own the lot, they own the house, they're happy with the home, but they did have some aggravation that they were not deeded that lot on time, according to contract.
But you were able to perform on what you had agreed to, that lot for $10?
Yes, sir, but I did it late.
Have you been able to weather the storm without filing bankruptcy?
Oh,
I would imagine you probably one of the
yes.
like several good friends of mine in the East Tennessee area that have had to file bankruptcy that was doing what you were doing.
Yes, sir.
Got caught and didn't see it coming.
That's right.
But you did perform and were able to deliver
That's
on
right.
what you had agreed to.
Yes, sir.
Mr. Chairman, I think I understand what happened, and I'd like to move that Mr. Sweeney.
If we could, Mr. Bloom, if it's customary in these type of proceedings, we always like to hear from the principal broker. Tell us about your company, if you would, Mr. Stafford. How long you've been in business? How many agents you have? It sounds like to me, with as many houses as Mr. Sweeney has sold in his career, I don't know how much of a mentoring program you're going to have to provide him. But tell us about your company. How you going to handle Mr.
well,
Sweeney if this commission votes in the affirmative on this matter?
Well, Mr. Sweeney's probably sold more houses than my whole company has. But, I'm a small company. We live right on the Alabama border, and I have 8 agents. So we're tight knit, and I pretty well know everything that's going on with every contract, because we're small, and that's just easier to do when you're such a small company. I do review all the contracts. We go over them. If there's any question at all about what they're doing, we talk it over, contact people for advice, and we do our best to try not to do wrong. Now, I've told Mr. Sweeney that I would be close supervision over him until I felt comfortable with him, if y'all should decide to allow him to be relicensed. And he came to me, I guess, a couple of years ago when we first started talking. I know this is all new to y'all, but I've hashed it over many times with him, and he knows he made a mistake, and he's repentant of it. And he would like to get back into a profession he loves. And I feel comfortable sponsoring him, over the many conversations we've had over the last couple of years. And I think that, he had his back to the wall, and he made a poor decision, and he knows that. And but anyway, I'd like to give him another chance.
Are you licensed in Alabama?
Yes, sir.
Will he be allowed to sell in Alabama?
No, sir.
I didn't know.
No, sir.
Or list or anything? Can't
No,
do anything?
he will not be able to do anything in Alabama without an Alabama license.
But, Mr. Sweeney, you indicated to us that your 2-year probation that was imposed comes up this April. And
May.
In May,
Yes, sir.
you'll have an opportunity to reapply with
Yes,
the
sir.
Alabama Real Estate Commission. Anybody have any other questions, either of Mr. Stafford or Mr. Sweeney, before I recognize Commissioner Bloom?
I would like to ask a couple more questions to Mr. Sweeney. Mr. Sweeney, when did you file bankruptcy?
It was in 2009,
What chapter did you file?
7,
Did you get a discharge?
yes,
Was there any distribution to your unsecured creditors in the case, or was
very
it a no-
little, very
There
little.
was, okay.
Anybody have any other questions of either Mr. Sweeney or Mr. Stafford? If not, then I'm going to recognize Mr. Commissioner Bloom.
Thank you, Chairman. I think I get what happened, and I think it's important that we all understand when it happened, because we all have friends who had something very similar to that happen. And I do believe Mr. Sweeney has righted a wrong, and he has done the honorable thing. And so I'd like to recommend that he have the opportunity to be licensed in the state of Tennessee.
I'll second that.
I have a motion that we grant the application and allow Mr. Sweeney to sit for the test and be relicensed in Tennessee. And it's seconded, motion made by Commissioner Bloom and seconded by Commissioner DeShara. Discussion on the motion. I'd just like to make one comment from what I've heard and when all this was going on, when you were struggling with the bursting of the bubble, I was chairman of a board of a bank in Clinton, Tennessee, small bank. We've subsequently sold the bank a year and a half ago to a group out of Middle Tennessee that bought us. But I'm very much aware that so many people did not see what was coming around the corner and just woke up one day and said, "Oh, shoot." And here we are. But I think you didn't do anything. I don't think you had ill intent. You were, from the get-go, you were sincere in what you were offering and what you were negotiating, and you didn't do anything wrong, and that's the only comment I have. Any other questions, any other discussion on the motion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
And I abstain.
We have 4 yes, 1 no, and 1 abstention. And the no, Commissioner Franks voted no, and Commissioner McMullen abstained. Good luck on the test, and good luck in the future with your endeavors. And I think that you're a much wiser individual, and you'll be a much better real estate agent as a result of the storm that you went through.
Very much.
Thank you. And I want to say, Mr. Stafford,
Yes, sir.
if Mr. Sweeney comes back, you come back. And we don't want to see either one of you here
Well, I hope
ever
I
again.
hope to never come back, except visit.
Thank y'all.
Good luck.
Good luck. You have anything, Ms. Maxwell?
No,
No.
I don't have anything.
Okay. Well, if you don't have anything for either Mr. Sweeney or Mr. Stafford, then the floor is yours for the executive director's report.
Gee, thank you.
You're welcome.
The first thing on the report is the complaint report, which is on the iPads. And the first page of that, sheet 1 of that, lists the open complaints by source. And you can see that we have currently 131 complaints that are open. So far this year, we've received, and this is since July the 1st, our fiscal year, we've had 329 complaints that we've received. I'm sorry, that was last year. We had 329 for the whole year. This year, thus far, we've had 191 complaints. So I think Julie mentioned the other day that we're ahead of the number of complaints this year that we have received over what we have received last year. And that, I don't know if that's an indication that business has picked up or what that's an indication of, but we do have more complaints that have been filed at this point in the year than we did last year. Are there any questions on that? The next sheet is the complaints over 180 days, and you can see that there are 23, and those have all been referred to litigation. So they've come before the commission, and they're either in the litigation department or there's a consent order that's outstanding in those. So they've all been brought before the commission to make a decision. The amount of money that the commission has received this year thus far from consent orders or citations has been $175,996, and of that we've received we received $4,000, and then this last month we received $1,400 from E&O, so we received $5,400 from E&O, which is a big difference from our $284,000 one year and the $121,000 the next year. But that also shows how few of the suspended people have actually paid the penalty fee that's set forth in the E&O statute to get their licenses back and to start out of suspension and to start practicing again. The next sheet is the total open complaints as of 1/31/2014, and the number that we've closed. As I said, we have 131 opened. We have closed to date 2,002 for the fiscal year this year, and you can see the breakdown of how they've been closed. 202. What did I say?
2002.
Oh, 2000. Sorry. 202. Y'all would have been busy for 2002. 202 have been closed for the year. Are there any complaints about that? And I mean, gosh, I don't know where my mind is. Are there any comments about that? Questions
About the complaint.
Yeah, about the complaint.
Complaints about the complaints. And then the next item is the disciplinary action report, and that lists the individuals that have paid civil penalties this past month and the individuals that have been suspended over the last month. And the suspensions include Tennessee Student Assistance Corporation, the Human Services for Child Support, and E&O. So it includes all suspensions. They're not broken down by type. The legal department wants them presented just as suspensions. So you'll see those at the bottom of the list on the disciplinary action report. And the next item on the iPad should be the pie chart that shows the percentage of complaints, how they break down. This is based on when they come in and the designation that they're given, and some things have more than one, appear to have more than one issue. So what you see here is not always the way it ends up, the grounds upon which it might end up being determined, but these are just the initial impression when the complaint is reviewed for the first time in our office. Are there any complaints any questions? I see I'm going to say it again. Are there any questions about any of those?
Ms. Maxwell, if I could, I'd just like to say to all you licensees that are out there, I don't know how long you have been in this industry and how long you've had a license and been practicing real estate. But if you will just keep people informed as to what is going on, disclose. That's one thing I've learned being on this commission for 9.5 years. If you'll just disclose, you can greatly limit the probability that you'll ever have a complaint filed against you. That's if you can learn that one thing from being here at this commission meeting. When you go back and treat people and deal with people, just keep them informed, let them know what's going on, and disclose, and you'll get along just fine in this industry. Just want to throw that in. I'm not going to charge you anything for that.
The next item on the report are the licensing statistics, and the first page of those show the number of licensees as of 1/31/2014. We had 23,844 active people as of that date, and that's 241 less than we had last month. The inactives, we had 1,101, which is 151 more than last month. The retired individuals, 8,301, which is 30 more than last month. Broker release, there were 240, which is 71 more than last month. And we had a grand total of 33,486 active and inactive retired broker released individuals, which is 11 more than we had the end of last month. The firms, we had 3,905, which is 8 less than last month. 211 retired, which is 4 more than last month. So we had a grand total of 4,116 firms, which is 4 less than we had last month. So our grand total of both firms and individuals is 37,602, which is 7 more than we had last month.
If I could inject one little number. In January of 2007, I think that's 7 years ago, somewhere in that ballpark, we had 34,430 total active licensees in Tennessee. 34,430. And today we've got 23,844 as of the end of January.
That's how many rats jumped off the sinking ship.
There's over almost 11 and a half people, 11,500 people less in this industry in Tennessee than there was back in 2007. That's good and bad. Fewer licensees out there, greater probability you can sell a house, you can make some money. Because there's not as many of you out there trying to chase the few sales that are out there. But anyway, just remember that. It's there's good in everything.
That's if you go to the additional statistics, you can see some additional numbers from years past and the number of licensees, total number of licensees that we had at that point. Like on 1/31 of 2008, we had 47,485 licensees. And even on 2/5 of 99, we had 37,021. So at this point, we have fewer than we had in 1999. So it's interesting to watch those statistics and see. But as I've said every month for the last few, our drop-off is less and less every month. So it has leveled out quite a bit over the last few months. You can see that if you go to the additional statistics on page 3, that this month in January we had 311 exams that were taken, and in January of 2013 there were 264. So the number of exams taken has increased. Our number of applications approved in January of this year was 200, which is less than last year, which was 244. And then if you drop on down to 2007, you look at the testing and the licenses approved, and we're way down from January of 2007 when there were 830 applications, licenses approved and issued, and 489 exams, 782 exams taken. So the decrease is pretty significant from those years.
Ms. Maxwell, is
yes.
the test that much harder now?
I don't think the test is that much harder. I just don't
mean,
think
just
there's-
looks like a lot of people not passing it now.
Well, these are actually exams taken. Are you looking at the? These are exams taken. So it's
Like
just that they're-
311 were taken, and we've only had 200.
Well, right, but you
applicants.
have that 6-month
Well, that's
period
true.
to turn in your application. So a lot of people take the exam and wait at some point during that. Some people wait till the very last moment and come racing to our office.
So we don't know how many of the 311 actually passed.
Right, so it doesn't, so that doesn't, well, we do know how many passed it, but what we don't know is, like, the 311 who, and I do have let's see, I have the past statistics. I don't know if I have them in one of my folders. Just like some people are going to wait that 6 months.
Yeah.
And this is who took it from January the 1st to January, actually I did this on the 29th, so it was through January 29th. So some of those people may not even apply until, February, March, or April. And
Well, I
so-
just wondered if that many
Yeah.
people were failing it. It looked like it.
No, our pass-fail rate is about the same
Okay.
as it's always been. They try to maintain a certain level of, pass-fail.
I know they encourage us to make it harder every time we go for that little.
And they just rolled out a new one, February the 1st, right? Like a new national, not just for us, but for everyone as far as the national test goes. And then our state test was
Well,
revamped.
there were some changes on the national level.
Right, and so they, that just started February the 1st. And we haven't had any reports. I don't know whether it's good, bad, or indifferent, those changes. I don't know. So that's, but you wish you kind of had a one-for-one
Yeah.
correlation, but we don't have that statistic. But maybe we could get it. Are there, and then there are other statistics. Are there any questions about any of the statistics? If not, we can move on to.
I always find that interesting to look at, and I know it's not something you can do in 3 minutes, so I do appreciate you putting that together.
Yeah, I think it's sort of good to have all those numbers to look sort of from a historical standpoint. At least I enjoy it. If there are no questions on the licensing statistics, the next thing on the agenda is fingerprint questions and clarification. And this is, I'll read you a couple of facts about the fingerprints so far and then go into a little bit of what our questions and concerns were. This is as of yesterday, 2/4 of 2014. The number of applicants who've been fingerprinted between 1/1 and 1/1 of this year and 2/4 of this year is 342. The number of reports that have come back with an indication, which just means there's something that showed up on the report that might be of interest to us, that it wasn't just a clean report, is 73. The number of reports with no indication is 269, and the number of report that had no reads on the prints, which means people had to go back and have the prints done a second time, which they can have done for free in the first 60 days after that, was 8. So, there are quite a few people who've been fingerprinted. Some people are doing it before the test, some after. So, that's not indicative either of how many people are going to test or apply. But we have noticed, I guess, more than we thought we were going to have. There are a number of people who have been fingerprinted, and their fingerprints came back showing an indication. And on their application, on question 5, they answered no. And the question 5 is, have you ever pled guilty, pled nolo, or been convicted of a criminal offense? Do not include traffic violations. Julie and I have talked about it, and the legal department thought that the best thing to do was ask the commission for a clarification on how we should handle these, on a day-to-day basis so everyone's treated consistently. Some of the people who have answered no to question 5 have had what maybe a DUI reduced to reckless driving, and those we can see how maybe they got confused on that question. Other people have had implied consent violations, possession of drugs, like a small amount of drugs, a misdemeanor, underage drinking, public intox, things of that nature that had they disclosed them would not preclude them from getting a license. And we just wanted to know so that we know how to handle them. If the person answers no on the question 5, on the answers that they do when they take the exam, yet their information comes back with something, how do you all want us to handle those people since there was not a truthful answer on the front end?
Is there anything specifically in the rules that address that, Julie?
Well, it would just be about
303. Yeah.
Within 6213-303, the first subsection A1, which is the reason why we have people like the gentleman that was just here come before you all for a determination. It says licenses shall be granted only to persons who bear a good reputation for honesty, trustworthiness, integrity, and competence to transact the business of broker, affiliate broker, or timeshare salesperson in a manner to safeguard the interest of the public, and only after satisfactory proof of such qualifications has been presented to the commission. No license shall be denied any person because of race, color, religion, sex, or national origin. So I guess the question would be, even though many of the ones we've seen would fall under categories of offenses that if they had said yes, we wouldn't have brought them before you all if they had a DUI 5 years ago or, something like that. It wouldn't have been something egregious enough to have brought them in before you all. The question would become, do you all consider that an indication of the honesty of that person if their answer on the paperwork is no, yet there is an offense in the background, however mild it may be?
Isn't it also possible that that was not a dishonest response, but they asked their broker, and the broker said, oh, no, it doesn't mean you had a DUI that was dismissed. It means convictions. Isn't that a possibility?
Well, and these would be people that did have convictions or did plead guilty to it, not dismissals. If it would be a dismissal, then they can answer no. It's just that we've had some come back with convictions for like implied consent laws. And I know for one example, someone had applied and had a conviction for, was it DUI? DUI, I believe, and they had answered no, and that person's response, because I think it was the first one we received, was, well, I thought that was a traffic violation. But there are some, like the implied consent or perhaps a misdemeanor drug charge, that it would be very difficult, I would believe, to argue you misunderstood the question. The problem,
I guess my concern about it is kind of a two-edged sword. If we say, no, we won't, they were dishonest and they need to go through the process, then already we're looking at 73. We're going to have to sit here and go, okay, you can have your license now. Because we're not going to deny them their license because they were stupid when they were 18 and now they're 50 years old and they had a drug charge, 35 years ago. So I have an issue with them being dishonest on the application, but there again, I don't know that I want to sit here and listen. I mean, it's like that poor guy that got arrested for rocks.
well,
And
there would be, I think, a differentiation between someone that maybe had a DUI or a misdemeanor drug charge that was maybe 20 years ago, and maybe they forgot in that circumstance. And of course, we would certainly bring someone before you all if they had a felony they would come regardless for a felony. But if they failed to disclose something that we would normally have them come up here before you all for, they would come anyway. This is just in instances of matters that,
Really,
had they
yeah.
said yes, wouldn't have really affected.
I'm willing to make a motion to give you ladies the discretion to know which ones need to come before us and be able to go ahead and move them forward if it's something that would not have
Okay.
been denied license for anyway.
Right, and the ones that would come before, like if it's a felony, that, as Julie said, if it's a felony they didn't disclose, or if they had larceny, we would bring them before the commission anyway, because that falls under the items that you all would like to come before you. Our question, it really is, what concerns us is the people who do have things that if they had just said yes, they wouldn't. It would not have precluded them from having a license, nor would they have been brought before the commission because it was, like DUI or minor drug, less than an ounce of marijuana, things of that nature.
Feel better if they answered it correctly and said yes and then made an explanation of it.
And we've gone back to the people and asked each one of them just to write an explanation. Sometimes they don't have. We're only interested in convictions, and if you've seen any of the reports, which I know you have in the past, ours look a little different that we get into the office now, but they, lots of times there's not a disposition. So we've had to go back to some of the people anyway to find the disposition of the charge, because you just see charge literal, and then you don't ever see anything that happened with the charge. So we've gone back to those people to clarify that. And then, if it turned out it was a conviction, then we've gotten a further clarification. But we just don't, because they answered no, it's just because they answered no and they were dishonest on the front end, but it's not a major offense. We just wanted to know how, before we gave them a license, how we should proceed in those regard.
Basically, whether you all want them to come before you, or whether you believe if it was something that was not egregious enough to have come before you anyway, is that something that you would rather us just go ahead and say, okay, and not have them come before you? That's
I would second Janet's motion that we give you all that leeway to make those determinations.
So then, in saying that, you're saying if it's something that they would have been okay with anyway, then to go ahead and approve them?
Yeah, just do what you, you're handling it fine the way you're doing it, and I think just go ahead and do it that way, and if they should have come before us, then bring them.
To put this into the record and to give staff direction as to how to handle these type of issues, we have a motion on the floor by Commissioner DeShara, and would you repeat your motion?
That Ms. Maxwell and Ms. Crop have the discretion to review those cases on a case-by-case basis, and if it's something that would not have had to come before us anyway, just to move forward with it.
And this motion by Commissioner DeShara has been seconded by Commissioner Franks. Is there any discussion on this motion?
I still don't understand why we couldn't make them say yes or no and explain it and let them make that decision. Well, if they say, no, I haven't had anything, and they have, it's going to come back to bite us from somebody else maybe.
Well, but they're doing that. They're getting explanations from them.
We are. We're going back and asking them.
Oh, okay.
Saying
I'm sorry.
that you answered no on your, on the sheet when you took the exam and the report. The reports we can't show to anybody. They have to stay internal to our office. But, we say on such and such a date, it says that you were convicted of whatever it was or pled guilty. And so we do that and give them an opportunity to tell us. And if there's any doubt remaining, we make them get the court paperwork. But it's just a matter of then the very basic tenet that they lied on the front end.
Any other discussion on the motion?
And then this all goes to their principal broker so that the principal broker can decide whether they want to oversee this person then too, right?
No, the broker doesn't know it.
The broker knows what they answered on the, on their sheet that they signed, their application, as it were. But the report isn't released to anyone but us. As I said, we can't even give it to the individual. The TBI, it's just, the TBI will only let it be seen by us internally. But I guess we could send I'm thinking maybe we could draft a letter that sort of just points out to the person that you've answered no and this, and then I guess we could send a copy of that once we get some sort of clarification. If it was, get the disposition of it, then we could send it to the principal broker so they'd have a copy of it.
I
That
would
probably
just,
be-
as a principal broker, hate to not know that, have that knowledge of a person I'm overseeing and that the
Right.
commission did.
I mean, I think we could send a copy of some sort of a letter to the principal broker that we send to the person, and then that way they would at least, as you say, could make a decision
Yeah.
going forward. Okay.
Any other discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Commissioner, could I ask a question?
Yes, sir.
Ms. Maxwell?
Yes.
Would it help, I mean, we've got 73 pieces of correspondence you're going to send out.
Well, it's not, all 73 were not people who answered. The 73 were the number of reports total that came back with an indication that they had something. Some of those people disclosed that they had something, so some of the people had actually disclosed it. We were just concerned about the ones who didn't disclose it, and it came back with an indication.
Which is only part of that
Right,
number.
which is only
Okay,
part of
but-
that number.
But would it make sense for us to consider changing the verbiage in question number 5?
Well, it actually had been changed, and it somehow reverted back to its former self. And so as of February 1, the handbook was redone in anticipation of the release of the new exam. It has been changed back to the way it was supposed to read, that says, include traffic offenses that involve drugs and alcohol.
Okay.
So it's been clarified now, the way it, as I say, it was, at one point appeared that way. Is that correct, Steve?
That is correct. There's an actual special note that we put in there that kind of clarifies this issue. Because at first blush, if someone is kind of nervous about the whole application process, they could get nervous and mark no when really there is a yes. And this note kind of clarifies any confusion.
So the question, as it's currently asked, if the answer is provided truthfully, would require disclosure of more things than would actually result in somebody having to come up and have a hearing before the board. Is that right? And under either the old language or the new language you're talking about? Okay.
Anybody have any other questions of Ms. Maxwell concerning fingerprint questions or clarification? If not, it is right now about it's 5 after 10. Why don't we take about a 10-minute break? I use Grover Collins as my signal when he has to. when
We can't have two.
in the session, and Ms. Maxwell is in the middle of her report, and she can continue on.
The next item on the agenda is the complaint process, and Commissioner Bloom had a couple of questions during the course of the last month over how TREC determines who will be the complainant in a complaint that's filed. And then if it's filed by an it was kind of a two-pronged question. If it's filed by an organization, is the organization named, and then the individual who filed it? So that was why this was on the agenda. And first, I'll just address how TREC determines who is the complainant, generally speaking. The complaint is opened in the name of a complainant if the complainant can be identified. And if it can't be identified and it comes in totally anonymously with the plain white envelope and nothing that identifies the person whatsoever, it will be opened anonymously. It will be opened as a TREC complaint if it's a failure to supervise complaint, or if the commission has asked us to open a complaint. Sometime in the middle of last year, I believe that we had a couple of complaints that were TREC complaints, and we were asked by the commission why we had opened them in TREC's name. And as I say, they were failure to supervise, and a lot of our TREC open complaints are failure to supervise as it relates to the timeshares, because every time a timeshare complaint is sent in, we open a failure to supervise against the principal broker. So those are kind of the guidelines that we use to open complaints. Everything that comes into our office is a public record, And so we can't take individuals' names off or identifying information off of information that's received into our office. So that, if some people have tried to send in what they think is an anonymous complaint, but in their email address you can see who it is. And so, yeah, in the fax or something, so you, that destroys any anonymity that might have. And the commission has found that anonymous complaints are difficult to follow through with, as has the litigation department, because you don't really have anyone to testify but someone from TREC. And we are not as familiar with the facts and circumstances as would be the person who actually filed the complaint. In the specific instance that Commissioner Bloom had a question about, there was a person who sent in some information, it was on advertising, sent in twice some information about a specific person, and the complaint was opened in the name of that person. That person is affiliated with an organization, and it was opened in the name of that person, and the person had preferred that it not be opened in their name. And I think that Commissioner Bloom just wanted to discuss it and see what, see what the feeling of the commission was. Is that correct?
Yes, ma'am. I really understand the premise that if somebody files a complaint, they ought to be willing to stand up and say, this is my problem with that individual. But if you were to take, for example, let's say it was a person who was the executive officer of a local board, say the Memphis Area Association of Realtors, that person is not going to file any complaint against any member because their name would be charged against a member of the organization that they have the responsibility for providing care for. So is there a possibility that some common ground could be reached so that complaints that need to be made on behalf of the public can be made without jeopardizing the position of an EO of an organization that has the responsibility of, we don't get any complaints from an EO of the Williamson County Board. Why would that person do that? Jeopardize their job.
They don't do anything wrong in Williamson County.
Well,
Amen.
I use the for example.
I agree, Gary, that there needs to be some kind of middle ground probably, because even not just EOs, but in our area, it's such a rural, close group. You're talking 300 agents in 7 counties. And, you file a complaint against somebody else and your name's mud, and then it really becomes an issue to have to deal with. So I can see some validity to it too, because people are out there doing the wrong thing and nobody will file a complaint because they don't want anybody else to know that they've been the one to bring the axe down.
Unfortunately, like she said, we can't take names off of complaints because they're open records. If somebody comes in, we can't scrub complaints of certain information. I think that individual would just be left to have to file an anonymous complaint. And, because we can't remove that information.
Which we discourage anonymous.
Because oftentimes what we've experienced with anonymous complaints are people don't give us very much information. Now, sometimes we get anonymous complaints that on their face, it's like a picture of a sign that's dated. Now, unfortunately, we don't have anybody that can go out and confirm when it was taken, where it was taken. That's a problem with that. But sometimes, it might relate to something where, even though it's anonymous, you could provide the documentation that on its face supports it. I still think there might be, some issues there with not having an identified complainant, but the way it has always been told to me and Ms. Maxwell as well is we can't alter a complaint that comes in.
I don't know that they need to be altered, but I'm not sure anonymous complaints need to just be shoveled under the door. Of course, I understand if you don't have enough information, you can't do anything about it. But maybe we need to relay some way that if they're filing a complaint anonymously, they've got to give enough pertinent facts to be able to do something with.
Right, and there have been times where we've had anonymous complaints that, and I think one was presented maybe a month or so ago, where it was an issue with a sign somewhere, and we were able to send an investigator because this person had provided enough information. Sometimes, though, they are just such bare bones, we really don't have enough to even go off of. So yes, something to the effect where if they could give us enough information to either proceed with what we have or investigate it further, then yeah, we can certainly do stuff with it, but we can only work with what we're given when it's an anonymous person that we can't contact and say, hey, what about this? So
My problem with anonymous complaints, most of the time it's from a jealous agent in your community or somebody that the jealous agent's told a friend to file a complaint, and we end up tarnishing a realtor who, he's the public too, and he spends several $1,000s defending his honor for something that wasn't worthwhile. And if somebody really truly wants to complain about something, I think they ought to have the decency to sign their name personally. I know that's not the way we go by it, but that's the way I feel.
I have one question to staff. What do you think we need to do? What's your suggestion?
I mean, I can't suggest that we change our process. I mean,
Okay.
we can try to educate people to say, if you are going to file an anonymous complaint, please be sure to provide as much documentation as possible, as it is, difficult to proceed on these matters without adequate information. But beyond that, I don't see how we can change how we open complaints.
Are they told that when they call, Julie?
Most don't call, do they? I don't deal with them usually
Yeah,
at
I
that
mean,
point, so I'm not sure.
What do
I
they do?
I don't know that really, well, I mean, I don't know the anonymous people. I guess if they call, they don't tell Connell who they are. Or but he would, we always tell people that you need to send in all the documentation that you have. If it's a sign, you got to have a date, location, things of that nature, so that we can actually know the incident that the person is talking about. I mean, we do honestly get just ads that are sent in, just pieces of newspaper, and sometimes
Not even telling us what
right. And
they
sometimes
see.
we look at it we look at it and we have no idea what the violation is. I mean, honestly, we don't know. We don't even know the date of the publication. So, they are told when they call in to have as much information as they can, all the supporting documentation. And, if someone files a complaint with their name on it and we need that, then we have a letter that we send out and, say you need to send some supporting documentation, like a lease agreement or a sales agreement, things of that nature. And I think in litigation, they run into a problem, Robin does, when there's not an identified complainant, because as I say, we don't have anyone really to testify as to what the complaint was about. All we can do is just say, well, yeah, this came into our office. We don't have the person who took the picture.
Right. It's hard to authenticate the documents
Right.
that are sent in sometimes.
We have an instance in our area that is happening where one of the companies is advertising this: if I don't sell your house in 90 days, I'll buy it. And that's what they say on the radio. I have not personally heard the ad, but then they go on to say some other things about other agents and everything else. I have gotten more phone calls about that ad on the radio. Every time somebody calls me, I tell them, file a complaint. And they're like, well, I can't file a complaint because he'll know I did it, and then it'll be a problem. And because it's one of the most, probably got more money than anybody in town, and you got real problems if you stir up a stink with them. We have got to be able to put a stop to some of this without penalizing agents who are doing the right thing, because there are agents who are not doing the right thing, and you can't afford to go up against them. I mean, it's like fighting a war with a bank or something. They've got a lot more money than you do, and you can't fight that battle that way, but yet they're out here doing something wrong. Like I said at the commission meeting last month, I'm running an ad that says, I'll sell your house in 90 days or I'll buy it. The commission comes in, sends me a letter and says, you can't do this. I keep running the ad because I've gotten 50 listings off that ad, and the commission's just going, you can't do that. Well, who cares? I mean, it's not costing them anything if they get a letter that says you've got to stop, because they're going to keep doing it. And we've got to have some way to police that makes it effective, and we've got to make the penalties large enough that people will stop. Yeah, I
So
know
that's
that,
something that would have to be
but
changed.
most of them have more than one violation in them.
Right, I mean, you've got the continuing violation, the day-by-day violation. Right, that we would have to prove, of course, and someone would have to substantiate it, I would assume. And I think that if someone's going to file an anonymous complaint, if they do, as Julie says, gather up as all the, as much information as they can get, say that ad, if they could gather up, I don't know that we would ever hear it. I mean, if you've never heard it, I don't know that we would ever hear it. Gather up whether it's the written text of it, whether it's on YouTube, and, they have that text underneath it, somehow so that we would have a timestamp, basically, copy of that.
Something to go off of it, maybe to have an investigation of it, just sometimes we literally don't have enough to
Right.
go on. And
Right.
I mean, it's always been the standard operating procedure of this commission that we investigate any and all complaints that come in here, even if they're anonymous. I mean, you aren't asking that we change that policy, are you?
We open every complaint.
That's what I'm saying, you open them
The
all.
only complaints we would not open would be one over which we have no
Right.
that it really is a consumer, it's totally landlord tenant, or it's totally contractors, that it's not, we have no jurisdiction whatsoever over it, like, no doubt.
Something about an auction or something like that, it's no jurisdiction here. You send it to auctioneer commission or send it to Consumer Affairs or wherever it should go.
Right.
But, I mean,
We need something like a Crime Stoppers.
I guess I'm a little
Call it an
confused.
anonymous hotline.
I guess I'm a little
Yeah, that-
confused as to this discussion as far as, are you asking for direction from the commission, or?
Well,
I mean, just like Commissioner Bloom, as far as,
Right,
anonymous
Commissioner Bloom just
complaint.
had brought it up, and I think just sort of an explanation of how it's determined that we open it. I mean, we have to, the anonymous complaint policy basically is set by the, by Commerce and Insurance, by
Yeah.
regulatory boards. So
Yes.
that's followed by all the agencies, and so is the standard operating procedure that we follow. I think really if someone sends an anonymous complaint, really the key is that they have enough information in there that you do have a time and a place and some way for us to actually verify it and make sure. Otherwise, it just goes on, and if it gets to litigation, it's not going to get any.
How much additional work is involved in an anonymous complaint?
depends. I mean, sometimes, we only have what we have to go off of. Sometimes I can research around and find more. Sometimes it involves making an investigation request through the investigations division, which can be rather costly and generally is only done when I am given enough information where I think that the investigator can reasonably come back with something. We don't have TREC investigators that I can just go to their office and hand it over to them. And sometimes there's just not enough to where even if we did, they would necessarily be able to find it because, sometimes it could be an advertisement that somebody's copied and pasted into an online complaint and we have no clue where it was from, when it was from, and that would just be something that...
When it's something like this, you don't have a clue what it is or what it's about. What do you do with it? Throw it in the garbage?
Oh, they're opened and we do the best we can to get as much information as we can. They're presented on here, but, sometimes it's just something where we don't have enough. Sometimes we can get enough.
On an annual basis, how many anonymous complaints do you think you might get, Ms. Maxwell? Roughly. Just
Trying to think if that's on.
if we average 30 a month, how many of those are anonymous?
Just checking her
Well,
statistics.
I'm trying to see I'm trying to see if if that's in here. I can't really say that it is in here. I would say that, it sort of varies. Sometimes we'll get 10 a month, and it's mainly advertising. Some are just a piece of paper that someone sent in to us. And then some months we won't get any, some will get one. It really varies because they seem to come in little clumps for whatever reasons they do. And so it just varies and it varies how much information we get too. And you know, some people, we had one person who filed anonymously, and they set up their own little email account that was, I'm mad about.
concerned you
Yeah,
should
I'm
be
concerned you should be too, was the name of their email. And so they filed complaints and followed up, and we don't, I mean, we have no idea who it was, and, you know, that, but, and people do that. We had someone else who did that as well. I think the key really is if there's enough information to go forward. And really, we were just explaining how the complainants are named. I don't know that we have a lot of leeway in the way we open complaints
Okay.
because there's
Now,
a protocol.
Does anybody have any other comments or questions or discussion pertaining anonymous complaints, this complaint process? Commissioner
Yeah.
Bloom?
Yes, sir. Mr. Chairman, I wasn't interested in changing any of that. What I was interested in investigating is if there's any possibility that people who probably know more about inaccurate actions on the part of realtors, we could encourage them to file a complaint, like the EO of the Williamson County Board. She or he, whoever that is, will never file a complaint if it's against one of their members because they're going to lose their job. And we make it a requirement that if they file a complaint, they give it, well, we don't make a requirement, but we don't want it to be anonymous. We want it to have their name. And if I was the EO of the Williamson County Board, I wouldn't want to do it either.
I mean, they can file an anonymous complaint
Which,
and send it in,
which,
and they'll open it.
okay, but if that amounted to a hearing, who would then represent the Williamson County Board?
Against the individual. It's against the individual licensee. I mean, the Williamson County Board would never come into
They'd be
play.
the complainant, though, wouldn't they?
Well, but we
But we wouldn't
if they
know.
filed
No, you would not
anonymously,
know.
we
It'd be
would
it'd be an
never
anonymous
know.
complaint.
Right.
So it would really
Nobody'd ever
be-
know.
It would be up to us to see if we could get enough information to where we could proceed anyhow in the absence of a complainant.
So we encourage them to do that in an anonymous format.
Right, but, and I think one thing that we can bring up with our seminars, which start
Yeah.
next week, is that just tell people, generally licensees who attend, that if you are going to file an anonymous complaint, make sure that you include as much information as you can. Now, sometimes if it involves a transaction, their name is probably going to be on the papers somewhere, if it, you know, if they're going to file all the agreements, and that's going to be a more difficult situation, I think, to file an anonymous complaint in, because it's a transaction. But if it's an advertising complaint, which is where we really do get the bulk of the anonymous complaints, then I think that we just need to make sure that everyone knows that you just need to send us as much information as you possibly have that shows dates, so that we then can relate it back and, you know, try to investigate it as much as we can.
Without your name and not on behalf of my organization.
Right, and it has to be like, and you know, when anonymous, I mean, honestly, I am talking a plain white envelope that has no return address. I mean, we get these and they have not a shred of, sometimes our address is listed as the return address. So, I mean, it just is really it's on a plain white piece of paper typed that in some type font that's not recognizable, so it's.
Sometimes they fill this complaint out and they mail it to their cousin in Florida, and it gets mailed from Florida, so they don't have a clue where it comes from.
Can't do anything with just the city and state.
I
So
know.
usually we do at least
I'm
have
just
that to
joking.
go by.
Is there anything else about this complaint process? Anybody have any other questions, comments, discussion? Well, I think all of this has led that we're going to continue as we have been with our process.
But we'll just try to make sure people.
Yeah, educate them as you-
Seminars
yeah,
educate people, and if people
right.
ask you all, then I think that's probably the best thing to tell them, like in your instance, Janet.
If you do
just-
feel like you need to
Yeah.
file an anonymous complaint, we need to have as much, at least documentation as possible. If you're not willing to put your name on there, we need to have as much information as we can.
Well, that's what I tell them, but obviously, nobody's filed the complaint yet, so.
It's called intimidation.
Yeah, it is.
Okay, continue on, Ms. Maxwell.
Bullying is the new word.
The next thing on the agenda is the timeshare overview, and we've had a number of questions from all the commissioners about timeshares and how they work, because we have a number of complaints, usually on the complaint report, about timeshares. And I think it might be better to wait till the other three commissioners are here, so everyone can sort of be updated about timeshares and the process and the overview of how they work, since we do have so many complaints that are involving timeshares. So I would ask the commission to defer that till March, if that would be
Would somebody
acceptable.
like to make a motion, we defer?
I will
timeshare?
make the motion, we defer that topic until next month.
Commissioner DeSharis made a motion, we defer the timeshare overview part of our report by Ms. Maxwell to next month, and it's been seconded by Commissioner McMullen. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. We'll talk about this next month.
The next item is the budget, which you all have on your iPads, and I sent it to you all on Friday, I believe. And I didn't know if there were any questions about the budget. It has the amount of, revenue and expenditures, and it's the December 2013. You can see that year-to-date, our total amount of revenue has been $1,074,797.87. And that's increased every month. And then there's a list of the individuals who paid consent orders, and this was as of December of 2013. And as I say, I'll just include it every month. They've asked us to do it in the administration, and I believe that probably every quarter, Assistant Commissioner Giannini and Kimberly Whaley will come down and answer any specific questions that, or detailed questions that the commission might have. But does anyone have any other questions? If not, then just a quick update on the testing RFP. As you remember, we talked about it we talked about it a little bit last month, but we also talked about it in October. We've seen a rough draft of it. Julie and I have. It's making its way up to the contract administration individuals who have to review it further. They anticipate that it'll be let around the middle of February, probably around the 18th or so of February. And what they do is they just post it on the website, on a website that contractors or vendors would go to, and they see that it's out there. And if they want to submit a bid, then all those specifications are set forth. Once it's once it's put up on the website, it's usually about 42 to 45 days before a decision is made. And if it's in February, the end of February, that'll give us plenty of time before our old contract expires, which is at the end of June of this year. And we'll see who, bids on it and how that goes. And so that's the testing RFP. The E&O update is the next item of business. And right now we have 55 people who are uninsured. 25 were cleared yesterday. It was a firm that had a firm policy, and they sent it in yesterday. So 25 of the 55 have been taken off, and then the other 30, Betsy's in the process of sending letters to them suspending their licenses. So you can see, if you look on page 2 of the E&O update, that we had 488 people who were suspended, and of that, 203 were affiliate brokers, 17 brokers. Principal brokers have dropped to 14, and that's because we had 4 PBs that expired and 2 that paid the penalty fee. And we have 254 timeshare sales people. The bulk of the people who right now are uninsured were in a broker release status prior to being put in a suspended status. So I don't know whether the bulk of those people will just let their licenses expire. The penalty fee, if you were suspended July 1st, which is when the largest number of individuals were suspended, the penalty fee began to increase by $100 a month on December the 1st. And so so now every 30 days it's going up $100. They already owed $500 for the first months, for the first 120 days. And so now it's going up to $100 a month, and it'll cap out at $1,100, and their licenses will be revoked on June 30th or July the 1st, at the end of a year. And so time will tell how many of these individuals actually end up with their licenses revoked pursuant to the E&O statute. Are there any questions about that? Okay. And just a quick update, it's not on here, but just a quick update on Arello. Steve and I submitted the request and justification Friday, and when I took it up there, Linda Goodwin said that the travel policy includes not only monetary limitations, but people limitations, and as we've been
If I could interrupt you right here, Ms. Maxwell. I'm sure most of you licensees out there don't have a clue what Arello is. We're talking about Arello. Arello is ARELLO, the Association of Real Estate Licensed Law Officials. There are a real estate commission in all 50 states, plus the District of Columbia, plus the 11 Canadian provinces, each one of them, which is a state. Canada's divided up into 11 provinces, aka 11 states, and they have a real estate commission. And then there's about 45 foreign countries that's members of this organization called Arello. And all of us that are on the commissions in all 50 states are members of Arello. And I think the dues are like $400 a year for each one of us to be a member of this organization. And there's anywhere between 5 and 9 commissioners in every state. There's an odd number, so you won't have a tie vote, theoretically. But we're talking about Arello, Ms. Maxwell is, and we have a couple of conferences each year. We're in 2 regions and have an annual conference every year, and it's really good information for not only commissioners but staff members who go to these conferences and learn about the industry and new things that are happening, and it's very, very informative, and that's what Ms. Maxwell is talking about. I just wanted to explain all of you who may not have a clue what Arello is. Now you know. Continue on, Ms. Maxwell.
Anyway, so there is, as I say, both a dollar and a person limit that can be approved within our building here. And if you go over the dollar or the person limit, it has to go all the way up the hill. The person limit is 4, and the dollar limit is some amount over what we're asking for. It's not specified exactly, at least not in the travel policy. I asked Linda if it was possible if she could let us know before the meeting. I haven't heard yet, whether Commissioner Giannini Assistant Commissioner Giannini will tell us that we have to start, from scratch just right here, or whether he'll let it go on up to Deputy Commissioner Myshak, who then would make a determination, I think, whether he would send it back down for us to take someone off or would let it go on up the hill. So anyway, if I hear something this afternoon or tomorrow, I'll bring it back to the commission and let you know. I just wanted to let you know that I'm not exactly sure if it'll be approved as it is.
Didn't Commissioner Giannini tell us there was not a person limit? That as long as we could justify that it was proper to do so?
I think that he said that we could submit as many names as we thought it would benefit, and we could justify. And so I wrote a justification. I mean, I wrote a justification, a strong justification for the attendance, but I just wanted to sort of warn everyone that might be the case. And I won't. Hopefully, I'll know something before the meeting's over so that we can go on, because it has to be 60 days. It needs to be up there 60 days prior, and that'll be the 9th of this month.
I was going to say, we're getting close to our 60 days.
That's why I was hoping we'd get it back, and if we needed to make an adjustment, we could do it before it went all the way up and then had to come back down. I mean, it may be approved, but she didn't sound that hopeful. Anyway, just to update you on that. And unless there are any questions, I think that concludes my report.
Anybody have any questions or comments or things they'd like to ask our executive director? Not just random things. Yeah, where'd you?
Let's just ask her random stuff today.
Yeah, where'd?
See how on the ball she is.
Yeah, what'd you have for dinner last night, Miss Maxwell? A lot of you out there don't realize it, but Miss Maxwell, who is executive director of the Tennessee Real Estate Commission, it was hired in '07, I think. Best thing, probably the best decision that I have ever made or was involved in being on this commission for the last 9.5 years was the day that we voted to hire Miss Maxwell as our executive director back in '07. She's also an attorney and is very knowledgeable and is doing a wonderful job being the executive director of this real estate commission. We're so fortunate to have somebody of her quality and her education and her knowledge to be the executive director of the Tennessee Real Estate Commission, of which your license is with, all of you that are here with a real estate license. Anyway, anybody have any other comments or questions of Ms. Maxwell? If not, I would like to, if it's okay with the commission, since we have a little bit of time before we get to our lunch break, I'm going to see if our education director, Mr. Steve McDonald, should happen to be ready with his report.
Yes, sir.
Okay, Mr. McDonald, you have the floor with your education report.
Someone with such esteem as Director Maxwell, it's very hard to follow.
This
Footsteps.
That's why you like going after lunch, right? So you only are following lunch.
Exactly. But I do have my report ready, Commissioners. We do, at the request of the Commission last fall, the Attorney General is sending Matt Pulley here today at 1 o'clock. He is going to be discussing the reverse mortgage. He is the mortgage settlement coordinator for the Attorney General. And I have some information here that I'll pass out at lunch when he gets here. And on your emails, when you get back to your office or your home, I've sent you his PowerPoint. If he does bring his PowerPoint, but I've sent the PowerPoint that he uses, so you'll have it for forever and ever. There are some items on the education report that have been moved for discussion, namely items F19 and F20. They deal with the reverse mortgage, so I just want to give you that warning before we hear from Mr. Pulley that those have been moved again to this education report, and I think you wanted to hear from him before you decided on the future of those courses.
I'll make a motion that we move F19 and F20 until after the discussion this afternoon.
Second.
Have a motion to move taking action on F19 and F20, which I think probably stands for February 19 and February 20.
F absolutely stands for February.
I mean, I am from East Tennessee, but I think I figured that one out. Well, F19 and F20, motion been made by Commissioner DeShar and seconded by Commissioner Franks that we defer taking action on those two until after we hear the report that's going to be given to us by Matt Poole, who is AG Officer's Mortgage Settlement Coordinator. We're going to be talking about reverse mortgages. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Okay, Commission, before you have 18 courses that have been reviewed. They seem to comply with the rule and the direction of the Commission. Do you have any questions about these courses?
Motion to approve.
Second.
I have a motion by Commissioner Collins that we approve courses F1 through F18, and second by Commissioner DeShara. Are there any comments or any discussion on any of these courses? F1 through F18. Hearing none, all in favor say aye.
Aye.
Opposed, no. Courses are approved.
McMullen abstains on F1.
Let the record show that Commissioner McMullen abstains on course F1.
Wonder if he's got a problem with that, one of those instructors.
I think it is the instructor that's the issue there. You know him a little too personally, Austin?
Yeah, he's
I'm not going to respond to that.
spoken like a good attorney. I have no comment.
There is one course that's listed as F21 for discussion. It wasn't a discussion of concern. It was more of, this course was the first that had been submitted to the commission for review. It was titled Virtual Offices. It's a paper pencil course. It's presented by Dearborn. That's who the publisher is. I felt that the course had good information, but I wanted to get some feedback from the commissioner. So Commissioner DeChara was she was willing to review it. So I mailed the booklet to her. And do you have anything that you'd like to add?
Well, as we've discussed on this commission, virtual brokerages are here, and we can't continue to ignore them. I felt like there was some good course material in this book, and it doesn't look like it would be 4 hours, but it's very fine print. It's not like it's jumbo print. So I feel like that is, you want to read it?
No.
No pictures.
No pictures.
But it does have some good information in there, and I feel like it's a worthwhile course.
I was just, as I was reading the topic of the course, says this paper pencil course is written by a Dearborn. I was just curious as to what a Dearborn was.
It's a deer that's born in Michigan.
A deer that's born in Michigan, huh?
That helps to proofread. Thank you.
Like a deer bear.
Bear, you might want to take a look at this book, because it's all about technology and wikis and social media and some things that you would find very interesting.
I need to take that course, I think.
And it is paper and pencil, so.
I know it.
He could read about it. Whether he could do it or not, it's another story.
Y'all are out of order.
No, we're not.
Does anybody like to make a motion as to the disposition of F21 about the virtual offices?
Move to approve.
No, we haven't had a motion on this one. You have a motion by Commissioner Franks to approve. Do I hear a second?
I'll second it.
Commissioner DeShara seconds. Any discussion? Are there any more comments? Hearing none. All in favor say aye.
Aye.
Opposed, no. Course is approved.
Okay, thank you. Moving on to the next item of business in the education report is the instructor approvals. We have 4 before you. We've got 4 providers asking for instructors before you. Candy Joyce of MTAR, that's provider 1141, requests the approval of Rhonda Dawson. Her license number is 222929 to teach the 2013-2016 NAR Code of Ethics. That's course number 7249. And the Code of Ethics new member orientation, course number 5258. Rhonda is a previously approved instructor with the Real Estate Commission. Number 2, Tina Marshall of Wells Fargo Home Mortgage is provider 1516. She requests the approval of Linda Corbin to teach renovation financing, approved course 6702. Linda has 17 years in renovation financing experience. She's been with Wells Fargo since 2002 and was a former certified real estate continuing education instructor in the state of Rhode Island. Number 3, Dottie Oslin of Trees, provider 1032, requests the approval of Brenda Brewster, licensee 274139, and Harold Lucky, license 258812, to teach the following courses for Trees: the Basic Principles of Real Estate, 1627, Course for New Affiliates, 1571, Office Broker Management, 335, Effective Buyer Representation, 2395, and Senior Housing Specialist, 3872. Brenda and Harold are both pre-approved instructors with TREC and both hold broker licenses with no open complaints. Lastly, Sally Cummings of TAR, provider 1110, requests approval of Monica Neubauer, licensee 285136, to be approved to teach real estate market reboot, approved course 6396. Monica, of course, is a previously approved instructor with the commission.
Laughing at this real estate market reboot.
That Reebok class by NAR.
I make a motion we approve these instructors.
Second.
I have a motion by Commissioner DeShara that we approve these instructors that have been presented February of 2014, and seconded by Commissioner Franks. Any discussion on the motion? All in favor say aye.
Aye.
Opposed, no. Instructors are approved.
Chairman, if I could, just address the commission that next week we will start our seminars. So Ms. Kropp and Ms. Maxwell and I will be going to Mount Juliet. We'll be host to some principal brokers that are members of the Eastern Middle Tennessee Association of Realtors by answering questions and talking about principal broker supervision. And then we will host, we'll be presenting a Trek 2-hour seminar. And then the second part of that seminar, Jared Burke from Rice Insurance Services will be the individual that will be presenting the E&O policy to the members of that association. That's going to start our seminars.
Now, you're starting out next week in Mount Juliet. Where do you go from there?
I'd have to consult the calendar. We don't have another one until it starts to warm up, and I believe
May, maybe.
May.
I think
But
we have a couple
Okay.
in May.
we're going to be going to
Okay.
Memphis, the Central West. We're going to the Robertson County Board, the Sumner County Board. We're going to Chattanooga and
Knoxville.
You're not coming to Knoxville?
Knoxville's calendar had already been booked, and there wasn't a time that
to Cookville,
Cookville.
Clarksville.
I'll print off the schedule and give that to y'all.
Yeah, because I always enjoy coming to see the road show.
I know.
Yes, in one of the other cities.
I guess I'll have to. If you're not
Lyle's-
coming to Knoxville, I go to Cookville.
Lyle's
or Chattanooga.
education calendar had already been set, and I put these together last fall. I try to get them pre-planned around the end of October, 1st of November, and his 2014 calendar. The days that we could work to where we try to get the most in for one trip. If we're going to travel to East Tennessee, we need to get as many folks as we can to see, and it just didn't
I
work.
guess you could just go down to Bear's office in Clinton
We
and
could.
set it up.
Yeah.
So do all
You won't
three
have
of you
two
go?
people.
Yes, ma'am, we do.
Yeah.
The first 50 minutes, which we count as our seat time, is an hour. We present different topics. I, of course, talk about education and the introduction of the seminar to folks. Ms. Kropp talks about the complaint process, and Director Maxwell talks about some of the hot issues that are going on that would be applicable to the licensees. And namely, sometimes we adjust it and tailor it to this specific area. So if we've been told there's a lot of septic issues and disclosure issues, we'll try to answer a lot of those questions for folks.
And when they come to your area, Marcia, they'll love to have you on the panel with them and there.
And it's 2 hours of continuing education just by coming. No test, 3?
Free.
Oh, I thought you said 3. I was saying it was 2. Yeah,
Free
2
is
hours of free education.
So
This-
for
And we are excited about having one with principal brokers, and I think Chattanooga wants us to come and do one for principal brokers as well, because at our seminars, for those of you all who have been there, you know we rarely have but a handful of principal brokers, sometimes none, and sometimes just 1 or 2. I think the most we've had is 6 at one of our.
that was
I think
Williamson
it's-
County.
yeah.
It was Williamson County. They were the 6
Yeah.
people that were there.
Right, so I mean, yeah, so we're pretty excited. That
the
wasn't
afternoon
that
session.
afternoon one, yeah. We are excited about having an opportunity to have principal brokers so that we can go over the supervision and those
Where is
items
that
that
one?
we don't usually get a chance to address to the people who really
Where?
need to know
Mount
about them.
Juliet.
Mount Juliet. So as I say, we are excited about that opportunity to do that.
I wish we could make that mandatory.
Yes.
Do you all have anything that you would like for us to address during our 50 minutes that jumps out at you that, besides, like we said, we would reference, telling them about if they're going to file an anonymous complaint, provide information. Is there anything else that jumps out at you all that
You just might want to share with everybody just how wonderful the real estate commission is.
Well, they know
The
that
people, the
already.
commissioners themselves?
I think it needs to be stressed on advertising because we are having so many issues with advertising across the state. I think that's something that needs to be stressed, as well as the rulemaking hearing we're going to be having coming up.
We're going to let them know, too, that those rules aren't in effect yet, because I think
Yeah.
there's been some confusion that people are thinking that they're already in effect. So that's something I'm going to explain to them about the rulemaking process a little bit, too.
It doesn't matter.
about-
You can explain that to your blue in the face, because I have one that I've just about had to beat in the head with that, but
Steve?
I have two last things, and then I'll be quiet. I don't want to open up any more questions. If I could address the attendees about the education they can receive, and then
I mean, this is
secondly-
your report.
Wonderful. For those of you that can see my back and listen to me,
Yeah, Steve McDonald is talking to all of you out there.
you have the ability to get your continuing education at little to no charge. Today's commission meeting or any other commission meeting that you attend is 8 hours of continuing education. And if you attend a Trek seminar, which will hold across the state, I know many of you have traveled either from Cordova or Kingsport, we do get close enough to those areas that you can attend a 2-hour seminar. So technically, you could get your 10 hours of CE at little to no charge. So we hope to see you there. Those calendars, of course, are posted on our website, and
And then all you have to do is take your core course and you're all set for your 2 years.
Now, you've already told us you're not coming to Knoxville. Are y'all going to Kingsport or you're going to Chattanooga?
correct.
Is that the only spot in East Tennessee you're going to?
Cookville.
You're going to Cookville
And unfortunately,
and Chattanooga.
and could not make it work with the NETAR folks. And we were in Great Smoky Mountains last fall.
Right.
If you'd like for me to book with Lyle, I'll see when he has available.
I mean, I'll drive Chattanooga. I mean, I'll
Drive to Cookville.
I rarely drive Chattanooga to see this road show.
It's a good one.
It is. I enjoy every
You get
time
what you
y'all.
pay for.
I know.
And then lastly, the News Journal, Director Maxwell and I, we have it in final draft, and we're just taking a look at it to make sure there's not any glaring mistakes. But that News Journal will be hopefully up by next week, and I'll make sure that you all get a copy of that.
Great. Does anybody have any questions of Mr. McDonald and his report? I don't think there's anything else that's on our afternoon agenda that we could pull forward.
You can go ahead and
Legislative
take.
update.
Well, there's a lady named Greer Kelly that works up on the 12th floor. I'm not sure she's with the legislative liaisons that's supposed to be giving the legislative update for all of the commissions. We just found this out beforehand. I can give you a little bit of information that I received about that. You can go ahead and look at the consent order log and ask me any questions about that. But I hate to start the legal report with just
Right.
15
Yeah,
minutes
we-
before lunch. If you want to take a look at the consent order log, see if you have any questions. Like I've told you all before, especially some of you new commissioners, this is just my tracking mechanism, and it just organizes by month the consent orders that you all have authorized, and I track when they're sent out, when they come back, because of course they're sent to litigation 30 days after receipt if somebody doesn't satisfy them. These ones that you're looking at right here are ones that have not been satisfied. If somebody pays it and satisfies whatever was in the consent order, I move it to a separate tracking sheet, and it's closed out. So these are, like I said, just the ones that have been sent out that either they haven't complied with or have been authorized for litigation. So
Julie, what is the taking listings? Is that where somebody left one firm and took listings with
y'all
them?
heard that last month. It was regarding a situation where the principal broker got fired and took some
Okay.
of the listings. That's just a notation where I can kind of remember.
Well,
which
that's what
one's
I was
which.
trying to
Right.
determine if that was
That's
what
the
that one was.
all
Okay.
of the ones you'll see, the gray bar that says January 2014, the ones listed under there were the ones that you all heard last month. And so they're still on this tracking sheet because, like I said, I have not had someone satisfy these. Like I said, we've had a lot. I think there were numerous from the December meeting, and I think all but one satisfied their consent orders, and that's why they've been pulled off of here. These aren't all the consent orders that you've authorized. These are just the ones that I'm currently still trying to track and that have been moved over to Robin. So. And I can give you a little information about the it kind of relates to legislation. It's an AG opinion that was published after our January meeting that I don't know if any of you are aware of. I have copies I'd be willing to give to you. We can talk about that a little because I'm not sure that that'll be covered in her report. Thank you, Steve. It was an opinion that was requested by a state senator here in the state, and the questions presented were, may a real estate broker who is not a licensed attorney acting in his or her capacity as a sole proprietor personally interplead disputed funds in the General Sessions Court without engaging in the unauthorized practice of law in Tennessee. And second, may a real estate broker who is not a licensed attorney acting as agent for a brokerage firm personally interplead disputed funds into the General Sessions Court without engaging in the unauthorized practice of law in Tennessee. And as you can see, they go through, the answer to question 1, if it's a sole proprietor, is yes. Answer to number 2, they go into much more analysis and basically say that interpleading in those circumstances requires legal training, skill, or judgment, and it's fact-specific and beyond the scope of the opinion, but it appears to differentiate between those two circumstances. And since this is fairly recent, this came out, we discussed a bill that had been filed at the January meeting that was relating to this. It was, I gave you all a copy, but it was, I think, House Bill 1387, and it had a companion bill in the Senate of Senate Bill 1712, and basically what it did was it stated, it was not within the Brokers Act, but do you have a question? It stated that a real estate broker may file an interpleader action without representation by an attorney so long as the broker or real estate firm is not claiming any right to any portion of the money filed with the court. Such an interpleading filed by the real estate broker shall not constitute the unauthorized practice of law in violation of Section 23.3103. This was filed, this bill that we discussed last month was filed in early January, and then this Attorney General's opinion, as you can see, came out on January 14th. And the interesting thing to me is the requester of this Attorney General opinion is the Honorable Ken Yeager, State Senator, who was the sponsor, I believe, of the Senate bill for this. Now, at this time, it looks like this bill has been withdrawn in the Senate. I've been told that it can potentially be brought back up. I don't know. The latest information I have this morning is that that bill had been withdrawn. But I wanted to provide you a copy of the Attorney General opinion, and also for the folks attending, I'm sorry I don't have copies for everybody, but you can go to the Attorney General's website and look at opinions for the year 2014, and this is listed amongst them. This was a January 2014 opinion. So thought I would provide you with that because it's something we didn't have last month.
What do you think about sending that to TAR and ask them to put it on their digest?
We can make them aware of it. They might be aware of it already, but I mean, I
haven't
think
seen
would
it
hurt
on
to.
the digest.
We can send it to
Thank you.
I noticed that they quote David Flitcroft on the bottom of
I know it.
That's like the first one where you look at it twice and go, is this good or is this bad? We've got to read this.
And there's one other bill, and she'll get into detail about that. I can give you all a copy of it where you can go ahead and be looking at it. That way, if you have questions for her when she gets here, I think that's for them. It's there's only been one other one since the interpleader bill last month that had been filed, and this is basically deals with commercial real estate brokers, and it's talking about revising the notice of agreement to pay a leasing commission, and it just does various changes to 62.13.501, and talks about paying the broker pursuant to leasing fees or commissions, and before said it was based on rental income, and now it just said, I believe it just says, as a result of securing a tenant for the real property. So it makes some changes to that. As of now, it looks like the latest information I have is that it's in the Business and Utilities Subcommittee of the House. But she may have more information on that when she comes later today, because according to the information I printed this morning, it was calendared for yesterday, but I couldn't find more information. So you've already got a copy of the bill. That way you can be looking at it, and she can probably give you more information this afternoon if you need it. But those are the only two that have at least come across my radar that have, affected the commission potentially, and like I said, they're relating Attorney General opinion. So Greer can probably give more information this afternoon, but at least now you've kind of already got it in front of you. And
Julie, is the first one withdrawn, did you say?
It was apparently, according to the information that I pulled off of the Tentrac's website, it was withdrawn on January 22nd, 2014 from the House. It looks like the Senate, it has not been withdrawn. The last action on it was on 1/22. It looks like it was referred to the Senate Judiciary Commission. It's a lot of abbreviations,
But should we not send that on to TER at this time, because it's not a law?
no, it's just a bill at this
Yeah.
point. So
And if they publish it, all the people reading it are thinking that's a law.
I think what he was asking to send was just the Attorney General's opinion that's been posted on the website. So
Anybody have anything else of Julie and her consent order log and this
would y'all
legis-
like a copy of the interpleader bill so you have it for when she comes in this afternoon? I've got copies of it. Thank you. I'm sorry.
It's okay, he needs his exercise.
So that's it, except for the legal report. And I know that you wanted to talk to Miss Ryan beforehand about those matters, and she also likes to be in here to hear the legal report. And
It's almost 20 after 11.
oh,
Get back on time if we leave
tell her
early.
not with that. And I guess there is one other issue that we could discuss with just a few minutes left. And I'm sorry it's not on the agenda. It's something that was kind of raised recently.
Okay.
We've not had this come up before, only once since I've been here, and it just came up a week or so ago. You know, these complaints initially are presented to you all anonymously for a probable cause determination, and at that point, we, dismiss, send a letter, or send a consent order. They can sign it or not, and if they don't, they come before you all, in this room with an ALJ face-to-face. You know who they are at that point, and they present evidence. In the past, we have not had anybody try to contact you all while it is still in the anonymous phase, but we had someone do that to at least some of the commissioners. And if you receive contact from anybody regarding a complaint that, is still in the anonymous phase, something that has not come before you all yet, it's best to not look at it, for if it's in an envelope, don't open it, forward it to us, don't read it any more than you have to. And for those attendees that are here and anybody else, please don't contact the commissioners. That's not, that could create a problem, I think, potentially when it comes into the litigation stage of the commissioners having this outside knowledge from this person turning around and contacting them. So, I think that's something we might need to educate people at these seminars as well. It doesn't happen often, but, I've discussed it with Ms. Ryan with reference to this particular situation, and she believes that probably the best course of action is to have that hearing in front of an administrative law judge sitting alone, now that there are at least several commissioners that have, gotten this outside information. And it is a potential issue that actually was already one of the ones that you all had authorized to be heard by an ALJ alone. But that's probably going to be what's going to have to happen here, because there's been this contact. And that's...
I don't think they realize how much it compromises the case when they start contacting us.
I'll tell you what I do when somebody calls me. In years past, I've had phone calls, and I right up front, I say, listen, you don't need to say another word to me. I'm not talking to you. And I said, number one, if you say anything else, I'm going to have to recuse myself, and I can't get involved anyway. I said, so you just need to be quiet and just go on and have a good day. And I hang up.
Sometimes it's hard, though. This was an email contact, and, you
Oh.
sometimes don't realize what you're looking at until, you've already seen it. And so we're going to try to make people aware that this, is, like Commissioner DeChara said, kind of compromises their own position if it comes down to a formal hearing, which usually it is, because it's somebody that's not in agreement with the consent order and is trying to plead their case. But that's just our process, and I know some people don't like that, but, it's anonymous initially because it's a probable cause determination. We don't want it to be somebody that you all know where there's allegations of bias or anything like that. And then their opportunity, if they don't agree, is to come before you all at a hearing and plead their case in person, not contacting you all individually in the interim. So,
Well, if they only email Bear, then it's nothing to
Well, that's
worry
true.
about. I mean, because the case has not been compromised
He
if
has not
Bear
seen
was
it.
the only one they emailed.
I have a question. Supposing they contacted each commissioner with the intent of having them recuse themselves, what would happen to the case?
Well, like this one, I assume we would have to have it before an administrative law judge alone, because, if it was enough to where the commissioners needed to recuse themselves and we didn't have a quorum to hear it, then I believe it would have to be in front of an administrative law judge. That's something that Robin might be able to speak to with more certainty when she's in here, but at least in this case, that's kind of was her feeling, because I showed her what, we had, and she said she thought that was the best way to proceed. And at this point, it's really hers, because it's hers to litigate however she feels best, so.
I think when that happened, we had that happen a couple or 3 years ago where they did contact every commissioner, the person did. And we discussed at that time appointing like a new special commission just to hear that particular complaint, because it did involve something that the commission would make the decision on and not, it would have been better made by the commission as opposed to an ALJ, so I guess it's a case-by-case basis. And sometimes, as Bear says, people will call and ask about, I have a complaint and I want to tell you about it. Well, and as Bear said, it is best just to head the people off at the pass, because you can't give a legal opinion or advice about it and tell them how to proceed. And that way, if you hear the fact situation, when Julie reads it anonymously, it won't be familiar to you. Otherwise, the fact situation might be enough, which I think a couple of times commissioners have had to recuse themselves because of fact situation, maybe from the town where they live, or they've heard something around town, they've had to recuse themselves when it comes up. But it is difficult because a lot of people don't know that.
Well,
they
a lot of
shouldn't do
people
it.
think that they can contact one of you and get an opinion from the commission, and as all of you know, one of you can't give the position of the entire commission, because frequently you all get up here and disagree on certain things, and so,
Well, and that's what I tell them when somebody calls me. I'm like, I'm one of 9. My opinion matters very little on its own. It takes 9 of us to make a decision. So
Write that down somewhere.
it takes 1 of 9. You want me to share that with Bear?
That's what Charles Haynes, who was chairman of this commission for 5 years, that's what our good friend Charles Haynes would say. I'm one of 9. That's all I am. That's all any of us are. We're one of 9. We're one of 6 today, but anyway. Anybody have anything else? If not, we're going to go to lunch just about 7 minutes early. We're going to be back at 1 o'clock, and we're recessed for lunch. And Jim Agee, if you would, wait just a second before you leave.
Well, now, Commissioner Francis defense, she was doing this.
I know. We've got our recording equipment up and operating, and I would like to call this Real Estate Commission meeting back into session. And I think, Ms. Maxwell, or would you like to, Julie, Ms. Crop, Mr. McDonald? Who's in charge? Who's going to introduce our guest speaker?
I would love to have the opportunity, Chairman.
I'd like for you to have it.
Matt Pooley has been wonderful to work with, and was very pleased and excited to come here and address you all to discuss reverse mortgages and hopefully answer some of the questions that you have, those risks involved. He's with the Attorney General's office. He's the mortgage settlement coordinator in the AG's office. And so other than that, I don't know what his favorite color is or his favorite movie, but I'll let Matt go ahead and take over. Thank you, Matt, for being here.
Steve, I just have a question for you in relationship to what he knows before we start drilling him. Is he aware of what we're trying to do here as far as determining an education value in it or anything like that?
Correct. I did address some of those concerns to Matt, and for those that are here in attendance, the commissioners have philosophically in the past not approved continuing education on reverse mortgages, and here in the recent months we've had several courses sent to the commission for their review, and the commission has stuck to their decision to not approve courses on the subject of reverse mortgages, mainly because it does not convey real estate property. It's a financing type of financing. And so with the questions that have been raised in the commission's discussion, the commission would like the AG's office to kind of weigh in and help them and guide them in making determinations about future courses, and also for the commission to be better educated on the topic. So that is the purpose of Matt being here today.
Thank you, Steve.
Thanks.
Now, pronounce your last name,
Pulley.
Pulley.
So, yeah,
Okay.
like the mechanical pulley, but without the Y.
Okay, Matt Pulley, thank you for being here, and you now have the floor.
Okay, well, thank you for having me. And Steve, thanks for the introduction. I am at the AG's office. I'm an assistant attorney general, and it's actually my job there to help implement and monitor the national mortgage settlement and the Ocwen settlement. Those are servicing settlements that apply to Bank of America, Wells Fargo, Chase, Citi Mortgage, and also Ocwen, which is now the nation's fourth largest mortgage company. Those settlements require that these banks work with homeowners who are in default, offer them modifications in many instances, and offer them principal reduction. So it's, I guess, because of that background, I guess that I was asked to brief the commission on reverse mortgages. I work with a lot of homeowners in default. There are some times when a reverse mortgage can help them, but most of the times the homeowners I'm working with don't have any equity or don't have enough equity to qualify. So I don't have day-to-day experience working with reverse mortgage lenders or working with borrowers who are seeking out a reverse. But it is something that I've definitely come across in the course of doing my job. So a few caveats going forward. There are complicated new HUD regulations that govern reverse mortgages, or 99% of reverse mortgages. Those regulations went into effect October 2013, so just a few months ago. I think consumer advocates are still trying to get a handle on what those regulations mean for borrowers and for lenders. So today, when I go over some of the concerns that consumer advocates have, some of those concerns might be addressed by these new regulations. We just have to kind of wait and see. And there are new protections in place for borrowers, but they should definitely proceed with caution before applying for a reverse mortgage. Also, one last caveat. If at any time today you feel like I'm betraying a bias, either for or against, that's unintentional. I just want to kind of give you guys just an overview of the industry, a little primer on some of the new regulations, and then some of the concerns that attorneys and other consumer advocates have, and then also some of the ways in which reverse mortgage can benefit a consumer. The thing to remember, and I'll be stressing this a lot today, reverse mortgages are complicated financial products. They're not easy. It's not like, even you think about a mortgage. My wife and I just bought a home recently. We knew exactly what our payments were going to be. We had an idea. We knew what our income was. We knew what interest rate we were getting. And there weren't a lot of variables to kind of figure out. But with a reverse mortgage, there are all sorts of variables that are very hard to predict, including the future value of your property, your own life expectancy, what sort of expenses you're going to come across in your later years. So that makes applying for a reverse mortgage or deciding to apply for a reverse mortgage, a little more complicated than I think a regular mortgage or other financial transactions. So just very basically, I just want to kind of define a reverse mortgage. There are different definitions out there. I think the Consumer Financial Protection Bureau has a good one. It just goes, a reverse mortgage is a special type of loan that allows homeowners 62 years and older to borrow against the equity in their homes. Now, it's called a reverse because you receive money from the lender instead of making payments to the lender. The money you receive and the interest charged on the loan that increases the balance of your loan each month. Over time, the equity you have in your home decreases as the amount you owe increase. Now, almost all reverse.
Matt?
Oh, I'm sorry.
Quick question there. When it says you receive money from the lender, is that a lump sum up front, or do you receive an advance every month?
You can choose. Okay. So there are different products. You can receive a lump sum. You can receive, a line of credit. You can receive payments every month, but that's something that you can choose. Now, reverse mortgages are very, very heavily regulated. Almost all of them are insured by HUD or the Federal Housing Authority, and that's because these are risky for the lender. Especially during the housing crisis too, you had many cases where, maybe the loan on the reverse mortgage was for $200,000, but at the time of the homeowner's death, the house was now worth $150,000, and that's FHA that was insuring these mortgages that lost money. FHA lost a lot of money over these reverse mortgages, and that's why you're seeing a tightening of these regulations. So reverse mortgages in many ways are governed by statute, but the main eligibility requirements for applying for a reverse, you have to be 62 years and over. You have to have significant equity in the property, at least 50% equity, maybe a little bit less, but right around 50%. You can't be delinquent on any federal debt. It must be your principal residence, and you must have the financial resources to pay taxes and insurance. You must participate in a HUD-approved counseling session. And a relatively new requirement, you have to get a financial assessment. So there are very strict rules. Not anyone can get a reverse mortgage. And the key is you have to have a significant amount of equity in your property. If you're not really sure you can qualify for a reverse and you have to get an appraisal out there, that's probably a good sign that you're not gonna qualify. So people in the first 5-6 years of their loan generally are not gonna qualify. The cost of the reverse mortgage, and we'll go over this a little more in detail a little bit later, but you have a mortgage insurance premium, and you have closing costs, you have servicing fees, origination fees too can be pretty high as well. So again, these are costly. These can be costly products. As far as how a reverse mortgage works, and by the way, I'm not going to follow the slides strictly, but if you have any questions, please stop me. But the balance of a reverse mortgage is due when the homeowner either passes away, sells the home, or moves. And at that point, the estate or whoever the home is willed to, they will have a certain amount of time to sell the home. One advantage of a reverse that we see, like I said before, I work with a lot of borrowers in foreclosure. We see many cases where somebody inherits a home and they are 5-6 months behind on the mortgage, or the previous owner was 5-6 behind on the mortgage. In those cases, the lender will move very quickly to foreclose, and it's very hard for the person who now has the house to work with the mortgage company because they're not on the note. So those are very difficult cases for our office to resolve. In the case of a reverse mortgage, generally the lender will give the children 6 months to a year to sell the home to pay back the proceeds before foreclosing. So that is one advantage. The law. This is a key detail, and I want to discuss this a little bit more later. But just on a general note, the law is currently right now in flux on whether the spouse of the borrower has to move. Because of this uncertainty, it's definitely advisable that spouses should remain on the deed and sign the reverse documents. And they should be suspicious of anyone who suggests otherwise. There are cases where you have spouses who deeded over the property to the borrower and didn't sign the reverse documents, and upon the death of the borrower, they were foreclosed on. They had to leave the house. Now, it looks like HUD is going to work to restrict that and prevent that from happening. But right now, like I said, the law is in flux. The Consumer Financial Protection Bureau, they regulate now all financial institutions just about. They discourage taking out a reverse mortgage under the following circumstances. One, if you can't afford your property taxes. Under a reverse, you still have to pay your property taxes and your insurance premiums. Not everyone knows that, and that's something that everyone obviously should know. But if you can't afford your taxes and your insurance going forward, a reverse is just going to cost you money in terms of transaction costs. You're going to lose equity in your property, and then you're going to be out of a home. So it's very important that homeowners understand their financial obligations going forward with a reverse, because failing to do so is going to cost them a lot of money down the road. It's also not really a good idea to take out a reverse if you don't plan on staying in your home for a long time. Again, because there are significant transaction costs. So if you're going through a temporary financial problem, but you only plan to stay in the home for 2 years, I think most financial planners will say that's not a good idea. The Consumer Financial Protection, I'm sorry?
What if a couple? What if a couple are getting old and one of them has a stroke and has to go to the nursing home, and TennCare gets involved in paying part of the nursing care? What happens when they die? Does it force the other partner to leave the place, or what?
Now, I'm glad you brought that up. If the person moving to the nursing home is a borrower, at that point.
What if they both couldn't be but one bar? I'm talking about man and his wife.
Okay. So long as one person stays in the home, the lender, I don't think, can foreclose, because one person who signed the reverse documents is still on the note. As far as TennCare paying for those expenses, I don't think that would trigger anything in the documents. And if that borrower in the nursing home passes away, so long as the remaining spouse, the surviving spouse, pays property taxes and insurance premiums, he or she will be fine. So, but it is important, and I'm glad you brought that up, that the borrower stay in the house. And it's always important. It seems like, what advocates say is that it's very important for both spouses to be on the note, because, to take your example, if the spouse who stays at home does not move into the nursing home, if he or she is not on the reverse mortgage documents and they deeded over the property, they could lose the home, because one of the conditions of the reverse mortgage is that the borrower make the home his or her principal residence. So moving out of the house can trigger the loan being due. So it's scary, and there's some evidence to suggest that a lot of borrowers didn't know these terms going forward. It seems like this is a lot more regulated. If you go into the National Reverse Mortgage Lenders Association, if you go on their website, which by the way is a very good website, it's just nrmlaonline.com. They have a code of ethics, and one of the ethical requirements is to be as transparent as possible, and to disclose all the terms of the note. But again, these are complicated instruments, and what triggers a lot of problems is many times when borrowers are taking out a reverse mortgage, they have a very urgent financial need. And no matter what financial product you're seeking out, if you have an urgent financial need, whether it's paying your car note, paying your mortgage, paying a doctor's bill, there's plenty of research to suggest that borrowers are not good consumers, and aren't really able to do their due diligence when they're applying for a financial product during those times. So yeah, it's like I said, it's you're going to hear me say this again and again. It's a complicated financial product.
Matt, right here.
Oh, sorry. Yeah.
Is the reverse mortgage lender, is its recourse limited just to the property, or is it also a personal obligation of the debtors that they would owe, or that their estate would owe, in the event there aren't sufficient proceeds from the sale of the home to cover the entire debt?
These are non-recourse loans, so they have no recourse to any personal assets. So if there is a deficiency between the sale of the home and the amount owed on the loan, that's where FHA comes in, and they reimburse the lender. So. Okay, the National Consumer Law Center, located in Boston, they put on a lot of conferences, and they do a lot of good research. They list the advantages and disadvantages of a reverse. Of the advantages, you keep the title. The mortgage can't be exercised unless the borrower passes away or moves out. And going to Austin's question, the lender can't seek repayment by seizing other assets. As far as the disadvantages, again, these are high-cost loans. Depending on what state, they can affect your eligibility for food stamps, possibly for TennCare. And obviously, they will subtract from any estate you're going to leave to your heirs. One advantage, we went over this a little bit before, but not listed by the NCLC, is, again, heirs will have a longer time to sell the home than if the borrower was in a forward mortgage that was in default. Just going through some policy and rule changes. I talked about this a little bit in the beginning. It used to be you can receive a loan amount up to about 77% of the home's appraised value with a fixed rate. And these were usually used to pay off an existing mortgage. Sometimes what was happening, I don't know if this is still happening, but sometimes what was happening was you had unscrupulous lenders. They pushed borrowers to take out a big lump sum right at the start because that generated more profits. The problem with doing that is that money gets spent early, quickly, and then the borrower has lost equity in their property and they don't have any financial resources to meet other expenses. And these loans cost FHA a lot of money. Senator Corker actually put a lot of pressure on HUD and on FHA to tighten these restrictions because, again, FHA, I mean, their losses on reverse mortgages were astronomical. So because of these rule changes, you can no longer tap the entire amount that you owe on year one. You can receive a single disbursement lump payment, but it's basically limited to, this is where it gets sort of complicated, but 60% of the principal limit, which is how much you can borrow, or your mandatory obligations plus 10%. So what that means, I printed out some examples here. To look at borrower 2, for example, I don't know if you're on the slide, it's on the first full or second full page of the slides. If borrower 2's principal limit is $100,000, and their mandatory obligations are $65,000. And mandatory obligations generally is just going to mean how much is still owed on the property. This borrower can take out an initial disbursement of $75,000. $65,000 will go to paying off that mortgage, and then the borrower will have $10,000 left. But you can no longer take the maximum amount in just one lump sum payment. Now, if you want to take out more after that, you can open up a line of credit or sign up for recurring payments. And by the way, if anytime I'm speaking too quickly, let me know. I grew up in New York. I've been in Tennessee for about 24 years, off and on. You know, there are a couple times I left but came back. So I've been below the Mason-Dixon line for 24 years, but you can't take the New Yorker out of New York. So please interrupt me if I'm speaking too quickly.
Congratulations.
We're glad to
So
have you.
for leaving?
No, for staying here 24 years.
Oh yeah, I know. I wouldn't think of.
And you don't speak as fast as Julie, so just.
Okay, that's good to know. My relatives and friends from New York think I speak too slowly now. So, payment options. We talked about this a little bit earlier. There are different ways to receive payments. Just going over some of the main ones. 10-year payments, those are equal payments as long as at least one borrower lives and continues to occupy the property as a principal residence. Term payments are equal payments for a fixed period of months selected. Line of credit are unscheduled payments or in installments at a time and an amount of the borrower's choosing. And then you have combinations of these. And then, of course, you have a single disbursement lump sum. This can get kind of confusing. I put the website for HUD that kind of goes over this. Just in general, the HUD website, which is just HUD.gov, has a lot of good information about reverse mortgages. It can be kind of hard to find, but they have a good search portal. So if you just go on HUD.gov, search reverse mortgages, you'll find a wealth of information to you. One of the most important things for borrowers is to seek impartial help. Now, it's a HUD requirement that borrowers, before they can receive a mortgage, go through HUD counseling. These are from certified housing counselors or financial counselors. In my job, I work with a lot of HUD certified counselors, and speaking frankly, the quality of counseling varies tremendously. Some are terrific and know everything there is to know about a mortgage, about housing expenses, about unforeseen housing expenses, about the intricacies of a loan, and some, don't really bring anything to the table. So because of that, and it's not just my observation, the Consumer Financial Protection Bureau has also talked about how the quality of housing counseling and HUD counseling for reverse mortgage borrowers definitely varies. So because of that, it probably makes sense for borrowers to seek impartial help beyond the HUD counseling. And that could be a financial planner, that can be an accountant, that could also, and probably should be, an attorney specializing in estates, an estate planner. Because again, these are complicated. You have, very hard to predict factors, including your life expectancy, the future value of the home. A lot of people guessed incorrectly about the value of real estate, 5-10 years ago. But at the same time, you want to at least have it. You want to at least have an idea on whether or not your home will appreciate. You could be wrong, but you want to at least have an idea, because that could also affect the decision. But again, it's important, and homeowners should also talk to their realtor, because their realtor will also have a good idea on whether or not the house will appreciate. It's certainly possible, and you don't want this to be the sole factor in your decision, but it's certainly possible if your home appreciates enough, the reverse mortgage actually won't cost you any equity. So it's something that again, borrowers should consider, but it's absolutely not something that should drive the decision, because as we all know, trying to guess where real estate's going is, can be very difficult. We have here in Nashville, I know this is the Tennessee Real Estate Commission, but I do want to bring up the Nashville Financial Empowerment Center, which is part of Metro government. They offer free financial planning, and you can set up an appointment, and they'll meet with you, and they have experience kind of dealing with these issues.
Do you have to live in Nashville?
I think you have to live in the Nashville area. I know this is sort of a pilot program that Nashville has started. I think it's coming to other cities, but I don't know when. So that was hopefully an overview of the reverse mortgage product and industry. I want to go over just some of the intricacies, some of the unique policy and legal considerations. One, there's a misnomer out there that if you have a reverse mortgage, you can't be foreclosed on, because the balance of the loan is due upon your death. So for a lot of people, they think, well, how can I be foreclosed on? I took out a reverse. And actually, that's not true. As we said earlier, you are required to pay property taxes and property premiums. Otherwise, not only can they foreclose, but FHA and HUD regulations require lenders to foreclose in those circumstances. So there's not even a lot of discretion on the part of lenders. So it's very important that homeowners pay property taxes and insurance premiums. Probably about 3-4 years ago, some of the big lenders got a lot of bad press on foreclosing on elderly homeowners who weren't paying their property taxes and weren't paying their insurance premiums. The one thing I'll say is, one thing I'll point out, though, and I think it's important to remember, if those homeowners did not take out the reverse, they would be in the same situation. It's not the reverse that caused them to fall behind on their property taxes. If they never took out the reverse, they obviously still would not have had the money, the financial resources to pay their property taxes, and they would still be in the same situation. So the reverse doesn't. I don't understand. I don't see how a reverse would lead to a default, but homeowners should understand that they absolutely have an obligation to pay property taxes and insurance premiums going forward. Now, there are some safeguards. The instant a borrower becomes delinquent in paying property taxes and property insurance premiums, the lender can't foreclose right away. They do have to advance these funds. But then the repayment plan is only 2 years. So if you are, as a borrower, $6,000-7,000 behind on your property taxes, for example, you have a 2-year window to repay that, which can be steep. That's $3,000 a year. That's going to be, a couple $1,000s every few months. Some advocacy groups have suggested that if the borrower falls behind on property taxes, that delinquency be amortized over the length of the loan. I don't know what HUD's going to do on that, but I know there's some discussion about that. And I know with conventional mortgages, if you fall behind on a mortgage, even an FHA-backed mortgage, and you fall behind on your property taxes, if you receive a loan modification that kind of cures your delinquency, the lender or the servicer is required to take your deficiency payments and amortize it over the course of the loan, not just over 2 years. So some people have brought out this discrepancy that default borrowers in conventional mortgages have more time to pay their property taxes than conventional than borrowers in reverse mortgages. So, we talked a little bit about reverse mortgages and non-borrowing spouses. I mean, again, it's just very important for the non-borrowing spouse. So when I say non-borrowing spouse, that's just the spouse that deeded over the property and is not on the reverse document. They can face eviction. You know, in many cases, it's the younger spouse, which in many cases is usually the wife. We've seen brokers encourage the wife to deed over the property to the husband, have the husband sign the reverse mortgage, because that can, in some ways, increase fees for brokers. The result of this, however, is that when the borrower dies, the other spouse may face eviction. Now, I am not saying that all lenders did this or most, but this was a reported problem, and it's come to the attention of HUD, it's come to the attention of the CFPB, and again, I think the rules are changing. I think the law is changing. The AARP, for example, actually sued HUD, saying that HUD's regulations actually conflict with the statute that sort of governs reverse mortgages. And the AARP won a kind of an unclear victory in court. What the court basically said is that HUD's restrictions or regulations on reverses actually conflicts with the law, and HUD has to fix those regulations. But the court's decision is not really clear on how that helps borrowers going forward, because lenders can still foreclose if the borrower is in violation of the terms of the note. So a lot of people expect that HUD will address this, and HUD will require all lenders to include both spouses on the mortgage, but that's not the case right now. So as of right now, it's probably advisable to tell both the husband and the wife, no matter what you're told, both of you have to be on the reverse mortgage document. So. So I talked a little bit about the National Consumer Law Center. They've reported to the CFPB about some of their concerns, and they actually did a very extensive survey of elder advocates, consumers, attorneys about some of the issues with reverse mortgages. I just want to kind of go over a few of them. What they found was that borrowers are being steered to options that offer little benefit to them but provide a hefty profit for brokers and lenders. Some of those options include fixed rate, lump sum reverse mortgages to consumers who may not need or benefit from that option. You know, in many cases, you're seeking out a reverse because you have a roof that needs to be repaired and it costs $2,000. And that's really your only financial need at that time. In that instance, taking out a big lump sum decreases equity in your property, and it increases the chance that money might not be used in the best way. So, but in many cases, I don't know if this still goes on, but there was a time when brokers were pushing for the borrowers to take out one big sum right away, because that would increase their fees, even when the borrower's needs were less than that. So that was a concern that the National Consumer Law Center found. The other thing too is that borrowers are more likely to consider the immediate need for money rather than the long-term costs of the loan, which are less transparent. And again, when you have these pressing financial needs and you learn a little bit about a reverse, you may think that it's the answer to your problems, and not necessarily think about these long-term costs. The Consumer Law Center also found that borrowers do not shop around for a reverse mortgage, and often accept whatever option the broker recommends. I mean, shopping for a reverse mortgage is no different than shopping for a car. You're not going to buy a car going to the first dealer that you visit. And there's no reason why shopping for a reverse mortgage should be different. Borrowers should be very good consumers, seek out different quotes, and then show those quotes to financial professionals and see, in some cases one loan may have higher costs, but the other loan may have a higher interest rate, and kind of compare and contrast that. Another problem is that borrowers look at this HUD required counseling as perfunctory, and they don't take it as seriously as they should. It's a requirement, but it's a requirement for a reason. And when borrowers speak to a HUD certified counselor, they can't just go through the motions. They need to ask the right questions. It needs to be a give and take. So, how am I doing on time, by the way?
You have all the time.
Okay, great.
Take whatever time you want.
Okay.
Matt?
Some other
Matt?
concern.
Matt, can I ask a question about the HUD certified counselors?
Yeah.
Who pays them?
They're not. They are paid by. I mean, they are employed by HUD. I'm sure there are there are transaction costs that go into the counseling, but the actual borrower doesn't directly pay for the counseling.
Are those people full-time HUD employees, or are they just people that may get a certification to do that and do that occasionally?
Now, that's a good question. Let me find that out, and I can get back to you. Okay. I'm not sure about that. So. Some other concerns, you have younger borrowers, in many cases, are steered to fixed-rate, lump sum reverse mortgages, and that has the potential, again, to deplete all the equity in your home. The one constant concern you see from consumer advocates about reverses are borrowers taking out too much money on the front end. And again, some of those regulations are designed to prevent that. The other thing too is that some of these HUD counselors are reporting that clients, the clients that they speak to, say that their lender only discussed one or two different reverse mortgage products and not discuss the full array of options that are available to them. I mean, other concerns too, and I think this is definitely an issue. Some of these marketing efforts, reverse mortgages, are pitched as free money. I do remember, as of a couple years ago, just driving, listening to the radio, and you would hear a pitch for reverse mortgages, and yeah, that term free money was used, and that's very reckless. Obviously, there's no such thing as free money, and there are costs to these loans. The marketing efforts for reverse mortgages can be very strong. That can include door-to-door ads, direct mail pieces, quote-unquote educational programs at senior centers, and celebrity endorsements. Those aren't in and of themselves bad. Banks advertise. We all advertise. Many businesses advertise. That's fine. The question is, what's actually going on in these advertisements, and are reverse mortgages being portrayed improperly? I think that's a concern that some advocates have. The AARP, I believe they have a lot of credibility on reverse mortgages because they actually, back in the 80s, really sort of pushed for HUD and FHA to kind of create this product in the first place. And the AARP believes that reverse mortgages can be a very good way for senior citizens to, the phrase they use is age in place. And I think as a policy, I think they would prefer that the reverse mortgage product remain available to their members. But again, they have concerns too. They talk about the securitization of reverse mortgages has led to the fixed rate lump sum product kind of dominating the market. So because of that, you had borrowers who were exhausting their borrowing capacity immediately. And this can be kind of controversial. Some lenders have pushed reverse mortgages as a type of investment portfolio insurance, and not as a way to stay in the home, but as a way to, for example, a reverse mortgage can be a way to obtain funds instead of depleting your investment account while asset prices are low. The problem with that is that the asset price recovery may not exceed the cost of the loan, in which case it's not really a good deal. In everything I read from the AARP, while they don't say this, what I think they kind of imply is that reverse mortgages should not be used as part of your investment portfolio. They should be used for borrowers who have a significant amount of equity in their property to basically help them stay in the home, to bridge the gap between their regular living expenses and their monthly income. And in that instance, a reverse mortgage can be a good deal, and I think the AARP, seems to be in favor. As far as using the proceeds of a reverse to buy an annuity, to invest to invest, I think, again, while they don't say this, just reading between the lines, it seems like they discourage that kind of use.
I'd like to ask a question. Can all of you back there in the back hear Mr. Pulley? Okay, I just want to make sure.
And I think I think again, what the AARP talks about are, and the borrower they're concerned about, just to give you a profile, is somebody who maybe their monthly income through investments, through Social Security, through whatever pension they may have, maybe it's $2,000 a month, and maybe their total expenses are around $1,800 a month, and they don't have a lot of wiggle room, but they have a significant amount of equity in their property, and maybe they have 5-6 years to go on a mortgage, and maybe their mortgage payments are $600-700. Under that scenario, if the homeowner takes out a reverse mortgage, that mortgage payment's done away with. So boom, that's $600 less that they're having to spend. And I'll provide them with some liquidity too, that they can tap into or not, but gives them some means of financial stability. I think that's the profile. That's the kind of borrower that the AARP would say can benefit from a reverse mortgage. Somebody who does not have equity or does not have a lot of equity, and somebody that just has a mountain of expenses, is probably somebody who should consider selling the home. And in some cases, this is a very sort of, I don't want to say simple, but it's a mathematical problem. And I am not the best math student in the world, but what you can do is you can look at your transaction costs from selling a home and moving into either a smaller home or a less expensive home, or even renting. Looking at the money you will gain from that transaction, selling a home that you have a lot of equity in, and then looking at the reverse, looking at what are the long-term costs of this product. What sort of cash liquidity are you going to receive? And you can do kind of a plus or minus analysis and kind of figure out what the best decision is for you. The problem, and it's a problem that I see too, is that, as I'm sure everybody in this room knows, your home is not necessarily, it's not just an investment. It's not just, you can't always attach a value to it. So I work with plenty of homeowners who are facing foreclosure, who are hopelessly underwater. And even with principal reduction available, they're still going to be underwater, and they don't care. They want to stay in their home because that's where they've been. They have very strong memories attached to the home. So, I think it's very important for borrowers to kind of do the plus minus analysis with the reverse versus selling the home. Again, in many instances, this is not something that boils down strictly to math. So I spoke a little bit with David Tarpley. He is an attorney at Legal Aid of Middle Tennessee. He's been practicing law, I think, since 1971. He helped actually write the Tennessee Consumer Protection Act, and he represents a lot of homeowners who are facing foreclosure. And I wanted to get his sense on a reverse mortgage because he's a very strong consumer advocate. And again, much like the AARP, there are times where he does recommend a reverse for his clients. Generally for people who have a significant equity cushion, and people who are facing, who may be facing foreclosure too. And we come across a lot of folks who may only have 5-6 years left to go on the mortgage, but they're facing foreclosure. So they have equity in the property. The problem that they're going to have is if you're foreclosed on, even if you have equity in your home, there's very little incentive for, say, Wells Fargo to sell that home at market value. They're going to want to sell that home and recoup the value of the loan, but they don't have the incentive to market that property super aggressively and sell that home for its market value. So say, for example, we see this scenario frequently. Say, for example, you have a borrower who lives in a home that's valued at $200,000, and their mortgage is $100,000. Wells Fargo, if Wells Fargo sold that home at market value for $200,000, the borrower, minus some costs, will get $100,000 because Wells Fargo will, recoup the loan and then give whatever's left over to the borrower. The problem, though, is that Wells Fargo's incentive, and I'm not picking on Wells Fargo, I'm just using them randomly, but their incentive is to just sell the home for the value of the loan. And there's some case law that says that Wells Fargo has to market that property. It has to get has to make a good faith effort to sell the home at close to market value. But the bottom line is, no matter who you talk to, you're going to get less for your home if it's sold at foreclosure than if it's sold privately. So going back to a reverse can help you save your home if you owe, if you owe. Now, again, you're going to need some equity, but by taking out a reverse, that will pay off in many cases the first lien holder, and then you won't have to make a mortgage payment. And if you have a lot of equity, again, it can be a good deal. But there are some homeowners who are behind in their mortgage, but their arrearage is relatively reasonable. So maybe you have a homeowner who is, say, 6 months behind. They're facing foreclosure, but they fell behind because they went through temporary expenses. Maybe they had a loved one who had health issues that they were paying for. So they're $6,000 behind. They can pay their mortgage going forward. They just can't pay back the arrearage, and the bank is demanding an immediate payment. In that instance, there are instances where a Chapter 13 plan might be better for the borrower than a reverse. And again, I'm not a bankruptcy attorney, and I'm not recommending one or the other, but it's an option that borrowers should consider. And bankruptcy has its own costs too. But the key thing when you're considering a reverse is to look at alternatives, whether it's bankruptcy, whether it's a second mortgage, and that's something to just kind of throw out there. I had a really good conversation with some of the employees. I wanted to also get some perspective of folks in the reverse mortgage industry. We spent a lot of time today talking about concerns advocates have, but I wanted to talk to some industry folks too. And I spoke to some folks at Newcastle Mortgage, and they were very patient in answering all my questions. I had a lot. They kind of talked a little bit about some of the advantages of a reverse. I mean, one, obviously, if you have a lot of equity in your home, it can definitely help you avoid foreclosure. Depending on the rate of your home's appreciation, you may not necessarily lose equity. A reverse can be a good time to pay. It can be a good way to pay for one-time expenses, including a new roof that you're probably not going to see again, that you can't really budget for, but that with a reverse you could possibly cover. And then there's also, and this can be somewhat complicated, but there's a reverse for purchase option. That's part of the HUD portfolio of reverse mortgage products that can allow a borrower with equity to sell an existing home and put a down payment on a new home while still preserving some liquidity. And the folks at Newcastle, they kind of gave this example here on the that I put here on the PowerPoint. I'll let you guys review it rather than go over the numbers. But again, this is something that is sanctioned by HUD, and a reverse. You do see elderly borrowers who would like to move closer to town, or would like to move from town, out to the suburbs. And a reverse can allow them to buy a home in instances where they wouldn't necessarily qualify for a traditional mortgage because of their income coming in.
Do you see most of this, the reasons are, though, because that people get into these problems is that they can't sell their house? That's been a problem.
Right. Well, and that's a good point. I mean, if you can't sell your home, then you may not have enough equity to qualify for a reverse in the first place. I mean, one problem with a reverse is that the people who need it probably can't qualify. And the kinds of people who are in a position to really do their due diligence, to talk to an attorney, to talk to their accountant, to really research the advantages and the disadvantages of a reverse. The kinds of people who have those resources may not need a reverse in the first place. So that's one problem you're gonna run into. So there are reverse mortgage calculators online. If you go into the HUD website, they also link to a reverse mortgage calculator. And there you can kind of see what your costs are. It's probably advisable for borrowers to kind of plug their numbers into a reverse mortgage calculator beforehand, before meeting with a lender. But just running the numbers here, and I don't know if this calculator reflects some of the new HUD requirements or not. It was linked to from the HUD website, but I don't know. But if you look at a home with if you look at a $200,000 home with $80,000 of mortgage debt, so you have, a significant amount of equity in your property. And suppose you would like $20,000 in upfront cash, as well as a $10,000 line of credit. You would also like to pay off the existing mortgage. You can get most of that, but you're not going to have enough equity to qualify for all of those benefits. So here are some of the costs. If you went with, and I say HECM, HUD refers to reverse mortgages as home equity conversion mortgages. But here are the costs. The loan origination fee is $4,000. Mortgage insurance is $5,000. Other closing costs are going to be a little over $2,000. Your initial loan rate will be 6.31% with a lifetime cap of 5.06. Your available principal limit is going to be $114,000. But after you pay off all your fees, your net is going to be a little over $100,000. So you can pay off that $80,000 mortgage, and you can receive $11,400 up front, and then close to that amount as a line of credit. So now for this particular borrower who still had $80,000 in mortgage debt off a $200,000 home, let's say they were paying $1,300 a month in mortgage payments. Those payments are now extinguished, and that's good. They also have some money up front to pay for costs, and they have $11,302 available as a line of credit. So all that's very good. But then again, look at these costs. These are significant transaction costs. Not saying this should discourage somebody from taking one out, but I think it's good when borrowers are in the initial sort of exploration process to kind of go on a reverse mortgage calculator and just see what their costs are gonna be. We talk a lot about. I mean, there's definitely. I don't know if this is entirely deserved, because I do think it does seem like the industry is changing over the last 3, 4, 5 years. It does seem like too with these new HUD regulations, this is becoming a safer product. And one thing to keep in mind too is that while a reverse mortgage costs you equity in your property, the same thing is true with a second mortgage. And yet you don't see the stigma associated with second mortgages that you do with. So again, I think even consumer advocates who have studied reverse mortgages, who work with consumers, who may have been burned by reverse mortgages, they still believe that reverse mortgages serve a purpose. And I'm more of a champion for the elderly than the AARP, and they have concerns. They do not discourage reverses in all circumstances, and the same thing with the National Consumer Law Center too. They have I believe the same view. But again, these are I say this again and again, but these are complicated financial products, and they should be evaluated very, very carefully. And you may determine upon doing the numbers that this is a good value to stay in your home while providing you with some liquidity. You may decide that it's not necessarily the best financial decision, but it's the best way to stay in your home. But again, these should be looked at very carefully, and borrowers should seek impartial help above and beyond what they're supposed to receive. So I hope that was a somewhat good overview. Does anyone have any questions? Or
I have 2 questions.
Sure.
I have one comment and then a question. Y'all remember reading that book, Die Broke?
No.
There's a book, Die Broke. Somebody wrote a book, Spend All Your Money. To heck with your heirs and your children, just die broke. Go ahead and spend all your money.
I hope my parents haven't read that book.
I was just thinking, it's a pretty good way of dying broke. Just go ahead and get all your equity out of your house, because I ran into one situation where a lady had taken one out in Oak Ridge, Tennessee, my home county, and the house, they owed that reverse mortgage. They owed about $80,000, and the house on a good day might have brought $50,000. So I don't know who wrote all that money off. But the second thing is, how much they paying Fred Thompson to make these commercials?
I was sick one day, and I was just at home watching TV, and those commercials are ubiquitous. You can't escape them. So,
I know it.
Right. But but what's interesting is that Senator Corker is the one who's kind of kind of led the way and pushing for HUD to kind of tighten down the eligibility requirements. So I don't know what their conversations are about this, but
One's an actor, one's a businessman.
right.
I don't know if this helped make our job any easier or made it harder, because we're still debating on whether realtors or real estate agents should be knowledgeable enough about reverse mortgages to help advise a client. And that's still kind of where we are with decisions.
One thing to keep in mind, one stat that I thought was interesting, older homeowners are pretty much the fastest rising class of people filing for bankruptcy. And we saw this especially during the financial crisis, where people's portfolios went down. So again, in those circumstances, a reverse could be an option. I mean, also too, over the next 5, 10, 15 years, where when you have boomers who start retiring and their income goes down, the reverse might be an option. Might be an option as well. So I mean, things are changing. I guess it's a field. I mean, things are changing in two main ways. One is demographically. We're going to have just a lot of older homeowners in their home who want to stay in their home but may not have the income to meet their expenses. And then two, the industry is different. I mean, I think it's safe to say that the industry is different than it was 5 years ago, 6 years ago. Now, whether or not these reforms will, it's always hard to tell when regulations will make a difference or not, and we'll find out. But there is, very safe to say that HUD recognizes the problem with reverse mortgages, that consumers were taking too much money up front and depleting their equity too quickly and not able to meet their expenses going down the line. I mean, HUD recognized that problem, and that the point of these new regulations was to address that. So.
Matt, one thing you talked about, I think in the context of the HUD counselors, was the importance of having people consult with other advisors as well, like a attorney or an accountant or someone like that. Would it be beneficial to have real estate brokers who are knowledgeable about both the pros and the cons of a reverse mortgage, so that in the event one of these senior citizens who is considering this could possibly go to someone like that, and that person would be educated and be able to advise them of the benefits and the risks?
Yeah, I think that would...
Matt, excuse me, if I would ask you if you could just lean over forward.
Sorry about that.
Yeah, we're taping all our meetings are taped, and we want to make sure that we have a good audio.
No, I think that would be advisable. I mean, one thing I discovered in doing this job and working with homeowners in default with conventional mortgages is that homeowners keep in touch with their realtors. They may be interested in selling at some point, or they just, they may see them around, if they're in a small town, and they look at realtors as trusted advisors. So so to go to a realtor who has that background in reverses, I think that could be a good thing. And then also going to your question, at least part of the analysis in taking out a reverse, it shouldn't be the entire analysis, but part of the analysis should be the future equity, the future value of your home. We have some areas in Nashville, and again, these are hard to predict, but we do have some areas in Nashville that are probably safer bets as far as whether or not your home will appreciate than others. And that's something that you should consult a realtor about. So.
Something else for the principal brokers to worry about, I guess.
Yeah.
Are there classes that they take to be certified? I mean, like a certification sort of affair?
For realtors?
No, I just meant for the counselors.
They have to be certified, and they have to have a certain level of expertise in reverse mortgages. So they can't just be generalists.
But they can't just have gone to a class and say hey, I can hold myself out? Is
Right. I mean, let me get because I know
That kinda
Austin
goes to
brought that
Austin's question as well.
Let me do some research on that, and I'll email the commission and because that's an important question. But and again, I mean, I've worked with some HUD certified counselors who are certified in helping homeowners with conventional mortgages, and again, just the quality. There's just a huge variability in the quality. So and other groups have pointed the same thing out with reverse mortgage counselors. So so for that reason, you should. I just think it's probably best to not rely purely on what the HUD counselor tells you. So, yeah.
Matt, go ahead. Go ahead.
Well, I just had this question. If I knew that these classes included what we just heard, I'd be more inclined to agree that realtors ought to have this information. But just to say that these classes are going to include pros and cons of this financing type, I don't know that I have the same sense of security that I did if this that Matt just shared with us was in the course. So I'm asking you because I don't know if that's even possible to inflict an item in somebody's course that they've prepared for us, or even if it's appropriate. But I have a better sense of a reverse mortgage today than I had before, but I don't have any comfort in these two classes that they're going to provide the same information.
One of those classes, Gary, we did hear the instructor when we were in, I believe, Knoxville's where he came and spoke to us, and we did send him back to rewrite his course and add the risk management part into it.
Gary, I agree with you 100%. I think Matt did an excellent job with its outline, and making somebody subscribe to this outline when they're doing their course outline, I think would be a good idea, because you did a great job, and I appreciate it.
Thank you. Appreciate it.
Matt, could I ask a follow-up question, if you know the answer? Do mortgage lenders, reverse mortgage lenders, or reverse mortgage originators, if there's a difference, do they compensate people in the community for bringing them clients to sign up for reverse mortgages, or is there any kind of referral fee or anything like that that's out there that you're aware of?
I don't know the answer to that, but that's something I can look into as well. So.
I know we have a person back here in the audience wanted to ask a question that's pertaining to this subject. Could we suspend and ask this lady?
There's a couple of them.
If you would, let me tell you what I want you to do. I want you to come up here to the front, state your name. Just come up here. We want you on the record. We have two people. If you'd like to have a question, state your name.
Janice Mathis.
And ask your question, please.
My question is, if someone is living in the home that's not on the loan, could they actually sign the reverse mortgage documents as well, along with the homeowner it's a two-part question. There's not a loan. The home is paid for. So if there are two people living in the home, one is the homeowner whose name is on the deed, and the other is the son, could the son sign the reverse mortgage documents along with the maybe mother?
It has to just be a spouse.
Matt, if you would.
Oh, I'm sorry.
I apologize.
So the reverse mortgage, I mean, the program is for older homeowners, 62 years and over. So, I mean, unless the son, and I think generally it has to be a spouse. It can't be a child or a dependent of the borrower.
Thank you.
So,
Matt, does that not depend on how the home was originally owned? If they're both over 62?
No, because I don't think so. Because if you're not either the homeowner or the spouse of the homeowner, you can't qualify for the reverse
Okay.
to begin with. So one other concern of reverses that I did not mention is, for children who live at home or or dependents, upon the death of the borrower, they are going to have to move out and sell the home, in an appreciable period of time.
Thank you. The next lady, if you would, come state your name for the record and ask your question. Speak into that microphone.
My name is Donna Clark, and I'd just like to say there are a lot of myths about reverse mortgages, but I know as a broker this last year, I sold 2 properties, and they were purchased by a reverse mortgage. Also referred 2 other clients to do a reverse mortgage, of which one was my own mother, who is 80 years old. She lost her spouse, $3,400 a month income, suddenly got cut to $1,200. Didn't know anything on the house. The house was valued at $350,000. We don't care to have the home upon her passing, but wanted, she had no retirement plan other than the little Social Security. So she did a reverse mortgage. So this is what I'm just here to say is that for us brokers or agents out here, broker affiliates, I do think we need the information, but be careful how much you give, because it's not a program for everyone. And even when I get to talking to people, before we do anything, I go on and give them the name of a lender who really that is their expertise, and let them go on and talk to them, or either a financial planner. But it's a good program. I do think some of the agents out here, because there's some that have asked me questions and they scared me. I'd hate to know they were talking to an elderly couple. And I'm almost 62, so I fit in that category. So I'd hate to know they were telling me what they thought reverse mortgage was. So.
Thank you for sharing this with us. Thank you very much. We'll go back off the record and back into session. Anybody else have any questions of Matt? I think you have. I want to echo what Commissioner Collins said. You've done an excellent job explaining to some of us who knew very little about reverse mortgages. I know we're still not experts, but at least we know a lot more now than we did an hour ago.
Well, thank you, and I appreciate the opportunity to speak with everyone. So.
And thank you for coming. Does anybody else have any questions of
I
Mr. Pulley?
I would just like to say that these sessions are online. Are all of them online? This would be a great place for the realtors who are here to go back and tell your principal broker you need to look at that and listen to what Matt has said, because this has been very thorough. And I think if you're going to be dealing in reverse mortgages at all, you need this information. So it is online on the TREC site.
It will be.
Will be.
When will it be up? How long will it be? What?
IS is the one that puts it on there, and it varies.
First of next week, roughly? Sometime next week?
Probably.
Week from
We
now.
don't have control over
Okay.
it, so I can't say for sure.
Okay.
But there is a link, and it's, I think, through YouTube. It's a video.
Okay. Once again, Matt, thank you for
Thank you,
coming and
Matt.
sharing this with us.
I'll get answers to all those questions too. So
Okay.
I've got one other question.
Oh, sure.
Let's suppose this couple has sized down a couple of times. And they owned a $600,000 house, they dropped to $400,000, and now then maybe a $300,000 house. They don't anticipate having to pay any capital gain because they've done all this sizing down and have already used that up. What if they get a bill after they've done this of like $22,000 or something for capital gain? Is that anticipated, or should they get an accountant to walk through this with them?
Are you talking about the context of just? Are you talking about the context of a reverse or?
Yeah.
Or
And when they get the money and they find out they owe capital gain on by sizing down.
no. Yeah, that's a good question. I don't know. I mean, I don't think. I mean, would they owe? I guess they would owe a capital gains tax because of the, I don't know how a reverse, I guess, would factor in unless they took out a reverse on the last home. Is that the scenario, or? you know, because you wouldn't pay a tax on the reverse.
But on the funds you get out of the house.
Oh, I see. You know, I probably don't want to answer a complicated tax question like that on the fly. So that would not be good. But that's a good question, and I'll add it to the list of questions I need to. So.
Okay. Thank you, Matt. Anything else? If not, we're going to take a short 10-minute break, and we'll come back and get on the legal report.
Agenda here.
Oh, Steve's going to do it.
Yeah,
Okay.
Steve's going to do it.
All
Come on,
right,
Marcia.
Thank you.
Don't worry about that back there.
All right, we're on. Steve's.
You got
Famous
an
last
engineering degree
words.
from Florida State, don't you?
What's that?
You got an engineering degree from Florida State.
I did.
No, he didn't.
I call this commission meeting back into session. I think the first thing on our agenda is to back up and to address two courses from our Educational Director's report, Mr. Steve McDonald, and I'm going to turn the floor over to you, Mr. McDonald.
Yes, sir. Thank you. If we go back to F19 and F20, these are the same courses presented to you by two different providers. The instructor is the same for both. The course discusses the characteristics of the senior population and the mortgage products available to them for purchasing and refinancing a home. Reverse mortgages are included in the coursework, and the course provides the pros and cons of this financing type. Of the 3 total hours for the course, 70 minutes are devoted to the topic of reverse mortgages on the outline. I know that Commissioner Collins and Commissioner Bloom had made a recommendation that any courses on reverse mortgages presented kind of follow Mr. Pulley's outline and presentation that he delivered today, and the information submitted on reverse mortgages is very elementary. It just talks about the pros and the cons. It doesn't go to the extent of the presentation that you heard today.
Since this presentation was a whole lot less than 3 hours, I think they could follow that.
And I'm not familiar with Miss McDaniel, the instructor. What education does she have in this?
She is a loan officer. She has taught for Chattanooga and
Memphis.
Yes, ma'am. So off the top of my head, I don't have her resume with me.
You feel good about
With
her
loan
leading
products,
it?
yes.
Okay.
It was just this area reverse mortgages that I brought it back to you for review.
Mr. Chairman, could I recommend that we approve F19 and F20 with the caveat that they include, we have a PowerPoint presentation that Mr. Pulley has along with this, that it include that PowerPoint presentation in the 90 minutes that they've set aside for the reverse mortgages.
I'd like to second that.
Steve's got a comment.
Okay, we have a motion on the floor that by Commissioner Bloom, that we approve these two courses with the caveat that it includes this instructive material that Mr. Pulley has just presented to us, and it's seconded by Commissioner Collins. Now, I'd like to ask for discussion, or I'd like to ask for Mr. McDonald.
We might need to check with Mr. Pulley
I was gonna
first
say
to
his-
be
we need
sure that
permission.
it's okay we use his information. I know y'all referenced it when he was in here and he didn't object, but I don't know,
And I agree with that because there might be some copyright issues. I would feel more comfortable, and of course I will respect y'all's decision and discussion, if I went back to these two providers and said, based on your discussion today, please follow kind of these parameters and send me your materials that show the adjustment, rather than going back with the caveat. But I'm welcome to whatever y'all decide.
I think the easiest thing to do is just vote this motion down and enter another motion that we defer this for a month.
And I would like to make a comment too, while we are thinking about this. As everybody knows, I'm a proponent of education and being educated in any way we possibly can. When we approve a course for reverse mortgages to get CE credit for it, then I think we need to be prepared to have a course on FHA financing or VA financing that's going to come before us for continuing education approval. So I think that's something that we need to think about when we're opening this can of worms on financing.
Now, there's one thing I'd like to, in the discussion, I'm going to vote against this motion so we can defer these two courses to next month. All in favor of the motion, say aye.
Aye.
All opposed, no. No. Motion fails. Commissioner Bloom, could I call on you to, Chair would entertain a motion that we defer these courses to next month to give Mr. McDonald a chance to talk to these two providers and also talk to Mr. Pulley?
I'd be glad to do that if I could remember what you just said.
Just defer.
Say so
Motion to defer
Motion
till
to
next
defer.
month.
Till next month.
Motion by Commissioner McMullen to defer these two courses for action next month, and seconded by Commissioner Bloom. Any discussion?
I think, as we've talked about, it would be good during the next month for Mr. McDonald to confer with this speaker and to share with her these materials and to ask that they be incorporated and then that they send you the revised materials in time for you to review it before next month. And if somebody could follow up with Mr. Pulley just to make sure he doesn't have any problem with that, which I don't anticipate he would, then I think we'd be ready to entertain the substance of these two courses for next month.
Okay. Very well spoken, Commissioner McMullen. Any other comments, questions, or discussion? Hearing none, all in favor say aye. To defer these two courses till next month, say aye.
Aye.
Opposed, no. Motion carries and courses are deferred to next month.
Thank you.
Thank you, Mr. McDonald. Now, the next thing on our agenda, before we get into our legal report, I think that we're going to have a discussion with Robin Ryan. If you would.
Yeah, I told her it was about whether we were going to keep her or not.
You come on up here, Ms. Ryan, get you a seat. And
That's the hot seat today.
And I'm going to turn the agenda over to our Commissioner DeShara. Is she the one that brought this up this morning as we amended our agenda for today?
I'd like to remind her that the last person that sat in that seat did an outstanding job.
Pull that PA down.
Okay.
Okay. Miss Ryan, we had a discussion some few months back about you not having any authority or leeway to negotiate on consent orders.
That's right.
What process do we need to go through or to give you the authority you need to do that?
Well, I can't speak to before I came to work for the state, but I can tell you that since I've been here, it has been relayed and at various meetings that the decision of the commission at what we call the probable cause hearing, and that is the presentation of the legal report, is that you all hear the facts as presented by your board attorney, and based on what's there, you make a determination of what is appropriate in that case. And it's been historically your position as a group that the bottom line is for the respondent to accept it, or they can come for a formal hearing. And in fact, that is how Ms. Kropp leads her legal report today. And that I, as a litigating attorney, and frankly, previously as a board attorney, have no leeway to discuss the respondent, a lesser penalty, a different kind of violation, et cetera, et cetera. And therefore, the pattern has been that once it's been approved in the legal report, then bottom line is that you have to accept the terms or you have to have a formal hearing. The advantages to negotiation are sometimes facts do come up between the time it's presented to you and the time it gets to me that may not have altered an ultimate decision. That is, you may have still determined that there's a violation, but it might impact the impact of that or the extent of the penalty for that violation. For instance, sometimes, and I'm making this up as I go, but it happens in another program, sometimes I learn that a licensee, for instance, is 70 years old and is not working at all and has no income at all, which might impact whether or not they could pay $1,000 within 30 days. So I am not asking to undermine your decisions at all, and I don't want to. But, and right now, I can't negotiate civil penalties, and Mr. Alexander, he's not here, and I would expect he'd be one of the ones that would be very interested in this particular issue about whether I should have that ability or not. I also cannot negotiate, and I don't necessarily think I should, negotiate what facts are going to be stipulated. If we and in fact, that was one of the questions that has come up before, will I agree to stipulate the facts? And I've historically said no. If I agree to stipulate the facts, then you won't hear any of the surrounding parts of the facts. We will just go on whether or not the facts support the violation. It's pretty clean that way, and in court, it can work very well. As the body you are, it may not work that way. But it could be beneficial if I had the ability to discuss, and I do generally discuss with both Ms. Maxwell and Ms. Kropp, it could be beneficial to have the power to say, this is something we need to think about. Maybe we should do not just a payment plan, but maybe the $5,000 is really, considering all the facts that we now know, it's maybe a little bit steep considering what he can and can't do or she can and can't do. Can we come back and say, we'll accept such and such? Now, if I were given any kind of power, you understand that any consent order or agreed order, when it comes to me, it'd be in terms of an agreed order, any agreed order is not written in stone until it's approved by this commission anyway. And as in the past, we have attempted to negotiate something, it is up to this commission to give the final approval of it. So if you were to give me power under certain circumstances, and I can't say absolutely what they are, and I don't think you should limit them, but if you were to give me the power to consider negotiations, if I thought another remedy was appropriate or another amount of money was appropriate or something, after discussion with the board attorney and with Ms. Maxwell, and a proposal with the other side, I would then bring it back to the commission as a whole for approval, with, of course, knowing that if it's not approved, it goes forward on a formal hearing.
Well, best I can recall, we had an all-day hearing on something that, had you had the power to do it, we would not have even been in that hearing at all, because you could have negotiated it.
Some parts of it, we probably would not have been. But that's not always true. But that can happen.
Okay.
What's to keep you right now from coming in and saying, I know that you all approved the such and such penalty in case number whatever, but having prepared it for trial and spoken with the respondent, there are some additional facts that you should be aware of, and my recommendation is to change your penalty to this, and if that was something the board agreed to, I've spoken with the respondent, and I know the respondent would agree to that.
Well, not necessarily anything, except for, again, in the history of this commission, that has not been the way it has been played out. Plus, I will tell you that Ms. Kropp often does have people come back, and she does when we have the facts, and that's an internal policy, I believe, is it not? Then when we have sufficient facts that warrants a new look at it, or new facts, we automatically bring it back before you, but if not, we don't. But as far as the rest of the story, as it were, when it gets to me, it is in the litigation process, which means I'm planning hearings well in advance. And I don't get down to the nitty-gritty until, frankly, about when I've got it filed. Okay? So, yes, I could do that, but it would mean another longer step in the long run. And as far as the time constraints go, it might make it more difficult. I mean, as almost all attorneys know, you don't ever want a client that doesn't let you negotiate, but there are clients that don't let you negotiate. But you can't ever do anything against the client, and as you all would be the client, I could never do or approve of anything that wouldn't be approved by you all. But it does help to be able to say, yes, I'm fairly certain that I can go back to the commission if we have an agreement on all the other terms and say, we're going to do 4,000 instead of 3,000 because of these facts, or that we are going to do this particular fact is not going to be included, even though that was part of the ones they considered, because we know we don't have proof for it. And Commissioner Chara, where you were referring was the one that we had recently, where this commission then told me to go out in the hall and negotiate. And then I was free to negotiate the terms for all of it. That it is likely that had I had that power, we might have come up with the same set of facts and terms and conditions. It's never guaranteed, of course.
No, that was one hearing that I had to leave, and I didn't stay for the entire hearing. But does it not factor in a lot of these cases that it takes the formal hearing to get the facts out, to get to the point where you can negotiate?
Well, sometimes that is true. Sometimes that is true. That is, frankly, more true when there's an attorney on the other side, and not always true when there's just a person representing themselves. But the kinds of things that I would be most inclined to come back to you with are, as I said earlier, somebody's 7 years old and they're not working and they have no income at all, and where you've given a $5,000 civil penalty, I'm pretty sure they can't pay it, and would it not be more appropriate to do something different?
Well, have you thought about talking to that person about a reverse mortgage?
No, but I did talk to him about, bankruptcies.
I like both of you trying to get that attorney paid.
I have no problem with you bringing to us a proposal that is one you think is the correct penalty and something that the other side would agree to, even after we've made an initial, proposal, because there always are additional facts that come up as you're preparing it for litigation, and ultimately, if it can be a wise use of our time, but apply the appropriate discipline for the facts of the case, then I think that's a good result.
It won't happen before tomorrow. Sorry, guys.
Okay.
You also talked about the question of stipulating to facts.
Yes.
Talk a little bit more about that process and what you do or don't do on that right now.
Well, it's only been asked of me maybe once. The problem I think this group has with stipulation to facts, as opposed to stipulating the facts when there's a judge involved, the judge knows all of the law and all the application and the history. I've not done but one jury trial, okay? But I can tell you that if you stipulate to a fact, then you can't necessarily bring up the surrounding circumstances around that fact because you've agreed to it and that's it. So, for instance, if you said there was a red light and they ran the red light, the fact that they ran the red light because of some other factor, you're probably not going to be able to bring up because you've already stipulated to the fact that the red light's been run. So it does limit the information that is presented, or potential information. It is, in my opinion, as far as that goes, is that for you to make, as a body, an informed decision, that you need to know all the facts before it that are relevant to the issue at hand. That is my opinion. I do my best not to bring in outside facts. When there's an attorney on the other side, they can always object to it if they truly think it's not relevant. But as far as stipulating to the facts in and of itself, I think, frankly, it can impede you in being able to make decisions. For instance, if you decide all the facts and you decided at the hearing, or based on the facts that was presented to you at the quote probable cause or in the legal report, and you determine at that time there was a violation of XYZ based on the exact same facts, and then later on you agree to all those facts and not presented, and all of a sudden it's not a violation of that particular part of the law, that could be problematic.
I'm smart enough to understand what you just said.
I wish I were too.
Commissioner Sharp, you wanted this put on the agenda. Where are you with it now?
Well, I'm still kind of at the same place I was. I think she kind of needs some authority to be able to negotiate some of these hearings before we get to that point, if there's something that she can do that with.
And may I just suggest, and this is probably a bit unfair because you brought it up for this meeting, but there are 3 members who are absent today who may have also an interest in this particular topic. And I would feel better because these members also are all 3 of them have been at many of them, if not most of my hearings. I would feel better if they also had an opportunity to have their input as well and the pros and cons, because again, I have to be before them when I'm presenting something.
That's why we brought it up today. We
Commissioner Commissioner McMullen, the chair would entertain a motion that we defer this matter until next month.
So moved.
We have a motion by Commissioner McMullen, and we defer this discussion, and seconded by Commissioner Franks. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Thank you, Robin. And Julie Crop, I'm going to turn the meeting over to you for our legal report.
All right. I'll start out by reading the wording at the top of the page. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. Am I close enough to the mic? Is it loud enough back there?
Kind of come and go sometimes.
It comes and goes. I can't tell, and I'm just going to move over a little more.
Get closer to Steve.
All right. Okay, the first matter is 2013-014-711. This was originally presented at the January 2014 meeting. Complainant was the buyer of a property, and respondent affiliate broker represented the seller. Complainant states the property was listed as a triplex, but after purchase, complainant discovered that the property was not a legal triplex and had been rented that way illegally by the previous owner. Where'd he come from? Thank you.
Right in front of it.
Okay. Complainant also states that complainant requested a revision to the contract to address a leak in one of the showers, and that respondent represented that the leak was fixed and the provision did not need to be in the contract. Complainant states that when complainant first used the shower, water was discovered in the basement, and upon relaying this information, complainant was told that respondent seller were not responsible as the issue was not in the contract. Complainant further states that after purchase, other leaks were discovered, making none of the bathrooms functional, and respondent refused to address the issue. Complainant further states that at the final walkthrough, complainant discovered that a large tree had been cut down and there was long electrical tube exposed. Complainant states that the complainant asked respondent if the home had any water intrusions from the 2010 flood and was told no, and the disclosure was marked as such. Complainant states that the house floods, but respondent claimed ignorance regarding this issue. Complainant states that respondent should have known many of the issues as respondent had managed the property on behalf of the seller. Complainant further states that the contract provided that the seller's items would be removed from the property prior to closing, but that on possession this was not done, and it took weeks for the for sale sign to be removed. Respondent states that respondent did not manage the property and had no dealings with the property prior to listing. Complainant was represented by a licensee, and respondent states that there were actually 2 contracts with complainant, but complainant terminated the first contract when the seller did not agree to make all repairs requested by complainant. Respondent states that respondent was later contacted and informed that complainant was interested in submitting a new offer with new terms, and a new contract was executed. Respondent states that the property had been rented for several years as 3 separate units and was referred to as a triplex by the owner, and complainant had representation and time to evaluate the property, but respondent never made representations regarding permitted use under current zoning as a triplex. Respondent further states the complainant became aware of the shower leak when complainant had an inspection done as part of the first failed contract, and the seller engaged someone to repair the leak. Respondent states that the first contract was terminated by complainant due to refusal by the seller to make a number of repairs, and when the second contract was entered, respondent informed complainant's broker that based on the information respondent had, the shower had been repaired. Respondent states that complainant had an inspection period, but no inspections were made until the final walkthrough. Respondent states that respondent was not aware of any long-standing water issues, and complainant had a contingency period for inspection. Respondent states at the walkthrough, everyone was surprised that a tree had been cut down, which involved an issue with the bank and insurance company, and respondent states that the buyer and buyer's agent said that they would address the issue, and the parties proceeded to closing. Respondent states that respondent was not aware of any previous flooding and was not giving any information regarding the previous flooding of the property. Respondent states that the seller hired a house cleaner and a handyman to address cleaning and removal of items, and respondent was told that the cleanup and debris removal was complete. Based on the information provided, there does not appear to be a violation by respondent. The recommendation at that time was to dismiss, and the decision was that the commission voted to defer this matter to allow Commissioner Bloom to review the file and report at the next meeting. So I'm going to turn it over to Commissioner Bloom to discuss.
Okay, thank you, General Counsel Crop. I looked at this file, and I did not feel that any of the things that were mentioned in there rose to the level of a violation, perhaps, of our rules or regulations. But my concern, as it was last month, was she said, the respondent said, she had never made representations regarding permitting under current zoning as a triplex. But there was, in her file, correspondence, an email where she referenced a triplex. So I thought that perhaps we need to look at what I think is a standard of care, which is Section 6213-403, which says here are the duties we have for customers. And certainly, in my mind, what would have been a duty was to say that a property is properly zoned for its permitted use before you're selling it. And in his complaint, the complainant says that he discovered that the property was not a legal triplex and had been rented that way illegally by the previous owner. So I contacted the Nashville Planning Department, and after several calls that came back to me unanswered, I did talk to a Mr. Brandon Burnett, who works in that department, and he confirmed that a triplex use was permitted in zoning advertised in the respondent's ads, OR2. He also confirmed that this individual property was in OR2 and triplex was a permitted use, and therefore no violation, and I would recommend adopting the previous recommendation to dismiss.
We have a motion by Commissioner Bloom. No, he'll have to recuse himself. So
Typically, someone that reviews the file abstains from the vote.
I know he abstained from the vote. He can't make a motion.
I move that we adopt council's recommendation to dismiss.
Yeah, we do. He can abstain. We got a quorum.
But Janet's not in.
That's okay. We don't need her. We got a quorum sitting at around this table.
Okay.
We have a motion by Commissioner McMullen that we take our previous recommendation, which was to dismiss, and seconded by Commissioner Collins. Any discussion? But I would like to say one thing. I want to thank you, Commissioner Bloom, for the thorough way in which you addressed this file. It's commissioners like you that Governor Haslam sees fit to put on this commission, and I think he has chosen wisely. Thank you for doing this for us.
I agree wholeheartedly.
And is there any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. The vote is 4 yes and 1 abstention, that being Commissioner Bloom has abstained from the vote. Motion carries 4 yea and 1 abstention.
Mr. Chairman.
Commissioner Collins.
On this next one, I noticed that she's our trusted attorney, has asked us to refer this to the Consumer Affairs Division. Is there any use in doing anything other than reading the number out and putting it in the record?
If you all have had the opportunity to review this prior to the meeting and are comfortable with that, then I've been told that's something you can do if all the commissioners have had time to review it prior to the meeting and are familiar with what it says, then I've been told that you all can determine that I don't have to read it aloud because it will be in our minutes for anybody to review. And I know you all have had the opportunity to review, and it's just whether or not you've taken that opportunity to do it. So.
Thank
you. We have, you didn't put that in form of motion, you just asked Julie.
Asking you a question.
You asking me, you asking legal counsel a question.
Rover, is that your motion?
I'll make it a motion.
I'll second the motion.
Motion's been made and seconded. We take legal counsel's recommendation on complaint number 2013-016-381 and close and refer to Consumer Affairs Division. Any discussion? And it's seconded by Commissioner McMullen. Any questions or comments, discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
Abstain.
We have 5 yes and 1 abstention, and it has been referred to Consumer Affairs. Number 3 is next.
2013-016-631. Complainant is a property owner and respondent affiliate broker acted as complainant's property manager. Complainant states that there were problems in the past with receiving timely rent payments, bounced checks from respondent, infrequent statements of accounting. Complainant included a copy of the only statement received in 2013 before complainant terminated services and difficulty contacting respondent. Complainant states that respondent collected rent for 2 months and did not send the money owed to complainant. Finally, complainant states that rent for one of the months was received, but complainant has not received the money owed to complainant for 1 month's rent. Complainant then terminated respondent's management services. Complainant sent additional documentation stating that a check was later sent by respondent to complainant for the rent money owed, but the check bounced. A copy was provided and good payment has not been made. Respondent submitted no response to the complaint, which was sent to the firm address on file with the commission and signed for by respondent. The recommendation is a consent order for $1,500 for failing to respond to a complaint filed with the commission in violation of Tennessee Code annotated sections 6213-312B14 and 6213-313A2 and failing within a reasonable time to account for or remit monies coming into the licensee's possession that belong to others in violation of Tennessee Code annotated section 6213-312B5 plus attendance by respondent at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of consent order.
Move to accept council's recommendation.
Second.
Have a motion by Commissioner McMullen and seconded by Commissioner, I don't know which one of y'all got there first, Commissioner Collins, to take the recommendation of council. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 4 is next.
20130166671. Complainant was a potential home buyer and respondent principal broker represented the seller. Complainant states that respondent is the daughter-in-law of the sellers. Complainant states the complainant was interested in a home listed by respondent, and the listing stated that the home included hardwood floors. Complainant states that the real estate appraiser stated that during the appraisal it was represented to the appraiser that there was hardwood flooring in the home, but complainant later discovers the floors were wood laminate. Complainant states that this home was brought to the attention of respondent, who changed the listing to reflect that the floors were laminate. Complainant states that since this was not discovered by complainant until after appraisal, it was an overstated appraisal as well as a factor considered in the offer and execution of the purchase and sale agreement. Complainant further states that at the first viewing, complainant discovered basement water seepage behind items stored in the basement, and the contract specified that this would be addressed before closing, but the seller's property disclosure did not reference the seepage. Complainant states that the builder told complainant that there was a leak in the same place and the leak had been addressed, but complainant states that this was not in the seller's property disclosure either. Respondent states that respondent is an in-law, which was disclosed to complainant and confirmed in writing, signed by complainant. Respondent states that respondent did list the home as having hardwood, as this was what respondent understood to be true at the time. At the appraisal, respondent stated that the floors were not discussed at any time, that the appraisal report only listed wood floors, and respondent was later told by the appraiser that this description can cover hardwood as well as wood laminate flooring. Respondent states the complainant requested more information about the floors as complainant intended to extend the flooring, discovered it was wood laminate, and requested a credit at closing due to this. After verifying that the floors were wood laminate, respondent states that the change was made to the MLS listing. Respondent states it was a very rainy season and complainant's agent called about the basement seepage, which was unknown to the sellers as items in storage obscured the view. Respondent states that this was not listed by the sellers in the disclosure as it was not known to sellers, but the sellers agreed to address the seepage accordingly. Respondent states that the builder was present at the inspection due to a possible garage extension, and there was a discussion that seepage was discovered during this construction, which was addressed. Respondent states that respondent had not been informed because respondent had not been involved at the construction of the home, which was approximately 1 year old at the time, and the seller stated that they did not list the issue as it occurred during construction, and they did not know it was necessary to list. Respondent states that respondent never attempted to hide adverse facts regarding the property. Respondent states that soon after the purchase was terminated, the home sold to a new purchaser for a higher price. Based on the information contained within the file, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Should we follow council's recommendation to dismiss?
Second.
A motion by Commissioner Collins, take council's recommendation and dismiss, and we have a second by Commissioner Franks. Any discussion on the motion?
I do kind of have some issues with that flooring problem not being disclosed. Marcia, I'm going to defer that to you, because if the builder was there, would he not have known what kind of floors was in that house?
Certainly.
What's the definition of a composite floor?
Composite
wood?
floor is more,
It's wood though, isn't it?
Well, it's wood, but it's compacted with glue. It's
Yeah, I
not,
know how it's made, but on appraisal, would it not be,
no, that wouldn't pass as a hardwood floor.
it would though, what I'm talking about.
It's wood.
Okay, that's all I said. It's just not hardwood.
I don't think anybody would expect it to be anything other than hardwood if they said the floors were wood, though. I agree. I don't think you can classify laminate as hardwood floors. And the cost difference is certainly substantial.
I don't want to be argumentative, but a lot of houses have got pine floors, and pine is not hardwood.
It would be considered a hardwood. Because it's wood. It's wood.
Back to what I
It's
said.
just a different kind of wood.
Okay. I never win with my wife either.
We have a
So
motion.
why should it be any different?
It just doesn't sound right when you say, how much laminate would a woodchuck chuck if a woodchuck could chuck laminate?
We have a motion on the floor and a second to take council's recommendation and
discussing
dismiss.
flooring.
I know you are.
We're through.
I'm with Grover. I've discussed it all I want to discuss it.
Let's vote.
Any other discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
We have 4 yeses and 2 noes. Motion carries. Next is number 5.
2013016691. Complainant was the purchaser of a property and respondent broker was complainant's agent. Complainant purchased a home in 2008 complainant purchased a home in 2008 and at closing, complainant learned that complainant did not qualify for a home loan. Complainant states that complainant was told that complainant had to pay $15,000 down, which complainant does not believe was properly administered toward the purchase price, and $1,500 per month for 3 years, after which all would convert to a mortgage. After 3 years, complainant states that complainant was again told that complainant still did not qualify and the plan had to be renewed for another 3 years, with the payment now being $1,900 per month. Complainant states that after confronting respondent stated there was nothing else that respondent could do. Complainant states that complainant was left with a solution to pay $25,000 to walk away. Respondent states that respondent first attempted to assist complainant in a home purchase in 2007, but complainant could not get the financing necessary for the purchase. In 2008, respondent states that respondent again assisted complainant in purchasing a home, and complainant's self-employment did not allow complainant to purchase via conventional or FHA loans. Respondent states that complainant was interested in a new home, and the builder was in agreement to finance with 3% down at 6% interest rate for 3 years with a balloon payment at the end, with the intent to give complainant time to improve complainant's credit score before the loan became due in 3 years. Respondent states that respondent met with complainant, discussed the deal and its terms, and to finish the transaction, complainant needed to pay the down payment and complainant's portion of the closing costs. Respondent states that a couple years after closing, complainant asked respondent to go back to the seller to request that the seller reduce the principal on the loan, and respondent refused and informed complainant that respondent was a real estate agent, had nothing to do with the mortgage process, and for that, complainant would need to deal with the lender, seller, and or hire an attorney for assistance. At the end of 3 years, respondent states that complainant could not secure a conventional loan as complainant had filed for bankruptcy, but the builder extended the term for 3 years with an increase in the monthly payments due to tax and homeowner insurance policy premium increases. It appears that the events surrounding the initial transaction in 2008 are well beyond TREC's statute of limitations. Further, based on the information contained within the file, there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
What is the statute of limitations, period?
2 years.
Okay.
Or 2 years from the date of when. Let me find the exact wording so I don't read it to you incorrectly. 13? Okay. I was in the right section. 2 years from the date of the commission of the alleged violation of 6213-312 or the date that the complainant actually became aware of the violation.
Any other questions of Ms. Crop pertaining to this complaint?
Motion to approve council's recommendation.
Second.
Have a motion by Commissioner DeShar and second by Commissioner Franks. We take council's recommendation to dismiss. Any other discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Next, 6, 7, and 8.
2013-017-311, 2013-017-312, 2013-017-313. Complainants were potential buyers, and Respondent 3, broker, represented complainants. Respondent 2, affiliate broker, is the owner of the firm, and Respondent 1 is the principal broker of the firm which represented the seller. Complainants state that complainants entered into a contract to purchase a home in July 2012 and paid $5,000 in earnest money to Respondents 1 and 2's firm. The closing was set for approximately 1 month later. Complainants state that a few days prior to the closing, the bank informed complainants that there was a problem with closing the loan and would have to be submitted for higher approval, or complainants could look into another lender. According to complainants, the contract expired on the closing date and was not extended, but complainants were still willing to buy the home if a new application would not pull credit scores until after a favorable bank appraisal. Complainants state the sellers then offered received a cash offer for a higher amount, and negotiation regarding complainants' purchase of the house ceased soon after that. Complainants state that complainants requested return of the earnest money by telephone and in writing several times in October 2012, and also asking that the money be interpled. Complainants state that the seller wrote complainants and stated the seller endured large losses due to complainants' apparent refusal to go forward with financing from another bank, and the seller offered to split the earnest money with complainants. Complainants state that complainants attempted on several occasions to contact Respondent 1 but received no response. Complainants state that after the transaction fell through, Respondent 3 divulged information that that past transactions involving complainants had not gone through and neglected to assist complainants by explaining complainants' right for interpleading. As of the date of the complaint, complainants state that the earnest money has not been returned or interpled. Respondents 1 and 2 replied, stating that the contract provided the holder of the earnest money with the authority to either disperse the earnest money upon a reasonable interpretation of the contract or file an interpleader action. Respondents 1 and 2 state that Respondent 1 spoke to agents to determine whether an agreement could be reached, and once it was determined that there was not an agreement, Respondent 1 consulted legal counsel who reviewed the contract and circumstances and advised the seller was entitled to the earnest money, but further advised that it would be better to interplead the funds. Respondents 1 and 2 state that Respondent 1 then informed the parties of the intent to interplead the earnest money and attempted to reach the seller regarding legal service, but the seller has failed to provide a valid address for service of process despite multiple attempts by Respondent 1 to reach the seller. Respondents 1 and 2 state that after this complaint was filed, Respondent 1 left further messages for the seller, advising that if a valid address for process was not provided within 24 hours, then Respondent 1 would disperse the earnest money to complainants. Respondent 3 states that Respondent 3 began working with complainants in early 2011, and since that time, Respondent 3 showed complainants numerous houses and assisted them through multiple sales which did not go through, including the subject transaction. When there was a red flag due to the appraiser's inability to find other comparable homes, which led complainant's lender to put a hold on the purchase, Respondent 3 states that the seller's agent attempted to get complainants to try working with a different lender, but they refused. Soon after, Respondent 3 states that complainants decided to back out of the deal for lack of financing, and Respondent 3 notified the seller's agent and asked for return of the earnest money, was told that the sellers would not consider returning the earnest money because complainants have refused other viable alternative for financing. Respondent 3 states that when complainants contacted Respondent 3 about this refusal, Respondent 3 told complainants that Respondent 3 could not make the sellers return the earnest money, and complainants may need to get an attorney. Respondent 1, as principal broker of the firm, did not disperse or interplead the earnest money until approximately 1 year after the transaction fell through, although Respondent 1 did consult an attorney on the issue and reported that attempts to interplead the money were complicated by the seller refusing to provide an address for service. The recommendation is to dismiss as to Respondents 2 and 3, as to Respondent 1, a consent order for $500 for violation of Rule 1260-02-.09, specifically referencing subsection 3, which states that brokers are responsible for deposits and earnest money accepted by them or their affiliate brokers, and subsection 7, which states that the funds in escrow or trustee accounts must be dispersed in a proper manner without unreasonable delay and should be dispersed or interpled within 21 calendar days from the date of receipt of a written request, plus attendance by Respondent 1 at one entire regularly scheduled meeting of the Commission within 180 days of Respondent 1's execution of the consent order.
Move to accept recommendation.
Second.
We have a motion by Commissioner McMullen and seconded by Commissioner DeShara to take council's recommendation with this particular complaint. Any discussion on the complaint or any questions of Ms. Kropp? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Number 9 and 10 is next.
9 and 10, 2013-017-701, 2013-017-702. Complainant states that Respondent 1 is principal broker, Respondent 2 is affiliate broker, did not get proper authorization from all necessary parties to list a property for sale which went under contract. Complainant's involvement and interest in the subject property is that of the child of a deceased heir. Complainant states that the property was listed by Respondent 2, went under contract, and documents were signed to allow the buyers to complete certain repairs prior to closing without proper authorization from all parties. Complainant states that numerous other family members should have signed the listing and sale documents but did not do so. Complainant states that complainant was later contacted to sign documents relating to those actions after the fact which complainant did not sign, as complainant felt the transaction was suspicious. Complainant states that complainant may request a respondent's firm to pull or cancel the listing and terminate the contract, but the requests were not honored, which resulted in complainant filing this complaint. Respondents submitted Respondent submitted a response to the complaint with Respondent 1 as principal broker, stating that, as evidenced by the documentation provided by Respondents, the situation relating to the property was very confusing, but Respondent 1 does not believe that Respondent 2, as listing broker, did anything wrong. Respondent 2 states that when Respondent 2 was asked to list the subject property, Respondent 2 immediately contacted an attorney with whom Respondent 2 had a long-time working relationship and who also does work for Respondent's firm and a title company. Respondent 2 stated the property was titled by a 1953 affidavit of heirship, which vested title to the subject property to the 6 children of the deceased owners. Respondent 2 states that only 2 of the 6 original heirs are alive and both are of advanced age. Respondent 2's mother-in-law is one of the surviving heirs. Respondent 2 states that Respondent 2 was advised by the attorney that Respondent 2 only needed to work with the 2 remaining heirs, and this is the path which Respondent 2 originally pursued. Respondent 2 states that the out-of-state heir had help with documents from that heir's child, and the local heir's daughter had power of attorney, and both heirs gave authorization to proceed. Respondent 2 states that the property, which was in poor condition, was placed on the market, and soon after an offer was made which is accepted by the 2 original heirs. This offer was intended to be a cash offer, but the buyer then decided to secure a mortgage, and permission was sought to shore up the property to pass bank inspection, and this was approved by the 2 heirs in a signed amendment. Once learning of complainant's dissatisfaction, Respondent 2 states that Respondent 2 contacted a title company and was told Respondent 2 probably needed the signatures of all children of deceased siblings as well. So Respondent 2 then sent the forms and signature pages to all potential heirs, but not all potential heirs could be located to sign the documents. Respondent 2 states that Respondent 2 has spoken with most of the heirs of the siblings, and all heirs that could be found are in agreement with what has been done except for complainant, who Respondent 2 states tried to remove a remaining original heir from the property in years past and failed and would like all the proceeds. Respondent 2 further states that Respondent 2 was put in touch with a different attorney who advised Respondent 2 that one of the original heirs needed to file suit against the estate, and Respondent 2 put the parties in contact. Respondents provided numerous documents relating to the transaction with descriptions by Respondent 2, including but not limited to documents signed by or on behalf of the original 2 heirs and the buyers, documents sent by Respondent 2 to the children of the deceased heirs, some of which were returned signed, and emails showing correspondence between Respondent 2 and an attorney. Respondent 2 also provided copies of documents showing that complainant signed all documents which Respondent 2 sent relating to the sale, except for the amendment allowing the buyers to make repairs and the hold harmless agreement. This is a complicated transaction, but it would appear from the information provided that Respondent 2 did seek legal advice on multiple occasions regarding the best way to handle the transaction and attempted to proceed accordingly. It appears from the information provided that Respondent 2 worked diligently to handle the sale in the correct manner. Therefore, the recommendation is to dismiss.
Motion to approve council's recommendation. Second.
Commissioner DeShara makes a motion to take council's recommendation and dismiss, and Commissioner Frank says second that motion. Any discussion or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 11, 12, and 13 is next.
2013-017-781, 2013-017-782, 2013-017-783. Complainant states the complainant rented a home from Respondent 1, affiliate broker, for a 12-month lease. Respondent 2 is a broker at the same firm at which Respondent 1 was affiliated at that time, and Respondent 3 was the principal broker of the firm at which Respondents 1 and 2 were affiliated at that time. Although not an allegation within the complaint, it was noticed upon receiving the complaint that the lease agreement which complainant executed with Respondent 1 was between complainant and a different licensed firm from where Respondent 1 was affiliated at that time, and the lease listed that Respondent 1 was an agent of that different firm, which would indicate that Respondent 1 was working for 2 firms at once. Complainant states that during the lease period, illness and inability to work for a period of time caused complainant to be late with rent for 2 months. Complainant states that at the end of the second month, complainant was served with a detainer warrant. The following day, complainant states that complainant paid the past due rent amount as well as the current month's rent. Complainant states that Respondent 1 told complainant not to worry about the court date, that Respondent 1 would take care of it, and complainant need only pay late fees. Complainant admits that the next 2 months' rent was paid late. In the meantime, complainant states that the court date was not canceled but was postponed for approximately 2 months later, that Respondent appeared and asked for an eviction and judgment against complainant and costs, which was granted. Complainant states that complainant was paying that rent in the meantime and nothing was said about the court date by Respondent 1 or the owner who visited the home and spoke with complainant around the time of the court proceeding. Approximately 3 weeks after the detainer hearing, complainant states that Respondent 1 conveyed that the owners wanted to set up a direct withdrawal from complainant's account for half of the rent on the 15th of the month and the other half on the 30th of the month. Then 4 days later, complainant states that Respondent 1 texted complainant that the owner would not wait longer for the rent and filed a writ of possession and told complainant that complainant did not have 30 days to move because it was waived in complainant's lease and the sheriff may only give 24 hours. The following day, complainant states that Respondent 1 arrived with the sheriff's and gave complainant's girlfriend time to remove some items, but said the movers would remove personal possessions to a secure location where complainant would have to make arrangements to retrieve them. Complainant states that complainant was then told by Respondent 1 that legally they were supposed to put everything on the street for trash to pick up. Complainant states that Respondent 1 then agreed to bring the items out of the home and allow complainant to remove them, but when complainant arrived to do so, there were a few boxes by the curb and complainant was told that complainant could move items from the shed, but there was nothing left in the home. Complainant contacted complainant's attorney. Then several officers arrived to tell complainant that complainant had all the possessions to be picked up and the items in the home belonged to the new tenants. Complainant states the complainant later called Respondent 2, who told complainant that Respondent 2 was not aware of the situation, then called complainant back and said there was no legal notification requirement for eviction. Complainant alleges that the house was not rented to new tenants and Respondent 1 is in possession of complainant's valuable personal items. Respondent 1 submitted a response through an attorney stating that complainant was late with rent payments throughout the lease period. Respondent 1's attorney states that the Uniform Residential Landlord and Tenant Act provides that a tenant may waive their right to notice of a breach of lease due to failure to pay rent, and complainant's lease agreement specifically stated that notice of termination of tenancy under lease agreement for non-payment of rent is hereby specifically waived. Respondent 1 states that after complainant was repeatedly late with rent payments, a detainer warrant was filed, and complainant was served with a copy, and the hearing was reset at the request of the owner who wanted to give complainant more time to pay the amounts owed. Respondent 1 states that the court notified Respondent 1 of the new date by letter and informed Respondent 1 that it would notify complainant as well. Respondent states that the court records reflect that complainant was notified of the new hearing date by mail. Respondent 1 states that complainant had failed to pay several late fees as well as the rent for the month of the detainer hearing at the time it took place. On the court date, complainant did not appear, and the General Sessions Court entered a default judgment in favor of Respondent 1 and the owner, and complainant did not appeal the judgment. Respondent 1's attorney states that complainant then had 10 days to voluntarily vacate before a writ of possession, and Respondent 1 and the owner attempted to work with complainant to pay all amounts owed and stay. However, Respondent 1's attorney states that complainant did not do so, and the writ of possession was issued and executed, terminating the landlord-tenant relationship. Respondent 1 states that Respondent 1 had consulted an attorney regarding what to do with complainant's possessions and was told that Respondent 1 did not have the right to keep the items and they needed to be placed outside the home, so Respondent hired a company to remove the property from the home and place it on the street. Pursuant to the forcible entry and detainer statute, Respondent 1's attorney states that once a writ of possession is executed, the landlord is to be restored to possession immediately, and there's no provision authorizing the landlord to keep the tenant's property once this is done. Respondent 1 states that a few days after the writ of possession was executed, complainant's attorney contacted Respondent 1 to see if any possessions were in the home, and Respondent 1 checked with the movers who said that some were still there, so Respondent 1 made arrangements for complainant to pick up those remaining items at that time. Respondent 1's attorney states that the parties are in litigation over the execution of the writ of possession because items were removed from the home when the writ was executed or set on the street and taken by third parties. Respondent 2 submitted a response stating that Respondent 2 does not recall speaking to complainant but confirms that Respondent 2 would have discussed the matter with Respondent 1 first, and Respondent 2 would have referenced paragraph 5 in the lease which complainant signed regarding waiver of notice of termination of tenancy for non-payment of rent. Respondent 3 states that Respondent 3 is the principal broker for the firm which operates as the sales division of the company, which was the firm that Respondent 1 was affiliated at the time of the transaction, and not the firm which serves as the rental and property management division, which has a different principal broker and which is the firm which is referenced on the lease agreement with complainant, listing Respondent 1 as agent, and the firm listed on the accounting of the money paid by complainant, which was provided by Respondent 1. Respondent 3 states that Respondent 3 supervises the sales transactions in the company and is not involved in any management, supervision, or day-to-day business in the rental property management division. The first time Respondent 3 was aware of complainant was upon receipt of the complaint. Complainant submitted additional information stating that a county general sessions court judge ruled against Respondent 1 in favor of complainant concerning complainant's possessions, and that complainant never received or was allowed to retrieve which not only included personal items, but sentimental family items which can never be replaced. That judgment has been appealed and is currently in active litigation in circuit court. It appears to legal counsel that based on the based on the parties to the lease agreement as well as the statement of account showing payments by complainant, Respondent 1 was handling the transaction involving complainant through a licensed firm other than the licensed firm at which Respondent 1 was affiliated at that time. After the complaint was filed and responses submitted, Respondents 1 and 2 changed their firm affiliations with Trek and are currently affiliated with the firm referenced on the lease agreement, which handles rentals property management, according to Respondent 3. The situation regarding the detainer warrant eviction and handling of complainant's items is a complicated issue that involves statutory law not administered by the Commission. However, it is recommended the Commission discuss these issues with regard to possible violations of the Brokers Act. The recommendation is to discuss. I did receive additional information right before I came into the meeting this morning, which I had a chance to review over lunch, which was further information from the attorney representing Respondent 1 that just basically reiterates the fact that the judgment of that was against that the complainant referenced was against Respondent 1 was appealed to circuit court, and under Tennessee law that appeal vacates the Sessions Court decision. The attorney further says that Sessions Court judgment was based on erroneous application of Tennessee law, and goes on to say that the Sessions Court judge, when announcing the decision, stated he couldn't find any specific law that governed the obligations of a landlord to a tenant while executing a writ of possession. And then the Sessions Court judge relied on the abandonment statute found in the Residential Landlord and Tenant Act and decided to apply the 30-day storage requirement to the execution of a writ of possession. And the attorney states this ruling was contrary to existing law. The attorney references the sections that govern writ of possession and had attached copies of those with the original response, and basically reiterates that the provisions state that there will be a 10-day period after the entry of judgment prior to the writ of possession, and state that once the writ is issued, the plaintiff or landlord shall be restored to possession immediately, and none of the statutes provide for the landlord to maintain possession of a tenant's personal items. Going on past that, the attorney references where in the past the Tennessee General Assembly proposed legislation that's repeatedly been struck down, which attempted to add an obligation on the part of a landlord relating to disposal or retainment of a tenant's possessions, and those have repeatedly been struck down. So the attorney reiterates the position that the landlord is not liable for damage to a tenant's personal property occurring subsequent to removal based on a writ of possession, and just asks again that the complaint be dismissed. That is just additional information that I got today, and so I'm sorry it's not in the report. I got it right before I came in. So,
Julie, it seems like there are kind of two sets of issues we need to look at. One of those is which firm Respondent 1 and Respondent 2 were with, and the other one seems to be all of these issues about what happened with the eviction and execution of the warrant and all that sort of stuff.
And that's what I was trying to lay out in the last paragraph, and I hope giving you the additional information didn't make that too confusing.
So let's talk about the issues with the execution of the warrant and the eviction and all that stuff first. What potential sections of the Broker Act do you think would be at issue when we're talking about that?
I would, my thought would be if found to be a violation, we don't administer the Landlord-Tenant Act, so we can't issue a fine based on a violation of that act. My gut feeling would be it would be a standard of care failing to diligently exercise reasonable skill and care or something of that nature. If it was found that that this person had done something incorrect, also kind of along that situation, this is an active litigation. It's in the circuit court now. I verified that. I actually had asked Regina, my paralegal over there, to call, and that's what I think prompted the letter from this attorney to find out exactly where this was. This may be something where, as to that issue, Based on the documentation that the attorney provided and what I looked at, relating to the arguments, it did not appear to me that there was anything that was egregiously violated here. However, I'm not as familiar with that as I am with issues directly relating to the Broker Act. This could be something that you all might want to put into litigation monitoring, considering it's in the circuit court. And things may come out there that don't come out now, but then there's that other issue of, on this lease was, the two firms appear to be in the same location, but have different licenses, different principal brokers, and at the time that the lease was signed, the respondent one was with one firm, and it states in the lease, it actually says between the other firm, and states that respondent one is an agent of it, and at that time that just was not true. To me, on the face of looking at all of this and all of the documentation that was provided by both sides, that appeared to be the only violation in my opinion. But again, I've never worked as a real estate broker. I don't know the ins and outs as much of the Landlord-Tenant Act. To me, the attorney's arguments appeared to be well supported by the law as I looked it up, and I didn't see any issues with that respect. But the other part, I did see some concerns with.
So turning to that other issue of which firm the respondent one and respondent two were with, which sections of the Broker Act would be at issue there?
Well, and it wouldn't necessarily be respondent two as much as respondent one, because respondent two, it didn't appear to ever make I'm not sure why respondent two got contacted necessarily, but I definitely didn't see that person, respondent two, referenced at all within the lease as, and that may have very well been why that person said, I'm not aware of it when they got contacted by the person. I really only see it as to respondent one. And because of the way the lease is worded, saying, I'm just going to say firm name, but the actual firm name's listed in there, and it says, comma, by respondent one has the name, comma, agent. To me, that would appear to be a misrepresentation under 6213.312B1. I think that's a substantial and I would call it willful. It's what firm you're affiliated with, and it's stated in there in writing that you're an agent of a firm you're not working with. And although the law doesn't state it as directly as one would like, if you look at 6213.309 subsection E, it states that no more than one license shall be issued to any broker or affiliate broker to be in effect at one time. While that doesn't specifically state it, you all know if you have your one license, you can't be affiliated with two firms. So this person apparently was holding a license at one place and at least executing lease agreements for another firm, which would appear to be kind of in conflict with that, because having only one license, you can only be affiliated with one firm, unless you're a principal broker who's a principal broker of two firms at one location, which was not the case with respondent one here. Did that answer your question? Those are the two that pop out to me. I mean, the misrepresentation being the more direct one, but just the fact of...
What's the civil penalty on that, Julie? Is that $250 to $1,000?
For 6213.312B1, which is substantial and willful misrepresentation, it's $250 to $1,000. If you were to find that, that also we wanted to reference no more than one license shall be issued to any broker or affiliate broker to be in effect at one time, that doesn't have a specific civil penalty range, but there is a provision in 6213.312B14, which is violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, the terms of any lawful order entered by the commission. And the range on that is $300 to $1,000. However, that seems to be kind of swiping at the same thing twice. So you might want to, I just think to make it clear to this person that, it's just that one issue, it might be helpful to reference both of those sections. But that's the issue I saw in it. But I recommended discussion because, and the reason my explanation was so long was, for one, there was a lot going on here and a lot of documentation. I felt you all needed to know most of this to have even an informed probable cause determination, but that was something that immediately struck me and Ms. Maxwell as well. I think even in opening the complaint was the issue with the reference of respondent one in the lease as working with a different firm, which respondent one is now affiliated with, but was not at the time that this was executed.
As familiar as you are with this complaint, after having heard a discussion that you have heard, at this point, what would you recommend?
All I've gotten is questions. You know, based on everything that's been presented here, the violation I see is just the issue of the separate firms. But I don't know that, I mean, I haven't gotten a lot of feedback if that's what you all are thinking as well.
What would you think would be the appropriate civil penalty, if any?
How about I make a motion?
If you're comfortable, you know as much as I know about that part of it. I mean, the landlord-tenant part was more the part that I wanted to, gauge everyone's thoughts on.
And I would say this, sloppy.
Yeah.
You don't even know who your license is with?
No, and
There's
that was
something-
never addressed in these responses. I don't know if they didn't see it as an issue. You would think there would have been a red flag when respondent 3 was going, I don't work with this.
I mean, no agent should be involved in stuff like that.
I would recommend we assess a $750 civil penalty and cite both those violations as well as attendance at a 2-day trek class.
Is that for respondent 1?
Yes.
Okay. Do you, with respect to respondent 2 and 3, with 2, like I said, I did not see any reference to that person representing itself, I'm going to say itself, or I'll say himself, that doesn't give away too much, as being affiliated with a different firm. I don't see any evidence of that. However, there is an issue of respondent 3 as being respondent 1's principal broker at that time. Do you all see a supervision issue with this person?
Yes.
So I also want to talk about respondent 2 and 3 separately.
Yeah, we're going there separately.
Oh, okay, all right.
All right, so
Okay.
let's just do respondent 1, get them out of the way.
We have a motion on the floor by Commissioner DeShar that the civil penalty of $750 be assessed to respondent 1 plus the attendance at a 2-day trek meeting within the next 6 months. Do I hear a second to this motion?
Second.
I have a second by Commissioner Franks. Discussion on the motion. Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. As to respondent 1, did you say no, Commissioner?
Pass.
You're passing. Commissioner Collins, that's 5 to 1 abstention. Now, what's your pleasure about the other 2 respondents?
I think probably the respondent number 2, probably bless his heart, was an agent on duty or something in that respect, and just tried to answer a question that it wasn't appropriate for them to answer. Probably, I mean, because this person has no knowledge of anything going on, really.
Stupidity,
I
and we
think that's
don't
what
fine
happened.
for that.
I think that's what happened.
Would you like to?
Two.
Would you
If
like
we
to,
assess civil penalties for that, we
Would-
would make lots of money.
would you like to put in form of motion that is to respondent 2 that we dismiss as to respondent 2?
Yes, I would.
Have a motion by
And I'll
Commissioner
second
Franks and seconded by Commissioner DeShar that, and as regards to respondent 2, that he be dismissed, or he or she, this individual, be dismissed. Any discussion on this motion? Hearing none, all in favor say aye. Opposed, no.
You got another
And we got
abstention.
another abstention, 5 yes, 1 abstention, Commissioner Collins. Now as to respondent 3.
And the failure to supervise penalty, Julie, is,
The range for that, failure to supervise is 15, which is $250 to $1,000.
well, I think traditionally failure to supervise, we kind of shake a ugly stick at that and assess about $1,000 penalty. So I'll make a motion, we do $1,000 penalty to the principal broker and attendance at the trek meeting within 6 months.
To Respondent 3, we have a motion by Commissioner DeShar that a $1,000 civil penalty be assessed in attendance at a Tennessee TREC meeting within the next 6 months. Do I hear a second?
Second.
Second by Commissioner Franks. Do I hear any discussion? Hearing no discussion, all in favor say aye.
Aye.
Opposed, no. Commissioner Collins' vote is 5 to yay, 1 abstention. Commissioner Collins. Those of you who are out there and have this legal report, I don't know if you noticed or not, but our staff attorney, Julie Kropp, is also the staff attorney for the Auctioneer Commission. So she has learned to read real fast. So continue on, Ms. Kropp.
14, 2013018141. Complainant is a licensee who represented a potential buyer. Respondent, principal broker, represented the seller. Complainant states that complainant's clients had a pre-approval letter prior to making an offer on the subject property. After going under contract, complainant states that complainant's clients immediately began working with their lender. Complainant states that approximately 2 weeks after the contract was accepted, complainant received a call from complainant's client's mortgage officer, who told complainant that the underwriter looked at the file and complainant's clients did not have enough income to qualify for the amount of the loan. Complainant states that complainant's clients attempted to get more money for a down payment but were not able to do so, and complainant informed the lender and asked for a denial letter. Complainant states the complainant then contacted respondent and told respondent that the buyer's income did not qualify for the loan amount due to lender error. Complainant states that complainant told respondent that complainant would send the termination of contract and release of earnest money form as soon as complainant received the denial letter from the lender. This all took place prior to the specified closing date. Complainant states that the lender never sent complainant a copy of the denial letter but mailed the letter directly to the buyer's home. Complainant states that the clients gave complainant a copy of the denial letter they received 9 days after the closing date, which complainant states the complainant forwarded to respondent on the following day. Respondent then told complainant that the notice was long after the expiration of the contract and therefore the earnest money was released to the seller in accordance with the contract. Complainant states that buyers and complainant felt that the seller should give the buyers their earnest money back because of the lender's error, and notice was given to respondent as soon as complainant had knowledge of it. Respondent states that respondent had multiple offers on the property, and complainant assured respondent that the buyer's income and credit was good and the buyers had a down payment, which led the seller to accept the offer. Respondent states that complainant phoned respondent a week before the scheduled closing date to notify respondent that the buyers were not able to obtain the loan and would be terminating the offer. Respondent states that respondent asked complainant to email the termination agreement along with supporting documents showing that the loan had been denied so that respondent could release the buyer's earnest money. When respondent did not hear back from complainant a few days later, respondent states that respondent sent complainant a text message inquiring about the documents. Respondent states that complainant responded back to respondent the next day and said complainant was still waiting on the documents to be sent to complainant. Respondent states that the seller asked that the earnest money be released to the seller per the contract agreement. Respondent states that respondent did not hear back from complainant. Respondent states that 9 days after the closing date, respondent released the earnest money to the seller. Respondent states that complainant sent the termination agreement and loan denial letter the next day. Respondent feels that respondent correctly released the earnest money to the seller per the contract. Based on the information provided, it does not appear there was a violation by respondent, and the recommendation is to dismiss.
Move to accept.
Commissioner Bloom makes a motion to accept council's recommendation and dismiss. Do I hear a second? Don't all of you speak at once.
Second.
Second by Commissioner McMullen. Now, does anybody have any questions or want to discuss the motion that's been placed on the floor as to complaint 2013-018-141?
I kind of feel like, excuse me, our hands are a little bit tied because we don't have the verbiage of the contract.
I have the contract. I would be happy to read it to you. I think it was a TAR contract, but
Okay.
I can pull it from the file. Would you like me to do that?
Yes.
Yeah, you gonna read all 9 pages?
No.
No.
Just
There's
respect
just an
to.
earnest money section that you would
Okay.
know if you would bother to look at it.
One thing I was told early on in my career was, if it's not written, it's merely conversation. And so, whatever that contract says, when you go in a court of law, that's what's going to be enforced. So let's just see what it says.
And I believe it did state that you had to have the documentation, but I'll read it. That's part of it to you.
I think it's on page 3, Julie.
I'm trying to find it right now.
I thought it was on page 4.
All right.
You've never even seen it.
I saw one time.
I'm going to be an auctioneer.
Want the earnest money paragraph?
Yes, please.
Okay. I'm going to eliminate the name of the holder because that's the firm, so I'll just say blank at that point. Buyer has paid or will pay within 5 days after binding agreement date to blank, name of holder, located at blank, an earnest money deposit of $1,000 by check. In the event that the earnest money check is not honored for any reason by the bank upon which it is drawn, the holder shall promptly notify buyer and seller. Buyer shall have 1 day after notice to deliver good funds to holder. In the event that buyer does not timely deliver good funds, seller shall have the right to terminate this agreement upon written notice to the buyer via the notification form or equivalent written notice. Earnest money is to be deposited promptly after the binding agreement date or upon entry or agreed upon delivery date in this earnest money paragraph as specified in the special stipulations paragraph contained at paragraph 18 herein. Holder shall disperse earnest money only as follows. A, at closing to be applied as a credit toward buyer's purchase price. B, upon a written agreement signed by all parties having an interest in the funds. C, upon an order of a court or arbitrator having jurisdiction over any dispute involving the earnest money. D, upon a reasonable interpretation of the agreement. Or E, upon the filing of an interpleader action with payment to be made to the clerk of the court having jurisdiction over the matter. Holder shall be reimbursed for and may deduct from any funds interpleaded its costs and expenses, including reasonable attorney's fees. The prevailing party in the interpleader action shall be entitled to collect from the other party the costs and expenses reimbursed to holder. No party shall seek damages from holder, nor shall holder be liable for the same for any matter arising out of or related to the performance of holder's duties under this earnest money paragraph. Earnest money shall not be dispersed prior to 14 days after deposit unless written evidence of clearance by bank is provided.
So they chose D.
They chose D, and
Which really, I've always had a problem with that one because it leaves it up to the interpretation of the principal broker. As a principal broker myself, I would feel very, I wouldn't want to make that decision myself.
there is another section of the contract that I thought was kind of instructive in this, and it's regarding the terms regarding the financial contingency, which it was the situation here. Can I read at least the part that I felt relevant to you in that? Let's see. In the event buyer, having acted in good faith in accordance with the terms below, is unable to obtain financing, buyer may terminate this agreement by providing written notice and a copy of lender's loan denial letter via the notification form or equivalent written notice. Upon termination, buyer is entitled to a refund of the earnest money. Lender is defined herein as the financial institution funding the loan. So from that, I took, calling and telling somebody that it was denied, was not necessarily satisfying termination under the terms of this contract, and that's essentially what the respondent said as well. So,
What concerns me that I guess you and I are probably seeing the same thing is that the lender's the one that dropped the ball by not getting that denial letter to them and mailing it to the buyer's home instead of to the agents involved.
that might have been emailed at the complainant's request. Not being a broker, I don't know, but it seems like this complainant's buyers, if the lender said, I mailed it to your client's home, I don't understand why this complainant didn't say, well, can you email me another copy or fax me another copy? To me, I don't see how this...
I almost feel like the complainant dropped the ball by not following up with that lender and getting the proper documentation to get the deal closed. It almost appears that the complainant needs a complaint opened against them for not following up.
We don't have any control over these lenders, though. Any other discussion on the motion?
Well, I disagree with that the complainant shouldn't have followed up with that lender.
We have a motion and a second on the floor to accept council's recommendation to dismiss. Any other discussion or comments? Are you ready to vote? All in favor say aye.
Aye.
Opposed, no.
No.
We have 4 yeses and 2 nos. Motion carries. Yes, ma'am.
Yeah, could I have just maybe like a 5-minute break real quick? We're about halfway.
And also Ms. Greer's here.
Oh, and Ms. Greer's here. Okay, Ms. Kelly's here. I'm sorry. That's fine. She can let her go ahead and.
We're gonna let her do her thing and then
Let her
do
go-
a
yeah, no, I
5-minute
didn't
break.
realize she was here.
You want to have break now, Ms. Crop?
No, she can go ahead and come up and do this. It's fine. I just thought we're roughly halfway through at this point, and I didn't realize she was here. So
Okay, we have next on our agenda, we have someone who is going to be giving us an update. Miss Kelly Greer, and going to be giving us an update on legislative. Update on current legislation and presentation on the Sunshine Law. Miss Kelly Greer.
Greer Kelly.
Greer
Thank
Kelly.
you. Hello. My name is Greer Kelly. I'm a legislative liaison here at Commerce and Insurance. I have been here about 2 months, and I'm thrilled to present to you all this afternoon. I came and sat in on your meeting in my first week here, and it's never dull. It's always entertaining here. Okay, I have a clarifying question before I start. Are you all in any way oversee real estate appraisers, or are you interested in legislation that's
Appraisers is a separate commission.
Yeah, they're
okay? I didn't realize if it was kind of a subset of this. All right, well, even better, perfect. You all have one piece of legislation in the 108th legislative session. It amends the Notice of Agreement to Pay Leasing Commission Form to entitle the broker to be paid leasing fees or commissions as a result of securing a tenant for commercial real estate. The bill also deletes the requirement that a fee or commission must accrue during that time that a subsequent owner holds title to the commercial real estate. So that's the only bill that you all have forth. That is House Bill 1663, Senate Bill 1761.
All I got to say is, where's John Grease when you need him? That's what John Grease does, commercial leasing.
Yeah.
What does the
Okay.
what does the bill really change?
Not a lot. According to the bill analysis conducted by our legal department, the bill is not expected to have an impact on existing programs or policies, and there's no fiscal impact. So I don't think you all have much to worry about, but we certainly want to keep you in the loop, and we'll be kind of returning on a regular basis as the session progresses. Today was the bill filing deadline, but I think the legislators have still got a few more hours should they wish to turn anything in.
Anybody have any questions of Ms. Kelly as far as any other things going on with the legislation in this current session?
There was also the House Bill 1387 that we talked about earlier this morning that had to do with interpleader actions. And our understanding was the House bill had been withdrawn.
Right.
Does that mean that issue is off the table now?
Yes, it does.
Okay, thank you for that update. And also, now what about the Sunshine Law?
You're not up for sunset this year, are you? Is that not
No.
true? I didn't. I was going to say. I was like,
we thought you were going to talk about the Sunshine Law.
oh,
But you know that
They might have mistyped it
Yeah,
in the
that might-
email.
yeah. I'm not. Just came to tell you about your legislation this year. I'll leave some business cards. Feel free to contact me if you have any questions, even if it's just as simple as sort of a procedural thing to know what committee routes.
I've got a real simple question. When is the sun gonna shine?
You know what? Your guess is as good as mine, but I hope it's soon. Anyway, you all enjoy the rest of your meeting. Thank you.
Okay,
Thank
thank
you.
you. Okay, now, Ms. Crop,
She wants 5 minutes.
you want a 5-minute
Okay, I
break?
mean, we can do a couple more. I just know you typically break about halfway through, and I think as far as the content, we're over halfway. We have a little bit more than half the complaints left, but they're shorter. So we're about halfway through at this point.
I want to take, you want,
I could just have a really short break. That'd be
okay,
great.
let's take a real short 5-minute break. Call this meeting back into session. Ms. Crop, we're down to 15 and 16, I think.
Back on?
We're back on.
Okay.
Steve's turned us on. We're back in session.
Okay. 15 and 16, 2013-018251, 2013-018252. An anonymous complainant alleges that respondents, both unlicensed individuals, are acting in the capacity of real estate affiliate brokers without licensure. Included with the complaint were copies of website advertisements for a real estate developer with respondent one's name and picture featured prominently with the telephone number stating that respondent one is the vice president of the development company, with a bio regarding respondent one's background with the development company. Also included are several web page printouts which list respondent one and respondent two's names along with their vice president titles for contact information regarding the development. Respondents submitted a response drafted by one of the co-founders of the development company, who is also the principal broker of two licensed firms. Respondents state that they are owners, officers, and stockholders of the development company, which is an LLC. Respondents state that the development company has developed the residential community referenced in the advertisements for years and sells their own property in addition to listing their property with an outside residential licensed firm. The response outlines Respondent 1 and 2's duties with the development company and describes the recent changes in brokerage firms utilized for the development company's listings, and explained that where Respondents 1 and 2 were listed on any web pages, they were clearly listed as vice presidents of the development company. Respondents state that unless it's not legal for an owner to represent and sell real estate property owned exclusively by the corporation that they own, the allegation of unlicensed activity is denied. There is an exemption for an owner of real estate with respect to property owned or leased by such person, as well as an exemption for corporations acting through officers where certain circumstances are met, though it clearly appears that Respondent 1 and 2 are part owners in the LLC that is developing the subject developments. It's recommended that Respondents 1 and 2 receive a letter of warning outlining the licensing exemption regarding corporations acting through the officers. Therefore, the recommendation is a letter of warning regarding that exemption, 6213-104A1F.
Motion to accept the recommendation.
Second.
Motion by Commissioner McMullen to accept council's recommendation with a letter of warning, second by Commissioner DeChara. Do I hear any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 17.
201301859. This complaint was referred to TREC from another state's Bureau of Real Estate. The initial complaint was filed against an individual who is a licensee in that state, but the property in question is located in Tennessee, which was the reason for the referral. The complainant was a tenant who claimed that the licensee from the other state did not provide complainant with a lead-based paint disclosure for the property, which is owned by the out-of-state licensee. The complaint included an unexecuted rental lease agreement for the subject property, which was between complainant and a company which is not licensed as a firm in Tennessee, this respondent. Therefore, a complaint was opened against this respondent for possible unlicensed activity, since it did not appear based on the information provided that the subject property was owned by this respondent, the company. No response was received from respondent, which is located out of state, and the certified mail card was not returned with a signature of receipt. In researching the property owner, who is a real estate licensee in the other state but not Tennessee, it appears that the property owner is actively licensed as a broker in that state, and this respondent, the company, is that individual's DBA as reflected on that state's license verification system. But respondent is not registered as a corporation in or LLC in either that state or Tennessee. Based on information obtained from that state's website and conversations with a representative there, all that is required to practice real estate in that state is an active broker's license but no firm license. In this case, this individual is an active broker who had respondent entity listed as that individual's DBA, which is a fictitious business name that some licensees choose to create in that state, but it is not required. Based on the fact that respondent is a DBA of the owner of the property located in Tennessee, it does not appear that there is any unlicensed real estate activity, and therefore the recommendation is to dismiss.
Motion to accept your counsel.
Commissioner Collins makes a motion. We accept council's recommendation to dismiss. Do I hear a second by Commissioner DeShara? Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 18 and 19.
20130187221, 20130187141. TREC opened complaint based on a newspaper story submitted to TREC by an anonymous source regarding Respondent 1, an affiliate broker. Respondent 2 is Respondent 1's principal broker, and the complaint was open for a potential failure to supervise issue. The author of the newspaper story discusses Respondent 1's involvement in a development group and the development group's activities, but does not state that Respondent 1 is a licensee, and the real estate firm name and phone number where Respondent 1 is affiliated do not appear in the article. Respondent 1 submitted a response stating that Respondent Respondent 1 is not only a real estate licensee, but is also part owner in the development group, which is featured in the newspaper article. Respondent 1 states that Respondent 1 knows to fully disclose that Respondent 1 is a licensee and mention Respondent 1's broker and firm at every opportunity, and Respondent 1's principal broker has held multiple mandatory trainings regarding disclosures and rules regarding advertising. Respondent 1 states that this article was not an advertisement. Further, Respondent 1 states that Respondent has never paid to be in any article such as this one, and states that when interviewed, Respondent 1 discloses that Respondent 1 is an agent, who Respondent 1's broker is, and the firm phone number. In the subject newspaper story, Respondent 1 states that Respondent 1 sent in a requested questionnaire. A copy was provided, wherein Respondent 1 provided the firm name and phone number, but only some of what Respondent 1 wrote was used, and the writer of the article did not use Respondent 1's firm name and telephone number. Respondent 2 states that Respondent 2 has held multiple mandatory trainings for licensees on issues of ethics and TREC rules. Respondent 2 states that regarding this complaint, Respondent 1 always discloses to the interviewing journalist that Respondent 1 is a licensee with Respondent 2's firm and provides the firm name and number, but respondents have no control over what a journalist writes or does not write in an article. Respondent 2 further states that news articles were not solicited and paid for and are not, in Respondent 2's opinion, advertising. Respondent 2 provided copies of other articles regarding Respondent 1's development group, wherein Respondent 2 points out that the author at least included the notation that Respondent 1 was a licensee.
Chairman, I'd like to make a motion we dismiss this.
Second.
We have a motion by Commissioner Collins, seconded by Commissioner Franks to just take council's recommendation. Do what?
McMullen.
McMullen?
I second.
We both did.
Oh, okay, I'm sorry, I didn't hear you.
Oh, I'm sorry.
Go ahead.
Commissioner McMullen. But anyway, Commissioner Franks.
Thirded it.
And any discussion on this motion to dismiss? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 22,
20 and 21.
2020, excuse me, 2021.
You skipped a page, I think.
No.
2013018881, 2013018901. TREC open complaint based on information received from anonymous source stating that Respondent 1 affiliate broker was conducting property management activities through an unlicensed firm. Respondent 2 is Respondent 1's principal broker, and a complaint was opened for a potential failure to supervise issue. Information from the internet regarding the unlicensed company does not appear to specifically describe the company's business activities, and information obtained from the Secretary of State's website regarding the business lists an individual other than Respondent 1 as the registered agent. Part of the company's name and the registered agent's last name are the same as Respondent 1's last name, which is a rather common last name. Further, all addresses found relating to the unlicensed company appear to be different from the address of Respondent 1's firm. Respondent 1 states that Respondent 1 does not currently work for and has never worked for or been affiliated with the unlicensed company referenced in the allegation or any other unlicensed branch office. Respondent 1 states that based on the claim and the documentation located and included with the complaint, it appears that someone has misinterpreted the facts or confused Respondent 1 with someone else due to the same last name. Respondent 2 states that Respondent 1 is not operating an unlicensed property management company. Respondent 2 states that Respondent 1 did speak with Respondent 2 about a personal property that Respondent 1 was advertising for rent and had questions about a licensed agent handling their own personal property, and Respondent 2 referred Respondent 1 to TREC. Respondent 2 states that Respondent 1 knew to disclose any potential renter that Respondent 1 was a licensee. Respondent 2 states that the personal property referenced has since rented. Based on the information provided and obtained, it does not appear that there was a violation by respondents, and therefore the recommendation is to dismiss.
So moved.
Second.
A motion by Commissioner DeShar and second by Commissioner Collins to dismiss. Do I hear any discussion on the motion? All in favor say aye. Aye. Opposed, no. Motion carries. Number 22, 23, and 24.
2013019131, 2013019132, 2013019171. Complainants attended a timeshare presentation given by respondents. Respondent 1 is a timeshare registration. Respondent 2 is a timeshare salesperson. Respondent 3 is Respondent 2's principal broker. Complainants state that after a long presentation, complainants decided to sign the paperwork to purchase the timeshare. Complainants state that after the purchase, complainants told Respondent 2 that they wanted to cancel and would call and cancel the next day. Complainants then state that they called the next day and told another individual that they wanted to cancel the contract, and that individual told
Motion to dismiss.
Second.
Have a motion by Commissioner DeShar and second by Commissioner Collins to dismiss these three complaints. Do I hear any, or is there any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 25 and 26 is next.
2013018921, 2013019021. TREC opened complaint based on information from the internet provided to the TREC office regarding a business which is not located in the same location as Respondent 1's affiliate broker firm, which appears to indicate that the company is involved in renting and selling homes. Respondent 2 is Respondent 1's principal broker, and a complaint was opened for a potential failure to supervise issue. Respondent 1 states that Respondent 1 is also a real estate investor who purchases properties on the open market and always discloses to Respondent 1's licensure when doing so, then rehabs the properties and offers them for sale or rent, again disclosing Respondent 1's licensure status. Respondent 1 states that Respondent 1 does not represent third-party buyers or sellers, does not manage, buy, or sell properties that Respondent does not own and are not owned by an entity Respondent 1 controls. Respondent 1 states that Respondent 1 uses Respondent 1's license occasionally to sell or rent property through the MLS and operates under the discretion and supervision of Respondent 2 and firm when Respondent 1 lists properties for sale or rent on the MLS system. Respondent 2 states that Respondent 1 has been affiliated with Respondent 2's firm for quite some time, and Respondent 1's business operation was discussed very early on, and disclosure requirements were also discussed. Respondent 2 states that Respondent 2 has verified that Respondent 1 and spouse own the business advertised on their website, and they buy and sell properties for themselves without representing buyers or sellers. Respondent 2 states that when Respondent 1 does list a property on the MLS for Respondent 1's company through Respondent's firm, a personal interest disclosure is signed. Based on the information provided and obtained, that does not appear there's a violation by Respondents, and therefore the recommendation is to dismiss.
So moved.
Commissioner Deschar makes a motion to take council's recommendation to dismiss, and Commissioner Frank seconds that motion. Any discussion or questions or comments? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Number 27.
20130192221. Complainant signed an exclusive buyer representation agreement with Respondent, principal broker, and Respondent's firm for a term of 5 months. Approximately 3 months later, complainant filed this complaint and stated Respondent had failed to find a house for complainant. The complainant asked Respondent to be released from the contract, and that Respondent refuses to release complainant from the exclusive buyer representation agreement. Complainant alleges that Respondent would not answer complainant's phone calls. Complainant feels that Respondent is being unfair, and complainant needs housing with all of complainant's belongings being in storage, and complainant states that the bills are adding up. Complainant wants to be released from the contract with Respondent. Respondent submitted a response to an attorney denying all of complainant's allegations and stating that Respondent made every effort to assist complainant in locating a home and maintained constant communication with complainant during the time the parties worked together. Respondent states the complainant did not have email or text messaging, so it was challenging to get the home information to complainant. Further, Respondent states it was difficult to locate properties and schedule showings for complainant because complainant often changed complainant's mind about what type of home complainant was looking for, and complainant only had specific days and times that complainant could even look at homes. Respondent attached documentation which including listings that Respondent gave complainant, as well as Respondent's call log showing how many times Respondent phoned complainant. Respondent states that Respondent received a call from another agent stating that complainant was in their office, and the agent realized that complainant had a contract with Respondent. The agent informed Respondent that complainant had just made an offer on the home which the agent had submitted to the agent's seller. Respondent alleges that in the background, Respondent could hear complainant stating that complainant wanted to be released from the contract from Respondent. Respondent states that Respondent never told complainant that Respondent would not release complainant from the contract, only that Respondent needed to consult with Respondent's firm and get back with complainant about this matter. Respondent states that ultimately Respondent did release complainant from the contract as Respondent did not feel their business relationship could be salvaged. Based on the information provided, it does not appear there is a violation by Respondent. Therefore, the recommendation is to dismiss.
Move to approve.
Second.
Motion by Commissioner Frank, second by Commissioner McMullen to take council's recommendation to dismiss. Do I hear any discussion on this motion or questions of Julie? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 28.
20130192281. Complainant contacted Respondent, affiliate broker, regarding complainant's interest in purchasing a home. Complainant states that Respondent encouraged complainant to look at a house in an area complainant states complainant did not want to live. Complainant states the complainant was interested if the home was completed, and complainant made an offer for the asking price based on advice from Respondent. Complainant states that Respondent encouraged complainant to have a home inspection and recommended a home inspector. Complainant states that when complainant asked if complainant would be present during the inspection, Respondent told complainant that complainant could come when the inspector finished. When complainant arrived, complainant said the inspector was present but finished, and complainant noticed sinks that were leaking underneath and toilets that were not mounted to the floor. Complainant states that complainant pointed out the leaks to the inspector, and the inspector stated he did not notice the leaks when he ran the water. Complainant states that complainant contacted Respondent multiple times before the closing date regarding another walk through the home, and approximately 1 week before the closing date, complainant states the parties met at the home for a walkthrough. Complainant states that soon after complainant arrived, Respondent had to leave, and complainant only quickly viewed the home. Complainant states the closing took place, but complainant was unaware that complainant could request to wait to close until complainant had a final walkthrough. After closing, complainant states that complainant and family members went to the home and noticed the electric wiring was not correct and needed rewiring. The toilets are stopped up and there was water underneath the seat. LLC. Complainant states that respondent contacted the seller to send over a plumber who attempted to fix the issues. Complainant alleges that complainant continues to have multiple problems with the home, including plumbing issues and raw sewage just running into the tub, as well as issues with the smoke detector and the wiring and electricity. Complainant feels that the home inspection was completely invalid and states that the city told complainant that the seller never pulled permits to remodel the home. Complainant states the home is unlivable. Respondent states that complainant was on a budget and needed a seller to pay closing costs as well as down payment assistance, and complainant was interested in 2 specified zip codes and move-in condition homes. Respondent states that respondent worked to find a home that met the criteria. Respondent states that respondent then discovered a for sale by owner home which appeared to meet all of complainant's needs. Respondent states that respondent recommended offering the asking price to complainant due to complainant needing the seller to provide realtor fees, buyer closing costs, and prepaid expenses, and respondent have researched comparable sales. Respondent states that complainant did not want to have a home inspection, but respondent encouraged complainant to have the home inspected, and because complainant needed to post-date a check for the inspection, respondent states that respondent helped locate an inspector who would agree to do this. Respondent states that respondent tells all clients it is best to arrive at the home inspection during the last 30 to 45 minutes of the inspection as to not interfere with the inspector's job. After the inspection, respondent states that complainant gave respondent a list of repairs, replacements for the seller to complete prior to closing, which respondent listed in a buyer inspection contingency removal notification form, which was signed by complainant and agreed to by the seller. Respondent states on the final walkthrough, complainant arrived an hour late. Respondent states that a respondent had arrived on time and had viewed the property, but asked complainant to quickly do the same, and respondent states that complainant walked around with a notepad and appeared satisfied. Respondent states that respondent told complainant that if complainant wanted to walk through again later that day or on the following Monday, please let respondent know. Respondent states that all documents were signed and all parties appeared satisfied at closing. Respondent states that respondent represented complainant to the best of respondent's ability. Respondent states that the respondent sent a letter to the seller after the closing listing outstanding issues with the home that the seller had agreed to fix but apparently did not, and the items were not detected during walkthrough. Respondent states that the complainant sued the seller and respondent attended the court date with complainant to support the complainant. And complainant told respondent that complainant was suing the home inspector next. Based on the documentation provided, it appears that respondent had all documentation signed and appears to have answered and attempted to respond to complainant's issues. The recommendation is to dismiss.
Any questions of Julie? See her recommendation.
Move to approve.
Commissioner Franks makes a motion to approve council's recommendation and dismiss. Do I hear a second? Second by Commissioner McMullen. Any discussion or questions of Julie? Hearing none, all in favor say aye. Opposed, no. Motion carries. Number 29 is next.
2013019401. Complainants state that they looked at rental property listed through respondent's firm and filed a rental application, paid the fee for a background search and credit check, and paid a deposit on the property. Complainants state they were passing through on their way to a funeral in another state and did not have a date readily available to move in at the time due to personal circumstances. Later, upon returning home to another state to prepare to move, complainants state they had a situation arise which made it impossible for complainants to move in the near future. By this time, it was approximately a month and a half after complainants had viewed the property, filled out the rental application, and paid the deposit. Complainants state that they asked for the deposit back and were told they would not get it back as it had been given to the property owner. Complainants believe that since no lease was signed and complainants were told that the money was refundable, that complainants should get their deposit money back. Respondent submitted a response stating that complainants submitted rental applications and paid the deposit. Respondent states that approximately 1 month later, respondent's assistant sent an email to complainants which attached a lease to be signed and returned with the first month's rent to start approximately 2 weeks later. Respondent states, and a copy was provided, that one of the complainants responded by email stating that complainants would not be able to move due to financial situations and the owners could keep the amount given by respondents as the deposit. Respondent states that the deposit was released and mailed to the owner on that date. Based on this information, it does not appear to be a violation by respondent. Therefore, the recommendation is to dismiss.
So moved.
Second.
I have a motion by Commissioner Deshard, a second by Commissioner McMullen to dismiss which is council's recommendation. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
2013019451, 2013019452. Complainant, a licensee, states that Respondent 1, unlicensed individual, leases homes owned by military personnel. Complainant states that one of complainant's licensees rented a property which was not owned by Respondent 1 and made rent checks payable to Respondent 1 and contacted Respondent 1 when repairs were needed. Complainant states that Respondent 2, an unlicensed individual, is an HVAC contractor handyman who may be working as a property owner to working working as a property management, working in property management as well. I'm sorry. Complainant states that complainant checks a for sale by owner website and contacts unrepresented sellers, and in one circumstance, the inquiry was not sent to an owner but to respondent one, who was apparently the contact on the listing and who replied to complainant's email regarding the property. Complainant attached an email thread wherein respondent one informed a party that respondent one only leases to military. Complainant also attached a for sale by owner online listing wherein it appears that respondent one's first name is the contact in an email chain between complainant and respondent one, wherein respondent one replied to complainant's inquiry regarding the advertised property. Respondent one submitted a response stating that respondent one primarily provides maintenance management services and does not receive any fees, commissions, etc. to promote the sale or lease of properties. Respondent one states that respondent one provides maintenance tasks for the homes and is allowed full access to the home, and in doing so is asked to allow owners to gain entry into the house by the owners. Respondent one states that respondent one has assisted some, including the owner of the home that was advertised online and referenced by complainant, advertised their homes online at no charge. Respondent one states that when some owners transfer from the area, respondent one is asked to provide maintenance for the homes, and respondent one has never received any sort of compensation other than for maintenance of the home. After receiving the complaint, respondent one states that respondent one was advised that respondent one should collect monthly maintenance fees from the owners directly and not handle any lease payments in any capacity. Respondent one states that the maintenance fees are not associated with collecting a rent payment. Respondent 2 states that the complaint against Respondent 2 is unfounded, and Respondent 2 was asked to do maintenance on the home after the contract with complainant's firm expired with the homeowner. Respondent 2 states that complainant told Respondent 2 that Respondent 2 needed a license, but Respondent 2 states that Respondent 2 does not need a real estate license to do maintenance because Respondent 2 is a licensed contractor. Respondent 2 states that Respondent 2 does not receive any fees for anything other than maintenance and repairs. The information provided indicates that Respondent 1 has been performing services requiring real estate licensure. However, it does not appear based on the information provided that Respondent 2 is performing anything other than maintenance work. The recommendation is to close as to Respondent 2, as to Respondent 1, a consent order for $500 for unlicensed activity in violation of Tennessee Code Annotated Sections 6213-103 and 6213-301, also including an order to cease and desist all unlicensed activity.
Make a motion, we accept your recommendation.
I'll second that.
Motion by Commissioner Collins and second by Commissioner DeShar to take Ms. Kropp's recommendation that she has read into the record. Any discussion?
I'd like to know why we couldn't charge the owner for paying a commission to an unlicensed person. That'd be nice, wouldn't it? I'd cut that out in a hurry.
And is $500 the standard amount that this commission usually?
No.
It depends on the circumstances. Here, it depends on a variety of factors, and I can point you to in the rule for the civil penalties. In subsection 4, it says, in determining the amount of a civil penalty, the commission may consider such factors as the following: A, whether the amount imposed will be a substantial economic deterrent to the violation; B, the circumstances leading to the violation; C, the severity of the violation and the risk of harm to the public; D, the economic benefits gained by the violator as a result of noncompliance; and E, the interest of the public. The range for unlicensed activity, I believe, is $50 to $1,000. Here, sometimes it is much more straightforward that there's a wider operation base of some of these people. Here, it didn't indicate that, which was the reason for my recommendation. But like I said, this is only about halfway of the maximum. So.
Any other discussion? We have a motion and a second on to take council's recommendation. Any other comments or questions? If not, all in favor say aye.
Aye.
Opposed, no. Motion carries. We only have 2 more complaints, and then we're going to let all you attendees leave.
2013019-581. Complainants purchased a timeshare from respondent, timeshare registration in 2005, and state they've been trying to give it back since that time. Complainants allege that several verbal misrepresentations were made during the sales process, including but not limited to that respondent would take the timeshare back if complainants did not want it, that complainants would be able to travel wherever they wanted to go, that the timeshare would appreciate in value, that a rental program would make...
Motion to dismiss.
Second.
I have a motion by Commissioner DeShara and a second by Commissioner McMullen to take council's recommendation and dismiss this complaint, which is pertaining to timeshare. Any discussion on the motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 33.
20130200201. Complainant purchased a timeshare from respondent, timeshare registration in 2000. Complaint states that at that time, complainant was not told...
Motion to dismiss.
Second.
I have a motion by Commissioner DeShara and seconded by Commissioner Collins to take council's recommendation and dismiss this complaint. Any discussion? Any questions of Ms. Kropp? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
That's all I have on my report, and we covered everything else under my listing.
Everything
this
else in the
morning.
legal report has been covered, and at this time, Mr. McDonald, all these attendees are your responsibility. Address them.
Hello. When you sign out today, make sure that you do so in the correct portion of the sign out sheet. I'll tell you tomorrow we do have a formal hearing. So we will begin at 9 o'clock with an administrative law judge, and this will be similar to a court setting. So I urge you, plan your bathroom breaks accordingly and make sure your cell phones are on silent, as the proceedings tomorrow will be a little more formal, more so than today. Be careful going home, and we'll see you bright and early tomorrow.
Thank you, Mr. McDonald. We'll see all of you in the morning. Is this everything?
Yeah.
Yes.
We are in recess until the morning at 9 o'clock. Mind all of you before we... I'd like to call this second day of the Tennessee Real Estate Commission meeting back into session. And at this time, I would like to turn the proceedings over to Judge Williams, who's going to be handling our deliberations for today. Judge Williams?
Thank you, Mr. Chairman. Today is Thursday, February 6th, the year 2014. This is a hearing conducted by the Tennessee Real Estate Commission. Today's commission is chaired by Mr. Bear Stevenson, and it's going to consider the case of Kenny Medlin, an unlicensed person, docket number 12.18-122766A. Assistant General Counsel Robin L. Ryan represents the state in this matter. Mr. Kenny Medlin is present today and is represented by Ms. Alex Scarborough of the Nashville Bar. My name is Madeline Williams, and I've been assigned by the Secretary of State to serve at this hearing as administrative judge. I'll make rulings regarding the order of proceedings, the admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but I will not participate in the findings of fact or the ultimate decision of this board. Those decisions will be made by the commission members. At this time, I would ask the commission members to introduce themselves for the record, starting with the gentleman to my right.
Austin McMullen.
Gary Bloom.
Marcia Franks.
Bear Stevenson.
Janet DeChara.
Grover Collins.
Thank you, and there is a quorum of the commission.
Yes, Your Honor.
Members of the commission are reminded that during the time this hearing is being conducted, no discussion of this case should take place between commission members, witnesses, attorneys, or other persons unless all parties are present. This commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires that all commission discussions and deliberations be in public before all parties. Failure to observe the Sunshine Law may result in the board's action being reversed or remanded if appealed. Commission members, you should not draw any conclusions until all of the proof has been submitted. Please listen to all of the proof with an open mind. I would ask the state to distribute the notice of hearing and copies of the law and applicable rules at this time. Before going further, I would remind the members of the commission that the law requires you to disclose on the record any outside knowledge of this case or any communications, written, verbal, or otherwise, from any parties concerning this case. Please take the notice of hearing and examine it to determine whether or not you have a conflict of interest with serving, or whether you have outside knowledge of this particular case. Commission members, have you had an opportunity to review the notice? Does anyone have anything to disclose? During the course of this hearing, there'll be an opportunity for each of you to question each witness that testifies under oath. Please use your questions as opportunities to gain any clarifications of the facts that you feel would assist you in reaching a decision in this case. However, you must reserve any expression of opinion you may have to that portion of the hearing that's set aside for the board's deliberations after all of the proof in this matter has been heard. The pre-hearing technical record in the Kenny Medlin matter includes the following: September 18th, 2013, notice of hearing and charges. September 20th, 2013, opening letter from Administrative Judge Leonard Pogue. October 22nd, 2013, the state's witness and exhibit list. October 22nd, 2013, notice of appearance via affidavit. November 15th, 2013, order of continuance. January 3rd, 2014, notice of appearance of counsel. At that time, Ms. Melissa Burton as well as Ms. Alex Scarborough. January 3rd, 2014, respondent's motion to continue hearing. January 15th, 2014, order of continuance. January 22nd, 2014, transfer order. January 28th, 2014, state's motion to have witness appear by telephone. January 31st, 2014, respondent's motion in limine to exclude evidence outside the scope of the notice of hearing and charges. February 2nd, 2014, state's response to the motion in limine. February 3rd, 2014, order denying the motion in limine. Are there other documents and pleadings that the parties have filed that I've failed to mention, Ms. Ryan?
Her witness and exhibit list, is that in there?
It was not in my file. Did you file your witness and exhibit list, Ms. Scarborough?
No, Your Honor. My reading of the rules was that the witness and exhibit list needed to be disclosed to opposing counsel. I have a copy of it for Your Honor and for the board at this time.
Okay, it's just a question of whether you want it to be part of the technical record or not.
Yes, Your Honor, at this time, I'd like to move it into the technical record, if there's no opposition. But
I have no objection.
Okay. All right, then it will be added to the technical record.
Your Honor, if I could, even though we have a court reporter, we tape all of these proceedings, video them, and I'd like to ask that people who talk talk into the microphone so we can have a good audio of it.
yes, sir. Thank you.
The respondent's witness and exhibit list is added to the technical record at this time. At this time, I'd like to swear in all of the witnesses. One witness is going to be appearing by telephone, so he'll need to be sworn separately. But for the other witnesses who are in the audience, I'd like to go ahead and swear them in.
Your Honor, one of our witnesses has stepped outside. Would you like us to bring him back in or swear him in when he comes in to testify?
We can swear him when he comes to testify. But for those of you who are in the room right now, and let the record reflect that 1, 2, 3, 4 persons are being sworn at this time, do you swear or affirm that the testimony you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. And you, sir? Oh, okay, I thought I saw your hand earlier, so then 3 people were sworn. Does either party desire the rule of sequestration?
Yes, but it's already been addressed.
Okay, so that one witness who's not going to be the party representative has already been excluded until it's time for his testimony. Are there any preliminary motions or stipulations?
Not for me, Your Honor.
Not at this time, Your Honor.
Opportunity for opening statements?
Please. Good morning. As you already know, this is a matter of question about whether or not there was unlicensed practice. And this matter, as you already heard, was initially set in November, and the request to respondent was continued because he had an attorney who couldn't be here, and then continued to January again for his new attorney to be able to present this before you all this morning. This is a matter of unlicensed practice concerning someone who once was a licensee. The proof will show that he had that license. It expired in 2002. And he attempted to secure another license in 2006, but it was denied by the commission as a body because he had a conviction of a conspiracy in federal court. Since then, the proof will show Mr. Medlin has had no license and has made no further attempts to secure a license. This present matter was opened after a complaint was filed by Mr. Ping Kui, and I'm not certain I'm pronouncing his name correctly, concerning business dealings with Mr. Medlin. Proof will show that Mr. Medlin negotiated with Mr. Kui for an investment for a condominium unit, and that negotiation included a purchase and sale agreement which was presented on a commercial purchase and sale agreement document form, a copyright form of the Tennessee Association of Realtors, and that Mr. Medlin provided the form, filled the form out, presented that form for Mr. Quee's approval, and that further included in this negotiation was a payment of earnest money to be held by Dan Stewart Realty, a real estate firm owned by Mr. Medlin. The proof will show that at all of these business transactions, Mr. Quee was already a client of Dan Stewart Realty with that company on a property leasing agreement. Proof will show that the totality of these facts and actions led him to believe that Mr. Medlin was licensed as a broker in Tennessee, as this respondent held himself out as a principal of Jam Investments, the company that was one of the parties to the business agreement, and as Dan Stewart Realtors. Proof will show that Mr. Medlin states that he is the managing and sole member of Jam Investments, who is the sole owner of Dan Stewart Realtors, and that although in his response he alleges he is not present on any Dan Stewart website in any fashion, instead, however, the proof will show he is listed as the person to call for anything to do with property management. These actions by Mr. Medlin, we assert, are deceptive and leads one and can lead others to believe that he has a license within this state. And his actions are such that would require a license and are violations of 62-13-301, which finds it unlawful for any person who directly or indirectly engages or advertises or claims to be engaging or conducts the business or acting in the capacity of a real estate broker, as defined in 62-13-102. That section states that a broker is any person who, for a fee, commission, finder's fee, or any other consideration, or with the intent or expectation of receiving that money, does things that require a license. In this case, the proof will show Mr. Medlin was acting as a representative of Jam Investments, which is owned solely by Mr. Medlin, which owns Dan Stewart Realty, again owned solely by Mr. Medlin, and that he used a real estate, the firm, which he stated is owned by Jam, for the escrow money, used forms that are only really allowed to be used by those who are members of TAR, and instead used it anyway, and he advertises on his company website as the contact person for real estate issues. Therefore, when you consider the facts in total, we would ask that you find that he is indeed practicing without a license, and that he should be punished by being assessed an appropriate penalty pursuant to 1260-0232, that because of this and because we're here today because of this entire matter, and if you so find, that he be required to pay all the costs in this matter, and that this matter be part of his record in the future, so it might be considered if he again attempts to apply for a license with this state. Thank you.
Thank you. And Ms. Scarborough?
Good morning. Ladies and gentlemen of the Real Estate Commission, thank you for your time today. I know it's very valuable, so I'll do my best to use your time efficiently. We're here today because the Department of Commerce and Insurance has alleged that my client, Mr. Kenny Medlin, acted as a real estate broker without being licensed as one. The department, in fact, as you've read through the notice of hearing and charges, alleges essentially two things. One, that he acted as a real estate broker, and two, that he presented himself or advertised himself as a real estate broker. The proof today will show that neither of these allegations are true. The evidence will show that Mr. Medlin has not been a licensed real estate broker since 2002. Since that time, he has never acted or advertised himself as a broker. In fact, you will hear testimony today that Mr. Medlin has proactively told others that he is not a real estate broker. A Mr. Ping Kui, who initiated the complaint today, will also testify. Mr. Kui may try and present himself as an unsophisticated, out-of-towner who was tricked by Mr. Medlin. Ladies and gentlemen, this is simply not true. You will hear today that Mr. Kui invested in numerous properties in and around Memphis. You will hear that he had a real estate agent, Jim Pickens, representing him in a number of these transactions. You will learn from the evidence that he is, in fact, very experienced in the real estate world, particularly in Memphis. You will hear that Mr. Medlin is the owner of JM Investments, LLC, which is the sole owner of Dan Stewart Realtors. You will also hear that Mr. Quee, as buyer, and Mr. Medlin, as seller, entered into a commercial purchase and sale agreement for the purchase of property located at 1837 Union Avenue. You will also hear that Mr. Quee claims that somehow in the course of this transaction, he was under the impression that Mr. Medlin was a real estate broker. However, you will hear from Mr. Medlin and a Mr. William Gibbons, who's a business associate of both Mr. Medlin and Mr. Quee, that this is not only entirely false that Mr. Medlin represented himself as a real estate broker, but that in fact, on different occasions, Mr. Medlin specifically told Mr. Quee, I am not a real estate broker. If you have a question about a certain thing, you should ask your real estate broker about that. Ladies and gentlemen, you will hear today testimony concerning the business transaction of the property at 1837 Union Avenue. You will also hear other testimony about the business relationship between Mr. Quee and Mr. Medlin. I respectfully have two requests for the Commission today. One, focus on the facts that are relevant to the charges before the Commission today, which is whether or not Mr. Medlin acted as or presented himself as a real estate broker to Mr. Quee or to others. And two, focus on the truth. The case really boils down to the statements of Mr. Quee and the statements of Mr. Medlin's and others who you'll hear statements from today. Mr. Medlin could have settled this matter months ago, paid a fee, ended things. Instead, he has incurred great costs and time and effort in order to clear his good name. If Mr. Medlin was guilty, it simply wouldn't be efficient or make sense for him to be before you today. Mr. Medlin is an honest businessman, and he's here today to clear his good name. I appreciate your time and consideration in helping him do so.
Thank you. Your first witness, Ms. Ryan.
I will call Mr. Ping Quee, who will testify by telephone. It'll take us a moment to get him connected with us. No, I'm not going there. Okay.
Hello?
Can you hear me okay?
Yes.
Okay. Miss Ryan?
Mr. Can you tell me if you pronounce your last name Quee or Key?
Cho.
Cho. Boy, was I off. Okay. Mr. Cho, the judge is going to ask you to be sworn in, and I'll turn this over to her at this moment.
All right.
Okay.
Mr. Crowe, if you'd please raise your right hand after me.
Okay.
Do you swear or affirm that the testimony that you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right.
Thank you.
You may proceed, Ms. Ryan.
Would you state your full name for the record, please?
My full name is Ping Cho.
Ping Cho. And what is your address, Mr. Cho?
I'm in Cranberry, New Jersey.
Okay. Okay. And how do you know the respondent, Mr. Kenny Medlin?
I was introduced by my previous property manager, Mr. Gibbons.
And Mr. Gibbons was your previous property manager?
Property manager, property manager. I acquired one property in Tennessee, in Memphis, and he was my property manager. And then at some point, he merged with Miss Medlin's company.
Okay. And did you ever do real estate then business with Mr. Gibbons?
You mean
As-
buy,
yep.
sell? No.
But
Except,
property
you know,
management.
property management, yeah, that's correct.
To your knowledge, is Mr. Gibbons a licensee?
Well, I think he mentioned that to me. He is also licensed.
Okay, thank you.
Yeah.
So, why then were you introduced to Mr. Medlin?
Well, as I mentioned, you know, Mr. Gibbons' company merged with his company, so in some sense, my property was managed by Mr. Medlin's company, and then back in 2011, and I think end of 2011, Mr. Gibbons sent me an email that he has a investment opportunity, you know, which is Ms. Medlin get involved. That's why I get to know Ms. Medlin.
Now, what company did Mr. Medlin say he was involved in? What company?
Well, he's the owner of the Dan Stewart Realtor,
Mm-hmm.
and for that particular investment property, he said he set up another company just to hold the property that he's purchasing and doing financing.
Mm-hmm.
That company is called JAM Investment.
Okay. What was the business proposal to you from Mr. Medlin?
His original proposal is to kind of joint ventures, but I disagreed. I said I only interested in purchasing property and own the property. So we negotiated and then come up with the sales contract that I have sent to the commissioner.
And was that sales contract on a form?
Yes.
Okay. What company was on the form as the company was representing you or Mr. Medlin?
The company on the form is JM Investment. And at that time, I believe the Mr. Medlin was representing, because he's the seller, and I was representing the seller himself.
So, was Dan Stewart Realtors representing Mr. Medlin at all in this transaction?
I believe so, because that's under my impressions. Because he drafted all those. At one point, I even think he representing me is the kind of dual agent, because he drafted all the sales contract, and the earnest money was held in Dan Stewart Realtor earnest money account.
Okay. Did you have any separate party representing you in this? Another realtor or anybody else?
No, I do not.
Where was the earnest money to be held?
On the contract, the earnest money was to be held in Dan Stewart Realtor escrow, earnest money escrow account.
And how much was that earnest money?
The total is $40,000. I wired in 2 batches.
Okay.
And later I find out, it's not the case. The earnest money account, the account number do not match with the name of the. The account number do not match the Dan Stewart Realtor earnest money account.
Okay. What did Mr. Medlin tell you would be JAM's Investments' involvement in this transaction?
I believe is the company that's going to purchase that Union Avenue property and also do the rehab financing. Get loan to hold the loan for the rehab finance.
Now, prior to this or during this, you had other properties being represented or working for you from Dan Stewart Realty. Is that right?
That's carried over by Mr. Gibbons.
So, the properties that you had were now being managed by Dan Stewart Realty because Mr. Gibbons brought those properties to Dan Stewart Realty?
Excuse me, I did not get that question. Could you repeat that question, please?
Sure. The other properties that you owned were, at the time, now being managed by Dan Stewart Realty because Mr. Gibbons brought them to Dan Stewart Realty?
That's correct.
Okay. Did Mr. Medlin ever tell you exactly that he was a licensee?
He did not say. I don't believe he states specifically because this never become a question to me, and it becomes a discussion. And he's the owner of it seems to be quite big real estate company.
Did you ever doubt or question or wonder if he was a licensee?
No, actually, I did not.
Well, what happened to this sale? Did it go through?
No, not at all.
Okay. And I know there was a request for the return of the earnest money. Was it returned to you?
Objection.
No, it did not.
Objection, Your Honor, as to relevance, as to how this relates, as to whether or not Mr. Medlin represented himself as a broker to Mr. Cho.
My response is, it is a part of the entire transaction, and one of the many factors they must consider, especially in light of the fact that Mr. Medlin was a licensee at one point, and he should know better about how he handled it and the issue of the earnest money and how it would be handled in the transaction because he was a licensee, and Mr. Medlin, in his actions, led him to believe that this money was being held by Dan Stewart Realty, and that's all part of the transaction here today. And it's part of the reason that he thought he was represented.
Any further argument, Ms. Scarborough?
Your Honor, I just renew my motion to limit evidence outside of the scope of the notice of hearing and charges, particularly evidence that's relevant to the matter at hand. This is certainly more prejudicial than probative at this time.
I believe that fact was in the notice of hearing and charges that the earnest money was requested and not returned.
Right, I believe that was in the notice of hearing. So then your objection is overruled.
Now, Mr. Cho, you then, I know, and I'm not going to get into any of this, I know that you have actions outside, not just this action for the Real Estate Commission, but did you provide a copy of the contract and other documents to the commission when you opened this complaint?
Did I?
Yes.
Could you repeat that question? Please?
Yes. Did you, when you filed this complaint, did you provide to the commission a copy of that contract that was on the TAR form and other documents concerning this matter as a part of your complaint?
Yes, I did.
I have no further questions at the moment for this witness.
Cross-examination.
Hi, Mr. Cho. My name is Alex Scarborough. I represent Mr. Medlin in this action. I just have a couple questions for you, if that's okay.
That's okay with me.
All right. Thank you. Mr. Cho, did you request an introduction to Mr. Medlin from Mr. Gibbons?
Request an introduction?
Yes.
Well, it's over the phone. Mr. Gibbons told me who he is. That's about it. And then Mr. Medlin called me and, very brief.
All right. And again, what was the purpose of the introduction to Mr. Medlin?
It's not really an introduction. It's an introduction about a business investment opportunity.
So the first time you talked to Mr. Medlin, the purpose of that first phone call was regarding an investment opportunity at 1837 Union Avenue. Is that correct?
That's correct.
So you didn't have any conversation with Mr. Medlin regarding property management or anything prior to that initial discussion regarding the investment opportunity at 1837 Union Avenue. Is that correct?
We had some interaction that's through emails, but I have never paid too much attention to it because I thought it just, because Mr. Gibbons was my property manager, and then the realtor was doing the invoice and rent roll deposit. So I never paid too much attention to, the email correspondence, but there's nothing no discussion with anything except the invoice and the rent roll.
So was Dan Stewart Realtors providing property management services to you prior to your conversation with Mr. Medlin regarding the investment opportunity at 1837 Union?
Could you repeat that question? Your voice is a little broken.
Sorry about that. Was Dan Stewart Realtors providing property management services to you prior to your conversation with Mr. Medlin about the investment opportunity on Union Avenue?
Yes, but that was because Mr. Gibbing was merged with Dan Stewart Realtor at that time. So it's carried over by Mr. Gibbing. I had no direct interaction with Dan Stewart Realtor before. Mr. Gibbing introduced me. Mr. Gibbing merged with his company.
Okay. And in Dan Stewart's role as your property management company, at any time did you deposit money for any reason into the Dan Stewart Realtors escrow account?
Yes, there's some deposit. I believe it's on the rehab of one of the properties. So he's holding the money for Ms. Gibbings. Before release to Ms. Gibbings, that money was held by Dan Stewart Realtors.
And did Dan Stewart Realtors then release that money to the appropriate party?
I believe so, because it seems to be paid to Ms. Gibbings.
Were there any other occasions that you placed money in the Dan Stewart Realtors escrow account?
I'm going to object to the relevance.
The relevance, Your Honor, is Mr. Cho's comfort and ease with Dan Stewart Realtors and his knowledge and comfort with placing money in the escrow account at Dan Stewart Realtors. Because that is being alleged as circumstantial evidence that he thought Mr. Medlin was a broker.
I renew my objection as the relevance. Unless there's an exact connection somehow between Mr. Medlin and these other deposits, I'm not sure what the relevance is.
Your Honor, the relevance is if Mr. Cho had placed money numerous times in the escrow account with Dan Stewart Realtors, that using Dan Stewart Realtors' escrow account for a later transaction would be a place where he felt comfortable placing money, so therefore it would not lead to the inference that he thought Mr. Medlin was a broker. It goes directly to one of the three alleged circumstances by which Mr. Cho thought Mr. Medlin was a broker.
Your Honor, the comfort level of Mr. Cho is not the issue. It's the actions of Mr. Medlin that are the issues today. And all the circumstances surrounding, I guess, including his prior history with Dan Stewart Realty, which is owned solely by Mr. Medlin, I still renew it as any other escrow deposits as being relevant to the issue today. This was a separate transaction dealing with Mr. Medlin separately.
I'm going to overrule your objection.
Mr. Cho, I'll ask that question again for you. On any other occasions, did you deposit money in the escrow account at Dan Stewart Realtors?
In any other case, except those I just mentioned, except those rehab money.
When you place money in the account, the rehab money, was that a number of times? Was that just one time? Can you describe for me that?
A couple of, I remember once. Maybe second time I don't remember. It's been 2 or 3 years.
Okay, that's fine.
That's a small money. Yeah, that's a small money.
When Dan Stewart Realtor served as a property management company for you, who was your person to contact at Dan Stewart Realtors?
It's Mr. Gibbons.
Mr. Gibbons was the only person that you interacted with at Dan Stewart Realtors in relation to their property management services. Is that correct?
That's correct. Except at some point, Mr. Medlin was doing the rent roll statement. I occasionally got email from that on that part.
Okay, and who is Miss Medlin?
What do you mean, who is Miss Medlin?
What is your understanding of her role? Does she work for Dan Stewart Realtors?
Well,
I'm going to object. I think that is a question without foundation. There's been no even question of whether he knows whom, if he knows her. I think we need to establish that before we can establish whether or not he had any contact with her or any work with her.
Your Honor, Mr. Cho just mentioned that he worked with Mr. Gibbons and Miss Medlin at Dan Stewart Realtors. So he mentioned her name.
I thought he said Mr. Medlin, so maybe we need to
Miss
clarify.
Medlin, yeah.
If you could ask the witness, was it Miss or Mr. Medlin, please?
Mr. Cho, are you saying Mr. Medlin or Miss Medlin?
Mr. Medlin.
Okay.
Oh, okay.
My apologies. I misheard you.
No problem.
Mr. Cho, where do you live again for the court?
I live in Cranberry, New Jersey.
Do you own any property currently in Memphis?
No.
In the past, have you ever owned property in Memphis or the Memphis area?
In the past, what do you mean in the past?
Have you ever bought or sold property at any point in Memphis or the Memphis area?
Yeah. That's why the property manager was involved, right? But I sold them all because I suffered quite some loss over there.
Roughly how many properties have you bought and sold in the Memphis area?
Could you repeat that question?
How many properties have you bought and sold in the Memphis area?
How many? With Mr. Gibbons, there's 2 properties associated with Dan Stewart Realtor.
Not associated with Dan Stewart Realtors, how many properties have you bought and sold in the Memphis area?
Do I have to answer that question? Because I don't think it's relevant.
Unless one of the attorneys objects and the judge rules that you don't have to answer it, I believe you have to answer it, Mr. Cho.
Okay, that's fine. I have a total, I have other 8 with other property company.
And who is the other property company?
What is that?
You said you had a number of other properties with a different property company. Who is the other property company?
That's another other company. It's called Hardcore.
And Mr. Cho, did you ever have a real estate broker representing you in any of those other transactions?
Yes, I do.
And why did that real estate broker not represent you in the transaction involving the property at 1837 Union Avenue?
Because this is a separate transaction, and the property doesn't even exist at that time. Because Ms. Medlin is purchasing it, and there's no. It's not I'm not bounded to the other realtor.
Did Mr. Medlin ever tell you that he was a real estate broker?
That never comes to discussion.
Did Mr. Medlin ever tell you that he was not a real estate broker?
No, he did not.
Hang on just 1 second, Mr. Cho.
Your voice is broken again. Is that a question?
No, sir. Hang on 1 moment.
Okay.
Mr. Cho, just for the record, who was your real estate broker who represented you in some of those transactions in Memphis?
Who is that broker?
Yes, sir.
Is it Jim Pickens?
And what company was Mr. Pickens with?
He changed name a couple of times. I believe it's called Blue Skies is the current name.
Mr. Cho, just one other question for now. You said earlier that Mr. Medlin set up JAM Investments just for the purpose of the transaction at 1837 Union. Is that correct?
That's my understanding at that time.
And what was the basis for that understanding? Did someone tell you that?
I think Ms. Medlin told me that in the phone conversation.
Mr. Cho, thank you for your time. Those are all my questions at this time.
Thank you.
Any redirect for your witness?
Just one or two. Mr. Cho,
Yes.
you said Mr. Gibbons was representing you as your property manager before he got to before he went over to Dan Stewart?
He is he is my property manager before he got brought into Dan Stewart Realtor.
Okay, and then he went over to Dan Stewart and was the property manager also at Dan Stewart?
Could you repeat that question?
When he became involved with Dan Stewart, was he still managing your properties through Dan Stewart Realty?
That's right.
And you said at one point you did get an email from Mr. Medlin concerning your rents and things on the properties through Dan Stewart Realty?
Yeah, it seems to me that he's doing the rent roll and account payable kind of things.
Okay. Thank you. I have nothing further.
Do you have any recourse?
No, that's all at this time. Thank you.
Commission members, this is your opportunity to ask questions of the state's first witness. Please proceed.
Mr. Cho, you deposited $40,000 in earnest money. And the transaction was not completed. Did you receive the $40,000 back?
No, I did not. I requested numerous times.
Why did you not get it back?
Why?
Why?
Because I was, I contacted Ms. Medlin many times through emails, phone calls, and he's just keep making excuses that, the deal is still going through, and at some point I just cannot wait anymore. I requested, the money to be back immediately, and that also at one point he sent a kind of promissory note saying he's going to, paying back as a loan kind of things, but my attorney objected because it's too loose.
Okay, and you also said that he had deposited not in his escrow account but into another account. And how did you know that, and what account did he deposit it into?
So after I demand the return of the earnest money, did some investigation to see exactly what's going on. So I called the other party's bank, the money in Tennessee, but because of the privacy, they cannot release the name of the name account. But I asked them, is that Dan Stewart Realtor? They said no.
Okay, thank you.
Mr. Cho, this is Commissioner Bloom. I have one question to ask you. It indicates that the contract for the purchase of Union Avenue was on a commercial purchase and sale agreement form used by the Tennessee Association of Realtors. Is that correct?
I cannot tell the difference. It's a standard real estate transaction form.
All right, sir. In the one that I'm referencing, anyway, at the bottom on the last page, it indicates who represented the buyer and who represented the seller. Who was representing you as a buyer in that transaction?
At that time, I'm little. I even believe, Miss Madeline was acting like a dual agent because he drafted the sales contract and
Yes.
directed the escrow account holder.
Yes, sir, I understand that, but what was written in that contract as to who was representing you?
On that form, there's nothing written. I believe there's nothing written on it.
So it was your belief, though, that you're being represented by Dan Stewart Realtors?
Yes, because the money, earnest money, was holding by them.
All right, sir, thank you.
Mr. Cho, this is Commissioner Stevenson.
Hi.
As a follow-up question that Mrs. Commissioner Franks asked you, the $40,000 earnest deposit, have you initiated any kind of legal action to recover those funds, that money?
Yes, I did.
And what happened?
It's still in court pending because it's waiting for the court hearing.
Okay, thank you, sir.
It appears there's no further questions from the commission members. Is that right? Okay. Thank you very much for your testimony.
Thank you.
Thank you.
Okay.
Your next witness.
Call Eve Maxwell.
Your Honor,
Yes,
before she starts, can we have a break?
sure.
Thank you.
Again, my next witness is Eve Maxwell. You've already been sworn.
Yes.
Okay. Would you state your full name?
Eve M. Maxwell.
And your position with the state of Tennessee?
I'm the executive director for the Tennessee Real Estate Commission.
And as that executive director, are you familiar with both the license files and the complaint files of Kenny Medlin?
Yes, I am.
Does he have a current active license?
No, he does not.
When was he licensed?
He was first licensed on 6/19 of 1996. He upgraded to broker on 12/6 of 99, and then upgraded to principal broker on that same day. He became inactive, which means he applied to retire his license, but did not have the education that was required, so that he was placed in a inactive status. At the time, he was a broker trying to get his 120 post-broker hours. And so he was placed in inactive on 12/17 of 01. He downgraded back to an affiliate on 4/4 of 02 because he did not have his post 120 hours as required by statute to be a broker. He retired his license as an affiliate on 4/4 of 02, and it expired on 12/31 of 2002.
And did he ever come and apply again?
Yes, he did. He applied to be relicensed, be able to sit and be relicensed in 2006, and he appeared before the commission. Appeared before the commission on October the 4th of 2006, and asked if he could. He appeared with his broker, who is Joyce Medlin, and requested relicensure as a broker. He had a conviction for mail fraud, conspiracy to commit mail fraud and wire fraud, and that resulted in a sentence and a conviction which he did not report to the commission as required by statute, and that's why he had to come before the commission, and he was not permitted to obtain a license again.
So, since 2002, Mr. Medlin has not had an active license of any sort as a real estate licensee?
That is correct.
Okay. When you get your license in the first place, is there a test involved?
There's a test both for an affiliate broker and for a broker. There's a state test and a national test.
And does that test involve questions about the Tennessee Real Estate Brokers Act?
Yes, it does. The state test does involve only the state statute, the Broker Act and rules.
Okay. Now, in this present matter, what was the reason this complaint was opened?
The complaint was opened because the Tennessee Real Estate Commission received a complaint from Mr. Ping Chow, and it was against Dan Stewart Realtors and Kenny Medlin. And it was, it alleged that Mr. Chow and Jam Investments, which was represented by Kenny Medlin, had entered into a contract which was attached. It was on a Tennessee Association of Realtors form. It was a commercial purchase and sale agreement, and it had Jam Investments as the seller. It was to purchase 10 units at 1837 Union Avenue for $295,000. The buyer, according to the contract which was included with the complaint, the buyer deposited the sum of $40,000 as earnest money. It's in paragraph number 3, which is titled Earnest Money. And that amount of money was to be held by Dan Stewart Realtors at 3205 Kirby Witten Road, Suite 102, Bartlett, Tennessee. It was to be held in their escrow account. And the contract is a multi-page contract, but it was signed by Mr. Chow as the buyer. It appears on 12/29/11, and by Mr. Medlin, Kenny R. Medlin, is the seller on 12/29/11. Mr. Chow said that in his complaint that the deal had fallen through, and he had requested a return of his $40,000 earnest money, and it had not been returned, and that Mr. Medlin owed him the earnest money because the deal fell through, and under the terms of the contract, Mr. Chow said that the money was due to him.
There was a separate contract, wasn't there, concerning that investment that he provided?
There was a pre-sale agreement. There was a contract of purchase and sale on the Tennessee Association of Realtors form, and then there was a pre-sale agreement with Jam Investments, and there was a joint venture agreement with Mr. Chow and Jam Investments.
On the Tennessee Association of Realtor forms, are those forms that are available to the general public?
It's my understanding that they are not, that they are only available to members of the Realtors, which is an organization of licensees who choose to join that particular organization. And it's a copyrighted name that one can't use. The Broker Act prohibits the use of it if you're not a member of that organization, association.
Were there also emails attached to the complaint?
There were emails attached from Mr. Chow to Mr. Medlin, and some from Mr. Medlin to Mr. Chow, and they outline they start in the ones that were attached to the complaint start July 21st of 2012, and it's Mr. Chow asking Mr. Medlin that it's been a month since their communication. Has the deal closed? And Mr. Medlin responds on July 23rd that the initial lender had backed out. He was trying to get a hedge fund. And then there was another one from Mr. Chow on September the 4th, subject to escrow deposit. Just wanted an update on this. If it can't close in the foreseeable future, I would like to ask you to send the deposit back. I think it makes more sense to ask you or your staff to find another investment for me to be using this money. We can talk about this deal when the union deal, when the picture becomes clearer. Thanks, Ping. Then there's another one sent September the 5th of 2012, which is It says flag this message rate escrow deposit, and it's from Kenny Medlin to Mr. Chow. And then Mr. Medlin says that he's out of town. The pension hedge fund's moving slow but close. And he said, I will look and see if I can find a good deal for you on another property. Probably a good idea until we know more. I'll be back later this week and we'll see what I can find worth buying in an area worth renting. Then there's another one from Mr. Chow to Mr. Medlin on September 17th. And he says, please wire the deposit ASAP and call my cell, and he lists the cell phone number. And then there's another one from Mr. Chow to Mr. Medlin. And he says, can you wire back the union project deposit so I can use them on properties to be identified? This is from Mr. Chow to Mr. Medlin on September 11th. And then there's another one on September 26th from Mr. Chow to Mr. Medlin. He says, let's get this resolved. I've requested you sending back my deposit since September 4th. I'm formally requesting that you send me the deposit back again, which is $40,000. And that was on, as I say, September the 26th of 2012. He says the escrow deposit money should not be transferred to property management account, as you mentioned, and should not be used in any way. And that's the last email that was attached to the complaint. Also attached to the complaint were evidence of wires into the First Tennessee Bank and to the Dan Stewart Realtors escrow account. There was one wire transfer for $27,500 on 1/11 of 2012, and then there was another wire transfer that was made earlier on 1/5 of 2012, and that likewise went to the First Tennessee Bank to Dan Stewart Realtors earnest money account.
I'm going to ask you to look at this document and see if this is the copy of the complaint you're referencing there. If I may approach the witness, Your Honor.
Yes, you may.
Yes, that is the same.
If the clerk please, I would like to have this copy.
Hearing no objection, the document's admitted as Exhibit 1, and you may distribute copies to the commission members.
For the record, this is the complaint and exhibits attached to it that were all submitted by Mr. Cho. Is that correct? That's correct.
Ms. Maxwell, what law applies to issues of licensed and unlicensed activity in the state of Tennessee as a broker?
6213-102 4A and B define activities that if one engages in such activities, they require licensure. Do you want me to read?
Is there another section?
Yes, there's another section that involves, well, there's 6213-103 that says any person who directly or indirectly attempts to perform any of the acts defined in 102 need a license. Just a single act would constitute that. And then there is 6213-301, which is titled License Requirement. And that states it is unlawful for any person directly or indirectly to engage in or conduct or to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent as defined in 62-13-102 within this state without first obtaining a license as such broker, affiliate broker, timeshare salesperson, or acquisition agent as provided in this chapter unless exempted from obtaining a license under 62-13-104.
What are the exemptions in 104, just for the record?
The exemptions in 104 are an owner of real estate with respect to property owned or leased by such person, an attorney in fact under a duly executed and recorded power of attorney from the owner or lessor, the services rendered by an attorney at law and the performance of duties as such attorney at law, a person acting as a receiver, trustee in bankruptcy, administrator, executor, or guardian, trustee acting under a trust agreement, deed of trust or will, or while acting under a court order or instrument, a resident manager for a broker or owner or employee of a broker who manages an apartment building, duplex, or residential complex where such person's duties are limited to supervision, exhibition of residential units, leasing, and/or collection of security deposits and rentals for such property. The resident manager or employee shall not negotiate the amounts of security deposits or rentals and shall not negotiate any leases on behalf of the broker, or a corporation, foreign or domestic, acting through an officer duly authorized to engage in such real estate transaction where the transaction occurs as an incident to the management, lease, sale, or other disposition of real estate owned by the corporation. However, this exemption does not apply to a person who performs an act described in 62-13-102-4A either as a vocation or for compensation if the amount of compensation is dependent upon or directly related to the value of the real estate with respect to which the act is performed. And then there's another section B which applies only to vacation lodging services and designated agents.
Based on your knowledge of this particular case and the information that was provided to you, does Mr. Medlin fall under any of those exemptions?
No, he would not appear to fall under any of those exemptions.
Okay. In the contract, if you would look at that contract, in paragraph 3, what company was to hold the earnest money?
Paragraph 3, which is titled Earnest Money, says buyer has deposited the sum of $40,000 with Dan Stewart Realtors located at 3205 Kirby Witten Road, Suite 102, Bartlett, Tennessee, 38134. That's the address of the holder. And it says the sum earnest money has been received by holder and is to be applied as part of the purchase price at closing. The earnest money should be deposited in holder's escrow account within one banking day from the binding date agreement. And it lists, holder shall disperse on earnest money only as follows. It lists 3 instances.
Do your records show who is the principal broker of Dan Stewart Realty?
The TREC records show that the principal broker of Dan Stewart Realtors, license number 256-988, is Joyce A. Medlin. Is a principal broker, holds license 261644.
And do your records show who owns Dan Stewart Realty?
No, they do not, because the person who owns it is not a licensee.
Okay. So do you know if this business is a member of the Tennessee Association of Realtors?
Its name is Dan Stewart Realtors. The Broker Act prohibits the use of the name Realtors if one is not a member of that association. But I don't know personally. That would just.
Do you know who Dan Stewart is?
Only because I read it on the internet. Okay. He was a person who used to own this company years and years ago. That's all I know. I don't know anything else about him.
Oh, did you look up this company on the internet?
I did indeed look up this company on the internet.
And Was there any information or ever any representations on the internet by Mr. Medlin?
His name appears on their website as an individual to call for both investments and generally to call him. And then also there's another part that has his name for investments and for property management.
And for property management, did you say?
For property management, his name is listed as the individual to call.
For property management?
For investments in property management and generally, just generally if you have questions. If you have questions about rehabbing, they talk about a company called A House for You, Inc., which is no longer licensed no longer registered at the Secretary of State's. But that's all part of the Dan Stewart website. But Mr. Medlin's name is on here in several instances.
Now, Mr. Gibbons, you heard that Mr. Cho was dealing with Mr. Gibbons, and then his property is taken over by Dan Stewart Realty through Mr. Gibbons. Is Mr. Gibbons a licensee of Dan Stewart Realty?
I searched for Mr. Gibbons, the way his name is spelled on his affidavit, which was submitted, which is Gibbins. We do not have anyone by the name Gibbins licensed with the Tennessee Real Estate Commission. I then went just and searched for GIBB in case maybe it wasn't spelled right, even though, as I said, we did get off his affidavit. And what returns are names that go from GIBBARD to GIBBONS. So again, there's not a Gibbons listed.
And is he listed in the TREC records at all as a licensee of Dan Stewart Realty?
No, he is not listed under an affiliate broker or broker listing for that firm. They have 13 affiliate brokers and one broker, and then the principal broker, Ms. Joyce Medlin. And he is not listed on there at all.
By the way, do you happen to know Miss Joyce Medlin's relationship, if any, to Mr. Kenny Medlin?
I think it's his mother, but I'm not positive about their relationship.
Did Mr. Medlin file a response?
He did file a response.
Do you have that response in front of you? Somewhere?
Somewhere. Somewhere amidst my papers, I do. Yes, I have his response.
On the first page of his response, what does it say? Let me have you read numbers 1 through 5, please.
Okay. This response is dated November 2nd, 2012, and it was received by the Tennessee Real Estate Commission on November the 9th of 2012. And it's addressed to our complaint coordinator, Mr. Connell House. First, I would like to note the following facts regarding this inquiry for your consideration. 1, I am not a licensed real estate agent. I have not been a licensed agent for about 10 or 11 years. 2, I have not represented in any form or fashion that I am a licensed agent to Mr. Ping nor anyone else. In fact, I have disclosed only that I am no longer licensed. I personally am not presented in any fashion on the Dan Stewart Realtors website, www.danstewartrealtors.com.
Let me stop for a minute. Is that the website you just referred to?
That is the website that I was referring to earlier.
Okay.
Number 3, and for the record, I am the managing and sole member of the limited liability company JAM Investments, which is J.A.M. Investments, which is the sole owner of Dan Stewart Realtors and currently the only remaining operating business unit of JAM Investments, LLC. 4, the contract in question relates to a project that was to be a separate operating unit of JAM Investments, LLC, but not affiliated to the Dan Stewart Realtors operating unit. Dan Stewart Realtors was to be retained as the property leasing management company for the project. 5, Dan Stewart Realtors is currently obligated on the leasing management of 2 properties that Mr. Choi Ping purchased and transferred management from Hardco Property Management to Dan Stewart Realtors. Dan Stewart Realtors has not engaged in acquisition, representation for Ping Choi.
So Dan Stewart Realtors, he's saying, is the management of the other properties owned by Mr. Cho?
He implies that they're contractually obligated on 2 properties that Mr. Cho purchased and transferred management to Dan Stewart Realtors.
Would you continue down and read the second full paragraph under the heading continuing to the complaint, starting with JAM Investments?
JAM Investments LLC did enter into a pre-sale agreement with Ping Choi for 10 apartment condo units in a speculative project at 1837 Union Avenue, Memphis, Tennessee. Dan Stewart Realtors was not involved in the transaction between JAM Investments and Ping Choi.
Oh, hold on for a minute. But the contract does have them be the escrow holder?
Yes, it does have them as the escrow holder in paragraph 3. That's where the escrow money is to be deposited.
And Mr. Medlin says that JAM owns Dan Stewart Realtors, and he's the sole owner, Dan, of the whole thing?
Yes, he's the managing and sole member of JAM Investments, which is the sole owner of Dan Stewart Realtors.
Did he address at all in his response the reason that everything was presented on a TAR contract?
He speaks again of the, he calls it the Tennessee Real Estate Commission contract, but the Tennessee...
Is there a Tennessee Real Estate Commission
No, the Tennessee
contract?
Real Estate Commission doesn't write contracts. They don't endorse contracts at all. That's not part of what the Tennessee Real Estate Commission has the jurisdiction to do.
Let me ask you something. Do licensees know that?
They certainly should know that because there's a difference between the Tennessee Real Estate Commission and the private associations that are like Tennessee Association of Realtors.
Did he indicate at all why he or how he got that TAR contract and why he used a TAR contract?
I believe he does. I'll just have to find it.
Okay.
There's several places where he references the contract that make reference to that, and in that same paragraph from which I was reading, he said, "This is evidence," meaning the agreement. "This is evidenced by the documentation submitted by Ping Choi, specifically the Tennessee Real Estate Commission contract, which provides designated spaces for listing agent and selling agent." That are not completed, indicating a lack of professional representation by either party. In light of the lack of representation regarding this transaction, there are no supporting documents that would indicate any type of agency or facilitator status. Since not documented, it would be necessary to surmise that none existed. Let's see. There's a paragraph about down payment money being deployed does not hold Dan Stewart Realtors as fiducially responsible other than for the collection and subsequent disbursement according to the request of the recipient of the money. Dan Stewart Realtors complied with the rest of the recipient as per the agreement. Nowhere in any of the agreements was it indicated the down payment was to be held in escrow. And it was, he goes on to say that the down payment was to be held in escrow. And in fact, the down payment was considered non-refundable other than the two circumstances noted in the agreement whereby the down payment would be refunded.
Excuse me, can you say the page number and paragraph number you're referring to?
I don't
for the
have like,
record?
yeah, I don't, like, mine doesn't have page numbers on it, my response. So it's, this is on the second page. I'm sorry I'm jumping around. It's, as I look through that, there's a number of references to the contract and to what it said. And so that was on page 2. That I just read was on page 2. And it's the fourth paragraph. And then the other that I read was from the first page, and it was that second paragraph, under continuing the complaint.
But I didn't hear you say that he mentioned anywhere why he felt like he could use a TAR contract. Do you see that anywhere in that response?
I was trying to see if I saw that exact language.
Yeah.
Because I don't, as I say, there are a number of just references to Dan Stewart. But I don't see where he specifically gives a reason for his use of that contract.
On the last page of his written response, can you read the second to the last paragraph?
It starts out, I would like to point out. I would like to point out that I was willing to try to resolve this issue with Mr. Ping Choi based neither upon the Union Avenue project investment nor contract, rather because he was a client of Dan Stewart Realtors on property leasing management. Mr. Ping was sent an offer to create a loan to repay his perceived earnest money loss. He has apparently rejected that offer to pursue other legal action.
So even at the point of this response, there was still a connection with Dan Stewart Realty, who held the escrow that is owned by Mr. Medlin. Is that right?
It would appear that way, yes, it would.
Okay. I would like to enter the response sentence in my next exhibit. I will make sure she's got the one looking in front of her is the right one.
Hearing no objection, the documents entered as Exhibit 2 and may be distributed to the commission members.
Yeah, just show it to you to make sure it's the right. I just have a couple follow-up questions. Did you look at Mr. Medlin's license history when you were preparing for this?
I did look at his license history.
Did he have any complaints in the time he was licensed?
From the time he was first licensed?
Yes.
Objection, Your Honor, as to relevance.
It's a history of, yes, Your Honor, it is a history of him as a licensee and what he should or shouldn't have known or could have done in his representations here with Mr. Cho.
He is not currently licensed, so the matter pending before the commission is whether he has currently engaged in activity as a broker.
But, Your Honor, his actions as a licensee would have led him and should have led him to the knowledge that he would have needed to know when he was doing licensed or unlicensed activity, and his license history could be reflective of that.
Close call, but I'm going to sustain the objection.
Now, Mr. Medlin said in his response somewhere, let's see if I can find it, I think the history will indicate that Dan Stewart Realtors have maintained a long history of good client and customer relations with little corrective action, if any. Were there any corrective actions against Dan Stewart Realties?
Dan Stewart Realtors?
Yes, sorry.
I'm going to object again, Your Honor, as to relevance unless the corrective action relates specifically to the current action involving Mr. Cho, that it would not be relevant and be unduly prejudicial to respondent.
Mr. Medlin alluded to and said exactly in his response to this commission and made a statement that there's little, if any, corrective action, and I'm just clarifying that point as a part of his own statements to this commission.
Other than when he appeared for licensure and it was denied, and his Joyce Medlin appeared with him, there doesn't appear to be corrective action against against Dan Stewart Realtors.
Thank you. I have nothing further.
Cross-examination.
Hi, Ms. Maxwell. I just have a couple of questions for you. First, what is the function of Tennessee Real Estate Commission?
The purpose of the Tennessee Real Estate Commission is to license timeshare salespeople, real estate affiliate brokers, vacation lodging services, designated agents, timeshare developers, and timeshare salespeople, rental location agents, location agencies, and acquisition agents and acquisition representatives, and to enforce the Broker Act and the Timeshare Act as it relates to those, to provide education and testing and to protect the public.
And does the Tennessee Real Estate Commission govern earnest money disputes?
This is a part of the Broker Act, and the rules that are promulgated thereunder do provide certain provisions in regard to escrow monies.
Okay, and what are those provisions?
First of all, every firm has to have an escrow account or have a waiver for one. And then Rule 1260, let's see, 12.02, I believe, deals with, one of the rules deals with the use and deposits of earnest money, and outlines, when it has to be deposited. And that's Rule 1260-02-.09, entitled Deposits and Earnest Money, and it lists 9 different items, provisions, as it relates to earnest money.
So outside of those specific provisions, does the Tennessee Real Estate Commission deal with individual disputes over escrow money or deposit monies or anything?
If the Real Estate Commission does, if it falls within the Broker Act or within the rule, and if it appears that there was a violation because of the handling of the earnest money, or it was not returned, which is one of the things that the rule requires to be done, in certain timeframes.
And the issue pending today is whether Mr. Medlin represented himself as an unlicensed broker. Is that correct?
Whether he was engaged in activities which require a license under the Broker Act under 62-13-102 for A and B.
Is there a pending allegation in this action or in a related one regarding the holding of the escrow money either via Mr. Medlin or Dan Stewart Realtors?
The earnest money deposit is part of the whether Mr. Medlin held himself out as an unlicensed individual or as a licensed individual when he was actually an unlicensed individual and engaged in activities that required a license.
Right, that's one of the alleged facts.
Right.
But is there an allegation that he has violated the specific provisions relating to the holding of escrow money, or that Dan Stewart Realtors has violated the specific provisions governing the holding and
There's not one against Mr. Medlin, who is unlicensed, as it relates.
Is there one pending against Dan Stewart Realtors?
I don't know if that is still pending or not. I don't know.
But that's not the action before the commission today, correct?
No, it is not.
Does the Tennessee Real Estate Commission govern or regulate the copywriting of TAR contracts, Tennessee Association of Realtor contracts?
Other than the provision that's set forth in 6213.12B4, which specifically says one cannot use the term realtor unless one is affiliated with that association.
So other than the copyright of the term realtor, the use of the term Tennessee Association of Realtors, that copywriting, is that something that the Tennessee Real Estate Commission enforces?
As it relates to that provision, yes. I'm not sure I really understand your question.
Okay, I'm sorry. I'll be more clear. If a copyright was infringed concerning a Tennessee Association of Realtors contract, specifically as copyrighted by TAR, not looking specifically to the term realtor, would someone have a course of action that they could bring before the Tennessee Real Estate Commission, or would that be a course of action that would need to be brought elsewhere?
It were an issue of copyright infringement and that was the basis of the action, that would not be something that the commission would be able to hear, because that would be that's an infringement of copyright, which is a different sort of thing. What's provided for the commission is in that particular section of 312, which prohibits the use of that.
So that sort of copyright issue would be something litigated in civil court or chancery court, not before the Tennessee Real Estate Commission. Is that correct? To the best
As far
of
as
your knowledge?
litigating the issue of copyright, if one used it and one was unlicensed, then that might be deceptive or misleading and indicate that one was holding oneself out to be a licensee.
But if someone had a concern about the copyright of something specifically copyrighted to the Tennessee Association of Realtors, that would be an action to be brought in civil court, not an action that could be brought and regulated before the Tennessee Real Estate Commission. Is that correct?
That, I believe, would be correct. That would have to be made by someone other than that determination, by someone who had more knowledge about copyright than I do. But
let's look at what I believe is Exhibit 1, the complaint and affidavit and attached exhibits submitted to the Tennessee Real Estate Commission by Mr. Cho. If we can start by looking at the third page of Exhibit 1, which is titled Affidavit of Complainant. If you could just glance through those three paragraphs there, and anywhere in this affidavit by Mr. Cho, does he refer to Mr. Medlin as a real estate agent or as a real estate broker?
of Mr. Medlin representing the seller and the earnest money escrow account, and that he was holding the monies that had come into Dan Stewart Realtors' possession. And he says that JAM Investments LLC was represented by Kenny Medlin. And again, that the $40,000 earnest money deposit was paid into Dan Stewart Realtors escrow account. Kenny Medlin is the president of Dan Stewart Realtors. and he makes those representations as it relates to Mr. Medlin.
Okay, and in that sentence where it says he, referring to Mr. Medlin, represents both the seller, JAM, and escrow account holder, Dan Stewart Realtors in this case, does he ever clarify whether when he says represents, he means like he's the company owner or the owner of the LLC or whatever, or that represents, he means specifically representing as a broker? Is that clarified in the affidavit anywhere?
That's something that you would have to ask Mr. Choi. I don't know what his intention was when he made that statement.
Okay.
I believe he testified earlier to it.
And does it appear, based on your reading of this affidavit, that Mr. Cho's complaint is the return of the escrow money, that's his concern that he's coming before the Real Estate Commission for? Is that correct?
He is concerned about his earnest money being returned, and the Real Estate Commission is concerned that there's a person engaged in unlicensed activity and holding themselves out to be a licensee.
Okay, that's the Real Estate Commission's concern. But Mr. Cho's concern in this affidavit he submitted, based on your reading of it, does it appear that his concern is the return of his escrow money, not an allegation that I can see, or at least a clear allegation, where he's alleging that Mr. Medlin represented himself as a broker or was acting as a broker for Mr. Cho in the action? Is that correct?
I don't know what his intent was, but his, I don't know what his intent was when he wrote this. You would have to ask Mr. Choi what his intent was. But when it came into the Real Estate Commission, we looked to see if there are other issues that might surround the complaint that came in.
Okay, thank you. Will you turn with me now to what is the 7th page of Exhibit 1? It's titled Commercial Purchase and Sale Agreement.
Huh?
And under Section 1, will you just read what it says beside the term buyer and what it says beside the term seller?
To the right or to the left?
Right, to the left, and on the blank part of the contract that is filled in by hand.
Right.
Left blank.
The buyer on mine does not have a filled in that blank. To the left, a buyer. To the left, a seller. It has JAM Investments, LLC.
Okay. And under paragraph 3, titled Earnest Money, the blank to the left of holder, can you read what's filled in there?
Dan Stewart Realtors, holder.
And based on your knowledge and understanding of the law as regulated by the Real Estate Commission, does someone who acts as a holder of escrow money, are they required to also be a broker to a transaction?
Ernest, under the Broker Act, any money that's received has to be returned, has to be turned over, it's earnest money or security deposit, has to be turned over to the principal broker and placed into the escrow account of the firm to whom it was made.
Okay, so escrow money has to be placed with a licensed brokerage firm, placed under the control of the principal broker of that brokerage firm. Is that correct?
If we license the principal broker and we hold the principal, the Real Estate Commission holds the principal broker responsible for earnest money returns. You can place them with under the rule with a third party, like a title company as well, if the agreement specifically states that.
Do the rules require a company that's a holder of earnest money to also represent one of the parties in the transaction, or can they be a neutral third party, or is the law just silent on that?
You can be a third party like a title company as long as it's set forth in the agreement. I mean, it has to be set forth in the agreement and agreed to between or among the parties.
And if it's not a title company, if it's a real estate brokerage firm, are they required to also be a representative of either the buyer or the seller in the transaction?
Oh, I haven't ever been faced with that question, so I don't know how the commission would decide that.
But there's no clear law on it that says that the holder of the escrow money, if it's a licensed real estate firm, that they are required to represent either the buyer or the seller. Is that correct? Based on your knowledge of the law?
It just requires that whoever is the holder be disclosed clearly in the agreement where the money will be held.
Okay. And it clearly says Dan Stewart Realtors in paragraph 3 on page 7 of this exhibit. Is that correct?
That's correct.
You could turn with me now to what is page 10 of Exhibit 1, the complaint and affidavit. It's still part of this same commercial purchase and sale agreement. In the middle of the page.
Did you say page 10?
Yes.
Are you on, but is it 10 of the whole thing or
10 of the whole document.
Do you know what page of the purchase and sale? At the very, very bottom, there little tiny little writing?
It is page 4.
Okay, thank you. Okay.
If you look at what takes up most of the page, it's section 5. If you read through that section, particularly section 5C, titled Dual Agency Disclosure, if you could please read through that and let me know if there are any disclosures of dual agency representation on this document.
On C?
Yes.
None of the items under 5 have been circled or checked or filled in the copy that I have in front of me.
Okay.
So there's nothing under 5. There's no, nothing filled in the blanks on 5A. B has no blanks. C has no blanks, but they're not circled either.
So it appears, based on at least this copy, that there's no disclosure or initials or anything under section 5C that says dual agency disclosure. Is that correct?
That's correct.
If you could turn with me now to what is page 7 of the commercial purchase and sale agreement, the last page.
Okay.
At the bottom of the page, do you see any companies or individuals' names listed under listing company, selling company, and the 2 blanks for independent licensee?
No, those are blank.
And in the middle of this page, are there signatures under the title seller and the title buyer?
Yes, there are.
What does it appear the signature is above the title seller?
Penny R. Medlin.
And it's not legible, but above the term buyer, there's a signature. And are you aware or are you under an impression of whose signature that is?
Just from the information that was supplied to us with the complaint, I guess it's Mr. Ping Choi's.
If you'll turn a couple pages over, it's page 15 of the total document, but it's titled Joint Venture Agreement.
Huh?
based on this page of the document and the document as a whole, if you want to flip through it, who does it appear that the agreement for the joint venture is between? What are the parties involved?
JAM Investments LLC and Ping Choi or his assigns, or as assigned.
Are you required to be a licensed real estate broker in the state of Tennessee to enter into a joint venture agreement?
Not to enter into a joint venture agreement, to my knowledge.
And at the end of this exhibit, the last 3 pages are a series of emails that Mr. Cho submitted along with his complaint. Can you please read through these emails and let me know if at any point Mr. Cho ever refers to Mr. Medlin either as a real estate agent or broker, or as his agent or broker, or if Mr. Medlin refers to himself as an agent or broker?
On the first email, on September the 26th of 2012, Mr. Ping Choi says we can continue to do business on rental or some form of joint venture. The escrow deposit money should not be transferred to property management account, as you mentioned, and should not be used in any way. And then on a message dated September the 5th of 2012 from Mr. Medlin, when the pension hedge fund is moving slow, but as of yesterday fairly close, I will look and see if we can find another good deal for you on another property. I will, and it goes on to say, I'll be back later this week and we'll see what I can find worth buying in an area worth renting. I think it makes more sense to ask you, or this is another one from September the 4th of 2012 from Mr. Choi to Mr. Medlin. I would like to ask you to send the deposit back. I think it would make more sense to ask you or your staff to find another investment single family for me to use this money. We can talk about the union deal again. Those are sort of the end of the emails. There's one more, that's all, that I have.
As to the first one that you mentioned, the September 26, 2012 email, where Mr. Cho mentions we can continue to do business on rentals or some form of joint venture. Are you required to be a licensed real estate broker to have a joint venture to purchase property that you then later rent?
If one of the parties were representing the other party and he engaged in activities which require a license under 6213-102, then yes, you would be.
But if 2 parties engage in a joint venture to invest in property that they're going to later rent, is either party required to be a licensed real estate broker?
Really, you'd have to ask an attorney that question. I don't know the answer to that question. I think that would require legal opinion.
Okay. And as to the other 2 emails, and if you don't know the answer to this question, that's fine as well. If 2 individuals are seeking to invest in property together and they're looking at various investment properties together as joint investors in investment property, is either of the investors required to be a licensed real estate broker?
It would depend on the structure of the vehicle that they used for the investment and who was going to manage it and how it would be run. And as I said, it would require a legal opinion that I couldn't render. Based on your knowledge of the law and your role
with the Tennessee Real Estate Commission, looking at the joint venture agreement that we already saw in this document, would the two parties to that joint venture agreement would either be required to be a licensed real estate broker in order to purchase investment property together as part of that joint venture?
That would require an attorney to review that agreement and determine what the roles of the parties were going to be, and then the commission would have the ultimate determination of what would be required, whether a license would be required or not.
Is there any law, to your knowledge, on point regarding which parties can enter a joint venture agreement that's regulated by the Tennessee Real Estate Commission?
The Real Estate Commission regulates the licensure and whether you need a license, not what type of agreement you enter into. That would you'd have to look at the facts of the case.
Okay, so a basic contract such as a joint venture agreement by two parties would be something governed by normal contract law, like in a normal civil court, not something that's regulated by the Tennessee Real Estate Commission. Is that correct?
It would be the actions that were taken pursuant to the joint venture agreement and whether those constituted actions that required a license under 6213-102 for A and B.
Okay. I have a couple of questions about, you were talking about the website for Dan Stewart Realtors. And let's turn to Exhibit 2, Mr. Medlin's response to the complaint against him. And if you turn past the cover page to the first page of the response. In that first paragraph that you've already read through, so I'm not going to make you read back through it. But point 2, where it mentions Mr. Medlin says he's not presented in any fashion on the Dan Stewart Realtors website. This letter is dated November 2nd, 2002. Is that correct?
That's correct.
And if you look to the last page of the letter, does it appear that it was notarized and signed by Mr. Medlin on November 6, 2002? Is that correct?
2012.
2012, I'm sorry. 2012.
That's what the notary is dated. Yes.
So when you're referring to Dan Stewart Realtors website, is that a screenshot print-off of the website as it existed on November 2nd, 2012, or November 6, 2012, or sometime between November 2nd and November 6, 2012?
No, it's as of yesterday.
As of yesterday. Okay.
Right.
So if Mr. Medlin stated that he was not on the website as of November 2nd, 2012, notarized on November 6th, we don't know if that was a true statement at the time he made it. Is that correct?
That's correct.
Okay. And can you tell me again real quick what it said, how his name was listed on the website, what the contact info was for?
It's listed in a number of places. You deserve a realty team that truly cares about your interests. Call Kenny Medlin today. If you have questions or would like more information, this is to rehabbers. Ask for Kenny Medlin. It talks about investing in flipping houses. And then it was contact us. The contact person is Kenny Medlin. And that one again. And then that's all I ran off.
Okay.
I didn't run off every page.
Based on your understanding of what the Tennessee Real Estate Commission regulates and what's required of a real estate broker, are you required to be a licensed real estate broker in order to have your phone number listed on a realtor company's website?
When the commission looks at whether it appears someone is licensed, they look at what the average, unlicensed or licensed, they look at what the average person would think when they looked at an advertisement such as a website. So,
Is there a specific web page on Dan Stewart Realtor's website where it lists the brokers in the firm, like a Meet Our Brokers page or something like that you saw?
there was.
And did it have all the brokers' pictures and names and contact info listed on there?
It had their pictures and their names. It probably had their contact info. I couldn't tell you if it did or didn't.
Remember who the principal broker of Dan Stewart Realtors was?
Joyce Medlin.
Okay. And then I think you said there are 13
affiliates, one broker, and then she's the principal broker. That was according to our records.
Does Kenny Medlin appear on that page of the website for Dan Stewart Realtors?
No, but he appears on other websites that say you deserve a realty team that truly cares about your interests. Call Kenny Medlin today.
Are you required to be a licensed real estate broker to accept phone calls at a real estate company?
It would depend on what you were saying in those phone calls and the nature of the phone calls, and that would be up to the commission to decide once they heard facts and circumstances surrounding those issues.
Right. Outside of specifically giving someone advice about listings or talking about taking them to houses, to the best of your knowledge, are you required to be a licensed real estate broker to receive phone calls at a real estate company?
Be the secretary at a real estate company and just answer the phone and just say hello and transfer a call. You wouldn't, if that's all you did, then you probably wouldn't need a license. But as I say, that would be up to the commission to determine, given the facts and circumstances of any specific case. So I couldn't answer it in a general, generally, other than say if all you do is just answer the phone and transfer it to one of the licensees.
But would you recommend that everyone who works at a real estate company be a licensed broker, even the secretary or someone doing tech work or anything, just to be safe, everyone should be a licensed broker?
I didn't say that. I said that if you are the secretary and just answer the phone and then transfer it, that you probably would not need a license, but that it would be facts and circumstances that if there was a question whether the person needed a license or didn't, it would be determined by the commission after they heard those facts and circumstances. So, to answer that question generally would be very difficult to do because it is very fact-driven.
If you create marketing material for a real estate company, are you required to be a licensed real estate broker?
No, but you are required to know what the rules, and the principal broker is supposed to know what the advertising rules and the statutes say about what goes on a website. The principal broker is charged with all the responsibility of the advertising that shows up on the website or anywhere else.
And has the principal broker, Joyce Medlin, or Dan Stewart Realtors in general been charged with any sort of false advertising or violations of the regulations regarding advertising?
I don't know. The commission hears all complaints anonymously when they're presented for the initial time for a probable cause hearing. So I do not know what's been presented to them and wouldn't be able to say in front of them something about any case because it would taint the case if it were to come later to them.
I understand. But to your knowledge, there's no, outside of complaints that are still pending investigation, there's no numbered complaint, to your knowledge, against Dan Stewart Realtors or Joyce Medlin regarding false advertising or some sort of violation of the advertising provisions that fall on a realtor company and the principal broker. Is that correct?
I can't answer that question because as I say, the complaints are presented to the commission anonymously, and they don't have knowledge of who's going to, who's heard and who's not heard.
Okay. Those are all my questions. Thank you for your time.
I do have some redirect.
Okay.
Let me start with
Okay.
What does it say is unlawful to do as far as advertising?
It is unlawful for any person directly or indirectly to engage in or conduct or to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent as defined in 6213-102 within this state without first obtaining a license as such broker, affiliate broker, timeshare salesperson, or acquisition agent as provided in this chapter.
Yes, you may.
You testified earlier concerning a website of Dan Stewart Realty. Copy of the document, one of the documents you were looking at?
Yes, it is.
Okay. In the end of paragraph 3, what's the last sentence of that?
Under heading 3,
No, under paragraph 3, after the first 3 paragraphs, what's the last sentence of paragraph 3?
as a realtor, if we can't collect your rent, we don't get paid?
That's correct. That's what I was asking about. And then at the end of that whole page, who is the contact person?
You deserve a realty team that truly cares about your interests. Call Kenny Medlin today.
And you said earlier that this is dated now, not back in 2012?
Correct.
So he's advertising now in this manner?
That would, I mean, yes, that would, this is dated 1/31/2014.
Thank you. Now, you testified earlier that the issue itself of copyright is not something this commission would determine.
Not the issue of copyright per se, no.
But what about the issue of holding yourself out as a, quote, realtor? Is that something this commission would be looking at, or could be looking at?
That the commission could be looking at under the Broker Act.
But that's for licensed parties, is that correct?
Correct.
So a licensed party can't hold themselves out as a realtor without that
That is correct.
designation. Okay. Now, in the complaint filed by Mr. Cho, in the affidavit of complaint,
Yes.
would you read the full second paragraph?
Over the next 3 weeks, Ping Kuei has called, text, email Kenny Medlin numerous times, but getting very few responses with regard to direct answer to returning the earnest money. On September 26, Ping Chow gave Kenny Medlin until the end of business day of September 28th to respond, but again no response from Kenny. Since Kenny Medlin represents both the seller and the earnest money escrow account holder, Dan Stewart Realtors, and he has failed within a reasonable time to account for or remit any monies coming into the Dan Stewart Realtors possession, I am requesting Tennessee Real Estate Commission to help me on this to ensure licensee to comply with state regulation.
Licensee, do you have any idea to whom he was referring when he calls this person or person's licensee?
It would have, from the sentence, it would appear it would be Mr. Kenny Medlin.
And if you look to the very first page of the complaint filed by Mr. Kui, under the respondents,
It's against, the respondents are Dan Stewart Realtors and Kenny Medlin.
okay, what would be the reason you bring a complaint in the Real Estate Commission against someone who is or is, I mean, would you bring a complaint if there wasn't some connection on the issue of licensing before the Real Estate Commission? In other words, would this commission hear something that had nothing to do with their license or being a licensee?
Though, if someone were holding themselves out to be a licensee and were not, they would hear that, because that's a violation of a license is required, it's a violation of the Broker Act.
And one more question. Wait a minute. Maybe it's one more. In the contract itself, JAM Investments is listed as the seller. Is
Correct.
there? But it's signed by Kenny Medlin, not in his role. It doesn't say JAM Investments is being sold, does it?
No, it does not. The seller it's signed by Kenny Medlin in no capacity other than his name.
Give me a moment, please. You were asked on cross-examination if Mr. Cho ever referred to Mr. Medlin as a broker in his complaint.
Correct.
Would referring him as a licensee be the same thing as a broker?
Right, because a broker is just, we have a broker, affiliate broker, but collectively they're called licensees, and that actually, that would encompass.
So he did he did file it as a licensee, or claimed that he was a licensee.
These states ensure this licensee to comply with state regulation.
I have nothing further.
Any recross?
Thomas, I'll let you go soon. Looking back at the complaint, and in the paragraphs on the affidavit of complainant, the 3 paragraphs written by Mr. Cho, again, in the second paragraph, we talked about the first one earlier, but in the second paragraph, middle of the paragraph where it says, since Kenny Medlin represents both the seller and earnest money escrow account holder, Dan Stewart Realtors, and he continues, is it clear in this statement whether Mr. Cho means represents as a president of the company or as a representative of a company, or represents in the way you think of a real estate agent representing someone? Is it clear what he means by the term represents?
It would it would be what the reader's interpretation was, and what Mr. Choi said that it was. But to me, it would appear that he'd be referring to the licensee as Kenny Medlin, but again, that would be really the commission's decision to determine that.
But you agree that the use of the word represents is ambiguous, correct?
I didn't say it was ambiguous. To me, it refers the licensee to Kenny Medlin. Ultimately, it's the commission's decision to look at the facts and circumstances and decide what it means.
But you read it a certain way, but do you agree that the term represents could be interpreted in different ways by different people, that it's not clear exactly what he means? I guess
that would have to be someone would have to ask Mr. Choi that question, since he's the person who is the author of that. And represents does mean, I'm sure if you look up in the dictionary, it has 5 or 6 different meanings. So, as I say, ultimately, after the commission hears the facts, it'll be their decision to make.
Looking at that Dan Stewart Realtors webpage that Ms. Ryan referred to a few minutes ago, it's dated 1/31/2014 at the bottom of the page.
Right, and what I was looking at before was dated 2/5, but it's the same. Okay. That page is the same page.
Okay. If you look down the page at the beginning of the various paragraphs, there are different pronouns used: are, we, are, if we say it. Is that correct? Do you see that on your reading of the page?
We and our. Is that what you mean? We and our. It says like we do something, or our.
And then at the bottom of the page, it says our team.
Right.
And can you read those 2 sentences underneath our team?
Our team, Angela Parks Wilson, who's an affiliate broker realtor and our property management manager, has a phone number. I guess it's hers, 901-336-4313. The vast majority of the investment property selection process will be carried out by Kenny Medlin, president. And then it says you deserve a royalty team that truly cares about your interests. Call Kenny Medlin today at 901-387-8526.
And after Angela Parks Wilson's name, it says she is an affiliate broker realtor and a property management manager. Is that correct?
It says is an affiliate broker realtor and our property management manager. Yes.
And after Kenny Medlin's name, it says, comma, president. Is that correct?
Correct.
And is it true if you're using kind of ambiguous language, are, we, you can refer to a group of people, but not necessarily refer to an individual? And as an example, I can say, our law firm represents people in commercial real estate transactional law, and I don't mean I represent people in transactional law because I'm a litigator. So you can use the term we to connotate a group of people without indicating an individual is performing an action. Is that correct?
I'm going to object. Wait a minute. I'm going to object to, there's no foundation for that. I mean, is she asking her as a language expert? I mean, in what capacity is she asking for that information from Ms. Maxwell?
For response?
Your Honor, this page of the website was brought up by opposing counsel to create an inference that Mr. Medlin is performing the actions of a real estate broker, and whether or not an individual, any individual, particularly Ms. Maxwell, while she's reading this, as the executive director of the Real Estate Commission, sees the use of this language and the way this website is presented as Mr. Medlin representing himself as a real estate broker. So I'm only continuing in the line of questioning that was introduced through the introduction of this document by Ms. Ryan.
Your Honor, I'll also say that I believe Ms. Maxwell said and has said collectively throughout her testimony that the issue of whether any of these arise to the fact of him acting as a broker is up to the commission to determine, not up to Ms. Maxwell. And it is up to them to make that determination. I will say, if it will help, I have copies of that website, and they are certainly welcome to look at it now as opposed to later when I'm going to introduce it later, but I'm happy to have them look at it now. But it is up to the commission to make the determination, not Ms. Maxwell.
Your Honor, I'm not asking Ms. Maxwell to make any determination of fact. I'm just asking for her impressions based on her reading of this. As the case is presented so far, it's based on the impressions of various individuals of whether Mr. Medlin is representing himself to others as a broker. So I think the testimony of the current witness on the stand as to whether she has an impression based on the reading of this document brought up by Ms. Ryan that Mr. Medlin is presenting himself as a broker is highly relevant.
I'm not saying it isn't, but what the question was an interpretation of the English use of the word our, yours, mine, etc. in any documentation, which I'm suggesting that if you're asking for a language interpretation on how it can and cannot be used in the English language, this is not the proper witness for that.
Your Honor, I'm not asking for a general linguistics analysis by Ms. Maxwell. I'm simply asking, based on the use of these pronouns, specifically her opinion and her interpretation of the use of these pronouns in this context as it relates to Mr. Medlin.
If it's, I'll use the pronouns as it relates to Mr. Medlin. I'm certainly happy to have her answer that.
I think you're now asking a different question than what you asked earlier. And the question you asked now is relevant.
Okay.
The question you asked earlier was not relevant.
Okay, I will rephrase. Thank you, Your Honor. I apologize, Ms. Maxwell.
Did you repeat whatever?
Yes, I
whatever
will.
Question.
Let me rephrase. The use of the pronouns are and we throughout the course of this page of the website, does that lead to your inference that Mr. Medlin is alleging that he personally and specifically would be performing any of the tasks that are set out in this, intro page on the website, for lack of a better term?
Yes, it would lead me to believe that he is engaged in activities such as that, by the way it says you deserve a realty team that cares about your interests.
One more question. I think you have the notice of hearing and charges before you.
I do not.
Oh, okay.
I have a lot of things before me, but that's not one of the ones I have before me.
All right. Can I hand a copy of that to Ms. Maxwell, the notice of hearing and charges that has already been presented to the board today?
Certainly.
Document, Ms. Maxwell.
Okay.
Can you please read the definition under count 1, the definition in Tennessee Code annotated 62133014A, the definition of broker, please.
Broker means any person who, for a fee, commission, finder's fee, or any other valuable consideration, or with the intent or expectation of receiving a fee, commission, finder's fee, or any other valuable consideration from another, solicits, negotiates, or attempts to negotiate or solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sell, rent, or exchange for any real estate or the improvements on the real estate or any timeshare interval as defined in the Tennessee Timeshare Act compiled in Title 66, Chapter 32, Part 1, collects rents or attempts to collect rents, auctions or offers to auction, who advertises or hold out as engaging in any of the foregoing.
In Exhibit 1, which is defendant chose complaint, or Exhibit 2, which were both introduced through you before the commission today, is there anything written on any contract or document or email alleging that Mr. Medlin performed one of these actions as enumerated under the definition of broker? Is there any specific written allegation?
That he held himself out as a licensee?
Not that he held himself out, but that he performed an action of a broker negotiating the listing, sale, purchase, exchange.
Well, as I say, the commission would have to look at the totality of the facts and circumstances and make that decision whether they believe that he did hold himself out or engaged in one of the activities that require licensure under the Broker Act.
But Mr. Medlin's name is not listed as broker on any of the documents that were submitted to the Real Estate Commission that you have reviewed. Is that correct?
But because he was engaged in unlicensed activities, what the commission has to determine is whether or not he was.
But on any of the contracts or documents where it has a blank line that says representative broker or anything like that, Mr. Medlin's name is not listed as a broker on any of the documents that came before you today. Is that correct?
In any of the spaces that we discussed earlier today that you questioned me about, they were not.
Thank you.
Commission members, this is your opportunity to ask questions of the witness.
To your knowledge, is Mr. Medlin operating through reciprocity from any other state? Is he licensed in any other state, or do you know?
To my knowledge, he doesn't hold a license in Tennessee, and we don't have any indication in our records that he was licensed somewhere else.
Is his firm licensed that he owns? What's the name of it?
The name of the firm right now is Dan Stewart Realtors. That's the name as licensed with the commission.
Thank you.
But Mr. Medlin has not held an active real estate license since 2002. Is that correct?
That is correct. His license was revoked in that time, expired, and then it was would have been revoked for the he didn't report his criminal conviction, and so then he came before. That's why he appeared before the commission for licensure.
Okay, thank you. So in 2002, his license was expired or revoked?
It was expired, and then it was subsequently revoked by action for failure to report his conviction within the 60 days required.
So when was it re-established after it expired?
It was not. I mean, he tried to get it back in 2006, and then he appeared before the commission in 2006. And he appeared before the commission with Joyce Medlin, who would have been his principal broker, and the commission voted 5-0 to not allow him to be licensed again, sit for the test and be licensed again. And he hasn't appeared since that time. I mean, he hasn't requested since that time.
One other question: has that firm that's mentioned here had any of the charges against them
Not that I saw on RBS.
Thank you.
There don't appear to be any further questions from the commission members for this witness. Thank you so much for your testimony.
I am prepared to call my next witness, but it has been requested for a short recess for.
Sure.
It is right now 11:33. As far as lunch, are we just going to continue straight on through and take a bathroom break? Judge?
It depends on the wishes of the commission, really.
I'm one of 9.
No, you're only 1 of 6 today.
1 of 6 today, but.
I just soon go ahead and keep listening to it after the break.
Okay, we want to just continue on, so let's take a 10-minute break and be back in here about, it's 11:33, you'll be back in here by 15 to 12.
There's somebody waving at you back there.
Fry some bread.
Are you going to let them go?
I need to talk to our education director. We need to talk to our education director.
Oh, that's a pretty good deal. Yeah, and just, because that's good, I mean, that's good.
We on, Kelly?
Yeah.
Thank you. I want to call this
Yeah, yeah.
second day of Real Estate Commission meeting back into session. We're going to take just a real short break to take care of some business that's not a part of our hearing today. I've talked with Steve McDonald, our education director, and I just want to clear it with the commissioners up here and get your thoughts as to some solutions as far as there are 5 people here today: Kenneth Adams, Jim Agee, Donna Clark, Ken Clinard, C-L-I-N-A-R-D, Clinard, and Charles Pecca. They are here due to an attorney, a consent order, and the consent order says that those 5 individuals have to attend a complete 2-day real estate commission meeting. It has been suggested that those 5 individuals give an opportunity for an hour of lunch. They want to go get some lunch, have a lunch break for an hour, and then come back. And because those 5 individuals are going to have to continue to stay, and it's been customary that after a day and a half of attendance for the other individuals who are in this room that are here to take care of other issues other than the 5 that I read their names off. And I just want to see if everybody's in agreement, because customarily we have let them go around noon in meetings past around the noon hour, go ahead and let them, they have fulfilled what they need, their obligations to get reinstated with their licenses, to let those go ahead and leave at this time. Give me some help here, commissioners. What y'all's feeling? I mean, we've done that before.
I would recommend that the ones other than those 5 who choose to leave may do so. However, you're welcome to stay with us and continue our little road show here. And the rest, those 5 get a lunch break and come back in an hour.
You want to put that in form of a motion?
I did.
Okay, we have a
Second.
motion. And have a motion by Commissioner DeShar that the ones who want to leave, the licensees who are here to fulfill reinstatement, then you can leave if you want to, you can stay. But the other 5 that I read their names, y'all can take a hour lunch break, but if you want to stay, you can. And seconded by Commissioner Franks. Any discussion?
They need to make sure they sign out when they leave.
Hearing none, all in favor say aye.
Aye.
Opposed, no. Okay. Those of you, be sure to sign out. You can get your certificate. Steve McDonald, our education director back there at the back of the room, is in charge of all you licensees. But make sure you sign out. And then those 5 whose names I read, y'all be back in an hour. Go get you something to eat. And we're going to...
They need to be quiet.
And just need to be quiet because we're going to continue on. But
You leave.
we hope
You're welcome to stay.
we hope this was beneficial to you and your future career in this industry. They'll be out shortly, and I'm going to get some coffee.
Back in
this
hearing
session.
mode. Okay.
Yes.
All right.
So you're in charge, Judge.
Oh. All right. Your next witness, Ms. Ryan.
I call Julie Kropp. Ms. Kropp, would you please state your full name?
Julie Eli Kropp.
And are you an employee of the state of Tennessee?
Yes, I am.
And what is your position?
Assistant General Counsel.
And are you Assistant General Counsel for regulatory boards or for?
I serve as the board attorney for the Tennessee Real Estate Commission and the Tennessee Auctioneer Commission.
And as the board attorney, did you review the complaint that was filed by Mr. Cho?
Yes.
And the response?
Yes.
And as a result of reviewing all of that, did you receive any other information from any of the parties?
There was additional information submitted by both parties. There was a letter from Mr. Cho's attorney that was submitted as additional information on December 9th. It was dated December 19th, 2012, and then after the consent order was sent to Mr. Medlin, he submitted additional information to me via fax in response to that.
Is that the fax letter dated March 20th, 2013?
That's correct.
Do you have that in front of you?
I do.
Okay. In that particular letter, can you read the entire letter for me into the record?
Just start with Ms. Kropp.
Please.
Okay. Ms. Kropp, I'm forwarding the attached affidavit received yesterday, March 19th, 2013, from William Gibbons of Randolph Construction. Mr. Gibbons' affidavit clearly states that he was present and heard me convey to Mr. Ping Cho that I was not a real estate agent on actually several occasions. I did not have this evidence before when requested by the state to respond to the allegations levied against me. I hope that this will prove that the statements that I made in my earlier response were in fact truthful and accurate. I'm not a lawyer, but based on my reading of the applicable and presented TCA, I would believe that this sworn affidavit would indicate that I'm not in violation of the law. I've always been zealous in my efforts to properly convey that I'm not a licensed agent to anyone concerning real estate. I fully realize that the necessity to do so is even more prevalent for me as I do own a realtor firm, and I was in fact previously licensed as a broker. History itself indicates that in the time that I've owned and operated Dan Stewart Realtors after relinquishing my license, there has not been any evidence to support any idea I have represented myself as a licensed real estate agent. As far as using the TAR contract, the company in which I own is a member of TAR and fully authorized to utilize those forms. I did not realize that it was a violation for a non-realtor to use the TAR or the TAR, as it has been customarily provided by most Memphis firms to non-realtors for their use whenever requested. Although the TAR version of the buy-sale agreement is written to provide protection to realtor, as I understand, its primary function is to protect the Tennessee consumer. As you're aware, realtors often provide a copy of the TAR contract to a for-sale-by-owner prospect in hopes that they will consider their company responsive to customer needs. As far as the company is concerned, I will issue a mandate to stop providing the contracts to consumers who wish to represent themselves in a real estate transaction. It is my intentions to sell JAM Investments as well as the namesake of Dan Stewart Realtors in order to pursue opportunities in industrial energy services. As I do have a prospective buyer, we are working to facilitate the sale of the operation. Upon closing, I will no longer be engaged in any type of real estate activities outside the possibility of buying another personal home. I would appreciate a letter of conclusion be forwarded to me of the state's position regarding this case now that new evidence has been submitted. If you would like to talk further, I would appreciate a phone call at 901-387-8526. Best regards, Kenny Medlin.
Now, he said that it was customarily used by most Memphis firms give these documents to non-realtors?
That's what it states.
Okay. And he said that he said, let's see, as far as I will issue a mandate to stop providing the contracts to represent themselves in a real estate transaction?
It states that as well.
Well, okay. He would issue the mandate? Is that what he said?
It says, I will issue a mandate to stop providing the contracts to consumers who wish to represent themselves in a real estate transaction.
Okay. And does he indicate anywhere where he gets this information that it's appropriate, legal, or otherwise acceptable for non-realtors to use documents of TAR? Does he say where he gets that information?
All the information I have is what I just read into the record.
Okay. And the affidavit, who is the affidavit of?
William Gibbons.
Now, Mr. Gibbons, that's the man that was testified earlier that was managing Mr. Cho's property before it went to Dan Stewart Realty? Is that the same person?
I believe that's what Mr. Cho said when he testified.
Okay. At the bottom of the page of his affidavit, the very last paragraph, what does he say?
Who?
Mr. Gibbons.
Beginning with, I declare that?
No, in the very last page of the first page.
Oh, the first page.
Okay.
Over the course of several months?
Yes.
Over the course of several months, during my personal conversations with Mr. Ping Cho, I had to remind him that neither I nor Kenny Medlin was a licensed agent or realtor, and that he should consult Mr. Pickens regarding property valuations. Mr. Ping advised that he had reservations regarding Mr. Pickens' offerings and wanted a second opinion. Dan Stewart Realtors elected not to provide that second opinion due to potential ethical issues that might arise from the Memphis Board of Realtors.
Now, wasn't it Mr. Cho's testimony that Mr. Gibbons had brought all this business to Dan Stewart Realty?
I believe Mr. Cho did say that in his testimony.
He did say that Mr. Gibbons had represented him.
He said I believe he said he was his property manager.
Does a property manager require a license in Tennessee? Do you know?
It would depend on the services being provided. It's not stated in the name itself. It would depend on if it fell under the definition of broker.
So a property manager could require a license in Tennessee. If you are managing someone else's property for them, that could require a license.
It's possible, depending upon what you're doing.
Okay. I would like to enter the letter and the affidavit as the next exhibit.
All right. Hearing no objection, the document is entered as Collective Exhibit 3. You may distribute the exhibit to the board, to the commission members.
All the complaints that you review are presented to the commission anonymously, right?
Yes.
And you don't give legal opinions or any kind of interpretation?
Ms. Ryan, I'm sorry, when you were walking away, I could not hear what you were saying.
All complaints that you review, you present to the commission anonymously.
That's correct.
And you don't offer any legal opinions as to the interpretation of anything. You just present the facts and let the commission make their determination.
I provide them with a recommendation most of the time.
Okay, but you never give a legal opinion to them on any interpretation. That's up to the commission to determine whether or not something falls within the guidelines.
It's up to the commission to make the determination. I make a recommendation.
I have nothing further.
Cross-examination.
Hi, Ms. Kropp. Looking at that paragraph regarding the TAR contracts in the letter that was faxed to you by Mr. Medlin.
Yes.
It states, it has been customarily provided by most Memphis firms to non-realtors for their use.
I see what you're saying.
Okay. Just making sure I read that correctly. Are you a realtor?
No, I'm not.
do you provide any sort of realtor or real estate services in the Memphis area?
No.
So in terms of what's customary for brokerage firms in Memphis to do, you can't speak to that, is that correct?
That's correct. I don't know.
And in your role as the advising attorney for the Tennessee Real Estate Commission, is that correct? Is that your role?
The board attorney.
Okay. Is one of the things that the Tennessee Real Estate Commission regulates, is that the use or the copyright of TAR contracts?
Excuse me, Your Honor, I'm going to object. That was asked and answered by Ms. Maxwell. Ms. Crop is not here, or it does not advise on, she can ask her, but she doesn't give legal opinions to the commission at all. But Ms. Maxwell did say that the issue of copyright is not something that they look at. The issue of itself, it's already been asked and answered of another witness. I think it's duplicative and confusing at best.
Your Honor, this is a different witness. I have not asked this question of this witness, and this issue has been specifically brought up by Ms. Ryan of this specific witness. So I do think it is relevant, and I think her answer would be appropriate.
I actually did not bring up the issue of copyrights with this witness.
Well, I think you brought up the issue of the use of the TAR contract.
I did,
with
but
this
that's not
witness.
the issue of a copyright issue, which is a separate and distinct issue from whether or not someone is entitled to use a contract or whether or not it implies anything by using a contract, which are the issues before the commission, not the issue of copyright at all.
Ms. Ryan asked whether or not it was she asked a question regarding the language, whether it's a violation of some law or regulation to use a TAR contract, which is the language contained in this letter, which has been introduced through Ms. Ryan. So I think it's appropriate on point to ask Ms. Crop a question regarding the authority of the commission to regulate the use of a TAR contract. If you'd prefer I not use the word copyright, that's fine.
I did not ask Ms. Crop that. I did not ask her for opinion about that at all.
Your Honor, she introduced the topic. I'm simply following up on it.
She's asking for a legal opinion on an issue of copyright, which is not before this commission, and it is not before Ms. Crop's purview as an attorney on a board for the Tennessee Department of Commerce Insurance Regulatory Boards. It is not something that Ms. Crop would be able to or is qualified to give an opinion on, and that question was not asked of Ms. Crop by me. So, the very minimum, if that's the issue, it goes beyond the scope of my direct examination.
Your Honor, I'm happy to rephrase the question, not using the word copyright.
If you'd rephrase the question.
Okay. Ms. Crop, in your role as the board attorney for the Tennessee Real Estate Commission, do you present items to the board or advise them in any way on items related to whether or not it is a violation, I guess, for a realtor or non-realtor or anyone to use a TAR contract of any sort who is a TAR member or is not a TAR member? Does that fall under the purview of what you advise the Tennessee Real Estate Commission about in your role?
I advise them on all kinds of things. It depends on what comes up in a complaint. I give recommendations as to whether or not it's a violation of the Brokers Act or not. With regard to, I would have to, I guess, state the same thing as Ms. Maxwell. What I recommend to the board and what they make determinations of are whether or not something is a violation of the Brokers Act, not other areas of the law.
Right. I'm not asking for a conclusion of law. Based on your knowledge of the Brokers Act, is there anything in the Brokers Act regarding the use of TAR contracts?
Specifically, I don't believe the Tennessee Association of Realtors is named in the Brokers Act.
And does the Tennessee Real Estate Commission produce or regulate or govern the use of TAR contracts in any way?
It doesn't endorse any type of contract. To my knowledge, Tennessee Association of Realtors is separate from the Tennessee Real Estate Commission. They're two separate bodies, often confused. I don't understand why, but there's the Tennessee Association of Realtors has their contracts. The Tennessee Real Estate Commission does not endorse those contracts or anybody else's contracts.
The Tennessee Association of Realtors is a completely different entity from the Tennessee Real Estate Commission, correct?
I work with the Tennessee Real Estate Commission. You can, it's my understanding of the Tennessee Association of Realtors that that's a voluntary association that some licensees can be a part of, but not all of them.
It's a separate entity, is that correct?
It's a separate entity than this group.
Okay, thank you.
I have nothing further.
Commission members, it's your opportunity to ask questions of this witness. It appears that there are no questions of this witness. Thank you for your testimony. Next witness.
Your Honor, I will wait to ask questions of the respondent after he testifies on their half, so.
Then the state is resting.
Yes.
Okay, all right. Ms. Scarborough, your first witness.
Your Honor, I'd like to go ahead and call Mr. Gibbons. He's going to be a shorter witness, and I don't know, we might want to take a break after him before we call Mr. Medlin.
All right.
Out in the hall, let me go grab him real quick.
Sure.
And Your Honor, this witness has not been sworn in.
Right. If you'd have a seat, you can have a seat. Then if you please raise your right hand. Sir, do you swear or affirm that the testimony you're going to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? The witness is now sworn.
Mr. Gibbons, please state your full name for the court reporter.
William L. Gibbons, William Lee Gibbons.
And Mr. Gibbons, what is your occupation?
I do property maintenance. I go on various different properties. Carpentry repairs, things of that nature.
Your Honor, if I could ask you to lean over a little bit and speak a little louder, because we're making a video of this proceeding,
Sure.
And we need to have good audio, so speak loudly, please.
All right, sorry about that.
It's okay.
Light goes off, we can't hear you.
Okay.
Mr. Gibbons, do you own your own company? Do you work for a company in terms of property maintenance?
Yes, ma'am, I do.
Do you own your own company?
I do own my own company, yes, I do.
And what's the name of your company?
Phoenix Investment Group.
Okay. And how long have you been doing property maintenance?
For roughly 15 years.
Have you ever been a licensed real estate broker?
No, ma'am, I have not.
Have you ever done property management?
I have not done property management. Knowingly done property management, if that makes any sense. What actually, the closest I ever came to it was when I was introduced to Mr. Ping by Jim Pickens, who's another realtor, and he had encouraged me to make that connection because he had some rehab work and maintenance work that he needed done.
So he wanted you to do maintenance work for Mr. Ping. I think Cho is how he told us this morning his name's supposed to be pronounced. So, you said Mr. Pickens introduced you to Mr. Cho. Is that correct?
Correct.
Okay.
At that time, I was not aware, or I was solely interested in, and still am, in just doing property maintenance. And Jim Pickens, the realtor who had introduced me to him, had told me that
Your response? Your response? Sustain the objection.
Don't say what anyone else told you out of court.
Right.
Okay.
So
I don't know what else to
you can
say.
either rephrase your answer, or my original question was, you do property maintenance, is that correct?
Correct.
You do not provide property management services.
Section to the leading?
Do you provide property management services?
No, I do not.
Have you ever provided property management services?
No.
Thank you. Mr. Gibbons, do you know Kenny Medlin?
Yes.
How long have you known him?
For several years. I don't know an exact date, at least 10 years.
And in what capacity have you and Mr. Medlin interacted?
When he has needed property maintenance performed, or been in need of something being fixed or remodeled or something along those lines, that is when I came into the picture.
What kind of person is Mr. Medlin? Can you describe his character, please?
Section to the relevance.
Your Honor, this is relevant because a large portion of what this action is based on, in terms of whether Mr. Medlin has represented himself as a broker or not, is based on his testimony compared to others' testimonies about directly contradicting statements that were made. So his character is directly relevant to whether the things he says are to be believed.
My objection, if she wants to ask specific questions about what he may or may not have said, or how he did or didn't represent himself, that's one thing, but a general broad characterization of him as a human being is quite another.
A question about respondent's character is directly relevant to what is at issue before the board, which is whether or not he has represented himself as a broker and made statements that he's a broker.
My objection, his character is not relevant to that at all. It's whether or not he did or didn't do, and she can ask him specific questions about what he did or didn't do to his knowledge.
Your Honor, I can ask a more narrow question relating to his honesty, if the court would prefer.
Yes, I'd prefer that you ask the narrower question.
Okay. Mr. Gibbons, you've known Mr. Medlin for a number of years, you stated, is that correct?
Correct.
Describe whether or not Mr. Medlin is an honest person.
Your Honor, again, I think she needs to ask specific questions, not whether his general opinion is of honest, because that's just conjecture. I could say he's honest or not honest. It has nothing to do with what his actions are here today.
It's not conjecture, he's a character witness. He's already stated, we've laid foundation, that he's known him and worked with him for over 10 years. His opinion about Mr. Medlin's honesty is directly relevant to whether Mr. Medlin's statements as to whether he's represented himself as a broker or not are to be believed.
Did not say that she was presenting him as a character witness. He was a witness of her case on her case. That if he's just a character witness, then I'm going to object to any facts that he testifies to.
He's not just a character witness, but if I need to call him 2 different times, once as a character witness and once for fact, we can do that.
I'm renewing my objection, Your Honor. I think she needs to limit to whatever specific knowledge he has of this particular translation, or, I'm sorry, this particular act or relation between Mr. Cho.
Your objection is noted for the record, but it's overruled.
Mr. Gibbons, I believe, well, could the court reporter read back what my question, is that too difficult? I just don't want to misstate it again. Okay. I believe my question was, Mr. Gibbons, is Mr. Medlin an honest person?
In my opinion, yes.
And what is that opinion based on?
A ongoing business relationship I've had with him for over 10 years.
Thank you. To the best of your knowledge, do you know if Mr. Medlin is a licensed real estate broker?
No, he is not.
And what's the basis of your knowledge for saying that?
He told me so and frequently states it when in my presence to others.
You know an individual by the name of Ping Cho?
Yes, I do.
And who is Mr. Ping Cho? All right, let me restate that. I'll
Yeah.
make it easier. When did you first meet Mr. Ping Cho?
I'm not sure what the exact date was, but it's been a couple of years ago.
And how did you meet Mr. Cho?
Through a realtor by the name of Jim Pickens.
And to the best of your knowledge, do you know how Jim Pickens and Mr. Cho knew each other?
Yes. Mr. Cho was had properties that were being managed.
I'm going to object to hearsay unless Mr. Cho or the person that's managed other than Mr. Gibbons is here. It is based on evidence that is not before, or based on testimony or evidence that.
He's not stating what anyone told him. He's just stating what he knows. That's not hearsay.
If he states that he knows because he's seen contracts or he's seen business relationships, that's one thing, but his understanding is another.
No other witness so far today has been held to the burden of stating the exact basis of all of their collective knowledge that they're testifying about. And I think that's an unnecessary and unreasonable burden, and it doesn't fall within the Tennessee Rules of Evidence, Your Honor.
Your Honor, he's about to testify to a relationship between Mr. Cho and another third party. And unless there's an opportunity to question either one of those persons about the relationship between Mr. Cho and another third party, it's hearsay.
Your Honor, respectfully, that does not fall within the definition of hearsay. He might have independent knowledge. He's not stated the basis for his knowledge. I've not asked him for the basis of his knowledge. I've simply asked him what the relationship was between two parties.
Based on his own knowledge.
Yes, based on his own knowledge. Sorry, Mr. Gibbons, continue.
Uh,
I can repeat the question for you.
Please.
Based on your own knowledge, do you know what the relationship was between Mr. Cho and Mr. Pickens?
Yes, I do. Jim Pickens bought or was the realtor representing him on.
Object to how he knows that, Your Honor.
Okay, could you lay the foundation, Ms. Scarborough?
Okay, yes, Your Honor. Mr. Gibbons, how do you know Jim Pickens?
I apologize. I'm trying to remember how I met him originally. I believe I met him at a party one time, a long time ago.
And since you first met him, describe your interactions with him. Did you guys know each other personally in a business context? How did you guys know each other?
He would have me do work on houses, and introduce me to people he would say were buying those houses, and I would do the work.
And you stated earlier that Mr. Pickens introduced you to Mr. Cho, is that correct?
Yes.
So based on your relationship with Mr. Pickens and his introduction to Mr. Cho, do you know what the relationship was between Mr. Pickens and Mr. Cho?
Mr. Pickens would tell me he...
Objection?
What
Hearsay.
Mr. Pickens told you is hearsay. Can you answer the question without indicating what Mr. Pickens told you?
Mr. Pickens would ask me to do work. I don't know how to answer that. I'm sorry.
Okay,
And-
well, then
and-
it's asked and answered.
He would call me and ask me to do work. I mean, I'm not...
Right. I'd suggest you move on, Ms. Scarborough.
Sorry.
Did you introduce Mr. Cho to Mr. Medlin?
Yes, I did.
And what was the purpose of that introduction?
Because he needed a property management company.
To the best of your knowledge, do you know what the relationship, the business relationship was between Dan Stewart Realtors and Ping Cho?
Dan Stewart Realtors was the property management company. They managed his property.
And do you know who the broker at Dan Stewart Realtors was who managed the property for Mr. Cho?
Yes, I
Based on
do.
your own knowledge.
Yes,
Who is that broker?
Joyce Medlin.
And to the best of your knowledge, Joyce Medlin is a licensed real estate broker. Is that
To the
your
best of
knowledge?
my knowledge, yes.
Okay. To the best of your knowledge, did Mr. Kenny Medlin ever perform duties as a real estate broker for Mr. Cho?
Not that I'm aware of.
Did Mr. Medlin, to the best of your knowledge, did he ever represent himself to others or to Mr. Cho that he was Mr. Cho's real estate broker?
Not that I'm aware of.
In your presence, did Mr. Medlin ever tell Mr. Cho that he was or was not a real estate broker?
I'm sorry, could you repeat the question?
In your presence, did Mr. Medlin ever represent himself to others or to Mr. Cho? Or, sorry. In your presence, did Mr. Medlin ever tell Mr. Cho that he was or was not a real estate broker?
Yes.
And can you describe the circumstances under which Mr. Medlin told Mr. Cho that he was or was not a real estate broker?
I had met with Mr. Medlin to discuss property maintenance, and the phone rang, and he said, Mr. Medlin said, "Hold on just a moment, it's Ping." I said, "Okay." I can't say what was being said on the other end of the conversation because I do not know. But in that conversation, he had said, "I can't, but we have realtors in the office that will be more than glad to help you." That was one time, and the other one, there was another instance when I again was in the office, and he had called into the office.
Object, I should have objected earlier. I need the dates and the times of these statements, of where they're in that, when they were made.
the best of your recollection, please, if you recall roughly the day or the time that these statements were made. And if you don't recall, just please state for the record.
Once about a year ago, once about, the one I just told you about was about a year ago, and the other would have been about 8 or 9 months ago, or close to that proximity. I can't be with all degree of certainty exactly how long ago. It has been about a year on both counts. At the time, I know I was being sent out to assess what the repair value, or what it would cost to repair the properties that needed to be repaired. And I'm sorry, I don't know if I'm allowed to say this.
Just continue answering the question. Please
I was
describe to
told
me,
for
in your
him.
presence, the best that you can recall, what Mr. Medlin said in regards to whether he was or was not a broker to Mr. Cho.
Second time he made the call, I was sitting there again, frequently in their office, talking about this needs to be repaired or that needs to be repaired, and he would ask me to hold, and it was Mr. Cho on the phone. He would say, "Hold on, it's ping," and he would take the phone call, and he had told him, he had made the statement, if you have another realtor representing you, we can't represent you. But once you're released from that contract, then we can represent you. I don't know what was said on the other end again, but then he said that I'm not a realtor, but we have realtors in our office that will be more than glad to help you.
And Mr. Gibbons, that was on 2 specific occasions that you remember, is that correct?
Correct.
Were there any other occasions that you were present where Mr. Medlin told Mr. Cho that he was not a real estate broker?
Not Mr. Cho, no.
Were you present at any other times when Mr. Medlin told others that he was not a real estate broker?
Oh, yes.
Can you estimate how many other occasions you were present when Mr. Medlin told others that he was not a real estate broker?
Well over a dozen times.
One second, Mr. Gibbons. Mr. Gibbons, do you work, other than being contracted out to do maintenance work, which you've previously stated, do you work for Dan Stewart Realtors?
No.
Have you ever been an employee of Dan Stewart Realtors?
No. No.
So if someone stated that they thought you were an employee of Dan Stewart Realtors, they would be mistaken, is that correct?
That's correct.
I think those are all my questions for now. Thank you so much for your time.
Cross-examination.
Gibbons, why did you bring the property, or Mr. Cho, you said, to Dan Stewart Realtors? Why did you do that?
Jim Pickens had brought those properties to me.
It's to manage.
Yeah.
Yeah, okay. Were you collecting any, did you ever collect any rents from the people that were there?
Yes.
Okay. Now, in your affidavit, you said that you were president of Randolph Construction. What's Randolph Construction?
What is Randolph? Randolph Construction is my it's dissolved, and it operates under Phoenix Investment Group right now.
Okay, and what was Randolph Construction's contractor's license number?
We perform property maintenance.
Well, I thought you said earlier you did remodeling. Do you do remodeling?
Painting is remodeling.
Do you do any remodeling that is something that's just not painting, any installation or any revamping of a room or anything like that?
Could you elaborate on what you mean by revamping?
Did you do anything besides painting?
We did sheetrock work, light carpentry work.
Sheetrock work, So what's the contractor license number?
There's not one for repairing a hole, ma'am.
Oh, okay. Did you ever do any work in excess of $2,500?
No, ma'am.
Okay, never.
Your Honor, I'm going to have to object to this line of questioning as to its relevance.
All right, well, actually, Your Honor, I'm attempting to discover whether or not this is a licensee or should be a licensee, which certainly goes to his ability to be a truthful witness and a witness that we can rely on.
Your Honor, I believe a requirement for someone to be licensed by some sort of regulatory board of the state of Tennessee is not a requirement for someone to testify at a proceeding.
I'm not suggesting that. She suggested earlier that he was truthful and a character witness, and I'm getting to his character.
I did not state that he was a character witness, Your Honor.
Yes, you did, Your
I
Honor.
believe you did. At least in part. Both a
I
character
apologize.
witness
That
and
he
a
was not
character
here for the
witness.
sole purpose of,
Right.
of being just a character.
Right.
I apologize.
Right. Your objection's overruled.
Okay, in any one project, in one house, in the number of the items you did, was it ever more than $2,500? In any one piece of property?
Not at one time, no, ma'am.
Oh, but collectively,
Over a period of time, yes.
on one property?
Yes.
Okay. And you do not have a contractor's license, is that correct? Or a home improvement license?
No, ma'am.
Now, you said that you found Mr. Medlin to be an honest person, and that's based on your knowing him for 10 years. Are you aware of his criminal conviction for conspiracy for mail fraud? And that he spent a year in jail? Are you aware of that?
Ma'am.
Okay, so even though he was convicted of that conspiracy, you still think he's honest?
Yes, I
Okay.
do.
Okay. You also said these two conversations where you overheard him speaking to Mr., who he said was Mr. Chow, although you didn't hear him at all, did you? It wasn't on speakerphone, was it? Okay. So on those two conversations, they happened, you said about a year ago, right?
Approximately, yeah, about a year ago.
Okay, not in 2011, which is 3 years ago.
I was estimating, I didn't have the exact time frame. I
Oh, there's
said
a
that
big
before.
difference between 1 and 3 years, sir.
I know.
Action counsel is making a statement, not asking a question.
Well, let me ask a question. Is there a difference between 1 and 3 years, sir?
Yes.
Okay. But you did say about a year ago, more than once, is that correct?
Yes, I did.
Okay. Now, you stated in your affidavit that on the second to last paragraph on the first page, it was only a matter of hours later that same day when Mr. Medlin asked me if it was acceptable to alter the partnership agreement. Are you a lawyer, sir? Are you a lawyer?
No, I'm not a lawyer.
Okay. Well, why would he be asking you advice about whether it's acceptable to alter a partnership agreement?
Objection, Your Honor. Individuals have permission to ask business associates questions without that individual being a lawyer. I don't understand the relevance of this line of questioning at all.
I'm trying to show the relationship and the character of these parties. He specifically said that Mr. Medlin asked him to give him advice of whether it was acceptable to alter in a partnership agreement. I'm trying to determine on what's that based. Why would he be asking him? He brought it up. It's in his affidavit.
The foundation of their over 10 years of friendship as business associates has already been laid. That seems to be foundation enough why someone would ask a business question. I still think the line of questioning is not relevant.
I'm going to ask the same question. I think it is relevant to show their relationship and what they thought was appropriate or not appropriate, and especially it goes in light of the fact of whether or not they're really telling the truth about whether or not someone represents himself as a real estate agent, especially in light of the fact that he's talking about partnership agreement and whether he can alter it. I think that shows the entire relationship between these two and whether or not this is a credible witness.
Overrule your objection.
Are you a lawyer?
No, I'm not.
Why would you be asked if it was acceptable to alter a partnership agreement?
Was it my partnership agreement?
You said Mr. Medlin talked to you. It says, here is what it says. I'll read the paragraph before. This is your affidavit. During the conversation, Mr. Medlin verbally advised Mr. Cho to consult and verify valuations of the property with his realtor, Jim Pickens. Was he his realtor? After you brought it all the way over to Dan Stewart, was he still his management property realtor?
Your Honor, could Mr. Gibbons be passed a copy of this affidavit? I believe it's already in the evidence, so that he could look at it as he's being asked specific questions about it.
I think that'd be helpful.
This one. Yeah. Paragraphs I'm speaking of, this begins with the third paragraph from the bottom of the page, wherein you state, during that conversation, Mr. Medlin verbally advised Mr. Cho to consult and verify valuations of the property with his realtor, Jim Pickens. Is this after you brought the property to Dan Stewart Realty because Dan Stewart needed to manage the property, or before you brought the property to Dan Stewart Realty to manage Mr. Cho's property?
It was actually after, it was another property. This was about another property that Ping was buying through Jim Pickens.
So what would the business have been doing at Dan Stewart's property at that time? Why would you bring it? Why are you involved in this at Dan Stewart's property when Mr. Cho already had property management or another realtor? Why would you have done that? And why would there have been discussions about it?
Your Honor, I believe that was 3 questions in one, so I'm going to object.
Yeah, that was
Okay,
3 questions in one.
let me stop at once. If this was this before or after you already brought the properties to Dan Stewart, you and Mr. Cho? Was this before or after?
Management properties, yes.
So this is after you brought the management properties.
Correct.
So why would Mr. Jim Pickens have still been the realtor?
Because Mr. Jim Pickens is the only person that ever found houses that I'm aware of for Mr. Ping to buy. He always used Jim to purchase property.
So he was still using Mr. Pickens? Are you saying after all the properties he owned were brought to Dan Stewart to be property manager, he was still using another realtor?
Correct.
Okay. Okay. Now, you said in that same paragraph that Mr. Ping should consult with a lawyer before entering in the purchase agreement, and Mr. Medlin specifically offered Mr. Ping about a week so he can consult with anyone if desired. And your next paragraph says, it was only a matter of hours later that same day when Mr. Medlin asked me if it was acceptable to alter the partnership agreement, allowing Mr. Cho's participation in the Union Avenue project. Why, again, would he be asking you?
Maybe just for an outside opinion.
Now, you said earlier that you're the one who brought Mr. Cho to Mr. Medlin. Is that right?
Yes, I introduced them, correct.
Through your work with Mr. Cho, collecting rent and doing other work for him on his property, right?
Right.
And after that, Dan Stewart was representing all the rental property at that time of Mr. Cho, right?
Sorry, correct.
And Dan Stewart Realty, do you know who owns that company?
It's my understanding that Kenny Medlin's president. I assume he owns it.
I have nothing further.
Can you redirect for your witness?
Gibbons, thank you for your time. I just have a few more questions for you.
Right.
Do you think that someone can be convicted of a crime and still be an honest person?
Yes, I do.
Do you think that someone can be convicted of a crime and not be guilty of that crime?
Yes.
Looking at your affidavit, which hopefully you have before you, that Ms. Ryan brought up, the paragraph that's one up from the bottom that you've been asked a number of questions about, where it says Mr. Medlin asked you if it was acceptable to alter the partnership agreement allowing Mr. Cho's participation in the Union Avenue project. Were you a participant in the Union Avenue project?
Sorry. No, I was there, but I didn't have anything to do with the contract. Or could you rephrase the question?
Were you a party to the Union Avenue project?
No.
You stated earlier that Jim Pickens was the real estate broker who found investment properties for Mr. Cho. Is that correct?
Correct.
And did Dan Stewart Realtors manage all of Mr. Cho's properties or some of Mr. Cho's properties?
Only 2.
And based on your own knowledge, how many properties did Mr. Cho have total that you are aware of?
9.
I'm going to object, unless he can name the properties and why he would know which ones he has, besides the 2 that he brought to Dan Stewart.
Your Honor, he has already laid the foundation that he did maintenance work on a number of Mr. Cho's property. I think it's reasonable to assume that he can testify on his own personal knowledge of the properties that he was aware of, a number that Mr. Cho owned.
If indeed he did the maintenance on other than the 2, I agree.
Objections overruled.
Well, no, I need to see that he did the maintenance on the other than the 2 that we already spoke of.
Your Honor, Ms. Ryan is requesting a higher burden for this witness than other witnesses, that they lay a specific background and give a resume for every single fact that they're testifying to, and that's simply not required.
Except for it's based on hearsay, unless there's a connection to show that he did the work on particular property, then it is based on something that was said to him, not something he knows personally. And that is hearsay evidence.
He is not testifying to hearsay. He is not making statements based on any out-of-court statement. The question was based on his own personal knowledge.
And what is that knowledge based on? That's my point. If he personally worked on that property, that's one thing.
If that's the new standard, Your Honor, I'd like to recall the prior witnesses and ask them what the basis of their statements were on, and if they were on affidavits that were out-of-court statements, then that would be hearsay testimony as well.
And, Your Honor, Mr. Cho already testified to the Denevieve's properties in his direct testimony, and she could have asked about them. Again, we already know what properties Mr. Cho had because he testified to them. I don't think we can get through with this witness what properties Mr. Cho had. He already testified to that. And the only way he could testify to what other properties they've had is if he has personal knowledge that would be based on something besides what he heard. He would have had to have personal knowledge of the properties that Mr. Cho had in some connection or form. I could say, I know one of these commissioners owns personal property or owns property, and what would that be based on? Unless I know it for a fact, I had some connection to it, it would be based on some thought process or some hearsay that I've heard. If she's going to ask questions about properties other than the two that we know about, then she needs to lay a foundation for that. That's my objection.
Can you lay a foundation for his knowledge?
I will relay a foundation, yes, Your Honor. Mr. Gibbons, did you work on properties, did you perform maintenance duties on properties that Mr. Cho owned?
Yes.
Did you work on numerous properties that Mr. Cho owned?
I performed the work on 2 properties.
Did you perform management duties on any properties that Mr. Cho owned?
Can you can you rephrase that question?
Did you collect rents or in any other way physically interact with any other properties that Mr. Cho owned?
I gave estimates for Mr. Cho on properties other than the 2 that Dan Stewart Realtors managed.
So in order to give estimates, did you have to go to these properties and look at them?
Yes.
How many properties of Mr. Cho's did you give estimates on?
There were 2 more duplexes in the same neighborhood as one of the properties that Dan Stewart Realtors managed.
And do you have personal knowledge, based on your own knowledge, of any other properties that Mr. Cho owned?
Not direct personal knowledge, no.
But it is your testimony that Dan Stewart Realtors managed 2 properties of Mr. Cho's and that you're aware of other properties of Mr. Cho's based on your own personal knowledge, correct?
Yes.
Those are all my questions at this time.
No further questions? Commission members, this is your opportunity to ask questions of the witness.
Mr. Gibbons, I'm Gary Bloom. You were asked twice, have you ever done property management? One time your response was not knowingly, another time your response was no. Mr. Cho, in his testimony, testified that you were his property manager. Do you know why he would have said that?
Yes.
And why is that?
Mr. Jim Pickens had the real estate agent that referred me to Ping had told me that a excellent way to guarantee that you keep...
Objection to the hearsay by Mr. Pickens, of Mr. Pickens.
It's a question of the board. I have no response, Your Honor.
Right, but it's a question from the board members.
It's still hearsay evidence.
Is there a way you can answer the question without saying what Mr. Pickens told you?
Can I ask the judge a specific? I guess I can ask the judge. Can you say what you were told to do?
Well, if you can, if it's not for the truth of it, but if it's merely to explain what you then did, then that would be acceptable.
Okay.
Your Honor, for the record, I think that might fall under hearsay exception 803. 1.23, then existing mental condition, to describe his mental condition and why he did something as a result of a statement by another, not for the truth of the matter asserted.
If we're going to have an argument about that hearsay exception, I would just action and what they did, and that's not what we're talking about here. We're talking about his knowledge and what he was told to do, and that's not the same thing. Not what he did, but what he was told to do, and that was my objection.
I can speak to me, can I, about what I decided without referencing somebody else.
Decided. Because that was a decision made by you.
I made a decision based off of the knowledge that I assumed I knew at the time, and once I realized that that you can't do that, and that within I can't give you an exact date. It was not even a year. It was not even half a year. I was terrified at the consequences and immediately went to my friend who happened to own a real estate firm and said, "This is the situation. What do I do? I don't want property management. I just want property maintenance." That's what this was all about all along. And did that answer your question without crossing?
Oh, we did, but we then quit.
Right.
Is that correct?
Right.
Okay, I got it. Thank you.
Mr. Gibbons, at one point, somebody asked you if you collected rents, and you said yes, you did. At another point, I think Ms. Scarborough asked you if you collected rents, and she asked you that as a two-part question, and you did not go back to that. So you are saying that for a small amount of time, you yourself collected some rents for Mr. Cho?
Yes, I did.
Okay. Once you determined that you were not a property management person and that you needed out of that, you went to Mr. Medlin for advice and help, correct?
That's correct.
Did Mr. Medlin then collect rents for Mr. Cho? That you specifically know, did he collect rents for Mr. Cho?
Well, sometimes the tenants would bring it directly to the office, and they would make the deposits or whatever they do there. And occasionally, I would be out there, and a renter, fixing something or what have you, and a renter would say I'd have my rent, and I would take it up to the real estate office and give it to them.
But you don't know if Mr. Medlin specifically collected rents?
I never knew him to, go out and collect rent, like I think you mean.
Well, as long as he received it. I mean, if they went to the office, would he have been the person they asked for when they went into the office?
No.
Is he the one that contacted you about maintenance for these properties? Or for any properties that they managed?
You mean specifically Mr. Cho's?
No. Any properties that were under property management by Dan Stewart Realtors, did Mr. Medlin ever contact you and ask you to go out and repair a property?
Sure.
Okay. Okay, thank you.
You're welcome.
Did you ever do any work for JAM Investments?
I never received, or did I receive a check? honestly, I can't remember if the check I received was from.
Did you
Jim
ever do
or
any
me.
work outside the Tennessee?
No.
Thank you.
I'm sorry, no.
Did Mr. Medlin help you write your affidavit?
No.
What is the difference between property maintenance and property management?
As I understand it, property maintenance is, you fix stuff. You go out and fix stuff that's broke on the properties. Property management, at least my understanding of it now, is that you have to be a licensed broker or realtor, and you can do contracts, and you have to have some sort of insurance and bonding to be able to do these contracts and show, like go show a unit or sell a house or something to that effect. You'll have to pardon me, I don't know all there is to know about real estate, but I know it very much requires a license to do it now. So,
Are you getting paid to testify today?
no.
Okay. Are you here just to help him as a friend?
Yes.
Okay, so you were not subpoenaed to be here. You're on your own here to help him.
Actually, I never picked it up. Apparently, that's what's at the post office, but I didn't find out about that till like the day before the hearing, which I'd already agreed. I think it was a matter of, I can't remember the term they used, but they did send a subpoena, but I didn't find out about it until afterwards.
Y'all ride up together?
Yes.
Mr. Gibbons, you have indicated you do quite a bit of repair work for Mr. Medlin on properties that is managed by his company. Have you known him to show properties to potential tenants while you
No.
were working on them or anything?
No.
Okay.
Hey, good afternoon. I'm Austin McMullen. I wanted to ask you a couple of questions
Sure.
about the 1837 Union project.
Okay.
Were you going to do, or did you ever do any remodeling or maintenance work on that project?
I was hired by, and I can't remember the initials, the company that actually owns that property, some kind of bank or something. I'm not sure exactly what they are. I was hired by them to actually do maintenance on the property. I actually worked directly for them, and they cut me a check. And during that period of time, I was around and all that. And we found the only really connection with that is Mr. Medlin. And I think they were looking for, any kind of data on that building. And in cleaning out some spots, we found some blueprints. And I turned those over. But that's really it.
Now, would you also talk with Mr. Medlin about what he was trying to work on with Mr. Choi with respect to, did I say his name right?
It's Cho.
Cho. I'm sorry. Let me start over. Did you ever talk to Mr. Medlin about what Mr. Medlin was trying to work out with Mr. Cho for Mr. Cho to be involved in the 1837 Union project?
Really limited. I mean, really limited. The most interaction I would get, of course, Mr. Cho has my number, and I made the introduction. Mr. Cho, I'm sorry, I got to get used to calling him that. Mr. Cho would call me and say, ask if I could get a hold of Kenny, that he tried to call him, and he would leave a message or something like that on occasion, and I would call Kenny and say, Ping's looking for, or sorry, Mr. Cho is looking for you.
But did you know that between Mr. Medlin and Mr. Cho, they were trying to work out the details of whatever Mr. Cho's involvement was going to be in that project?
I knew that there was some kind of negotiation going on, but I don't know the details of it. I wasn't involved in that process.
And that would have been between Mr. Medlin and Mr. Cho, the negotiation you're talking about?
Yeah, that was them, not me.
Okay, thank you.
Okay.
It seems that there are no additional questions. Thank you so much for your testimony, your release at this time. Next witness.
My next witness is Mr. Medlin. I'm not sure if the commission wants to take a break for lunch or take a break before we start with him.
We've decided we're not going to have a lunch break. There's a cafeteria, not a cafeteria, but it's just a break room with vending machines in it on the far side, on this same floor in the other corner. We may go over there and I may get me a pack of crackers, but we just, if it's okay with the court, we just work on through and go over and get us something to drink or get you something to eat, and we'll just continue on. But it's how long?
Starts.
Okay, we're back. We've been back in session now about an hour, so let's take a short 10-minute break and come back, and we'll reconvene and continue on.
So we'll be back in session.
We've been back in session.
Judge Williams, I'm turning it back to you.
All right. Ms. Scarborough, your next witness.
I'd like to call Kenny Medlin, please.
All right.
Mr. Medlin, please state your full name for the court reporter.
Kenny Ray Medlin. And can you speak a little louder? I can't hear very well.
Not a problem. Sorry about that. Mr. Medlin, where do you currently work?
Currently, I work as a manufacturer's rep for a company called TEU Services out of Kerrville, Texas. And I am still the owner of Dan Stewart Realtors via Jam Investments.
Okay. What is Jam Investments?
Jam Investments was originally a LLC established with my family. We owned an apartment complex in Memphis, and we owned a couple of other businesses. And when the opportunity to buy the company known as Dan Stewart Realtors from HomeQuest LLC that was owned by Leonard McCoy at the time, then we put it under the umbrella of Jam Investments.
Are you the sole member of Jam Investments?
Yes, I am.
So you're the sole member of Jam Investments, and Jam Investments owns Dan Stewart Realtors. Is that correct?
That is correct. It's a DBA.
Okay. And you said you're the owner of Dan Stewart Realtors?
I am the sole member of Jam Investments that owns Dan Stewart Realtors.
Correct. Do you know who the principal broker at Dan Stewart Realtors is?
My mother, Joyce Medlin.
And to the best of your knowledge, what is her role as the principal broker at Dan Stewart Realtors?
Taking care of the clients of the company, taking care of the agents, ensuring that they do everything in compliance with the state of Tennessee and the ethics that we have all agreed to be bound by with the Tennessee Association of Realtors and the Memphis Area Association of Realtors.
Mr. Medlin, are you currently a licensed real estate broker?
No, ma'am.
Have you ever been a licensed real estate broker?
I was many years ago.
Why are you no longer a licensed real estate broker?
One thing, I think I ran short on my time with the hours to get renewed, but back in somewhere around 2002, a company called New Century Realty was going out of business in Memphis, Tennessee, and I acquired about 20 of their agents who were left abandoned. And one of the problems that was common in that day and time was principal brokers and owners competing with their agents. And I made a commitment to the agents that they come on board and would work hard, I would retire my license or let it go or whatever and not compete against them.
So you decided to retire or let it expire, your license, so that you weren't competing with the agents who were at the company that you owned. Is that correct?
Correct.
Including the time you were a licensed real estate broker to now, approximately how long have you been involved in the real estate industry?
I think I originally got my license in '96. I don't remember what Ms. Maxwell's actual statement was. Dan actually talked me into going to work for him. But the standpoint, when was in bad health, I bought the company. And in factuality, I've been involved in real estate from a standpoint of managing the operation from word go. I take care of the marketing, assist Joyce, which is why we actually appealed in 2006 to potentially get a license back because of the workload with having 30 agents trying to manage that many agents at one time. The commission denied the request, which was understandable. And so I just continued on in the marketing endeavor. And that's really all I've been able to do.
Okay. Let me get a copy of the notice of hearing and charges to hand you. Okay, hang on one second. The notice of hearing and charges has already been given to the board?
Right. Mm-hmm. Yes, you may.
Mr. Medlin, I believe if you look at the bottom of the first page there, I handed you my copy, so I'm just kind of going by memory here. It defines what a broker is according to TCA 6213-3014A. I'm going to read that definition.
Where are you reading, hon? Bottom of the first page?
Hang on one moment. Let me get a copy to look at also. All right, the bottom of the second page. My apologies, Mr. Medlin. I'm going to ask you if you have ever acted as a broker according to that definition. Can you please read the definition of a broker at the bottom of page 2 of the notice of hearing and charges that's under count 1? Can you read that definition for me?
Referring where it picks up with 62-13-3014A. Wherein it states pertinent part as follows: for a broker means any person who, for a fee, commission, finder's fee, or other valuable consideration, or with the intent of expectation of receiving a fee or commission, finder's fee, or other valuable consideration from another, solicits, negotiates, or attempts to solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sell, rent, or exchange for any real estate or of the improvements of the real estate or any timeshare interval as defined in the Tennessee Timeshare Act, compiled in Title 66, Chapter 2, Part 1. 32, Part 1.
It continues at the top of the next page.
Oh, does it? Okay. Collects rents or attempts to collect rents, auctions or offers to auction, who advertises or holds out as engaged in any of the foregoing. Is that? Okay.
Thank you. Mr. Medlin, since your license expired in 2002, Have you acted as a broker according to that definition you just read?
No, ma'am.
Have you told anyone that you would perform any of the duties of a broker as contained in that definition you just read since 2002?
No, ma'am. I always refer them to an agent.
And Mr. Medlin, I'd like you to look ahead to count 2, where it starts Tennessee Code Annotated 6213312B, which states, and can you read that definition following the colon there, please, for the court?
It is unlawful for any person directly or indirectly to engage in or to conduct, to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent, as defined in 62-13102, within this state without first obtaining a license as broker, affiliate broker, timeshare salesperson, or acquisition agent as provided in this chapter, unless exempted from obtaining a license under 62-13104. No person shall be permitted to hold at the same time an active timeshare salesperson's license and active acquisition agent license.
And according to that definition you just read, Mr. Medlin, have you directly or indirectly advertised or claimed to be engaging in the conduct of a broker?
Ma'am.
And just for completeness of the record, let's go to count 3, and if you could please read which follows the semicolon following Tennessee Code Annotated 6213301.
It is unlawful for any person directly or indirectly to engage in or conduct, to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent, as defined in 62-13102, within this state without first obtaining a real estate or obtaining a license as broker, affiliate broker, timeshare salesperson, or acquisition agent, as provided in this chapter, unless exempted from obtaining a license under 62-13104. No permission shall be permitted to hold at the same time an active timeshare salesperson license and an active acquisition agent license.
Mr. Medlin, according to that definition you just read, since 2002, have you directly or indirectly engaged in, conducted, advertised, or claimed to be engaging in the business of a real estate broker?
Ma'am.
Have you represented yourself to others as a real estate broker?
Ma'am, not since 2002.
Since 2002, have you advertised your services as a real estate broker?
No, ma'am, not as a broker.
Since 2002, have you acted in the capacity of a real estate broker?
Ma'am.
Mr. Medlin, since 2002, have you ever told anyone that you are not a real estate broker?
Many occasions.
Please describe the occasions and to whom you have told that you are not a real estate broker, to the
I don't
best of
think-
your recollection.
Can we limit this to a short thing, because I don't think the court wants to hear of this long list. Especially in 2002, 2003 era, there were many occasions where people that did actually know me as a licensed real estate agent would approach me with opportunities. They wanted to buy or sell a list or whatever. And I always referred them to the customer and advised, I've retired my license. And I used the word retired, whether it was revoked, as Mr. Maxwell has said, or what. In my estimation, it was just not active. After a couple of years, a lot of that subsided. Obviously, when you quit marketing yourself and networking, that comes slow down. From a standpoint of dealing with, they ask what you do for a living. Pull out a business card. I have a business card that says Dan Stewart Realtors President. Now, unless they're asking about something lighting, then I have a different business card for that option. But from a standpoint of actually presenting myself as a broker, no, I'm not a licensed broker. My real estate card indicates that. I have been asked specifically, are you a licensed agent? No, I am not. When I was engaging in the buying and selling of houses, and what we commonly call as flipping, but I'm not referring to the illegal flip, I would always go the extra mile because I was selling a property personally. And under law, if I'm not mistaken, a real estate agent that has an active license has to disclose that he is, in fact, a licensed real estate agent and receive said disclosure with signature, making the purchaser aware of the implied that I'm a lot smarter than real estate than what they are, for lack of better terms. And I'll be friendly there. And many times I would actually have to go in, and after that I would get a document that would say that. You realize I used to be a real estate broker. I am no longer a licensed agent. However, my memories didn't just go away because I was no longer an agent. And I tried to notify people that way. And that was what surfaced in the 2005, 2006 era, rolling into 2007. And that's because I was selling off most of the properties that I had at that time, because I had actually had a little bit of foresight of what was going to happen in 2008. So there was a lot of indicators that would lead us down that path. So from that standpoint, I went the complete opposite of making sure that they understood. Recently, when I started to, I wasn't buying and selling houses anymore. Obviously, I wasn't doing real estate as an agent. There was a couple of different investment opportunities come up that I did pursue. One of them was the 1837 Union Avenue project. There were others. And I tried to let everybody know exactly where I stood. And in the process of my first communication with Mr. Ping, I advised him then I was not a licensed real estate agent. And I did explain to him that I was in the past. And I guess to give just a little more understanding, when you're convicted in a federal penitentiary, okay, and it was a mail fraud charge, it was over a fax that was sent across state lines that the United States government determined was a party to a criminal activity that was happening in California. Okay. When you get convicted of something, especially by the government, you do not broach any kind of area of indiscretion. You make sure that you cover yourself and protect yourself. And that is what I've done all these years.
Mr. Medlin, you've already stated that you're the sole member of JAM Investments, LLC, which is the owner of Dan Stewart Realtors. So as a former licensed real estate broker, how is owning a real estate company through JAM Investments different from acting as a real estate broker?
Very frustrating. When I was a broker and more or less trying to run the operation, and Joyce was running, I believe, one office and I was running another office, and I had very limited connectivity, or limited agents actually assigned under me at that office. And I spent most of my time out running around generating business or trying to generate business for myself and everybody else. When we reached the point of letting the license go, we actually closed one of the offices at any point in maintaining two offices. We all merged back together, and I took a role of strictly a marketing standpoint. I would help the agents market themselves, give them ideas on how to network themselves. So really more of a training mode for the agents. Joyce, as the principal broker, was obviously responsible for training as far as the law goes and all the ethics and all that stuff.
Okay, so,
we just served a dual function.
Sorry. So owning a real estate company has a lot more to do with marketing, and that's really what you're doing all day, versus when you were a real estate broker, you'd be showing houses and taking clients around. Is that
Yes,
what you're
ma'am.
saying? Mr. Medlin, do you know a Mr. Ping Cho?
Yes, ma'am.
When did you first meet Mr. Ping Cho, to the best of your recollection?
Mr. Gibbons approached me. He wasn't quite doing property management, but he was getting really close on that border for Jim Pickens. And I think Mr. Ping had some properties with Hardco, if I'm not mistaken, and I don't recall specifically. In any case, he was not satisfied. They was looking for a new property management company. We did some property management. It's not something that I enjoy doing, and in fact, I don't like property management. But
And when you say
Mr. Gibbons had come to my office.
I'm sorry, real quick, just to clarify, kind of break it down. When you say we did property management, what are you referring to?
We had a couple of agents that had picked up stray properties, ones or twos or threes, not anything
Okay, so when you
significant.
say the word we, are you referring to Dan Stewart
I'm referring
Realtors
to
as
Dan
a
Stewart
company?
Realtors.
Did you personally perform duties of property management?
No, ma'am.
So when you use the pronoun we, you mean the company Dan Stewart Realtors performed property management duties via one of the licensed brokers. Is that what you're saying?
Yes, ma'am. But we were a team.
Okay.
We all have our parts to play.
Okay. Sorry. So you met Mr. Chu, Mr. Gibbons introduced you to Mr. Chu, is that correct?
Yes, ma'am. He came to my office. He actually had talked to, I guess, several of the people that he was working with, and he was doing maintenance primarily on everything that I was aware of. He actually, on the phone, Mr. Ping had called, they were talking, and Mr. Gibbons handed me the phone and introduced me to Mr. Ping, in which we started a discussion on, and I couldn't give you the property address. I have no idea. That, again, I wasn't the principal broker. I didn't keep up with the contracts. I didn't keep up with property addresses. I tried to deal with the overall company's concerns with a potential client.
Okay, so Mr. Gibbons introduced Mr. Cho to you so that he could have some properties managed by a broker and Dan Stewart Realtors. Is that what you're saying?
Yes, ma'am.
Okay. Do you recall what broker handled the property management for Mr. Cho?
I believe it was Hardco on property management initially.
Do you recall did Dan Stewart Realtors end up managing any properties for Mr. Cho?
We managed 2 properties, as I recall.
Which brokers inside of Dan Stewart Realtors managed those properties for Mr. Cho, if you recall?
Joyce Medlin.
Okay. If you are aware, did Mr. Cho ever transfer money to the escrow account at Dan Stewart Realtors?
Yes, he had a concern regarding contractors and having work done. They wanted half the money up front. He didn't want to give half the money up front, and the equitable solution was, okay, do you mind a third party holding your money? We'll go out and make sure the work was done to your satisfaction, take pictures, whatever, and then release the money. And there was occasions that money was sent into the escrow account for somebody else's, such as Mr. Gibbons, when he would do the maintenance work that was required.
To the best of your recollection, how many times did Mr. Cho transfer money to the escrow account at Dan Stewart Realtors for it to then be passed on to a contractor or someone else?
To be honest with you, I really don't know how many times he transferred it. We actually did it for a number of other out-of-state clients, allowing them to do that because it was a good protection factor for them.
Okay.
How many he did? A couple? I don't know.
Okay. That's fine. If you don't know, that's fine. Did you and Mr. Cho enter into an agreement regarding property at 1837 Union Avenue?
Yes, we did.
What was that agreement for?
Mr. Gibbons had talked to Mr. Cho, and you'll have to beg me because I was always under I thought it was Quee. But in any case, he had talked to Mr. Gibbons. Mr. Gibbons was working on a project on the 1837 Union Avenue that I was already contracted with to buy the property. We were trying to ascertain all the maintenance and repairs and things like that needed to be done. From what I recall, Mr. Ping was not happy with his investments in Memphis and was looking for a different avenue. Mr. Gibbons had recommended, well, you might take a look at this. So, again, Mr. Ping and I spoke. And I said, well, this is what we're doing. And I laid out the entire outline for him as to the marketing plan, the whole nine thing. I said, no, this is what I'm doing. This is my investment, so to speak. And Mr. Gibbons at that point was a partner in that, not a full-blown partner from a standpoint of let's all go in and pull our money. He was providing maintenance services, and I was negotiating a position to reduce the rehab costs because we were facing about a $9 million rehab on that building.
Will you describe for the commission what the property is at 1837 Union Avenue, just so they can have an idea of what we're talking about?
1837 Union Avenue is an old 8-story Holiday Inn hotel with an adjacent 4-story office building. Approximately 172 rooms on the hotel side and approximately 80,000 square foot, I think, on the multiple levels, plus a 3-car basement garage. The project was going to be split down into a multi-use facility with the hotel being converted to apartment-styled units with specific renters from several different charitable organizations where they managed people's money because of whatever disability they had. And we had established a set rate price for going into the hotel.
It was an old hotel that was being converted into an apartment.
Yes, ma'am.
Okay. So what was the agreement for specifically that you entered into between you and Mr. Cho regarding the property at 1837 Union?
Originally that morning when we got into the conversation and talking, we were simply saying 10 units, select whichever ones you want. And we were going through what he could rehab them the way he wanted to or whatever, which was fine. But somewhere around noon, 1 o'clock, I was hungry, and I remember I was so hungry. He come back at me and he said, how can I be assured if you've got Dan Stewart Realtors being your property management company for all of us, that they won't rent your properties before they rent my properties? I said, well, Mr. Cho, I can't mandate who rents what where. If somebody wants on the second floor, the third floor, the eighth floor, I can't mandate that. I cannot control that. You can't ask an agent to only rent the eighth floor or the seventh floor or whatever. It's all going to be client-based, and we have no idea who's going to want what. Well, I just believe that Dan Stewart Realtors would come near wanting to rent your properties over my properties. So we argued back and forth for a while, and we come to the conclusion of the joint venture agreement. Okay, we're all going to go in, and we're just going to collectively own this entire thing, pull it all together in this nice little package. That way, if we have somebody on the first floor who wants to rent a unit of the second floor, great. It's a percentage division of the intake versus percentage ownership of the total investment. And we identified that in the contract. And then the problem is we had already established the purchase-sale agreement, and then we had to change to the JV agreement. And that's, it was a round-robin day before Mr. Ping was satisfied.
Okay, so the agreement was for a joint venture that you guys would all own a percentage, that you and Mr. Cho would both own a percentage of the units at 1837 Union. Is that correct?
That's correct.
Okay. Did you have a real estate broker representing you in this transaction?
No, ma'am.
Did Mr. Cho have a real estate broker representing him in this action?
No, ma'am, he did not.
Did you act as an unlicensed broker in this real estate transaction involving the property at 1837 Union Avenue?
No, ma'am, I operate as a for sale by owner.
Based on your own personal knowledge, did Mr. Cho have a real estate agent representing him in any other transactions he was doing in Memphis?
At that time, I don't believe he had Jim Pickens representing him. I do know that he had told me that he had representation from Jim Pickens earlier. At that point, I think he had terminated that relationship, but I don't know for sure.
Mr. Cho told you he had a real estate broker at some point. You weren't sure if he still had a broker at the time that you guys...
At the time of this contract, I do not know.
Never mind.
One moment, Mr. Medlin. Based on your own personal knowledge, did Mr. Cho own other real estate in Memphis or elsewhere at the time you entered into this transaction with him on 1837 Union Avenue?
I do not know how many properties he owned. I knew that he had several, but I didn't know how many.
Based on your own personal knowledge and impression of Mr. Cho, did Mr. Cho appear to be a sophisticated businessman to you?
He didn't miss a detail in our negotiation, I assure you.
For the purchase of the property at 1837 Union Avenue, was there any sort of earnest money required from Mr. Cho?
Originally, there was $40,000 going to be used as earnest money to the purchase of those 10 units. By that afternoon, he had transformed, and his total commitment was $290-something thousand, and I don't remember exactly what the number was. And I said, well, let's don't move that. We'll use the $40,000 as your financial commitment until we get the thing closed. Because the lender that kept delaying us required a secondary appraisal, and that's where the money was actually ultimately used, was paying for the secondary appraisal.
Okay, and where was that money deposited?
It was deposited as Dan Stewart Realtors escrow account.
Did you suggest to Mr. Cho that it be deposited at Dan Stewart Realtors?
Originally, yes. In the contract on the buy-sell agreement of the 10 units, that was what was discussed. And he was familiar with the county. He'd used it before.
Did he have any objection to depositing that money with Dan Stewart Realtors?
No, ma'am.
Did you ever think at any point that Mr. Cho thought that you were a real estate broker or thought that you were his real estate broker?
No, ma'am.
Did you ever tell Mr. Cho that you were not a real estate broker?
Multiple occasions.
To the best of your recollection, please describe the circumstances under which you told Mr. Cho that you were not a real estate broker.
First one was the first day that we got on the phone talking about property management. He was asking me questions about a property that had been presented to him. And I explained to him, I am not a licensed real estate agent. I have no idea what the property value is in that neighborhood. You need to contact your agent and discuss this. He said, well, I want a second opinion. I'm bound by ethics. Our company cannot do that. And you need to go back to your agent. If you're not satisfied with his services, release him, and then we can talk. We'll get you an agent that can help you with whatever area you're talking about. That was
You
just
say
one.
we, were you referring to Dan Stewart Realtors as a company?
Dan Stewart Realtors is me. For all practical purposes, I own this company. Everything, my blood, sweat, and tears has been in this for 15 years. Yes, ma'am. When I say we, I refer to the company as a whole.
Okay. Was there any other occasion during which you told Mr. Cho that you were not a real estate broker?
About 3 times into this whole equation, during the property management, he continually asked about my opinion of values, opinion of demographics, opinion of all kinds of things. Things I'm not licensed to talk about. And I kept explaining that I am not a licensed real estate agent. Please go back to Mr. Pickens. The last time that I said that, well, I really don't have one. I don't know if he was implying that he had terminated the relationship or not. Until I had that clarification, we were not willing to talk, and I was not willing to assign him to an agent. I mean, agents are hungry. But if I'd have called one of my agents and said, you need to talk to Mr. Ping, that would have been bad. Not when I didn't know.
Was there any other occasion that you can recall during which you told Mr. Cho that you were not a licensed real estate broker?
Those 3 or 4 times, that's all I can recall offhand.
I think those are all my questions for now. Thank you so much.
Okay.
Cross-examination.
Mr. Medlin, in the purchase and sale agreement that was dated, let me find the exact date so I don't lie. December 29, 2011. It says that you're the seller, JAMA Investments LLC, but you didn't own the property at that time, did you?
No, ma'am. It was, and you will note in the contract, is also subject to closing on said purchase.
I'm talking about the commercial and sale agreement, sir, not the separate contract. At the time this is in here.
Your Honor, can we?
Your Honor, I'd like
sorry,
to have
can
a copy
we
of that,
hand
please.
a copy? Can I hand a copy to the witness of what she's?
Of the purchase sale agreement, that's fine.
Sure. If you'd hand a copy to the witness, please.
Okay, look at paragraph number 1 in that agreement. Who is the seller? Who is the seller?
Investments,
Okay.
LLC.
You didn't own the property when you drafted this contract on the 29th of December of 2011, did you?
No, I did not.
Okay.
Objection, Your Honor, as to relevance in this line of questioning as to whether or not he owned the property. I don't see how that.
I think it's relevant relevant to the entire matter, how he held himself out, what actions or reactions he had with this person, what he actually owned or didn't own at the time he's negotiating with him, which goes to his credibility and his ability to present true and correct facts before this commission and concerning all other obligations of this contract. It's relevant, Your Honor.
The issue before the commission today is whether or not Mr. Medlin acted as a broker or represented or advertised himself as a broker. The essence of a contract between he and Mr. Cho is not before the commission to decide today.
This contract is on a TAR form. It is between a person who was apparently the buyer, and a seller who is Mr. Medlin, who apparently didn't even own the property in question at the time of this contract. This definitely goes to the truthfulness and the honesty of this particular witness, and I've asked again that I be allowed to go forward with that.
I'd like to renew my pre-hearing objection to extrinsic evidence outside of the notice of hearing and charges, particularly evidence related to the transaction between Mr. Cho and Mr. Medlin, as there is a civil court case pending. This is public record, and evidence related to this transaction is not only not relevant, it's highly prejudicial to Mr. Medlin in this civil action that is pending.
Civil action is not present here, Your Honor. All of these facts are facts they need to consider whether or not he held himself out as a realtor, and his honesty is one of those things that they can consider, especially in light of his testimony when he says he's never held himself out that way. And his honesty in this particular transaction is at issue here today.
Ms. Ryan can ask other questions as to his honesty and his character, but specific questions about details of this contractual deal between Mr. Cho and Mr. Medlin are at issue in a civil case that is pending, and it would be highly prejudicial and not relevant to this action here for this line of testimony to be admitted today.
This is the crux of the matter that's in the notice of hearing and charges. The fact that it was on this contract, on this form, it's all a part of it. And it is relevant to the issue today. And the fact that he has another case going is not our concern. Our concern today is whether or not we as the state can show enough proof for this commission to make a determination on whether all his actions in total arise to that of someone who needed a license. And I respectfully submit that his honesty at the time he drafted a contract that is a real estate contract is something this commission needs to consider, and his honesty includes whether or not he owned the property on the date he drafted this contract.
Your Honor, the essence of the Uniform Administrative Procedures Act in relation to evidence is whether it's relevant or immaterial. I think that not only is this not relevant, it is immaterial, highly prejudicial to Mr. Medlin. Ms. Ryan is certainly welcome to ask questions about the use of a TAR contract, whether or not he represented himself as a broker, any other questions that could go to his honesty, but specific questions about the transaction that occurred between Mr. Cho and Mr. Medlin are at issue in a civil case pending, and it is the duty of the court to ensure the exclusion of evidence that would be highly prejudicial to an individual in all pending matters.
Your Honor, if indeed there's a decision made here today that impacts his present court matter, he is certainly free to raise the issue of relevance in that court matter. We are not a part of that court matter. In this present case, this is a sale agreement that he drafted, and my purpose of asking these questions goes to his whole transaction and whether or not he held himself out to be a realtor in any way, shape, or form. And his truthfulness and honesty are something this commission must consider in determining all the facts in this case. This is something she certainly can object to if there is something that is held against him today, or if indeed Mr. Cho intends to try to use something from this hearing today in the court matter, she can object to at the proper time. This is not the place for that objection. And I asked to be able to ask about the transaction that is at the crux of the matter in the notice of hearing. That is what brought us here today, and this is a part of that same transaction, Your Honor.
Objection overruled.
You didn't own that property on the date that you drafted this contract, did you?
No, ma'am, I did not.
Okay, you did not.
Mr. Ping did. He understood that I didn't own it either. In his own evidence, he recounts that he understood that because he was implying about the loan.
Did he own the property?
Who?
Was he, Mr. Cho, did he own the property?
No.
Okay, and you didn't own it either?
No.
So Jam Investments didn't own it?
No.
But you did a purchase and sale agreement between Jam Investments, who did not own the property,
Right.
and Mr. Cho.
That's correct.
And in that contract, Dan Stewart Realty was to hold a $40,000 earnest money, is that right?
That's correct.
Okay. And you say in your subsequent response that you own TAR and therefore, and that Dan Stewart Realtors is a member of TAR and
Your Honor, can we have a copy of this to be handed to the witness while he's questioned about the specific
I think he
language?
has that. Doesn't he have that?
Is that in Exhibit 1?
I've got a notice of hearing and I've got a commercial sales agreement. I don't know what I've got. Your Honor, I can hardly hear her.
bit louder, please, Ms. Ryan.
Just in case it comes up again, I would like to give them a copy of the initial response.
For the record, what is the document that was just handed to him?
Do you want to see this one?
The document that was handed to him is a copy of the document that was presented in Evans and Ms. Kropp's testimony, which are a letter from Mr. Medlin subsequent to the filing of this complaint. And it was addressed to Ms. Kropp, and it's a part of the record. I believe it's exhibit number 3.
Great, thank you.
If you turn to the next page, second page of that document, your letter, Mr. Medlin, you said, as far as using the TAR contract, the company in which I own is a member of TAR and fully authorized to use those forms. Who gave you the form?
We keep them printed out for the agents to pass out to sub-owners.
So you just picked up a form and used it?
Yes, ma'am.
Even though you're not a licensed realtor or a licensee?
Show me a law that says that a licensed realtor has to use the TAR forms.
Has to use the TAR form?
That's recommended because it is the form that was created by the state, the Tennessee Association of Realtors, in fact, to ensure that the contract is protected for all parties, most especially the consumer. That's the best form written in the state by anybody to do buy and sell transactions.
Okay, well, is it a form that is sanctioned or approved by the Tennessee Real Estate Commission that somehow gives it a higher power than another form?
I think that you told me
Honor,
earlier the Tennessee Real Estate Commission didn't endorse them.
Wait, please. Objection, Your Honor. I don't know what the basis for his knowledge would be as to whether something is regulated by a certain agency. If she wants to ask if he's aware of something being regulated by a certain commission or agency, she's certainly welcome to, but I don't think he can testify to matters of law.
He made a statement that it is the best form, and the purpose of the form is to protect the people, and I'm just asking him if it's a form sanctioned by the Tennessee Real Estate Commission as a form that is created to protect the people of Tennessee.
If Ms. Ryan could just rephrase that, something along the lines, to the best of his knowledge, because again, I think as a non-lawyer, he can't speak to a matter of law or a matter of regulatory issue.
As a former licensee, do you know that this form is a form that is sanctioned by the Tennessee Real Estate Commission and recommended by the Tennessee Real Estate Commission?
I don't believe that the Tennessee Real Estate Commission endorses any form of thing for a contract.
But having said that, you said earlier that it's TAR's position that the form can be used to protect the public and therefore it's okay as a non-licensee to use this form?
The purpose of the form was to protect the consumer and to ensure that all transactions had full disclaimer and disclosure.
Were you a member of TAR?
Of course.
So you know as a member of TAR that you are limited in what you can use in TAR and that the forms are owned by TAR and not available to the public, do you not?
And why is it that the real estate agents in Memphis, including my own attorney that is not a real estate lawyer, use the TAR form? Again, for the same reason. It is the best contract to keep everybody safe and protected.
I don't think we have any proof on that, sir. Let me go on. Now, you said in your response to your complaint that...
Are you referring to Exhibit 2?
If you'll give me a moment, I will tell you what I'm referring to when I get to it. In your response to the complaint, in the letter that you wrote, in your response, subsequent that you were just looking at, it says that your intention was to sell Jam Investments as well as namesake of Dan Stewart Realtors. Did you sell it?
No, I have not. No one will buy it under state litigation.
Okay. And this was written in 2013. Was it in litigation then?
We've been involved in this now for over a year, hon.
So is the answer yes?
So nobody would take Jam Investments as long as we had litigation going on.
I'm asking, were you involved in litigation in March of 2013?
From the state, yes.
Were you involved in litigation in court in March of 2013 concerning your contract or issues with Mr. Cho?
I recognize this as being a courtroom.
Were you involved in circuit or chancery court in Shelby County in March of 2013 regarding your transaction with Mr. Cho?
I don't recall the date of the lawsuit that was filed.
Okay. Now, in exhibit number 2, you state that I personally am not presented in any fashion on the Dan Stewart Realtors website. Do you recall saying that?
Yes, ma'am.
Okay. I'm going to show you a copy of the document that you've already seen, but I'll let you look at it again.
This is a copy. I think it's the same.
It's the same thing, but I'm talking about the other pages.
February 5th, 2014.
But the letter that you wrote is dated November 12, 2012, when you said you were not present in any fashion on the Dan Stewart Realtor. Is that right? You have that in front of you. If you look at your response, exhibit
Okay.
number 2,
And where do I go?
top of the page, what's the date on that?
Oh, March 20th, 2013, page number 1. Sorry?
The date of your response, exhibit number 2, it says, "Dear Mr. House." You
Excuse
have
me.
it in front of you. It
Second
looks
page.
like this.
Honey, I can't hear you, that's all.
Looks like that.
Oh, Mr. Connell's house? I don't think I have that one, do I?
Yes, sir, I gave it to you. It's right there.
Okay.
I believe so. Date in the top right-hand corner,
November 2nd, 2012.
and that's the date you said you weren't presenting yourself in any way. Is that right?
Not as a real estate agent, no ma'am.
That's not what I said. You say
Then
you
what
were
you said
personally
was
not
correct.
presented in any fashion on the Stewart Realtors website. That's what you say on that date. Is that right?
Not as a real estate agent, that's correct.
And that's not what you said. You said, "I personally am not presented in any fashion on the Dan Stewart Realtors website." Is that not what you said?
The implication was I represented myself as a real estate agent, and I
Sir,
was not
would you
on the
please
website.
answer my
I am
question?
on the website.
Did you say that on that day?
Obviously, I wrote it. Yes, ma'am.
All right. And on the documents I gave you that are pink,
Okay.
that say Dan Stewart's website,
Yes, ma'am.
okay, what does it say at the bottom of the first page? What's the date?
February 5th, 2014. It says, I think we've read this a bunch of times, but our team, Angela Parks Wilson is an affiliate broker realtor and our property management manager with her phone number. The vast majority of investment property selection process will be carried out by Kenny Medlin. And the reason being is this. I don't
wait a
allow
minute,
them
sir.
to just sign
Wait,
properties.
sir, please.
I'm sorry.
Objection, Your Honor.
I didn't
The witness
even-
is trying to finish his answer to the question.
I didn't even ask him a question about that. I asked him to pull up this document. I was going to ask him a question when he started to read it. Now, I'd like to be able to ask my question.
I think the witness was just finishing his answer. Ms. Ryan would allow him to do so. I think he could give a
Right,
full.
but had she asked him a question yet?
He asked me to read the bottom, and that's what I was
And you
doing.
didn't read the entire bottom, and I wanted to have the entire bottom read before we went on, and that's where I was going.
Objection withdrawn.
Please read the very last sentence, sir.
You deserve, this one, you deserve?
That's it.
Okay, you deserve a realty team that truly cares about your interest. Call Kenny Medlin today, 901-387-8526, which is my personal cell phone.
Now, at the top of the page, sir,
Mhm.
read the very headline where it says, "Will help."
We'll, as in we will help you invest in and manage your Memphis, Tennessee properties.
And that first paragraph, what does it say?
As a property management client of Dan Stewart Realtors, obviously, we look forward to managing your real estate investment portfolio in Memphis. After 35-plus years, we have a strong established reputation and look forward to the ongoing opportunity to proving that to you personally.
Now, was this the same website that was or was not in place when you made the statement in 2012?
I don't have any idea. I don't manage my website.
You didn't put the website together?
No, ma'am.
You didn't review it?
No, ma'am. I haven't seen the website in 2 years.
You did not review the website.
Objection, Your Honor.
That is the
Asked and
principal broker's
answered.
responsibility.
Wait a moment, Kenny. Asked and answered. She's asked the same question. He's already answered it.
As president and owner of Dan Stewart Realty, you had no interest in reviewing the website?
My mother is the principal broker. Why wouldn't I trust her?
In 2012, had you reviewed the website then?
Objection, Your Honor. Asked and answered. He said he hadn't looked at the website in 2 years.
Your Honor, I am going back to follow up what he already said early in 2012 when he said he wasn't involved, so I want to make sure he had reviewed the website when he made that statement.
That's a slightly different question.
2012, had you reviewed the website?
I don't recall.
You don't recall, okay. If you look at all the rest of the pages, please, can you tell me whose name is phone numbers on the second page of that pink document?
Yes, mine.
Okay, and on the third page of that pink document?
Yeah, if it says if no answer, call my cell phone, because I want to know why it wasn't answered.
And the fourth page of that pink document?
Again, for information, please feel free to call the main office number or my personal cell phone.
And the next page of that pink document?
It goes back to the property management, which we've already discussed.
And on all those pages, is it Dan Stewart Realty is the headline on those pages?
Yes, ma'am.
Okay. So, in 2014, your name appears on the website in a prominent way, does it not? You have no idea whether it was there or not, although you made the statement it was not, in 2012.
I don't know.
You don't know, okay?
And I would say that it probably was, just to be honest about it. I've always provided customer service. My name is on there because I am the president of the company. And if somebody has a problem, I want them to be able to get a hold of me. It does not imply or mean that I'm here to help you do your real estate stuff. But it is customer service, and that is something extremely important in real estate. Am I banned from offering that to my clients?
You said in your statement in response to this complaint that Dan Stewart Realty was not involved in any way in this transaction between you and Mr. Cho.
Not at the conclusion, no, ma'am.
Not what?
Not at the conclusion that afternoon, he was not.
Okay.
Or the company was not.
Although, from that point on, they held the escrow money, didn't they?
Excuse me?
From that point on, they held the escrow money, didn't they?
Up until the time it was deployed, yes, ma'am.
So the Dan Stewart Realty Company was involved in some way with this transaction, was it not?
Yes.
Okay. And at the time of this transaction, Mr. Cho was already a client of Dan Stewart Realtors, was he not?
Yes, ma'am.
And he had properties managed by Dan Stewart Realtor, did he not?
Yes, ma'am.
And he had talked to you, at least on one occasion, about purchasing properties for him, or sent an email about purchasing other properties for him, did he not?
Yes, ma'am.
And you actually replied to him, let me read this for you, and it's in the complaint of Mr. Cho. You said to him, quote, on September 5th, I will look and see if we can find a good deal for you on another property. Probably a good idea right now until we know more. I will be back later this week, and we'll see what I can find worth buying in an area worth renting. Are you a licensee to do that?
Well, I was representing the company. We'd have an agent look into it. I always did that.
You're
In
making
fact, I
sta-
called an agent immediately after that conversation and had them start looking. There was a property I thought was a good deal.
Well, why would you be doing that for Mr. Cho if you didn't represent Mr. Cho?
Mr. Cho called me because I'm the president of the company. He had a customer service issue.
Why would you be looking for property for him if you were not representing him?
I was not looking for property for him. I knew a possible property.
You
And
just said you would look for property for him, sir. You just said that in your, you
And
said
I think
that
I
in
even specified I thought of one that might be a good one in that email also, didn't I?
No, you didn't.
Bottom line is the company found him a piece of property. It wasn't a big issue. I think Gina and Gotti was actually the one that I referred that one to.
Just a moment, please, while I consult with my client. Deposited the $40,000 into the escrow account?
Mr. Ping did.
Into your escrow account?
In the Dan Stewart escrow account, yes.
He went to the bank and made the deposit?
No, he wired the money in.
You gave him that information? You gave him the bank account information to wire it?
He had the Dan Stewart Realtors escrow account information from previous wire transfers to do the facilitation of the rehabs.
Okay, and who dispersed the money from the Dan Stewart account? Who wrote the checks out of that account?
Check was initiated by wire transfer direct to the appraisal company.
When you paid money out of that, who wrote the checks?
I mean, I authorized the wire transfer, if that's what you're asking. There was no checks written.
So you authorized the transfer out of the escrow account?
Yes, I did.
Okay. I have nothing further.
Have any redirect for your witness, Ms. Scarborough?
Just one or two questions, Your Honor.
All right.
Mr. Medlin, to the best of your knowledge, are you aware if you are required to be a licensed real estate broker to own a real estate company?
To my knowledge, no. I mean, there's probably 1,000 shareholders in Cry-Lite.
That's my only question.
Have anything further? All right. Commission members, this is your opportunity to ask questions. of the
Mr.
witness.
Medlin, you choose to be in our industry, but choose not to be licensed by our industry. Now, when Ms. Maxwell stated your license was revoked, you said, oh, no, that's inaccurate. So how should have Ms. Maxwell referred to your current licensure?
I retired the license. They later revoked it on I guess they didn't receive the documentation. That's understandable, but I retired the license prior to it being revoked, if I'm not mistaken, Ms. Maxwell. Is that correct?
It was retired and then, yes. You
So-
downgraded and retired.
Yes, ma'am.
So her characterization of your license was inaccurate?
No, sir. I mean, I retired the license. I was actually not aware that they went back and revoked them. This is actually the first, Maybe I've heard it in 2006.
You also
I don't know.
testified that you were in a position on the 1837 Union Avenue property as for sale by owner.
I was buying the property.
No, you said you were selling it for sale by owner, but later your testimony was you did not own the property.
For sale by owner being a colloquial term, I wasn't having real estate representation. That's all I meant. I mean, I sell LED lights right now. I don't own those lights. And then I go buy the lights and fulfill the order. This is the same thing. Mr. Ping was made aware of exactly where we're at in this transaction, and his own testimony would adhere to that.
Okay, I just have another couple questions. One, your counsel said that to use the term represent was ambiguous, which we probably all agree with. But in Mr. Cho's testimony, I asked him specifically who he felt represented him, and he said you. Where did he get that idea?
I don't know. I really don't. The only thing we ever talked about, other than on the property management, it was always a maintenance thing, because I usually ran out there and made sure Bill did the work. On the 1837 Union Avenue, he did talk to me, and I was explaining to him what our process is and what we're doing and where we're at in the contract. Other than that, I did not talk, I couldn't tell you his property addresses.
Okay, and then you put, or Mr. Cho put $40,000 in your escrow account?
That is correct.
And is that the same escrow account that you use for rehab money? So you only have one escrow account?
We now have a property management account because of the new law, yes, sir.
But you were taking money out of your earnest money escrow account for rehab on one of his projects? Did I get that testimony correct?
I would say it probably was to one extent, yeah. It's not my money, so it couldn't go into our account.
And I have just one other question. The earnest money was characterized, the $40,000 was characterized as earnest money. Later, it was characterized as down payment?
It was characterized more as investment at that point.
Okay, but in this one contract form that you submitted, it says that, did you ever complete the transaction of 1837 Union?
No, we did not.
Okay, well, in this one statement here that you provided, it says down payment money is refundable in the event that JAM Investments LLC is unable to perform. So you did not perform.
We were unable to perform.
So that money is entitled to go back to the purchaser, according to
Actually,
this
he
document?
authorized the money to be invested in the secondary appraisal required so the contract could go forward.
Okay, where is that? I missed that.
It's
I missed
not in
that
any of
all-
these documentations.
Oh, so that's just what,
It's hearsay.
yeah. Okay, thank you.
So where is the money now?
Money was given to the appraisal for the secondary appraisal on the property.
So the money came out of an escrow account?
It was originally transferred to the escrow account because it was a buy-sell agreement. And then when we changed it to a JV agreement, he sent it to the escrow account anyway. It didn't bother us sitting in the escrow account until Joyce found out. She said, it's not escrow anymore, get it out of the account. We moved it and paid for the appraisal with it.
What's your definition of commingling of funds?
Commingling fund is my personal money or the company's personal money being mixed with the client's money. That's not legal.
Okay, how many hours are you spending at the real estate company a week?
None right now.
Well, when this happened, how many hours were you spending?
I would go in, I'd come in the morning or so and leave and go do my thing.
So your mother took care of all the day-to-day operations then?
Primarily, yes.
Okay. Let me ask you a question. Go ahead. I'm not finished, but I gotta. Okay, and she told me go ahead. I'm gonna work on it while she's getting her thoughts together. Okay, I want to back up just a little bit.
Yes, ma'am.
To 2002 when you acquired New Horizon.
New Century.
New Century. Okay,
I didn't
sorry.
acquire them. They were, the Bank of Barnett had called their loan, and the Bank of Barnett called me in hopes that I would come down and buy furniture and desk from New Century on Winchester Road. When I went down there was 20-something agents standing around twiddling their thumbs wondering what to do because the door's been locked down. Those, whatever number of agents, went to work for Dan Stewart Realtors, transferred the license.
Okay, so you made the comment earlier that you agreed to give up your license so that you were not a competing broker.
That was one of the concerns they had, yes, ma'am.
Okay, so were you overseeing those agents?
After I retired my license, no, ma'am.
Okay, so what was the purpose of you retiring your license then at that point?
Confidence for the agents. They didn't know me, I didn't know them.
Okay.
I went from having 2 or 3 agents, I had to work. Now we have 20-something agents. When I could gather were decent producers. In theory, I should not have had to work in the real estate industry.
Okay. Your license, you said you retired. They were later revoked, and I believe that was because of the criminal conviction that you probably answered no on your test exam too, and was later found out that you did have.
No, ma'am. I had my license in 96, I believe Ms. Maxwell said. This is all 2002. I took the broker's exam in 98, if I remember correctly.
Oh, you upgraded to broker in 99.
99. This is all still prior to, so no, ma'am, I didn't lie on the application.
When did the conviction happen?
2001 or 2002, somewhere in there.
Okay, so after you retired your license is when the conviction
Yes, ma'am.
happened, and then they were revoked. Who was Mr. Cho's contact at Dan Stewart?
Joyce Medlin, he did most of his communication with his maintenance guy. I mean, by the time that we received the property, whoever was their prior property management guy had a tenant in there. They just sent their money in. When it come in the mail, it was recorded, deposited in Mr. Ping's. I would actually, a lot of times, would take Mr. Ping's check and drop it by his bank account for him. I did do that.
Okay, so your mother was his contact person
ma'am.
at that office. Now, you made the comment that when Miss Ryan questioned you about this email where you said, "I'll find you another piece of property,"
Yes, ma'am.
that you assigned him to an agent.
Gina Ngati.
Is that not a duty of a broker?
Gina Ngati, for the property that he's doing, she specialized in that. More or less common knowledge of who should work it. I mean, you know your agents, you know what their specialties are, whether you're doing it or not, you're just aware of it. I mean,
Okay, your contract that Ms. Ryan referred to is dated December 29th, and it says the seller's Jam Investments. You've admitted you didn't own that property when this contract was
No, ma'am.
written. Can you sell property that belongs to someone else without a real estate license?
we were buying the property. We were in the contract with a full-blown approval letter.
But you didn't own the
It was
property.
representing anybody. There was, I mean, even the seller didn't have, I take that back. I think a seller did have an agent. And I think Joyce was representing Jam Investments on the purchase. That's why she could not represent Mr. Ping. Mr. Ping had the option to go find a real estate agent. I was expecting to hear something from Larry Pickens wanting a commission. I never heard anything. So from our standpoint, we had no real estate agents representing us, and he was fully aware that the acquisition, this is where we're at. And you're buying this subject to us being able to close this. And I was very forthright with him with what we were up to. He just wanted to participate in the venture, that's all.
Where is that noted in this contract?
I don't know, I don't even remember, huh, to be honest with you. There would have been a section there somewhere that said I would have written subject to, in the page, and I apologize, I'm having trouble seeing, page 3 of the contract, conditions of closing, line item 8, Jam Investments LLC successfully concludes overall acquisition of the closing. Contract was set, condition of closing was closing of the acquisition.
And when was this set to close?
Originally March, then the lender come back with a question on the appraisal, so we had to go back and get a secondary appraisal, which that was somewhere around April or May of whatever year it was now. And then we waited, it took them 35 days to complete that appraisal. It just, commercial deals take a long time. I don't know what else to say.
But there's nothing in writing that gave you the authority to use earnest money for a secondary appraisal.
At that point, probably nothing in writing. I called Ping and said, this is what we need to do. What do you want me to do?
And that appraisal cost $40,000?
$38,000, yes, ma'am.
That's a little steep even for a
Yes, ma'am, it was
secondary
very
opinion. Okay.
But it was, you realize it was multiple buildings, multiple use. They had to do a after repaired appraised value based upon the renovations and the changes that were being done. We were having retail on the first 2 floors. We were going to run office on the top 2 floors of the office building, and a complete conversion of the first and second level on a quote-unquote tenant rec area, and then have the upper stairs. It was quite intense in appraisal, and it required multiple inputs on because it was a multi-use facility.
But Mr. Ping was not.
Cho.
Mr.
Well,
Cho.
it's Ping Cho.
Right. I know everybody's been referring to him as Mr. Ping and Mr. Cho.
It's Ping Cho. Mr. Ping Cho, we'll just get Doll in there, was not involved in the retail part of it. He was only involved in 10 units,
Hotel
according.
section, initially it was 10 units. Before the ink even dried, Everything had changed to add to the joint venture agreement because now he was a part of the entire hotel side of that equation, all 170 some odd rooms. And he got paid based on whatever room rented, not based on his units. Totally changed the whole scope of the contract.
Do we have some documentation that shows what percentage Mr. Cho was given and what percentage?
I would have to look at, see if it's, there was documentation. I have no idea if it's included in this or not. It would be under the joint venture agreement.
That.
That's in Exhibit 1.
What's the question, Janet?
What percentage Mr. Bean Cho was given?
I don't know that we ever actually identified a percentage because we weren't totally sure of our total cost in that project at that point, but we had agreed that it would be a percentage of the amount input versus the gross. Now, beyond that, I don't think we identified, we didn't have all the repair numbers back to understand what that number really was.
Okay, so him, assuming that he's a learned investor, agreed to this, all I can think of is the movie Money Pit, where all this money's going out and nothing's coming in. He has no clue what percentage he's going to get.
If you used 172 as the total number of units, and I think it was going to be reduced to 167 so that we could allocate for some two-bedroom units in the thing, he'd have basically 10 of the versus the 160 or 167, whatever it was. So that percentage was where we were driving at, was really based on number of units for the most part. We did run into the situation of, he was talking about, well, you're going to do all the repairs. Then he wanted to really make the 8 units extremely nice. Then he backed back off of that. So there was a lot of confusion initially that whole day as to what it actually would break down to be. Basically speaking, it was a percentage of your input versus a percentage of the total output. It's the way we ended up running it, just to help him understand what we were doing.
Okay,
And not
one
to
more
confuse me,
question,
'cause
and
I
I'm
got
going to give
really
it
confused.
back to Marcia. You said you're a member of TAR.
In 2002, I was a member of TAR. Dan Stewart Realtors is a member of Memphis Area Association of Realtors, which therefore includes TAR and NAR membership.
Okay, but you made the comment, I am a member of TAR. But
Dan Stewart Realtors.
you are not an agent.
No, ma'am.
Okay, thank you.
You made a statement that what you mainly did was you approved marketing.
No, I didn't approve marketing. I did a lot of marketing.
You did a lot of marketing for the company?
Yes, ma'am.
Okay,
And
so.
help the agents to develop a marketing program for them and networking program.
Okay, so you knew what the rules were as far as helping them to know what size on the signs and what to say and what not to say in advertisements, right?
Back in the day.
Okay, on your business card, do you still have a business card for this realty company?
I believe I do.
What is your title on that?
President.
Okay.
I had to pull a broker off of it.
Okay. Now, after all of this, why is your name still on the website today?
Because I'm still on the company, and this is a matter of customer service.
But
I
you
want
know
people to be
about
able to call me.
marketing because you advised your realtors on marketing. You know what the rules are. You had a broker's license. You knew what the rules are, and you still have your name on that. That is. Do you agree that the website is a marketing piece?
I do agree it's a marketing piece.
Okay, that's all I have.
I have a question.
So,
Is JAM Investments LLC licensed with the state of Tennessee at this particular
it
time?
is not right now.
Was it
actually,
ever?
Again, the whole idea was to sell it. Now we're not able to sell it because of the lawsuit, so it's just going to go to.
So it wasn't a legal entity. It was just something y'all created.
It was a legal entity, yes, sir.
But wasn't licensed with the state. Did you have a secretary of the state to get an LLC?
Was the company a legal entity in the state of Tennessee?
Yes, that's my question.
Yes, sir, I believe it was until recently when we didn't renew the paperwork.
Oh, okay. And do you have a website for JAM?
No, sir.
Okay.
It's strictly a holding company.
Okay. Well, if you Google that, you'll find about 100 of them, and I didn't know if you were in other states or not.
No, sir.
And it's your mother's the principal broker. Did she approve any contracts you did?
I didn't do any contracts except this one, and no, she did not do this one because she had nothing to do with this.
Well, she's supposed to as a principal broker. You know that, don't you?
On a contract between a buyer and a seller?
Yeah, if it's going through your company. Second question.
Okay.
All this money for secondary appraisal,
Yes, sir.
was that for the whole $9 million? Or
Yes,
just,
sir. It was for everything.
So his appraisal money was paying for the whole project?
Paying for
And
the
he only had
right.
1/67th of it? I don't add up to me.
Now, we had a little over $100,000 invested at that point. I just said, look, we're going to have another appraisal. I don't
So
have
he
the money
paid
to
for
put
all
into
of it?
Do you want me to use this and get it done so we can close this thing, or we can't close it?
So he paid for all of it?
So he basically paid the second appraisal.
Okay.
But the problem is, he's not here for us to ask that.
Sure.
He just told us that
No, I mean, Mr. Choi.
he didn't pay for all of it.
But he has no documentation of what his money went for.
My point is, irregardless of where we got documentation, he's just stated that he paid for all of it, and he only should have paid a percentage. I'm wondering how much you paid of it.
I had over $100,000 in the property investment.
For this
For
new
the first
appraisal.
appraisal for everything we've been doing. I mean, is a percentage equals? I don't know, maybe, maybe not. Nobody was trying to hurt anybody. We're just trying to get it closed so we could go on and do our thing.
All right.
That's what everybody was driving towards. Mr. Ping's email subsequently pointed that. What's going on? I mean,
I can see that.
okay.
I want to ask one. I got a couple of questions. What does JAM Investments own today besides the real estate company?
Nothing now. We had an apartment complex, we had some houses, and then everything's been sold off.
Okay. Your attorney, Ms. Scarborough, way back earlier this morning in her opening remarks, said that you had been given an opportunity to settle this matter, but you have chosen instead to be here. What was the offer that was made you to settle this matter?
For me to I think, admit to one of these charges of the three that was filed, pay a $1,000 fine, and end the story.
Where is the rest of that $40,000? I know where $38,000 of it went. Where's the other $2,000?
We had to bring in get some reports done. There was an environmental report done for asbestos and mold removal and potential cost of remediation. Part of the money, I guess, went there. I put a bunch of money into that as well. So, I mean, everything was put into the project with trackable numbers, if you will, so that where it was deployed. So it wasn't like I put anything in my pocket or in the company's pocket.
But there is a paper trail with all these emails that shows us Mr. Choi on several occasions asking for his money back. Is
Yes,
that
ma'am.
correct? Okay, so and until the very end, he's asking, not only asking but demanding for his money back, right?
Yes, ma'am, he is.
Okay. Do you have any documentation at all that will show different? I mean, you said that you didn't have an agreement with him about that $40,000. So are you saying you have no proof?
On the $40,000, when I went to Mr. Ping to use it for the appraisal, and we knew the asbestos was coming up, but on the appraisal, he told me, no, go ahead. Go ahead. I did. Now, did we have anything written in document? Joyce had already told me to get the money out of the account because it wasn't considered escrow. She didn't want it in her account. So we paid for the appraisal, sent it up to First Quick Funding in New York, to accommodate the appraisal management services that had been retained to do the commercial appraisal.
Do you have any idea about when he gave you the go-ahead to take that money out of the escrow account? Do you know month or year or?
No, I mean, it was somewhere in April, March or April era, or somewhere in that. I can't remember exactly when we had the lender, we had the loan, and we got the letter back saying that the lender is questioning the first appraisal, we're requiring a second appraisal. Got to go through appraisal management service. And I want to say it was somewhere around March or April.
Of
It's
what
my
year?
best guess right now.
Of what year?
2011, 2012? It was 2012 because this was done on December 29th.
Okay, so the complaint was filed on October. And seems to be his major complaint is getting his $40,000 back.
Yes, because it was convenient when we figured out we weren't going to be able to close because the lender, we went to the closing table on 2 occasions at Alliance Title. The trustee representing the federal bankruptcy court in which the property was tied up in was at the table. I went to the table. The lender never showed. We got on the phone, the seller from Las Vegas. We all got on the phone, called the lender. What's the deal? And he said, we had a paperwork issue. We're going to take care of it. We rescheduled. 3 days later, we went back. Didn't show up again. When we called him then, he's gone to Israel. And everybody's like threw up their hands. That's when I started talking to the hedge fund guy, trying to find a way to resolve this. Because here I have a seller who's about ready to throw a temper tantrum, a federal judge in Las Vegas really irritated. Obviously, I was mad, Ping was mad. I think everybody was mad at that point. We never could quite get the hedge fund to come together and get it done, for whatever reason.
No more
That's what
questions for me.
transpired.
Who ended up buying the property?
The property is under contract to, I believe it's Whole Foods, I could be mistaken. They've had it under contract for 1.5 years and still can't get it closed. The property has deteriorated now to the point that the repair estimate is probably going to be in excess of $19 to $20 million, and it will probably be torn down. But it's still open sale, everything else.
Sir, Austin McMullen, have a couple of questions about the 1837 Union transaction.
Yes, sir.
Just help me understand. So, JAM Investments was going to buy that property out of the bankruptcy. Is that what the plan was?
In essence, yes, sir.
Okay.
And then rehab it.
And then, as part of JAM's either getting paid back for the money that it had to put into it or making money on it, JAM Investments was going to turn around and sell certain units or certain floors of the condo part of it. Is
No,
that right?
sir. The original intent was to buy the property, do the rehab. We were going to rent the first 2 floors of the office building as retail. We were maintaining the entire hotel side as the apartment/condos for a specific charitable group that was managing people's money because it was kind of like a guaranteed revenue stream. But these people had an income check coming in from the government. So it became not a I can't think of the term I'm looking for. These people are independent living. They're quite capable. They just have issues that they had to deal with. That whole hotel was going to be maintained and owned. We chose the option of selling a couple of units because I needed to raise the $40,000 because we knew we were going to have that second appraisal when it come up. I knew it was coming because the first appraisal was only partial of the hotel the office building renovations. We had a feeling we were going to need some extra cash. That's why we were going to sell those units. Plus, it solidified with the lender the market value of the units. And that was one thing that there was no real history available for that type of development locally in that general area. So he said, well, go sell some units. I'll give us, so fine, whatever you want. I'm just trying to borrow money and get this thing done. And that was part of the reason why 10 units was sold, to establish a market value for that property. What would be somebody willing to pay?
Okay, and then that would help you establish the market value, get money to do the appraisal.
Finish the loan and everything.
And then ultimately, the idea was to sell the entire project or to sell JAM Investments?
No, sir.
Okay, help me understand
No.
that part.
During that time frame, my mindset was to create a long-term investment vehicle. I wasn't doing real estate. At the time, everything else was shaky anyway. That was my whole purpose. And just a note, $295,000 divided by 10 is $29.5 a unit. Okay, market value in that neighborhood was $45,000 for a studio. Okay, we were well under market value, but it did serve the purpose that I had to establish it could be sold for $30,000. But no, it was intended strictly as a long-term investment vehicle.
And that was how you personally were going to end up making some money up for all this work you were doing. Is that what the goal was? That was your retirement?
That was my retirement.
Okay,
And
I understand.
Mr. Gibbons and Mr. Ping, Dan Stewart was going to manage it to maintain, again, the integrity more than anything else.
Okay, thank you.
Yes.
Your Honor, I've been requested by Commissioner Collins that we take a real short break.
All right, and then continue questions after
Yes.
the break.
Yes.
All right.
Okay, Commissioner Collins.
Can be additional questions for the witness, are there? No? Okay. Thank you for your testimony, sir. Ms. Scarborough, did you have an additional witness?
Yes, Your Honor, I have an additional witness who is appearing via affidavit. It is unopposed by
Okay.
counsel. May I approach?
Sure. The affidavit will be entered as Exhibit 4, and you may distribute it to the commission members.
Here's the affidavit.
And Your Honor, would you like me to read it in?
It's up to you.
I'll read it into the record. Just
Okay.
thank you. The affidavit of Melody Wagner. It states, my full name is Melody Wagner and I currently reside in Memphis, Tennessee. I'm over the age of 18 and otherwise competent to provide this affidavit. I make this declaration based on my personal knowledge. I am an REO manager and affiliate broker with Dan Stewart Realtors, a real estate and property management company located in Memphis, Tennessee. As an affiliate broker with Dan Stewart Realtors, I'm familiar with Kenny Medlin, and I have known Kenny Medlin for 7 years. I'm aware that Kenny Medlin is the acting owner of Dan Stewart Realtors. In his role as owner of Dan Stewart Realtors, Kenny routinely works with investors, real estate developers, and agents of Dan Stewart Realtors. However, Kenny Medlin has never presented himself to others as a broker, advertised himself as a broker, or acted as a broker. I'm aware of numerous occasions during which Kenny referred investors or other individuals to real estate brokers at Dan Stewart Realtors. If Kenny is working with an investor, his typical practice is to refer the individual to a real estate broker at Dan Stewart Realtors if she expresses an interest in working with a broker. Pursuant to Tennessee Rules of Civil Procedure, Rule 72, I, Melody Wagner, declare under penalty of perjury that the statements contained herein are true and correct based upon my knowledge, information, and belief and the information available to me. Executed on the 24th day of January, 2014. Signed, Melody Wagner. Your Honor, that's the conclusion of respondent's proof.
Did either side have rebuttal witnesses, Ms. Ryan?
I do not.
We do not, Your Honor.
And it's now time for closing arguments.
The issue before you today is whether or not, when you look at totality of the circumstances, was Mr. Medlin acting in a way such that he should have a license under the Tennessee Real Estate Brokers Act. You heard a lot of testimony today. You heard that he uses the TAR contracts and that apparently didn't think it was inappropriate to do so. You also heard that on this particular TAR contract was an obligation to sell a piece of property that JAM Investments that he owns did not own. You heard that Mr. Q, sorry about that, Cho. If I learned nothing else today, I learned that. You learn that Mr. Cho was already a client of Dan Stewart Realtors when this whole transaction transpired. That Mr. Cho, in filing his complaint, thought he was a licensee. That Mr. Cho had a disagreement with how this contract ultimately transpired and asked for his escrow money back that was claimed as escrow in the contract. You also learned that Mr. Medlin said in 2012 that he is not represented anywhere on the website as a, quote, realtor or in any form. But you learned today that, of course, all throughout that website, he's the person to call for Dan Stewart Realty. And indeed, he owns Dan Stewart Realty. And at the time of this transaction, Dan Stewart Realty was already representing Mr. Cho in other matters in his property. You learned today that throughout his testimony, he refers to it as we, as the company as we, that we do this. In his emails to Mr. Cho, he said, I will find your property. I will do this. He's the person that authorized money to come out of the escrow account. The website is replete with references to call Kenny Medlin as part of that realty group, as that realty team. The reason we care about whether or not someone is licensed is to what happens to other individuals out there who wouldn't know enough to ask to see a license. In this particular case, Mr. Cho states he thought he was a licensee, and he worked with them after being brought to this whole matter by somebody else who should have had a license, Mr. Gibbons, who was taking money for managing that property, and he brought the whole thing to this particular company. He had a reason to believe that. They were managing his properties anyway. Mr. Medlin was his contact person. Mr. Medlin had all the emails to him and told him he'd find property. Mr. Medlin presented him the agreement. Mr. Medlin presented that he was the owner of JAM and the owner of Dan Stewart Realtor and the sole owner of all of that. The question is, are these actions enough to say, hey, you are presenting yourself in such a way that it's reasonable and understandable for somebody in the public to think that you're a licensee and therefore you're in violation of law because you are advertising or holding yourself out as a licensee in violation of law? We'd submit today that that's exactly what Mr. Medlin has done. And we ask today that you issue a civil penalty, that as part of your punishment, you come back and say, this needs to be considered if he even intends to apply for a license in the future, and that a part of the punishment, you also say he needs to pay the court costs in this matter. Thank you.
Judge Williams, is it possible for members of the board to ask a question to counsel as part of concerning the law here, as part of their closing statements?
Generally speaking, no.
When we deliberate.
Go ahead, Ms. Scarborough.
Ladies and gentlemen, thank you for your time today. I know we've been here for a while. I appreciate it. The department today has the burden of proof in proving that Mr. Medlin has acted as an unlicensed realtor. The proof today has shown that he has not acted as, advertised, or told anyone that he is a licensed real estate broker. In fact, you've seen in Melody Wagner's affidavit, in Mr. Gibbons' statements, and Mr. Medlin's statements that he has affirmatively told people that he is not a licensed real estate broker. He has affirmatively told Mr. Cho on numerous occasions that he is not a licensed real estate broker. Mr. Cho is a sophisticated businessman who you heard from himself and from Mr. Gibbons and from Mr. Medlin. He owned a number of properties in Memphis. Mr. Cho is understandably upset that he lost money, as most people are who lose money in a real estate transaction. And rest assured that any concern or issues with the money that he feels he has lost will be addressed in the civil court action regarding that. But the action before the commission today is whether or not Mr. Medlin acted as an unlicensed broker. In the notice of hearing and charges, it states that Mr. Medlin's use of a TAR contract, his ownership of Dan Stewart Realtors, and the placement of the earnest money at Dan Stewart Realtors, those three things led Mr. Cho to believe that he was a licensed real estate broker. You've heard testimony about the use of the TAR agreement, that it's used by others, that he was unaware of it, that it had been used in the past. You have heard that Mr. Cho had placed money before on numerous occasions in the escrow account with Dan Stewart Realtors, that he felt comfortable placing money there, that he didn't object to placing money there. And you have heard that the role of an owner of a company is very different than the role of a broker in a company. And that Mr. Medlin has been very clear in representing himself as an owner and a president and not as a broker in the company. But even if somehow these three attenuated circumstances were enough to make Mr. Cho believe that Mr. Medlin was a licensed real estate broker, we have proof that Mr. Medlin told him, hey, I'm not a licensed real estate broker. So it's nearly impossible to believe that he thought Mr. Medlin was his broker or was a broker. Heard a lot of testimony and a lot of evidence and a lot of facts come before you today. And I humbly request that you focus on the evidence that is relevant to the charge pending as to whether Mr. Medlin has acted or advertised himself as a licensed real estate broker. I think the evidence very clearly shows that he has not presented himself as a licensed real estate broker. And I request that the commission find that he is not in violation of these charges alleged by the Department of Commerce and Insurance. Thank you for your time.
Does either party have proposed findings for the commission to consider?
I do.
All right.
I do not, Your Honor.
All right. If you, Ms. Ryan, if you distribute
Thank you.
your set at this time, please.
Your Honor, if I could address the commission, I know there have been times in the past where, in these type of proceedings, where the notice of hearing and charges that was handed out this morning, that when this document is handed out, some commissioners have operated off the one that was handed out this morning versus operating off of this one. Sometimes it's gotten very confusing.
Right. Well, the commission members can utilize the proposed findings that were just handed out,
Right.
or they could utilize the notice of hearing this morning, or you could completely go from scratch.
Right. I just wanted to say that, to keep each one of them separate as we deliberate,
Okay.
so they don't get confusing.
Right. Why don't I give you a minute to look over the proposed findings of fact and conclusions of law before I start my charge to the commission.
Everybody had a chance to read over this findings of fact that we have been given?
I've got a question, Mr. Chairman.
Collins, ask it.
The complaint was against the real estate company and Kenny. Can we not include the real estate company in with this also?
I have the same question.
We've had evidence to prove that they didn't do a lot of things. The complaint originally says Dan Stewart Realtors and Kenny Medlin. And he said he is the real estate company several times.
That's an excellent question, but the notice of hearing is against just Mr. Medlin. It's not against the company.
He said he was the company.
So there could be a separate case?
No, I think what's before us today, I think, is like the judge said, it is whether or not this respondent, Mr. Kenny Medlin, has been engaged in unlicensed activity. Yes, he does own the company, but what's before us today and what the state has brought before us to deliberate on, I think, is the issue of, was he involved in unlicensed activity?
We didn't include both. That's all I'm saying.
Such is noted for the record.
That's just me as one of the commissioners. If I could, I know Commissioner McMullen, how do you feel about what I just said? I mean, it's my understanding that the issue before us is, did this individual, Mr. Kenny Medlin, engage in unlicensed activity?
I think you need to let the judge read her charges.
I think that's a good summary of the question that we have to deal with. But this other firm, I don't think, is in front of us.
Oh.
Right. That could be another matter later.
Let me go ahead and give the charge to the commission members. The commission has now heard the proof in the case of Kenny Medlin, an unlicensed person. In the Medlin matter, the state is seeking that the respondent be disciplined for allegedly violating the Tennessee Real Estate Broker License Act of 1973, found at Tennessee Code Annotated 62-13-101 et sec, particularly section 63-13-102 4A and B, wherein broker is defined, and section 63-13-301, which indicates that it's unlawful for a person to serve as a broker without first obtaining a license to do so. TCA 56-1-308 permits the commission to assess civil penalties for violation of statutes, rules, or orders. TCA 56-1-311 and Rule 0780-5-11-.01 also permit the commission to assess the respondent the actual and reasonable costs of investigating and prosecuting this matter. As sole and exclusive finders of fact in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found, determine the penalty if appropriate, and determine policy reasons for your decision. You must make findings of fact based solely upon the evidence presented before you in this hearing. This evidence includes the testimony of witnesses, any exhibits introduced, as well as affidavits. The notice of hearing filed by the state is not evidence, but may be used as a guide to assist you in making your findings, but it's the sole responsibility of the commission to make its own findings in this matter. The attorneys have argued their respective theories of this matter. The statements of counsel are not evidence, but are merely arguments to persuade you to see the evidence in the light most favorable to their particular position. Give such arguments whatever, if any, consideration you feel is appropriate. In making your findings, the commission must determine the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it's the responsibility of the commission to reconcile those conflicts if possible. But if it's impossible to reconcile the conflicts between witnesses, the commission must make the determination as to which witness to give the most credibility. In reaching this determination, the commission should bear in mind the following principles of law. The law presumes that all witnesses who are sworn to the oath testify to the truth. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, then it's necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the commission members as fact finders have wide discretion. However, the commission members should consider in determining the truth the witness's interest, if any, in the outcome of this matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, as well as their conduct and demeanor on the witness stand. Before the commission should consider any possible disciplinary action, the commission must first determine whether the state, the petitioner in the Medlin matter, has met its burden of proving the charges that it has brought by a preponderance of the evidence. If the commission finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the commission must find for the state. If the scales tip in favor of the respondent, the commission must find for the respondent. If the scales are evenly balanced, the commission should bear in mind that the state has the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. If after full and impartial review of the evidence presented to you, the commission feels that the state of Tennessee has carried its burden of proof by a preponderance of the evidence, the commission must then, based on its findings of fact, determine whether the conduct of the respondent is such that he is guilty of one, two, or all of the charges. If the commission finds the respondent guilty of a charge or charges, then the commission may take appropriate disciplinary action. The commission may find, for example, that the respondent has not violated the Real Estate Brokers Act and its accompanying regulations. The commission could find that the respondent has violated the Real Estate Brokers Act and that assessment of civil penalties is appropriate. The commission could find that the respondent has violated the act and should also pay the costs of the proceeding in addition. In assessing the alleged violations and appropriate penalties, the commission may consider any evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature versus was a one-time occurrence, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the general interest of the public. Additionally, the Commission may also consider what it has done in previous similar matters for comparison purposes. I mention these examples of possible discipline for illustration only and not in any effort to sway the Commission in its determination. From time to time, I may have been called upon to make rulings of law and procedure during this hearing. The Commission alone must make the decision regarding the merits of this matter and must not draw inferences concerning any opinion that I might have in this matter from any statement or ruling that I have made. Chairperson Stevenson, please proceed with the deliberative process establishing findings of fact, conclusions of law, and policy reasons for your action.
Thank you, Your Honor. As we start to deliberate as to the findings of facts, anybody have anything they'd like to bring before the Commission in this matter?
I'd like to make a comment. It is pretty obvious to me that the consumers who we're here to protect, and in his mind's eye, Mr. Medlin was representing him. Mr. Medlin did numerous things that would make him think that, and even under testimony, he did agree to things that he has done that are acts of the broker, and I think that's something we should consider in our deliberations.
You talking about Mr. Cho?
Yes, I'm talking about Mr. Cho.
Mr. Cho and his, what he thought.
In his complaint and in his testimony today. I come from a very big family. I counted up a while ago. I got to thinking about it. We have 25 people in our family that are they're developers, builders, realtors, real estate attorneys, and even a judge at one time. And we have this discussion a lot. And it is very easy. My husband, who's the developer, it is very easy for him to want to do something that he has the ability to do, but it is illegal in the state of Tennessee because he's not licensed. So we have this a lot. I think that maybe that's what has happened here. The difference being in that that he has had a real estate license and he has been to real estate school and even set for the broker's exam. So I think he knew exactly what the laws were, and I think he's just gotten kind of caught up in something he was able to do. But in the state of Tennessee, we also have to protect other realtors who go through the process and who take the classes and who do their continuing education. And I kind of see that as maybe what has happened here. It's just been a little slippery slope for him.
You know, along that same line of thinking, it would be very difficult, I would imagine, for someone as in Mr. Medlin's situation, having once held a license and owning a company now, a real estate company, that his mother is the principal broker, and it would be hard, I'm sure, for somebody like Mr. Cho not to just have the impression that he too had, that Mr. Medlin, being the owner of the company, that would, and his involvement with the company as brought out in the testimony as far as the website and his involvement in that, with that website, that he would not think that he had a real estate license. I mean, you'd just have to walk around every other sentence, I don't have a license, I don't have a license, just to let people know that you don't have a license.
Well, but even when you're telling people you don't have a license, but your actions show otherwise, is the problem here. I mean, when he's saying, I will find you a piece of property, you know, or I will assign you somebody to help you, you know, that would indicate that he is wholly involved. And while out of one side he's saying, I'm not a licensed agent, but yet he's doing things that a licensed agent should be doing, including writing a contract on property he didn't own at the time.
Which goes to his credibility.
Absolutely.
Any other commissioners have any thoughts as we?
Yes, sir. Is it possible to go beyond what our council has suggested for conclusion of law?
Judge?
Potentially, yes. It depends on what it is specifically.
Okay, 1613-312-4 says that he's engaged, in my opinion, untruthful advertising, and specifically mentions the term realtor.
What?
1613-312-4.
312B4.
Yes, ma'am.
Right. Well, 312 is the section for discipline of holders of licenses.
So that wouldn't
Whereas-
apply?
Yeah, no.
Well, then I'd like to make the recommendation that we follow the conclusions of law as represented by our counsel, and then in deliberation determine the exact amount. And in my suggestion, it would also include paying the cost of these proceedings today.
Mr. Chairman?
We're just discussing. But Commissioner McMullen?
I think we need to go through some findings of fact first before we get into that. Ready to make a motion if y'all are
Yes, sir.
bumping your gums. All right. Mr. Chairman, I move that we adopt the following finding of fact. The respondent, Mr. Medlin, was at all times pertinent hereto unlicensed with the Tennessee Real Estate Commission. Mr. Medlin did at one time have an affiliate broker license numbered 261145, but that license expired on December 31, 2002. Mr. Medlin attempted to renew the license, but was denied by the commission.
Second.
Motion has been made by Commissioner McMullen, second by Commissioner DeShara, that the findings of fact that is presented to us is it's number one on that findings of fact. Any discussion on this motion? All in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I'm going to deviate from the piece of paper now and move that we adopt the following finding of fact. Prior to the transactions at issue, the complainant, Mr. Cho, had a working relationship with William Gibbons, who became associated with the respondent, Mr. Medlin. Mr. Cho became a client of Dan Stewart Realtors with respect to certain rental property that Mr. Cho owned.
Second.
Have a motion by Commissioner McMullen, second by Commissioner DeShara, that you've heard read into the record, and I want to ask each of you to, when he deviates, just to pay close attention, and if you have any objections, to voice them at the discussion phase of any motion that are made. Any discussion on this motion that Commissioner McMullen has made? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following finding of fact. Mr. Medlin is the sole and managing member of JAM Investments LLC, which is the sole owner of the licensed real estate firm Dan Stewart Realtors.
Second.
I have a motion by Commissioner McMullen and seconded by Commissioner Franks. What you've heard read into the record. Any discussion on this motion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following finding of fact. Mr. Medlin and Mr. Cho discussed the possibility that a joint venture would be created between Mr. Cho and JAM Investments LLC concerning the development of 1837 Union Avenue, Units 801 through 810, Memphis, Tennessee, which is the subject property.
Second.
I have a motion by Commissioner McMullen and seconded by Commissioner DeShara of an additional finding of fact. Do I hear any discussion?
Yes. I thought this occurred after they had a contract to purchase eight or 10 units.
I believe Mr. Cho's testimony from this morning was that it was actually initially presented to him as a joint venture. And if you look at the dates of the joint venture agreement and the commercial purchase and sale agreement, I believe they're dated the same date. And the commercial purchase and sale agreement actually refers to the joint venture agreement. So I think they were contemporaneous documents.
Any other discussion on this motion made by Commissioner McMullen regarding additional findings of fact? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following finding of fact. JAM Investments LLC intended to purchase the subject property out of bankruptcy to develop it as a mixed-use commercial and residential project.
Second.
I think that Commissioner Franks beat you to this.
That's quite all right. I'm not going to fight with her.
We have a motion by Commissioner McMullen and second by Commissioner Franks that this additional findings of fact. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move that we adopt the following finding of fact. JAM Investments LLC and Mr. Cho entered into a joint venture agreement dated. A second, let me make sure I've got the right date.
Of 29, I think, Austin.
Okay. Dated December 29th, 2011, governing the subject property.
Second.
Motion made by Commissioner McMullen, second by Commissioner DeShara pertaining to this additional findings of fact. Any discussion on this motion or comments? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. JAM Investments LLC and Mr. Cho also entered into a commercial purchase and sale agreement for the subject property dated December 29, 2011. Mr. Medlin signed this agreement on behalf of JAM Investments LLC.
Second.
Motion made by Commissioner McMullen, second by Commissioner Franks. Any discussion? All in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. The agency and brokerage section of the commercial purchase and sale agreement does not identify any broker representing the buyer or the seller.
Second.
Motion by Commissioner McMullen pertaining to this testimony that was entered into the record and seconded by Commissioner DeShara. Any discussion on this motion? This additional findings of fact. Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. The commercial purchase and sale agreement form used is a form copyrighted by the Tennessee Association of Realtors, TAR, which is provided by TAR for use of its realtor members. Mr. Medlin is not a TAR member.
Second.
Motion by Commissioner McMullen and seconded by Commissioner Franks. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Medlin, acting on behalf of JAM Investments LLC, solicited and negotiated with Mr. Cho for the commercial purchase and sale agreement.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeShara, pertaining this additional findings of fact. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Let's see. Mr. Chairman, I move we adopt the following finding of fact. The sale agreement between Mr. Cho and JAM Investments LLC helped to establish a market value for the subject property and obtain funds to pay for an appraisal that were necessary for the success of the project.
Second.
Motion by Commissioner McMullen, second by Commissioner Franks. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. For Mr. Medlin, the success of the project and development of the subject property were essential to his personal retirement.
Second.
Motion by Commissioner McMullen, second by Commissioner DeShara, pertaining to additional findings of fact in this matter. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. Pursuant to the commercial purchase and sale agreement, Mr. Cho deposited $40,000 earnest money with Dan Stewart Realtors.
Second.
Commissioner McMullen has made the motion as pertaining to additional findings of fact of the testimony, and seconded by Commissioner Franks. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. By September 2012, the transaction between JAM Investments LLC and Mr. Cho had not closed, and Mr. Cho demanded return of the earnest money. The earnest money was not returned.
Second.
Mr. McMullen has read in the record, made this form of a motion of additional facts presented in this matter, and seconded by Commissioner DeShara. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following finding of fact. Mr. Medlin's name and phone number appear on the website for Dan Stewart Realtors as the person to call generally, for investments, and for property management.
Second.
I have a motion by Commissioner McMullen, second by Commissioner Franks. Any discussion on this motion pertaining to additional findings of fact? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I'd like to make a recommendation in terms of findings of fact that we add respondent's relationship with Dan Stewart Realtors, use of Dan Stewart Realtors as holder of the earnest money, and use of a TAR contract led Mr. Cho to believe that respondent was a real estate licensee.
You want to put that in form of a motion?
He did.
And he did.
Okay, I'm sorry.
Second.
Motion made by Commissioner Bloom and second by Commissioner DeShara. You've heard this findings of fact read into the record by Commissioner Bloom. Is there any discussion?
Mr. Chairman?
Yes, sir.
I did not make this motion because I was not personally convinced that Mr. Cho believed that the respondent was a real estate licensee. That's just my take on the evidence and what I heard. And so I did not make the motion because I didn't want to speak against my own motion, but that was just my thought on it. So I intend to vote no on this motion, but each person has to weigh the evidence and make a decision for themselves.
I don't have, can you restate your motion?
It was just number 8 on the proposed findings of fact.
Okay, that was, you read, that's what you read. Okay, I'm sorry. It's number 8. The motion was respondent's relationship with Dan Stewart Realtors, use of Dan Stewart Realtors as holder of the earnest money, and use of a TAR contract led Mr. Cho to believe that respondent was a real estate licensee. Any other additional discussion?
Yes, sir, I'll discuss that. Mr. Cho said that, and there was no other competing evidence.
Second that.
That's number 8. It's already been seconded, and we're discussing his motion.
Well, and I'd also like to make the comment that in Mr. Cho's affidavit, in his original complaint, he states that he thought that, well, if I can find that form. He states that he thought that Mr. Medlin was the licensee. Let me find that.
As he represents both the buyer and the seller.
And he also says, I am requesting Tennessee Real Estate Commission to help me on this to ensure licensee to comply with state regulation. That's in his affidavit in the next to the last paragraph.
I think what Mr. Cho in this particular affidavit of complaint, what he was asking the Real Estate Commission to do was to assist him in getting his $40,000 back.
Well, I agree, but I also think he believed Mr. Medlin to be representing him because he made that statement on the call this morning. And all the correspondences that we have, Mr. Medlin made the remark that Mr. Cho's contact person was his mother, Miss Medlin. But in all these correspondence that we have, they're all with Mr. Medlin himself. They're not with anyone else. And
I'm sure if they were, that Mr. Cho would have added that too and maybe have included her as a
But he never even mentioned her this morning.
No.
But y'all got to realize also, this particular contract was a contract that Mr. Medlin was going to be an equity partner. It was one that he was buying out of bankruptcy. We needed some investors to go in with him, what I understand, based on the testimony. And he was buying a piece of property, and he was going to be one of the owners. And I mean, if you're buying your own property, you don't need a real estate license to enter into a situation like he was entering into with Dr. Cho, or Mr. Cho.
But he didn't own the property when he was entering into the contract to sell it.
That is true. He was trying to buy it, but it didn't belong to. It wasn't like he was writing a contract that the property belonged to somebody else, and he was out here writing a contract on that property. He was going to be one of the owners in this property.
He was going to sell a property he didn't own to another person, is what the contract says.
Because at this current time, he testified that he did not own the property. He was trying to buy the property. So he wrote a contract representing himself as the seller of the property on a piece of property that he owned.
Per the signature line.
To a buyer who was Mr. Cho. And the property was still owned and still is today by someone else. And the emails are clear that Mr. Cho felt that Mr. Medlin was representing him. He even asked for him to look for additional properties. Mr. Medlin responded, I will look and see if I can find a good deal for you on another property. There's nothing about that that in that whole email that mentions that he's going to turn that over to someone else.
Any other discussion on the motion? It was read into the records, identified as number 8 in the proposed findings of fact and conclusions of law. Last one on the first page. Any additional discussion? Hearing none, then I think it's time to vote.
I've got on that one.
Yeah, on number 8.
All right. Ready to go.
Any additional comments or discussion on number 8 that's been read in the record by Commissioner Bloom? Hearing none, all in favor say aye.
Aye.
Opposed, no.
No.
I'm gonna vote no also. It's 4-2, 4 yes and 2 no's.
Mr. Chairman, I don't have any other motions to make with respect to findings of fact.
Commissioner Collins.
That Kenny Medlin, the owner of Dan Stewart Realtors through JAM Investment, failed to show written agreement for the release and disposition of the $40,000.
Second.
Have a motion by Commissioner Collins. Additional findings of fact based on the testimony, and seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Does anybody have any other findings of fact that they would like to have read into the record? Make a motion that we make it a part of the record.
If not, Mr. Chairman, I'd have a motion to make with respect to conclusions of law.
Commissioner McMullen.
Mr. Chairman, I move that we adopt the following conclusion of law. Tennessee Code Annotated, Section 62-13-102-4A, defines broker as any person who, for a fee, commission, finder's fee, or any other valuable consideration, or with the intent or expectation of receiving the same from another, solicits, negotiates, or attempts to solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sale, rent, or exchange for any real estate, or for the improvements thereon, or any timeshare interval as defined in the Tennessee Timeshare Act, compiled in Title 66, Chapter 32, Part 1, collects rents or attempts to collect rents, auctions or offers to auction, or who advertises or holds out as engaged in any of the foregoing.
You've heard read into the record by Commissioner McMullen, the second by Commissioner Franks, the conclusions of law and pertaining to Tennessee Code Annotated 62-13-304, 301.
No, 102, 4A. That's not right.
Okay.
That's not right.
102.
It's 102, 4A, right,
Yes, ma'am.
Austin?
Yes, ma'am.
Okay, 102, excuse me, 102-4A. It's been made, Commissioner McMullen, and seconded by Commissioner Franks. Any discussion on this particular conclusions of law? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following conclusion of law. Tennessee Code Annotated Section 62-13-301 provides in relevant part, it is unlawful for any person, directly or indirectly, to engage in or conduct or to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker, affiliate broker, timeshare salesperson, or acquisition agent, as defined in Section 62-13-102, within this state without first obtaining a license as such broker, affiliate broker, timeshare salesperson, or acquisition agent as provided in this chapter, unless exempted from obtaining a license under Section 62-13-104.
Second.
Motion made by Commissioner McMullen pertaining to Tennessee Code Annotated 62-13-301, and he has read it into the record. It's been seconded by Commissioner DeShara. Any discussion on this particular conclusions of law? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following conclusion of law. Mr. Medlin's actions violated Tennessee Code Annotated Section 62-13-301 as charged in Count 3 of the Notice of Hearing and Charges.
Second.
We have a motion by Commissioner McMullen and seconded by Commissioner DeShara. Do you think we need to read into the record, Commissioner McMullen, number 3? What?
301's already been read into the record.
Most of it's just quoting the statute that we just adopted in the previous conclusion of law.
Okay. You've heard this motion. And I have a second. Any discussion?
Mr. Chairman?
Yes.
I indicated earlier that I wasn't sold on the question of whether Mr. Cho was led to believe that Mr. Medlin was a licensee, but I do believe that Mr. Medlin acted as a broker without a license in the transaction because he was acting on behalf of JAM Investments, LLC. And there was no one else there representing them in that transaction. He was doing it. He was selling property on behalf of another without a license, and that's the violation that I think occurred in my mind, and so that's why I made the motion, and that's why I'm planning to vote in favor of it.
Any other discussion on this last motion pertaining to the conclusions of law? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I move we adopt the following conclusion of law. This violation constitutes grounds for disciplinary action and civil penalties and the assessment of investigatory and hearing costs.
Your second to this motion?
Second.
Made by Commissioner McMullen and second by Commissioner DeShara. Any discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, that's all I have in the way of conclusions of law.
Does anybody have anything else that they'd like to put in the form of a motion and make it part of the record? Conclusions of law, other than the 4 that Commissioner McMullen has made and 1 that Commissioner Bloom has made. That was findings of fact. I'm sorry. You're right. Keep me straight. All right, anything else? Now, having read into the record and the motions made, the findings of facts and the conclusions of law, now it's the duty of this commission in this matter to determine if there's what would be the appropriate civil penalty, if any.
Mr. Chairman, I move we adopt the following penalty. I move that we adopt a $1,000 civil penalty pursuant to Rule 1260-2-.32 and the assessment of all investigatory and hearing costs pursuant to Tennessee Code Annotated 56-1311 and Rule 0780-5-11-.01.
Second.
I have a motion made by Commissioner McMullen, seconded by Commissioner Bloom. Is there any discussion on this motion?
Is that the maximum penalty we can put on that?
As I read the book, yes.
Any other discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Now, since we have gone through the findings of fact, conclusions of law, and established the appropriate civil penalty, we need now, if someone would like to read into the record and make a policy statement regarding this particular matter.
I have a policy statement if nobody else wants to make one. I move that we adopt the following policy statement. Licensure of individuals who act as brokers is in the public interest. Through the licensure process, TREC ensures that people who act as brokers comply with all provisions of applicable law, which serves to protect the public.
Second.
We have a motion made by Commissioner McMullen and read into the record as to a policy statement concerning this matter, and seconded by Commissioner Franks. Does anybody have any comments about this particular policy statement? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Judge Williams, does any other commissioners have anything that they would like to say or bring up? If not, I'm going to turn these proceedings back over to Judge Williams. And I think we have finished our deliberations, Judge Williams, and if you have anything else.
So you have finished, the hearing is concluded, the state will draw the necessary documents for your signature, Mr. Chairman. This hearing is concluded. Thank you.
We're concluded. Thank you for your patience, and everybody drive safely going home. This meeting is adjourned.
Thanks, Steve.